The New Canon Law, a commentary and summary of the New Code of Canon Law by Reverend Stanislaus Hoywad, OFM, with a preface by Right Reverend Manager Philip Bernardini, JUD, Professor of Canon Law at the Catholic University, Washington. New edition, augmented by recent decrees and declarations. Imprimatur, John Cardinal Farley, Archbishop of New York, July 3, 1918. Copyright, 1918, by Joseph F. Wagner, New York. Preface. For several months past, the articles by Father Stanislaus Hoywad in the Ecclesiastical Review have informed the clergy of the most important features of the new Code of Canon Law. The same author now gives to the public a summary and commentary of the whole code. As the present volume is published mainly with a view of the needs of the clergy engaged in the care of souls, the bulk of the book has been kept as compact as possible. Wherefore in such places only where explanation and comments seemed necessary they have been given, and in as brief a form as possible. Chapters which are not needed by every priest have been mentioned only with few words and en passant, as it were. The fourth and the fifth book have been summed up very briefly, giving the most important points of legislation contained therein. A very complete index will make it easy to find any desired point of law. We heartily congratulate Father Hoywad on the good work and trust that the clergy of the United States will be pleased to find in this volume a welcome means of acquiring the necessary knowledge of the new legislation of the Church. Dr. Philip Bernardini, Professor of Canon Law at the Catholic University, Washington, D.C. Introduction. When on May 27, 1917, a new Codex Juris Canonici was promulgated by papal bull, this memorable event marked the happy conclusion of a revision of the Code of Law for the Catholic Church which had taken 13 years of the most painstaking work on the part of a large number of erudite scholars and specialists in canon law. The new code is truly a monumental work, the magnitude of which will be apparent when thought is given to the truly gigantic task of revising and coordinating all the existing church laws, including the laws of all ages since the times of the primitive church, eliminating all those that have dropped out of use, or that have been revoked or suspended in the course of the centuries. Never before in the history of the Church was such a compilation on the same immense scope attempted. During the Middle Ages various popes caused official collections made of laws that had been enacted within a limited period of years, but never before was the entire legislation of the Church unified and codified as it has now been done in the new Codex. The papal bull decreed that the new book of law was to go into effect on Whitsunday, May 19, 1918. The period of time allowed before a new law after its official promulgation goes into force is known in the terminology of canon law as the vacatio legis. Canonists have generally held that for all laws promulgated by the Holy See 2 months' time is granted before in places outside the city of Rome the obligation of observing the law begins. For very remote countries even a longer time has been conceded, in order to let the knowledge of the law become sufficiently disseminated to make its enforcement possible. In more recent times the Holy See has in important laws frequently specified the period of the vacatio legis, as for instance in the case of the decree ni tenure which was published about 8 months before it was to be enforced. The general principle, however, valid in civil law as well as in canon law, is that it is the duty of subjects to keep themselves informed through the ordinary channels of information, as, for instance, official magazines and papers, what laws, amendments, decisions, etc., have been enacted by the new canon law by the authorities. It is not necessary, hence, that the bishop announce to his clergy the laws and regulations passed by the supreme authority of the Church, nor can it be said that this is his duty, though for uniformity of action on part of the clergy of a diocese it is advantageous that the bishop announce to his priests the important new laws with direction to make them known on one and the same day to the people throughout the diocese. The purpose of the new codex is, to supersede all existing collections of papal laws, whether contained in the various official compilations published with the special approval of former popes, or in the volumes of decrees and declarations published by the various Roman congregations, or, finally, in the many existing private collections of papal laws. Only in those instances in which the new code expressly declares that a former law on a specified subject is to be retained, are former laws to continue in force. Instances of this kind are discussed in the course of the present volume. The benefit of the new code is inestimable, and it will go far toward unifying and strengthening the activities of the Church, by effecting a more uniform course of action in all the important details of the Church's life. Let no one, however, labor under the impression that the Code means the legislation of the supreme head of the Catholic Church has now come to an end. An organization like the Catholic Church, living and laboring in the great, wide world, and guiding millions of people of all races in the way of truth, must needs adapt her work to the ever-changing conditions of peoples and times. The present Code, therefore, is not, and cannot be, the final law in all and everything, for, inasmuch as canon law is the regulation of the activities of the Church, and since these activities are changing and developing with the gradual progress of civilization, new amendments, decisums, declarations concerning the meaning of some of the laws, and exceptions and particular regulations to fit the exceptional conditions of particular countries or dioceses, must naturally be expected. The Holy Father has, however, provided, motu proprio, September 15, 1917, Eta App. St. F. Volume 9, Pag. 483, that any and all new laws, as well as the possible repeal of some canons of the new Code, also any interpretative declarations, etc., issued either by the Supreme Pontiff himself or by one of the sacred congregations, shall be turned over to a committee whose duty it will be to formulate the new laws, etc., into canons, and to insert introduction vn them in the Code in their proper places, so that the Code may for all times remain the one, authoritative and complete law book of the Church. The canonist will note the difference in the arrangement of matter in the new Code from the order followed in former collections of canon law. Previous collections were, as a rule, divided into 5 books, in the order of Judex, Judicium, Clems, Connubia, Cremen, whereas the 5 books of the present Code are, Lib. 1, Normi Generates, Lib. 2, De Personis, Lib. 3, De Rebus, Lib. 4, De Processibus, Lib. v. De Delictis et Poenis. Reference to the laws has been made easy by short canons, or paragraphs, numbered consecutively from beginning to end of the Code, 2,414 canons in all, so that the number of the canons suffices to enable one to find a certain law, no matter in what book, or under what title, this law may be placed. The purpose of our present volume on the new Code is, mainly, to give the clergy engaged in parish work in a handy volume all that which is of practical importance for them in their daily life, in the exercise of their sacred duties that must be guided by the laws of our Holy Mother Church. Prolonged discussion and lengthy comparison with former law, such as might appeal to the student who has no other duties but his studies to attend to, are avoided in this volume. Such discussion and comparison will find proper place in a complete and thorough commentary on the Code which the author has under consideration for future publication. In arranging the subject matter of this book we have faithfully adhered to the order of the new Code, in deference to the Holy Father's desire that no one introduce an arrangement differing from the Code. The author. On the Feast of Saint Bonaventure, D.S., July 14, 1918. Contents. Page. Preface I. Introduction. V. The First Book, General Principles of Canon Law. I. Title I. Principles of Ecclesiastical Law 3. Title II. Customs 7. Title III. Manner of Reckoning Time 8. Title IV. Rescripts 10. Title V. Privileges 13. Title V. Dispensations 15. The Second Book, Laws Concerning Persons 17. Part 1. Laws Concerning the Clergy. Section I. The Clergy in General 22. Title I. Manner of Ascribing the Clergy to a Diocese 22. Title II. The Rights and Privileges of Clerics 23. Title III. Obligations of Clerics 25. Title IV. Ecclesiastical Offices 29. Title V. Ordinary and Delegated Jurisdiction 30. Title V. Reduction of Clerics to the State of the Laity 34. Section II. Clerics Individually 35. Title VII. 11 The supreme authority and those who by law share in it. 36. Chapter 1 The Roman Pontiff. 36. Chapter 2 The General Council. 37. Chapter 3 The Cardinals of the Holy Roman Church. 38. Chapter 4 The Roman Curia. 41. Article I The Roman Congregations. 42. Article 2 The Tribunals of the Roman Curia. 46. Article 3 Offices of the Roman Curia. 46. Chapter 5 Legates of the Roman Pontiff. 47. Chapter 6 Patriarchs, Primates, Metropolitans. 48. Chapter 7 Plenary and Provincial Councils. 49. Chapter 8 Vicars and Prefects Apostolic. 51. Chapter 9 Administrators Apostolic. 51. Chapter 10 Inferior Prelates. 52. Title 8 Episcopal Jurisdiction and Participants of the same. 53. Chapter 1 Bishops. 53. Chapter 2 Coadjutors and Auxiliary Bishops. 59. Chapter 3 The Diocesan Synod. 61. Chapter 4 The Diocesan Curia. 62. Article I The Vicar General. 63. Article 2 The Chancellor, Other Notaries, the Episcopal Archives. 65. Article 3 Synodal Examiners and Parochial Consultors. 67. 9. X The New Canon Law. Page. Chapter 5 Chapters of Canons. 68. Chapter 6 Diets and Consultors. 68. Chapter 7 Obstruction in the Government, Vacancy of the Episcopal See, the Vicar Capitular. 69. Chapter 8 Deans. 72. Chapter 9 Pastors. 74. Chapter 10 Parochial Vicars. 80. Chapter 11 Rectors of Churches. 83. Part 2. The Religious. 85. Title 9 Erection and Suppression of a Religious Organization, of a Province, or a House. 87. Title X The Government of Religious Organizations. 89. Chapter 1 Superiors and Chapters. 89. Chapter 2 Confessors and Chaplains. 94. Chapter 3 Temporal Goods and Their Administration. 98. Title 11 Admission into a Religious Community. 100. Chapter 1 Postulate. 101. Chapter 2 Novitiate. 101. Article I Conditions for Admission. 101. Article 2 Education of the Novices. 106. Chapter 3 Religious Profession. 111. Title 12 Studies in Clerical Religious Communities. 115. Title 13 Duties and Privileges of Religious. 117. Chapter 1 Duties. 117. Chapter 2 Privileges of the Religious. 122. Chapter 3 Duties and Privileges of the Religious promoted to an ecclesiastical dignity, or to rectorship of a parish. 124. Title 14 Transition to another order. 127. Title 15 Departure from religious life. 128. Title 16 Dismissal of religious. 131. Chapter 1 Dismissal of religious with temporary vows. 131. Chapter 2 Dismissal of religious with perpetual vows in non-exempt clerical and in all equal organizations. 132. Chapter 3 The canonical trial and the dismissal of religious with perpetual or solemn vows in a clerical exempt religious organization. 134. Chapter 4 Dismissed religious who had taken perpetual vows. 136 Title 17 Societies of men or women, leading a community, life without vows. 138, Part 3, The Laity. 139. Title 18 General Regulations for Associations of the Faithful. 140. Title 19 Particular Regulations for Associations of the Faithful. 143. Chapter 1 Third Orders Secular. 144. Chapter 2 Confraternities and Pious Unions. 145. Chapter 3 Arch Confraternities and Primary Unions. 147. The Third Book, Sacred Things. 149. Part 1, The Sacraments. 150. Title I Baptism. 151. Contents X. Page. Chapter 1 The Minister of Baptism. 151. Chapter 2 The Subject of Baptism. 152. Chapter 3 The Rites and Ceremonies of Baptism. 154. Chapter 4 Sponsors. 156. Chapter 5 Time and Place of Baptism. 15. Chapter 6 Recording and Proof of Baptism. 158. Title 2 Confirmation. 159. Chapter 1 The Minister of Confirmation. 159. Chapter 2 The Subject of Confirmation. 160. Chapter 3 Time and Place of Confirmation. 161. Chapter 4 The Sponsors 161, Chapter 5 Record and Proof of Confirmation 162, Title 3 The Blessed Eucharist 162, Chapter 1 The Holy Sacrifice of the Mass 163, Article I The Celebrant 163, Article 2 The Rites and Ceremonies of Holy Mass 165, Article High Time and Place of Holy Mass 165, Article 4 The Alms or Stipends of Masses 166, Chapter 2 The Blessed Sacrament 170, Article I The Minister of Holy Communion 170, Article 2 The Recipient of Holy Communion 171, Article 3 Time and Place for the Distribution of Holy Communion 174, Title 4 The Sacrament of Penance 175, Chapter 1 The Minister of the Sacrament of Penance 175, Chapter 2 Reservation of Sins 179, Chapter 3 The Subject of the Sacrament of Penance 182, Chapter 4 The Place where Confessions are heard 183, Chapter 5 Indulgences 183, Article I Concession of Indulgences 183, Article 2 Manner of Gaining Indulgences 186, Title V Extreme Unction 188, Chapter 1 The Minister of Extreme Unction 188, Chapter 2 The Recipient of Extreme Unction 189, Chapter 3 The Rites and Ceremonies of Extreme Unction 189, Title V The Sacrament of Orders 190, Chapter 1 The Minister of Sacred Ordination 190, Chapter 2 The Subject of Sacred Ordination 194, Article I Requisites for Candidates of Ordination 194, Article 2 Irregularities and Other Impediments 197, Chapter 3 Requisites prior to the ordination 200, Chapter 4 The Rites and Ceremonies of Ordination 203, Chapter 5 Time and Place of Ordination 203, Chapter 6 Record and Testimonial of Ordination 204, Title 7 The Sacrament of Marriage 205, Chapter 1 Requisites before marriage and especially the banns 206, Chapter 2 Impediments in general 209, Chapter 3 Impedient impediments 214, Chapter 4 Diriment impediments. 216, 12 The New Canon Law greater than, page, Chapter 5 The Matrimonial Consent 219, Chapter 6 Form of the Marriage Contract 221, Chapter 7 The Marriage of Conscience 225, Chapter 8 Time and Place of Marriage 226, Chapter 9 Consequences of Marriage 226, Chapter 10 Separation of Married People 227, Article I Dissolution of the Marriage Bond 227, Article 2 Separation from Bed and Board 230, Chapter 11 Validation of Marriage 231, Article I Simple Validation 231, Article 2 Senatio in Gratis 232, Chapter 12 Second Marriage 233, Title 8 The Sacramentals 233, Part 2. Sacred Places and Seasons 234, Section I Sacred Places 234, Title 9 Churches 235, Title X Oratories 242, Title 11 Altars 243, Title 12 Ecclesiastical Burial 245, Chapter 1 Cemeteries 245, Chapter 2 Transfer of the Body to Church, Funeral Services and Interment 247, Chapter 3 Persons to whom ecclesiastical burial must be granted or denied 253, Section 2 Sacred Seasons 254, Title 13 Holidays of Obligation 255, Title 14 Fast and Abstinence 255, Part 3. Divine Worship 257, Title 15 The Keeping and Cult of the Blessed Sacrament 259, Title 16 The Cult of the Saints, of Sacred Images and Relics 262, Title 17 Sacred Processions 265, Title 18 Sacred Utensils 266, Title 19 Vow and Oath 269, Chapter 1 Vow 269, Chapter 2 Oath 270, Part 4. The Teaching Authority of the Church 272. Title 20 Preaching of the Word of God 273. Chapter 1 Catechetical Instruction 273. Chapter 2 Sacred Preaching 274. Chapter 3 Sacred Missions 277. Title 21 Seminaries 278. Title 22 Catholic Schools 283. Title 23 Censorship and Prohibition of Books 285. Chapter 1 Censorship of Books 285. Chapter 2 Prohibition of Books 287. Title 24 Profession of Faith 290. Part 5 Benefices and Other Non-Collegiate Institutes of the Church 292. Contents XM page. Title 25 Ecclesiastical Benefices 292. Chapter 1 Constitution or Erection of Benefices 293. Chapter 2 Union, Transfer, Division, Dismembration, Conversion, and Suppression of Benefices 294. Chapter 3 Conferring of Benefices 298. Chapter 4 The Right of Patronage 298. Chapter 5 Rights and Duties of Beneficiaries 299. Chapter 6 Resignation of Benefices 299. Title 26 Other Non-Collegiate Institutes of the Church 300. Part 6 Temporal Goods of the Church 301. Title 27 Acquisition of Ecclesiastical Goods 302. Title 28 The Administration of Ecclesiastical Goods 306. Title 29 Contracts 309. Title 30 Pious Foundations 312. The Fourth Book, Canonical Trials 315. Part 1 Procedure in Court 315, Section A Trials in General 316, Section 2 Special Rules to be observed in certain specified trials 316, Title 18 Manner of Avoiding Canonical Trial 316, Chapter 1 Transaction 316, Chapter 2 Compromise by Arbitration 317, Title 19 Criminal Trials 318, Chapter 1 Accusation and Denunciation 318, Chapter 2 Inquisition 319, Chapter 3 Reprimand of the Delinquent 321, Chapter 4 Construction of the Criminal Trial and Summons of the Offender 322, Title 20 Matrimonial Cases 323, Chapter 1 Competent Forum 323, Chapter 2 Constitution of the Tribunal 324, Chapter 3 Right to accuse a marriage and to ask the dispensation from the matrimony in Radum 325, Chapter 4 Proofs 326, Article Eyewitnesses 326, Article 2 Bodily Inspection 326, Chapter 5 Publication of the Trial, Conclusion of the Case, and Sentence 327, Chapter 6 Appeals 328, Chapter 7 Cases accepted from the foregoing rules 329, Title 21 Cases against Sacred Ordination 330, Part 2, Cases of Beatification of the Servants of God and Canonization of the Bliss 331, Part 3, The Manner of Procedure in Certain Affairs or in the Application of Penal Sanctions 331, Title 27 Manner of Procedure in the Removal of Irremovable Pastors 333, Title 28 Manner of Procedure in Depriving Removable Pators of their Parish 335, 14 The New Canon Law, page, Title 29 Manner of Procedure in the Transfer of Pastors 336, Title 30 Manner of Procedure against Clerics not observing the Law of Residence 337, Title 31 Manner of Procedure against Clerics living in concubinage 339, Title 32 Manner of Procedure against a pastor who is negligent in the fulfillment of the pastoral duties 340, Title 33 Manner of Procedure for infliction of the suspension ex infirmata conscientia 340, The Fifth Book, Offenses and Penalties 343, Part 1, Offenses 343, Title I Nature and Division of Offenses 343, Title II Imputability of an Offense, Causes which aggravate or diminish it, and Juridical Effects of an Offense 344, Title III Attempted Crime 347, Part 2, Penalties 348, Section I Penalties in General 348, Title IV Definition, Species, Interpretation and Application of Penalties 348, Title V Superiors having coercive power 350. Title V Persons subject to the coercive power 352. Title VII Pardon of penalties 355. Section 2 Penalties in particular 356. Title VIII Corrective penalties of censures 35. Chapter 1 Censures in general 356. Chapter 2 Censures in particular 361. Article I Excommunication 362. Article 2 Interdict 365. Article 3 Suspension 367. Title 9 Punitive penalties 370. Chapter 1 Common punitive penalties 371. Chapter 2 Punitive penalties special to the clergy 373. Title X Penal remedies and penances 375. Chapter 1 Penal remedies 375. Chapter 2 Penances 377. Part 3 Penalties for individual crimes 377. Chapter 1 Penalties incurred ipso facto. Ludi sentential 378. Chapter 2 Penalties frendi sententiae 385. Appendix, New decrees and declarations regarding the elections in religious orders, faculties of bishops, etc. 423. The New Canon Law. The First Book. General Principles of Canon Law. 1. It is stated in the first canon of the Code that its laws are obligatory only for Catholics of the Latin Rite, except in those points which of their very nature affect also the Oriental Church. This ruling is not new. It has obtained for many centuries on account of the great difference in manners and customs between the peoples of the East and those of Europe, and of countries Christianized by missionaries of the Latin Rite. The Holy See wisely modifies for the Oriental Church some laws in accordance with requirements. A special congregation for the Orientals has been established at Rome to regulate the affairs of the Catholics of the various Oriental rites. The laws on points of faith and morals, however, of their very nature bind all Catholics in union with the See of St. Peter. For in principles of faith and morals all who wish to be members of the Catholic Church can acknowledge but one guide, viz., the infallible teaching authority of the Supreme Pastor and his colleagues, the bishops, in unison with their head. Canon 1. 2. All liturgical laws heretofore decreed for the celebration of Holy Mass, for the divine office and other sacred functions, retain their force, except those that are explicitly corrected in the Code. Canon 2. 3. Special agreements or concordats made between certain nations and the Holy See are not changed by the Code. Canon 3. 4. Acquired rights, privileges and indults which have been granted by the Holy See to individuals or organizations, if they are still in use and have not been revoked, remain in force unless they are explicitly abrogated in the Code. Canon 4. 5. Now existing immemorial customs, both particular and universal, at variance with these canons are abolished. To the New Canon Law, if the Code explicitly disapproves of them. Centenary and immemorial customs not disapproved by the Code may be tolerated, if the bishop judges that they cannot prudently be abolished. Customs disapproved by the Code are to be considered corruptions of the law and can never in future revive and obtain the force of law. Ordinary customs at variance with the laws of the Code are to be considered suppressed, unless the Code explicitly states otherwise. Canon 5. 6. 1. As regards laws published prior to the Code, the general rule is that all former laws, whether particular, for instance, for a certain country, for a religious order, etc., or universal, that conflict with the laws of the Code, are abolished, unless the Code explicitly rules otherwise in reference to any special law. Canon 6. 1. 2. Canons of the Code that restate former laws exactly as they were before, must be interpreted according to the approved and accepted interpretation of commentators on the old law. Canons which agree only in part with the former law are to be interpreted like the former law in the points in which they agree, but in the points in which the new law differs from the former they must be judged by their wording and context. When it is doubtful whether a law of the new Code differs from the old law, one must not deviate from the former law. Canon 6. 2, 3, 4. 3. All former ecclesiastical punishments, whether spiritual or temporal, corrective or punitive, ludi or frendi sententiae, of which the Code makes no mention, are held to be abolished. Canon 6. 5. 4. All other disciplinary laws which have been in force up to the present time cease to be binding, unless they are explicitly or implicitly contained in the code. The laws contained in the approved liturgical books, however, remain in force. This part of the canon refers to the common law of the Church, for the Code states in Canon 22 that particular laws, namely for dioceses, individual countries, or ders, are to remain in force unless they are opposed to the laws of the Code. Canon 6, by declaration of the Est Congregation of the Holy Office, March 22, 1918, the rules and regulations concerning the oath against modernism, Principles of Ecclesiastical Law 3, prescribed by Pope Pius X, of happy memory, are to remain in force until such time when the Holy See shall otherwise ordain. Acta Post Situs, Volume X, Pag. 136. 7. By the term Apostolic See or Holy See, wherever it occurs in the Code, is meant not only the Roman Pontiff but also, unless the context proves the contrary, the sacred congregations, the Roman tribunals and offices, through which the same Roman Pontiff does usually transact the affairs concerning the universal Church. Canon 7. Title 1. Principles of Ecclesiastical Laws. 8. The laws are instituted when they are promulgated. A law is not presumed to be personal but rather territorial unless the law indicates that it is to be considered personal. In the common law of the Church it makes little difference whether a law is personal or territorial, but in particular laws for dioceses or countries the distinction is important for the reason that the law, if territorial, does not bind outside the limits of the diocese or country. Canon 8. 9. The laws issued by the Holy See are promulgated by being published in the official magazine of the Holy See, the Acta Apostolici Sedisef, unless a special mode of promulgation should be prescribed in special cases. The laws do not begin to bind in conscience until 3 months from the date of the number of the magazine containing the law have elapsed, unless the nature of the law is such that its immediate enforcement is evident, or the law itself should provide a longer or a shorter period of vacation. Canon 9. 10. Laws concern future actions and not those done before the law was made, unless they make special mention of past actions. Canon 10. 11. Those laws only are to be considered invalidating or inhabilitating which explicitly or equivalently state that an action is null and void, or that a person is incapable of acting. Canon 11. 12. Unbaptized persons are not held to laws which are purely church laws, nor baptized persons who have not a sufficient use of their mind, nor children under 7 years. For the new canon law, of age though they may have sufficient knowledge and judgment, unless the law does in some instances declare the latter to be held to its observance. Canon 12. The word purely is to be emphasized in this canon, because laws which are an explanation or application of the natural or the positive divine law bind every human being as soon as there is sufficient understanding of the law and consequent responsibility, apart from any definite age. Wherefore also the Committee for the Interpretation of the Code answered the Bishop of Valleyfield, January 3, 1918, that children who had the sufficient use of their reason before 7 years of age were held to make their Easter duty even before they were 7 years of age. Review, March 1918, Pag. 313. 13. The general laws of the Church bind all persons for whom they are issued anywhere in the world. Laws issued for a particular territory, e.g., a diocese or a nation, bind those persons who have a domicile or a quasi-domicile in that territory and actually live there. For those who are absent from their own place for a while the following canon provides. Canon 13. 14. Those persons who have a domicile or a quasi-domicile but are for a time staying in another place are called in law peregrini. They are not held to the observance of the particular laws of their own diocese or country while absent unless the transgression of these regulations causes some harm in their own place, or in case the laws are personal. They are not held to the particular laws of the diocese or country in which they are traveling with the exception of those laws that concern public order or determine the formalities of legal transactions. They are, however, bound to observe the general laws of the Church, even those that have been abolished for their own place. Thus, for instance, an American traveling in Europe is bound to observe the holy days of obligation, fasts, etc., that may by papal indult have been abolished in America. On the other hand, the peregrinus enjoys the dispensations from the general law in the country where he actually stays, even though there are no such dispensations granted to the diocese or country where he ordinarily resides. Those who have neither a domicile, Principles of Ecclesiastical Laws 5, nor a quasi-domicile in any place are called vagi. They are bound to observe both the general and the particular laws that are in force in the place where they actually stay. Canon 14:15. All laws, even those that invalidate an action or inhabilitate a person to act, do not oblige in doubt of law, dubium juris, in a doubt of fact, dubium facti, the ordinary may dispense, provided there is question of laws from which the Roman Pontiff usually dispenses. Canon 15:16. No ignorance of invalidating or inhabilitating laws excuses unless the law explicitly admits ignorance as an excuse. Likewise, ignorance or error is not presumed when it concerns the law or its penalty, or one's own action, or the notorious action of another. Concerning the non-notorious action of another, ignorance is presumed until the contrary is proved. This rule applies mostly to cases where the delinquent is brought to court for the transgression of a law. How far ignorance of the censure attached to the violation of a law excuses is specified in Canon 2229. Canon 16:17. Laws are authoritatively interpreted by the lawgiver and by those to whom the power of interpreting has been committed. Authoritative interpretation of a law given in the form of law has the same force as the law itself. If such authoritative interpretation merely declares the meaning of the words of law that are certain, the interpretation does not need a new promulgation and reacts on past actions. If the interpretation restricts, or extends, the law or explains a doubtful point of the law, it does not react on past actions and is regarded like a new law, so that it must be promulgated in order to have binding force. An interpretation of the law given by way of a judicial sentence, or by a rescript in some special case, has not the force of law and binds only the persons and affects only those matters for which it was issued. Canon 17:18. Ecclesiastical laws must be interpreted according to the proper meaning of the terms of the law considered in their context. If that meaning remains obscure, one must have recourse to parallel citations of the code if there are any, or to the purpose and circumstances and the intention of the lawmaker. Canon 18:6. The New Canon Law 19. Laws that establish a penalty or restrict the free exercise of one's rights, or establish an exception from the law must be interpreted in a strict sense. It has always been an axiom of interpretation of canon law that odious laws are to be explained in such a sense as not to unduly extend them to cases not strictly covered by the words of the law, while in favorable laws a more benign interpretation is allowed. Canon 19:20. If there is no definite rule of law, neither in the general nor in the particular law, concerning some affair, a norm of action may be taken from laws given in similar cases, from the general principles of law applied with the mildness proper to canon law, from the manner and custom of handling similar cases in the Roman Curia, and from the common and accepted teaching of doctors. In the application of penalties, however, this liberal interpretation must not be adopted. Canon 20:21. Laws made in order to safeguard the faithful against what is commonly dangerous, oblige even though in a particular case there is no danger. An example of this kind is the law of the Church forbidding bad books of various kinds. Though there may positively be no danger for some particular individual to read such a book, he is not thereby entitled to read it unless he has obtained a dispensation from the law. Canon 21:22. A more recent law given by the competent author abolishes a former law when it explicitly makes a statement to that effect, or when it is directly contrary to the former law, or, finally, when it takes up and readjusts the entire subject matter of the law. A general law, however, does not abolish laws for particular places or the statutes of inferior legislators, e.g., of bishops, unless the general law is either directly opposed to the special law, or the general law explicitly revokes the particular law. The Code, therefore, does not abolish the decrees of national and provincial councils, nor diocesan statutes, rules and constitutions of orders, except in as far as they may in some points be against the canons, or in points where the Code explicitly states that notwithstanding particular laws the Code is to be followed. Canon 22. Custom 7:23. In a doubt whether the former law has been revoked, the repeal of the law is not to be presumed, but the more recent law is to be, as far as possible, conciliated with a former law, so that one may supplement the other. Canon 23, 24, precepts given to individuals bind them wherever they go, but they cannot be urged in a canonical trial, and they expire with the expiration of authority of the one imposing the precept, unless they are given in the form of a legal document, or before two witnesses. Canon 24, Title 2, Customs. 25. In order that a custom may assume the force of law in the Church, it must receive the consent of the competent ecclesiastical superior. Canon 25, 26. Only those communities, dioceses, religious orders, etc., that are capable of receiving laws, that is to say, governed by laws, can introduce customs that have the force of law. Canon 26, 27. No custom can abrogate or modify the divine law, either positive or natural. In order that a contrary custom may have the power to change church laws, it must be 1. Reasonable, and 2. Lawfully prescribed by a continuous and uninterrupted usage of at least 40 years' duration. In the former law, the period of time required for usages to obtain the force of law was not definitely specified, wherefore there was a great diversity of opinion of canonists on this point. The majority of authors conceded that the period of 10 years was sufficient, provided the other conditions were present, to abolish a law by contrary custom. The new code demands 40 years for any custom either contra or pro jure to become law. Against a law of the Church which contains a clause forbidding contrary customs for the future, only a reasonable custom that is either immemorial or of 100 years standing can obtain the force of law. A custom which is explicitly disapproved in law is not considered reasonable. Canon 27, 8. The new canon law. 28. Customs pro jure, that is to say, such usages as are not against a law, but outside it, and which have been knowingly introduced by a community with the intention of binding itself, become law if they are reasonable and lawfully prescribed by 40 continuous and complete years. Canon 28, 29. Custom is the best interpreter of laws. Canon 29, 30. With the exception laid down in Canon 5, the general principle is that a custom against the law, or outside the law, pro jure, is revoked by a contrary custom or a contrary law. A law does not, however, abrogate centenary or immemorial customs, nor does a general law abolish particular customs, unless the law specially mentions such customs. Canon 30. Title 3, Manner of Reckoning Time. 31. Apart from the liturgical laws, time is to be reckoned according to the following rules, unless the canons explicitly prescribe an exception. Canon 31, 32. A day consists of 24 consecutive hours, to be counted from midnight to midnight, and a week consists of 7 days. A month in law means a period of 30 days, a year, 365 days, unless month and year are ordered to be taken according to the calendar. Canon 32, 33. In reckoning the hours of the day, the common custom of the place is to be observed, but in the private celebration of Holy Mass, in the private recitation of the Divine Office, in receiving Holy Communion, and in the observance of the law of fast and abstinence, one may follow also the local true time or the mean time, or the legal or any other of the several ways of marking time. Naturally, midday and midnight fall earlier or later as one travels east or west. For business purposes, the local natural or true time is not practical, wherefore so-called standard time is followed in the United States, in which we have 4 zones, namely, Eastern, Central, Mountain, and Pacific Standard Time, each of the 3 latter marking a difference. Manner of reckoning time 9 of 1 hour under the previous one. The difference between the standard and the local true time varies with the location of the towns and cities within the respective zones. Thus it may be 12 o'clock midnight by standard time when according to the local true time it is only 20 minutes, or a quarter, to 12. The code gives us the benefit of the difference in the observance of the fast, the recitation of the Divine Office, etc. The time for determining the obligation arising from contracts is to be reckoned according to the rules of the civil law of each country, unless a special agreement has been made on this point. Canon 33, 34. If the month or the year is designated in law by its proper name or its equivalent, for example, the month of February, the following year, they are taken as in the calendar. If the terminus equo is neither implicitly nor explicitly assigned, for instance, suspension from the celebration of Holy Mass for a month or for 2 years, 3 months vacation in a year, and the like. The time is to be calculated from moment to moment, and if, as in the first example, the time is continuous, the month and the year are taken as in the calendar. If the period of time is intermittent, a week means 7 days, a month 30 days and a year 365 days. If the time consists of one or several months or years, one or several weeks, or several days, and the terminus quo is explicitly or implicitly fixed, the following rules obtain. 1. The month and year are taken as in the calendar. 2. If the terminus quo coincides with the beginning of the day, for example, 2 months vacation from the 15th of August, the first day shall be counted in the number of days and the time expires with the beginning of the last day of the same number. 3. If the terminus quo does not coincide with the beginning of the day, for instance, the 14th year of age, the year of novitiate, 8 days from the vacancy of a bishopric, 10 days for appeal, etc., the first day shall not be counted and the time expires when the last day of the same number is ended. 4. If the month should not have the same number of days, for example, 1 month from the 30th of January, the time expires either with 10 the new canon law, the beginning or the end of the last day of the month, as the case may be. 5. If there be question of actions of the same kind to be repeated at stated intervals, for instance, a 3-year term from the taking of temporary vows to the taking of perpetual vows, 3 or more years between elections, etc., the time expires on the same day of the month on which the period began, but the new action may take place any time during the last day. The fact, therefore, that a profession took place early in the morning or late in the day does not oblige one to wait for the same hour for the renewal of vows. The same holds in case of elections, etc. Canon 34-35. The term tempus utile means that the time for the exercise or prosecution of one's rights does not elapse if one was ignorant of the rights, or could not act at the time. The term tempus continuum in law means a space of time that does not suffer any suspension by reason of one's ignorance or impossibility to act. Canon 35. Title 4. Rescripts. Canons 36-62 of this title state the general principles concerning rescripts by which the Holy See or other ordinaries grant dispensations and various other favors. I shall direct attention to the most important points. 36. Favors and dispensations of any kind granted by the Holy See avail even those who are under censure with the following exceptions: an excommunicatus vitandus, a person excommunicated by a condemnatory or declaratory sentence of the ecclesiastical judge, cannot validly receive any favor from the Holy See unless the papal rescript states that it shall be valid notwithstanding the excommunication of the recipient. The same rule applies to those personally interdicted or suspended by sentence in the ecclesiastical court. Canon 36-37. Rescripts by which a favor is granted without requiring the ministry of an executor take effect from the moment that the rescript is issued. Other rescripts from the time of execution. Canon 38. Rescripts 11-38. Conditions demanded in the rescripts are essential for their validity in such cases only where they are expressed by the particles si da modo or others of the same signification. Canon 39-39. All rescripts are considered as given upon condition si preces veritate notantur that the reasons given in the petition are based on truth. There are 2 exceptions to this rule. 1. Canon 45 states that a rescript given with the clause motu proprio is valid even though in the petition things are not explained that otherwise are demanded. If, however, the only motive reason under the plea of which the rescript is requested is false, the rescript is invalid with the exception, 2, of dispensations from marriage impediments of lesser degree, which are valid even though all reasons or motives advanced to obtain the dispensations are falsehoods. Canon 1042 explains which are impediments of lesser degree in marriage. Canon 40. Cf. Canon 1054-40. If one of the Roman congregations or offices refuses a favor asked of them, the same favor cannot be petitioned from and granted by any other of the sacred congregations, nor even by one's own bishop who may have delegated faculties, unless the sacred congregation of which the favor was first asked gives its consent. Canon 43-41. The granting of a favor that was first asked of and refused by the vicar general and later obtained from the bishop, without mentioning that application had been made first to the Vicar General and refused, is invalid. A favor that has been refused by the bishop cannot validly be granted by the Vicar General, even though the petitioning makes known to him the bishop has refusal. Canon 44, 42. Rescripts are no longer considered invalid on account of an error in the name of the person to whom, or by whom, the favor is granted, or a mistake in the place of residence, or a mistake concerning the object of the concession, so long as, in the prudent judgment of the bishop, there is no doubt concerning the identity of the person and the object of the favor. Canon 47, 43. A rescript of the Apostolic See in which no executor is demanded need not be exhibited to the ordinary of the person obtaining the document, except this is demanded. 12. The New Canon Law. In the document or there is question of public affairs e.g., publication of an indulgence granted to a church or place, or, finally, if a favor is granted for the use of which the bishop has a right to examine required conditions, e.g., a concession to keep the blessed sacrament, celebrate Holy Mass in a private oratory, etc., in which cases the law gives the bishop the right and the duty to see that the requirements of canon law are complied with. This canon does not demand the presentation under pain of invalidity, unless, therefore, it is demanded in the rescript itself in terms importing invalidity. The neglect to comply with the ruling of the present canon would not invalidate the rescript, but such neglect is sinful. Canon 51, 44. Rescripts must be understood according to the proper meaning of their words in the common usage of the language, and must not be extended to other cases besides those expressly mentioned. Canon 49, 45. When doubt arises as to the meaning of the words of a rescript, those rescripts having reference to cases in court, or to matters which hurt the acquired right of others, or those that concede to a private individual favors contrary to the law, or, finally rescripts obtained for the purpose of securing an ecclesiastical benefice, must be strictly interpreted. All other rescripts may receive a benign interpretation. Canon 50, 46. If in a rescript the mere office of execution is committed to someone, e.g., bishop, confessor, the execution of the rescript cannot be refused, unless it is evident that the rescript is null and void on account of a lie, or of concealing the truth, or if there are conditions demanded in the rescript which the executor knows have not been complied with by the recipient of the document, or the latter is in the judgment of the executor so unworthy of the favor that its concession would be a scandal to others. In the last mentioned circumstance the executor shall at once inform the official granting the rescript and in the meantime suspend its execution. If in the rescript the granting of the favor is left to the executor, so that he is delegated to dispense, he shall according to his own judgment and conscience either grant or deny the favor. Canon 54, Privileges 13, 47. Favors granted through a rescript are not revoked by a contrary law, unless it is otherwise stated in the law, or unless the law was made by the superior of the grantor. Canon 60, 48. Vacancy of the Holy See, or of the bishopric, does not invalidate rescripts given by the deceased bona fide bishop, unless the terms of the rescript state otherwise, or unless the rescript gives power to a delegate to grant the favor to individuals specified in the document and the delegate or executor had not begun to exercise his power before the death of the pope or the bishop, as the case may be. As soon as the rescript has been presented to the individual so delegated the case is opened, and he can act even though the pope or the bishop who granted the rescript should die or resign their office. Canon 61, Title V, Privileges. Canons 63-79 under this head deal with the question of privileges, which are favors, either against law or outside of law, which a person or a community enjoys without limit of time. 49. Privileges can be acquired not only by direct concession but also by communication, by legitimate custom, and prescription. However, Canon 613 states as an exception to this rule that between religious orders the communication of privileges is revoked, and that each order shall have only what is conceded by the code, and the favors that have been directly granted to the order. Canon 63, 50. The habitual faculties which are granted either in perpetuum or for a definite period of time, or for a certain number of cases, are counted among the privileges prodigiu. This consideration allows a liberal interpretation of such faculties, whereas, if they were to be considered contra jus, their explanation would have to be strict. Unless they are given personally to the bishop, or otherwise restricted to him, the Vicar General has the same faculties. Canon 66-51. Doubts concerning privileges must be solved. AC 14. The New Canon Law. According to Canon 50, which decrees that rescripts as well as privileges that injure the acquired rights of a third party, or such that are against the law, in favor of private individuals, are to receive a strict interpretation. Any privilege, however, must be so explained that the privileged party does derive some benefit from the privilege. Canon 68-52. No one is obliged to make use of a privilege that is granted for his own personal benefit, unless the duty to make use of it arises from another source. Canon 69-53. By a general law are revoked the privileges contained in the Code. Particular privileges are not revoked by a general law, unless the law explicitly revokes all contrary privileges, or unless they were granted by an inferior authority. Canon 71-54. Privileges cease by renunciation accepted by the competent superior. Privileges granted only for any private individual as own benefit may be renounced by this individual. Those granted to any community, dignity or place, private individuals are not allowed to renounce, nor is a community or body of persons free to renounce privileges given to them in the form of law. For instance, the exemption granted to the regulars, or when the renunciation is prejudicial to the Church, or to other persons. Canon 72-55. Privileges did not cease by the fact that the one granting them dies, or in any other way loses his jurisdiction, unless they were granted with the clause ad bene placidum nostrum or another equivalent clause. Thus, for instance, faculties granted to a priest by the bishop without such a clause continue though the bishop dies or is transferred to another see. Canon 73-56. Privileges may also terminate if, according to the judgment of the superior, in the course of time circumstances change to such an extent that the privilege becomes harmful or its use illicit. Finally, privileges cease when the time expires for which they were granted, or the number of cases for which faculties were given is exhausted. One exception to this rule is made in Canon 207-2, where the Code benignly supplies jurisdiction, if, in his faculties for the internal form, the priest through inadvertence makes use of the dispensations 15 faculties though the time for which they were granted has elapsed, or the number of cases has been exhausted. Canon 77, Title VI, Dispensations. 57. Dispensation, which is the relaxation of a law in a particular case, can be granted by the lawgiver, by his successor or his superior, and by those whom they have delegated. Canon 80-58. From the general laws of the Church, ordinaries inferior to the Roman Pontiff cannot dispense, not even in a particular case, unless this power has been conceded to them implicitly or explicitly, or when recourse to the Holy See is difficult and there is at the same time danger of causing great harm by the delay, and the case is one in which the Holy See usually dispenses. Canon 81-59. Bishops and other local ordinaries can dispense from diocesan laws, from the laws of provincial and national councils, but they cannot dispense from laws which the Roman Pontiff has published for a particular country or diocese, except in cases indicated in the preceding canon. Canon 82-60. Pastors cannot dispense either from a general law of the Church nor from special laws of country or diocese, unless this power has expressly been conceded to them, by custom introduced from time immemorial and confirmed by Canon 1245. Pastors can dispense their parishioners in individual cases from the fast and abstinence and from the law forbidding servile work on Sundays and holidays of obligation. Canon 83-61. Dispensations from the law of the Church should not be given without a just and reasonable cause, which should be in due proportion to the gravity of the law from which dispensation is granted. Dispensations granted by an inferior without just cause are both illicit and invalid, while the lawgiver himself may always validly dispense from his laws, though also he sins by dispensing a subject from the law without a good reason. When it is doubtful whether the reason for a dispensation is sufficient, the N. 16 The New Canon Law. Individual is allowed to ask for the dispensation and the superior may validly and licitly grant the same. Canon 84-62. Dispensations must be interpreted according to Canon 50. and also the faculties to grant dispensations must be strictly interpreted. Canon 85:63. Dispensations extending for some length of time cease not only for the same reason as a privilege, but also whenever it is certain that the reason for the dispensation has entirely ceased to exist, e.g., dispensation from reciting the divine office, fast, etc., in case of ill health, when the dispensation ceases of itself after complete recovery. Canon 86. The Second Book. Laws Concerning Persons. 64. By baptism a person becomes a subject of the Church of Christ, with all the rights and duties of a Christian, unless as far as rights are concerned there is some obstacle impeding the bond of communion with the Church, or a censure inflicted by the Church. Canon 87:65. A person who has reached the age of 21 years is called of major age, under 21 he is called a minor. A boy reaches the age of puberty when 14 years of age, a girl at the completion of the 12th year. Children under 7 years of age are spoken of in law as infants, parvulus, and they are not considered responsible for their actions. When fully 7 years of age, the law presumes that the child has the sufficient use of reason to be responsible. Persons habitually devoid of the use of reason are in law held equal to infants. Canon 88:66. A person of major age has the full exercise of his rights. The minor remains subject to the parents or guardian in the exercise of his rights, except in matters in which the law exempts minors from the paternal power. Canon 89:67. By locus originalis is meant the place where the father, or in case of illegitimate and of posthumous children the mother, had a domicile, or in defect of a domicile a quasi-domicile. If there is question of children of vulgi the very place of birth is the place of origin, of exposed children the place where they were found. In the case of converts the same rules obtain. The opinion of canonists who have held that the place of baptism of adults might be considered as their locus originalis must therefore be corrected. Canon 90:68. A person is called an incola in the place where he has a domicile, advena in the place where he has a quasi-domicile, a peregrinus, if he is actually outside the place of domicile or a quasi-domicile which he still retains. Vegas, if he has nowhere domicile nor quasi-domicile. Canon 91:18. The New Canon Law. 69. A domicile is acquired by residence in some parish or quasi-parish, or at least in a diocese, vicariate apostolic or prefecture apostolic, which residence must be acquired with the intention to stay there forever unless something calls him away, or it must be the actual residence of 10 complete years. Canon 92. A quasi-domicile is acquired by residence in a parish or a diocese with the intention to stay there for the greater part of the year unless something should call one away, or by having actually lived there for the greater part of the year. The domicile or quasi-domicile in a parish or quasi-parish is called parochial, in the diocese, vicariate or prefecture, though not in the same parish or quasi-parish, is called diocesan. The diocesan domicile is new in the language of canon law. 70. The wife, if not lawfully separated from the husband, necessarily shares the domicile of her husband, the insane that of his guardian, the minor that of the person in whose charge he is. A minor can after the years of infancy acquire a quasi-domicile of his own. A quasi-domicile can be acquired by the wife not legally separated, while the legally separated wife can acquire a domicile of her own. Canon 93:71. Through domicile or quasi-domicile each of the faithful gets his proper pastor and ordinary. The proper pastor and ordinary of the vulgi are the pastor and bishop of the place where the vegus actually stays. Those also who have but a diocesan domicile, or quasi-domicile, have for their proper pastor the one in whose parish they actually stay. Canon 94:72. Domicile and quasi-domicile are lost by the act of leaving the place with the intention not to return there. Minors and married women are an exception, as stated in Canon 93. Canon 95:73. Consanguinity is traced by lines of descent and degrees. In the direct line there are as many degrees as there are generations, or, in other words, as many degrees as there are persons, not counting the stipes or head of the line. In the branch lines there are as many degrees as there are generations in one line, if the distance from the common parent is equal. If the distance is not equal, There are as many degrees as there are generations in the longer line. Canon 96-74. Affinity arises from a valid marriage and it makes laws concerning persons 19. No difference whether it be only a matrimonium radum or also consummatum. Affinity exists only between the husband and the blood relations of his wife, and the wife and the blood relations of her husband. Brothers, sisters, etc. of husband and wife do therefore not enter into any affinity with each other. The degrees of affinity are numbered in the same way as the consanguinity, so that the blood relations of the husband become the affines of the wife in the same line and degree as they are standing towards the husband, and vice versa. Canon 97-75. To determine to which of the various Catholic rites a person belongs, baptism decides, so that one belongs to that rite in which he was baptized, unless perhaps baptism was administered by a priest of another rite who was not entitled to baptize that person, or baptism was given in case of necessity where no priest of the proper rite could be secured, or, finally, when by apostolic indult a person obtained the permission to be baptized with the ceremonies of a certain rite without the obligation to adhere to that rite. The clergy should not presume to induce either Catholics of the Latin rite to join an Oriental rite, or Catholics of Oriental rites to join the Latin rite. No one is allowed without permission from the Holy See to go over to another rite, or after legal transfer to return to the former rite. The wife who belongs to another rite than her husband is at liberty at the time of marriage, or at any time during the marriage, to join the rite of her husband. When marriage is dissolved, she is free to return to her own rite, unless particular laws rule otherwise. The custom, no matter of what duration it may be, to receive Holy Communion in another rite does not entitle to, or mean, a change of rite. Canon 98-76. There are in the Catholic Church besides physical also so-called moral or legal persons, that is to say bodies of men, instituted by the public authority of the Church, which persons are distinguished into collegiate bodies and non-collegiate, for instance, churches, seminaries, benefices, etc. Canon 99-77. The Catholic Church and the Apostolic See have the nature of a legal person by divine ordinance. The other, 20. The New Canon Law. Inferior, legal persons get their personality either by law, or by a special concession of the competent ecclesiastical superior through a formal decree for the purpose of religion or charity. Unless there are at least 3 individuals, there can be no collegiate moral person. Moral persons, both collegiate and non-collegiate, are held equal to minors. Canon 100-78. The actions of collegiate legal bodies in the Church are subject to the following rules. Unless either the common law or particular statutes prescribe a different course of action, it shall be the rule that the absolute majority of votes of all those who have a right to vote, and actually do vote, decides a question, and if in the 2 first votings no majority was obtained, the relative majority of votes in the third voting decides. If in the third voting the votes are even, the president of the election can, by giving his vote to one of the parties, decide the matter. If the president does not want to do this and there is question of elections, the senior in ordination, in first profession or in age, is to be considered elected. Those matters that touch each one individually, must be approved by all. If there is question of the actions of non-collegiate legal persons, the particular statutes and the norms of the common law regarding such persons are to be followed. Canon 101-79. A legal person is of its very nature perpetual. It may be extinguished by suppression by the legitimate authority, or by having ceased to exist for a space of 100 years. If at least one individual of a collegiate legal person remains, the rights of all rest with that individual. Canon 102-80. An action that is done by either a physical or moral person through extrinsic force which could not be resisted is considered as though it was not done. Actions done because of great fear from unjust threats, or an account of deceit, are valid unless the law rules otherwise. In some cases, they can, however, be declared null and void by the ecclesiastical judge according to Canons 1684-1689, at the petition of the injured party, or even without such petition. Canon 103. Laws concerning persons 21-81. Error annuls an action when it concerns the substance of the action, or amounts to a conditio sine qua non, otherwise the action is valid. unless the law states the contrary. In contracts, however, error may give the person contracting under such error the right to an action in court for the rescinding of the contract. Canon 104-82. Whenever the law states that the superior needs the consent, or the consultation, of some persons, the following rules obtain. If consent is required, the superior acts invalidly against the vote of these persons. If only consultation is demanded, by words like de concilio consultorum, or audito capitulo, virtue, etc., it is sufficient for the validity of the action that the superior consults these persons. Though he is not bound to follow their advice, he should nevertheless have great regard for the unanimous vote where several persons had to be consulted, and he should not without a very good reason go against their counsel. If the consent, or consultation, of several persons is required, these persons should be legally convoked and thus manifest their mind. The superior may, if he thinks the matter of sufficient importance, oblige them to take the oath of secrecy concerning this affair. All persons whose consent or counsel is required should with due respect, truthfulness and sincerity state their idea on the subject. Canon 105. This canon does not say whether the action of a superior is invalid if in cases where consent or counsel of others is required, he should neglect to call some of these persons. Reference is made to Canon 162. 4, which states that the convocation of individuals for election is not essential, provided they were present anyhow. The same canon, in number 3, declares that elections are invalid if more than 1/3 of those having a vote were not called and did not take part in the election. We believe the same may be applied to the validity of an action where certain individuals must intervene. 83. In Canon 106 are to be found rules on precedence of various ecclesiastical persons. 84. By divine institution the clergy is distinct from the laity in the Church, though not all degrees of clerics. 22. The new canon law are of divine institution. Both clerics and laics may be religious. Canon 107, Part 1. Laws concerning the clergy. Section 1. The clergy in general. 85. Those who have been assigned to the divine ministry by the first tonsure, are called clerics. They are not all of the same degree. There is a sacred hierarchy by which one is subordinate to the other. This hierarchy, which is of divine institution by reason of the sacred orders, consists of bishops, priests and ministers. By reason of jurisdiction it consists of the supreme pontificate and the subordinate episcopate. By institution of the Church other degrees have been added. Canon 108, 86. Those who, in the Church, are received into the ecclesiastical hierarchy, are not accepted by consent or a call from the secular authority or the people, but are placed in the degrees of the power of orders by sacred ordination. In the supreme pontificate the person lawfully elected and freely accepting the election receives power of jurisdiction by divine right. All others receive jurisdiction by the canonicomissio. 87. Though the Holy See does give to some of the clergy the title of prelate as an honorary title without jurisdiction, the proper meaning of the term denotes those of the secular or regular clergy who have ordinary jurisdiction in the external forum. Canon 110, Title 1. Manner of ascribing the clergy to a diocese. 88. Every cleric must belong either to some diocese or to some religious community. Vagrant clerics are not at all recognized. By reception of the first tonsure a cleric is ascribed to, or incardinated in the diocese for the service of which he was promoted. Canon 111. The rights and privileges of clerics. 23, 89. With the exception of the cases mentioned in Canons 114 and 641, 2. It is necessary for valid incardination of a cleric into another diocese that his own bishop grant him letters of perpetual and unconditional excardination, and that the bishop receiving him likewise issues letters of perpetual and unconditional incardination. Letters of in and excardination must be signed by the bishops. Canon 112, 90. The vicar general cannot grant incardination or excardination without a special mandate from the ordinary, nor can the vicar capitular do this except after 1 year's vacancy of the bishopric, and then only with the consent of the cathedral chapter. Canon 113, 91. If the ordinary gives to a cleric of another diocese a benefice requiring residence, e.g., a parish, with the written consent of his ordinary, or with the written permission allowing the cleric to leave his diocese for good, This is considered an incarnation. Canon 114, 92. By religious profession, a cleric is excardinated from his diocese, according to the rules of Canon 585. Canon 115, 93. Excardination cannot take place without good reasons, and it does not take effect, unless incardination in the other diocese has followed, the ordinary of which diocese is held to inform the other bishop as soon as possible. Canon 116, 94. A bishop should not incardinate a cleric of another diocese, unless, 1. The cleric is necessary or useful to the diocese and the rules of canon law have been observed, 2. The bishop has the authentic document of excardination and letters of the curia about the conduct of the cleric, 3. The cleric has taken the oath before the incardinating ordinary or his delegate to serve the new diocese for all times according to the sacred canons. Canon 117, Title II. The rights and privileges of clerics. 95. Clerics only can obtain either the power of orders or that of ecclesiastical jurisdiction, and ecclesiastical benefices and pensions. Canon 118, 24. The New Canon Law. 96. All the faithful owe the clergy reverence according to their various rank and offices, and they become guilty of sacrilege if they do them personal injury. Canon 119, 97. All cases against clerics, both civil and criminal, must be brought into the ecclesiastical court, unless for some countries other provisions have been made. Cardinals, legates of the Holy See, bishops, even titular ones, abbots and prelates nullius, the supreme heads of religious bodies approved by Rome, the major officials of the Roman Curia in reference to business belonging to their office, cannot be sued in the secular courts without permission of the Holy See. All others, clerics and religious, who enjoy the privilege of the forum, cannot be sued in a civil court without permission of the ordinary of the place where the case is to be tried. The ordinary, however, should not refuse such permission, if the suitor be a lay person, especially after his attempts to effect an agreement have failed. If clerics are sued in the civil court by one who has not obtained the permission, they may appear in court because they are forced to obey the summons if they want to protect themselves against more trouble, but they shall inform the ordinary from whom permission should have been obtained. Canon 120, 98. All clerics are free from military service and from duties and public offices that are unbecoming to the clerical station. Canon 121, 99. Clerics who are forced to pay their debts should not be deprived of what is necessary for decent living, according to the prudent judgment of the ecclesiastical superior, but they are bound to pay all debts as soon as possible. Canon 122. The cleric cannot renounce the aforementioned privileges, he loses them, however, if he is reduced to the condition of laix, or is punished with perpetual privation of the ecclesiastical garb, according to the rules laid down in Canons 213, 1, and 2304. If the penalty is remitted, or if he is received again among the clergy, the privileges revive. Canon 123. Obligations of clerics. 25. Title III. Obligations of clerics. 100. Both the interior life and the exterior behavior of the clergy must be superior to the laity and excel them by the example of virtue and good deeds. Canon 124. 101. The ordinary must take care, 1. That the clergy frequently go to confession, 2. That they make each day a meditation of some duration, visit the Blessed Sacrament, say the Rosary, and examine their conscience. Canon 125, 102. All secular priests must at least once in 3 years make a retreat for a length of time to be specified by the ordinary, in a religious house or other place designated by the bishop. No one shall be exempted from the retreat, except in a particular case, for a just reason, and with the explicit permission of the ordinary. Canon 126. 103. All clerics, but especially the priests, are under the special obligation to obey and respect their respective ordinary. Canon 127. 104. The office imposed on clerics by the bishop must be accepted and faithfully attended to as long as the bishop judges that the needs of the church in his diocese require the services of the priest. Canon 128. 105. The clerics after being ordained priests must not neglect studies, especially of the sacred sciences, in which they should always follow the sound doctrine handed down to us by the Fathers and universally received by the Church, and should avoid profane novelties of expression and what is wrongly called scientific. Canon 129. 106. All priests, even though they should have a parochial or canon s benefice, must for 3 years after their ordination yearly undergo an examination in the sacred sciences as outlined by the bishop. The bishop may for good reasons dispense from this duty. In the appointment to offices and benefices those ought to be preferred who, all other things being equal, were foremost in the examinations. Canon 130. 107. The diocesan conferences should be held repeatedly during the year in the episcopal city and in each deanery. 26. The new canon law. If it should be very difficult to have the meeting, the answers to the cases for conference should be put in writing and sent by mail according to the directions of the ordinary. All secular priests, and also all those religious who have the care of souls, as pastors or curates, and, if the cases of conscience are not held in the monastery, all religious priests who have the faculties of the diocese, must attend the diocesan conferences. Canon 131. 108. Clerics in major orders are, under pain of nullity, forbidden to marry, and they have the obligation of observing chastity, so that sins against this virtue are also a sacrilege. If a cleric received major orders through grave fear or force, and did not ratify his ordination by accepting willingly the duties of the clerical state of major order men, he may bring his case before the bishop, and if he can prove his case, he must be pronounced free from the obligations of the major orders. Clerics in minor orders may indeed get married, but, unless the marriage was invalid on account of their being forced to such a marriage by grave fear or violence, they cease to be clerics ipso facto. A married man who in good faith receives major orders without a dispensation from the Holy See is forbidden to exercise such orders. Canon 132. 109. The clergy shall take care not to have in their houses, nor to visit, women that may give reason for suspicion. They are allowed to have in their houses only such women concerning whom there can be no suspicion either on account of the natural bond, as mother, sister, aunt, or about whom on account of their character and more advanced age all suspicion is removed. It is left to the judgment of the bishop whether in any case a woman is to be removed from the priest's house, or the priest to be forbidden to visit a woman. If the priest has been admonished repeatedly and yet continues to be obstinate, he is presumed guilty of concubinage. Canon 133. 110. The custom of the secular clergy to lead a community life is praiseworthy and is to be encouraged, and where it is in vogue it should be continued as far as possible. Canon 134. Obligations of clerics 27. 111. Clerics in major orders are tender obligation to daily recite all the canonical hours according to their proper and approved liturgical books. Those clerics that have been reduced to the state of laics, as described in Canon 213 and 214, are not obliged to recite the office. Canon 135. Cf. Number 144 and 145. 112. All clerics are bound to wear a becoming clerical garb in accordance with the legitimate customs of places and with the orders of the ordinary. They shall also have the clerical tonsure, unless the custom of nations is against it, and the dressing of their hair shall be free from vanity. Clerics are not allowed to wear a ring, unless it is conceded to them either by law or by apostolic privilege. Clerics in minor orders who of their own authority and without a legitimate cause did not wear the ecclesiastical garb and the tonsure, and have been admonished by the ordinary and do not obey within a month, are by the very fact deprived of the clerical state. Canon 136. 113. Clerics are forbidden to give bail for anyone, even with their own money, unless they have the permission of the local ordinary. Canon 137. 114. Clerics must abstain from all things that are unbecoming their state. They must not exercise unbecoming arts, not play games of chance with money, not carry weapons, unless there is justified cause for fear, not indulge in hunting and never in that kind of hunting that is done with much display and publicity, not visit saloons and places of the same nature except in cases of necessity or for any other just cause approved by the ordinary. Canon 138. 115. Even those affairs that are not unbecoming to the clerical state, but are foreign to it, The clergy must avoid, without apostolic indult they shall not practice medicine or surgery, not act as notary public, except in the ecclesiastical curia, not accept public offices that import secular jurisdiction or duties of administration. Without permission from the ordinary the clerics shall not act as agents for goods and property of lay people, or assume secular offices that impose the obligation of rendering an account, not exercise the office of procurator or 28 the new canon law lawyer, except in the ecclesiastical court, or in the civil court when there is question of his own case or of his church. Clerics shall not have any part at all, not even that of witnesses unless they are forced to act as such, in criminal cases in lay courts where the criminal is to be punished with a grave personal penalty. Without permission from the Holy See the clerics are not allowed to run for or accept the offices of senator and deputies in those countries where there is a prohibition of the Pope. In other countries they shall not attempt this without the permission of their ordinary as well as of the ordinary of the place where the election is to take place. Canon 139, 116. The clergy must keep away from such performances, dances and shows which are unbecoming to the clergy and where it would be scandalous to see them attend these, especially in public theaters. Canon 140, 117. Clerics shall not volunteer for military service, unless they do so with the permission of the bishop in countries where they are forced to serve, in order the sooner to put in their period of service. Clerics must not take part or help in any way, in internal revolts and disturbances of public order. Clerics who in violation of this law volunteer for military service thereby forfeit their clerical standing. Canon 141, 118. Clerics are forbidden either by themselves or through others to engage in any business or gainful occupation, whether for their own benefit or for that of others. Canon 142, 119. Clerics, even though they have no benefice or office requiring residence, are forbidden to be absent from their diocese for a notable length of time without at least the presumed permission of their bishop. Canon 143, for absence of pastors cf. Canon 465, 120. Clerics who go into another diocese with the permission of their bishop, but are not excardinated, can be recalled for a just reason, but the laws of equity must be kept in mind. The bishop of the other diocese likewise can for a just reason deny a priest permission to prolong his stay in that diocese, unless he has given the extern priest a parish. Canon 144, Ecclesiastical Offices 29. Title 4, Ecclesiastical Offices 121. An ecclesiastical office, in the wide sense of the word, is any employment that has a spiritual purpose. In the strict sense an ecclesiastical office means a stable position which is created either by God Himself or by the Church, conferred according to the rules of canon law, and carrying with it some participation of ecclesiastical power either of holy orders or of jurisdiction. In law the word office is accepted in the strict sense unless the context clearly shows the contrary. Canon 145, Canons 147-195 treat of appointment to offices, election, postulation, loss of office. We will here quote the canons that might find application to the condition of the Church in the United States, and in countries where the same conditions prevail. 122. An ecclesiastical office cannot be obtained without a canonical appointment. By ecclesiastical or canonical appointment is understood the conferring of an ecclesiastical office by the competent ecclesiastical authority, according to the sacred canons. Canon 147, 123. Offices that have the care of souls attached to him either in the external or internal form, cannot validly be given to clerics who are not yet ordained priests. Canon 154, this regulation is new, for according to the former law a cleric could be appointed pastor of a parish before he was ordained priest. 124. Appointment to offices that have become vacant should never be deferred over 6 months from the time when the vacancy became known, if special laws do not otherwise specify the term. In the appointment of pastors the concession of Canon 458 is to be considered. Canon 155, 125. An office that has become vacant either through renunciation or by the sentence of the ecclesiastical court cannot validly be conferred by the bishop, who accepted the resignation or gave the sentence, on his, the bishop's, relations, either of kin or by marriage. in the first and second degree, nor on a cleric in his service. Relations, either of 30 the new canon law, kin or by marriage, to the second degree and clerics in the service of the one resigning the office are at the same time barred from taking said office. Canon 157, 126. Appointment to any office should be made in writing. Canon 159, Title V. Ordinary and delegated jurisdiction. 127. In the Catholic Church there is, by divine institution, the power of jurisdiction or government. This is twofold, that of the external form and that of conscience or the internal form, which latter is subdivided into sacramental and extrasacramental jurisdiction. Canon 196, 128. By ordinary jurisdiction is meant the one that goes by right with the appointment to an office. Delegated jurisdiction is such that may be committed to a cleric by his superior. Canon 197, 129. In law the term ordinary, besides having reference to the Roman pontiff, refers to the bishop, abbot or prelate nullius and their vicars general, administrator, vicar and prefect apostolic, in their respective territories, and, in case of vacancy in these offices, to those who by law or legitimate custom succeed them in office. In exempt clerical religious orders the major superiors come also under the name of ordinaries. By the term ordinarius loci or local are meant all person enumerated in this canon except religious superiors. Canon 198, 130. He who has ordinary jurisdiction can delegate it to another, either totally or in part, unless the law expressly restricts the power of delegation. Jurisdiction delegated by the Holy See can be subdelegated, either for one act or also habitually, unless the person was delegated for reason of personal aptitude, industria personae, or subdelegation was forbidden. Jurisdiction delegated for a universality of cases by an ordinary inferior to the Roman pontiff can be subdelegated in individual cases. In all other delegations the delegated jurisdiction cannot be subdelegated except the power to subdelegate has, ordinary and delegated jurisdiction 31, been expressly granted. Acts that do not import jurisdiction can be subdelegated by delegated judges even though subdelegation was not expressly conceded. No subdelegated jurisdiction can be further subdelegated, unless this power has been explicitly granted. Canon 199, 131. The ordinary power of jurisdiction and the jurisdiction delegated for the universality of cases is to be interpreted liberally, all other jurisdictions strictly. To whom, however, jurisdiction has been delegated, to him it is understood all such power has been given as is necessary to make his jurisdiction effective. He who claims to possess delegated jurisdiction has the burden of proving his delegation. Canon 200, 132. The power of jurisdiction can be exercised directly over subjects only. The judicial power, both ordinary and delegated, cannot be exercised for one's own comfort nor outside the proper territory. For exceptions Canons 401, 1, 881, 2, and 1637 are to be considered. The non-judicial or so-called voluntary jurisdiction can be exercised even in one's own favor, and made use of even outside one's territory, and in favor of a subject who is outside the territory, unless the nature of the case or the positive rules of law forbid such use of jurisdiction. According to this rule a bishop can give various faculties to one of his priests even though the bishop is outside his diocese, and he can give them to his priests even though they be absent from the diocese. Faculties, unless restricted by law, or by the one conceding them, can be used also outside the diocese of the bishop who granted them. The faculties granted to their priests by bishops in virtue of the 5 or 10 years faculties they formerly received from the Holy See were, as a rule, granted to priests only as long as they worked in the diocese. Whether certain absolutions from censures and other faculties could be exercised by the priests also while they were for a time outside their own diocese depended on the wording of the faculties. Many of the papal faculties were granted even to the bishops with the restriction that they could not make use of them outside the limits of their 32 the new canon law. Diocese, Canon 201, cf. Number 900 on the revocation of these faculties. 133. An act of jurisdiction in the external forum, whether ordinary or delegated, holds also for the internal forum. The act of one having jurisdiction for the internal forum only does not hold in the external forum. Jurisdiction given for the internal forum can be exercised also out of confession, unless the faculty is restricted to the sacramental form. If the wording of the faculty does not mention the forum, it is considered as given for both the internal and external forum, unless the nature of the faculty indicates the contrary. Canon 202, 134. The delegate who acts beyond his mandate, either as to the matters or the persons over which he received power, acts invalidly. The delegate, however, is not to be considered to have exceeded the limits of his delegation if only the manner in which he transacted the affair is contrary to the wishes of the one who delegated him, unless the way how to proceed was prescribed as a condition of the delegation. Canon 203, 135. If a person applies to a higher superior, passing the inferior, the so-called voluntary jurisdiction of the inferior, 1e, such as is exercised outside judicial proceedings, is not thereby suspended, whether he has ordinary or delegated power. He shall, however, not interfere when the matter has been brought to the higher superior except for grave and urgent reasons, in which case he shall immediately notify the superior. Canon 204, 136. If several individuals have received delegated power concerning the same affair and doubt arises whether the delegation was given in solitum, or collegialiter, it is to be considered given in solitum in matters that do not require judicial proceedings, as collegialiter in matters of judicial proceedings. If several persons are delegated in solitum, he who first makes use of the power in the case excludes the others so that they no longer have power, unless the first is afterwards impeded, or does not wish to continue to act in the affair. Ordinary and delegated jurisdiction 33. If several persons are delegated collegialiter, all must act together in the case in order that their action may be valid, unless in the faculty other provisions are made. Canon 205, 137. If several persons have been delegated for the same affair but at different times, the one first delegated in order of time must attend to the affair unless the later delegation explicitly revoked the former. Canon 206, 138. The delegated jurisdiction ceases in the following ways: when the mandate has been complied with, when the time has expired or the number of cases is exhausted, when the motive for WRH delegation was given has ceased, by recall of the delegation made known to the one delegated by the superior, by renunciation of the delegate and acceptance of the same by the superior, but delegated jurisdiction does not cease by the passing out of office of the one delegating, except in the case mentioned in Canon 61, cf. Number 46. Jurisdiction granted for the internal forum is still validly exercised if through inadvertence the priest has not noticed that the time for his faculties has expired or that he had used up the number of cases for which he had faculties. When several persons are delegated collegialiter, all lose their jurisdiction by the fact that one is absent, dies, refuses to act, etc. unless the contrary is stated in the document of delegation. Canon 207, 139, as stated in Canon 183, 2, the ordinary jurisdiction does not cease on account of the death, etc., of the one conceding the office. When the office is lost, the ordinary jurisdiction attached to it is likewise lost. The ordinary jurisdiction is suspended in the case of legitimate appeal, unless the appeal is only in devolutivo. Canon 208. Exceptions to this canon are found in Canons 2264 and 2284. 140. The Church supplies jurisdiction both for the external and the internal form, 1, in common error, 2, in a positive and probable doubt of fact as well as of law. Canon 209. The former teaching of authors concerning supplied jurisdiction, especially as to the titulus coloratus, etc., must be corrected to agree with this canon. 141. The power of orders which has been attached to an office by the legitimate ecclesiastical superior or been 34. The new canon law committed to a person by him, cannot be delegated to others, unless the law or the indult explicitly allows delegation. Canon 210. Title VI. Reduction of clerics to the state of the laity. 142. Though the sacred ordination once validly received cannot be invalidated, Nevertheless, a cleric in major orders may be reduced to the state of the laity by rescript of the Holy See, or by the decree or sentence of the ecclesiastical court according to Canon 214, and, finally, by the penalty of degradation. A cleric in minor orders may be reduced to the state of the laity not only by the very fact of committing actions to which the law attaches loss of the clerical state, but also by his own free will under condition that he requests the ordinary to allow him to return to the lay state, or the ordinary may of his own accord issue a declaration to that effect when he prudently judges that the cleric could not, with due respect for the clerical state, be promoted to sacred orders. Canon 211. 143. If a cleric in minor orders has for any reason returned to the state of the laity, he can again be admitted to the clergy with the permission of the ordinary into whose diocese he was incarnated by the orders. The ordinary, however, should not grant permission except after a diligent inquiry concerning the life and morals of the individual and after a trial the length of which is to be determined by the same bishop. A cleric in major orders who has returned to the lay state cannot be admitted again to the clerical state except by permission of the Holy See. Canon 212. 144. All clerics who have been legally reduced, or have returned with permission, to the state of the laity thereby lose the offices, benefices, rights and privileges of clerics and are forbidden to wear the cassock and the tonsure. A cleric in major orders, however, is held to celibacy, saving the exception made in the following canon. Clerics individually 35. 145. The cleric who received a major order out of grave fear may by the sentence of the ecclesiastical judge be reduced to the state of the laity, provided he can prove that he was ordained in fear and has not ratified the ordination afterwards, at least tacitly, by the exercise of the order with the intention of subjecting himself to the obligations of the major orders. He is then free from the obligation of celibacy and from the duty of saying the breviary. The want of liberty and absence of ratification must be proved according to the rules of Canons 1993 to 1998. Canon 214, Section 2. Clerics individually. 146. The supreme authority alone can erect ecclesiastical provinces, dioceses, abbeys or prelatures nullius, vicariates apostolic, prefectures apostolic, or change their limits, divide, unite, suppress them. In law the term of diocese refers also to abbeys or prelatures nullius, and the name of bishop also to the abbot or the prelate nullius, unless the nature of the case or the context of the law show the contrary. Canon 215. 147. The territory of each diocese shall be divided into distinct territorial sections and each section shall have its own church to which the Catholic population of the district shall be assigned. Such a church is presided over by a rector as the proper pastor for the necessary care of souls. In like manner shall the vicariates and prefectures apostolic be divided where it can conveniently be done. The parts or sections of a diocese are called parishes. Those of vicariates and prefectures apostolic are called quasi-parishes, and the priests assigned to the quasi-parishes are called quasi-pastors. Without special permission from the Holy See, parishes may not be established that are not divided by territory but by the difference of language of the people in the same town or city. It is likewise forbidden to establish purely personal parishes, 1e, for certain classes of people, or parishes for certain families. As to already established parishes of the kind. 36. The new canon law. Mentioned in this canon nothing shall be changed without consulting the Holy See. This law of the new code does away with the difference between pastors of European countries and those of countries like the United States. Both are equally pastors, no matter whether they are irremovable or otherwise, whether they have a fixed income or get their salary from the voluntary offerings of the faithful. For many centuries past, the immovability from office and the endowment of the church were considered essential to a pastorship in the strict sense of the word. In more recent decrees concerning pastors there has been a noticeable tendency not to insist so much on the irremovable feature of the office. The condition of the church in many countries at the present time makes it impossible to have a benefice connected with the parish. The benefice, consisting of lands and houses belonging to the church, from the rent of which the pastor drew his living, was made impossible in countries where either the government has taken the property with which the Catholic people had endowed the churches in the course of centuries, or the Church is laboring under difficulties among a scattered Catholic population, so that endowments are impracticable or impossible. Canon 216. 148. The bishop shall divide his diocese into regions or districts consisting of several parishes, which districts are known under the names of Vicariatus Fauroni, Deconatos, Ordinaries, Archipresbyteratus, etc. If this division should on account of peculiar circumstances be impossible or inopportune, the bishop must consult the Holy See, unless provision has already been made by Rome. Canon 217, Title 7. The supreme authority and those who by law share in it. Chapter 1. The Roman Pontiff. 149. The Roman Pontiff as the successor of the primacy of Saint Peter, has not only the prerogative of honor, the General Council 37, but also the supreme and full power of jurisdiction over the universal Church, in matters of faith and morals as well as in those that pertain to the discipline and government of the Church that extends itself throughout the whole world. This power is truly episcopal, ordinary and immediate, and extends over each and every pastor as well as over the faithful, and is independent from any human authority. Canon 218, 150. The Roman Pontiff after his legitimate election obtains at once, from the moment he accepts the election, by divine right the full power of his supreme jurisdiction. Canon 219, 151. Affairs of greater importance, which are reserved exclusively to the Roman Pontiff either by their very nature or by law, are called causae majores. Canon 220, 152. If the Roman Pontiff should resign his office, it is not necessary for validity that the cardinals or any others accept the renunciation. Canon 221. Chapter 2. The General Council. 153. There can be no General Council unless it is convoked by the Roman Pontiff. It is the right of the Roman Pontiff to preside, either in person or through others, at the General Council, to determine the matters to be discussed and in what order, to transfer, suspend, dissolve the Council, and to confirm its decrees. Canon 222, 154. There are to be called to the General Council the following persons who shall have a decisive vote. 1. The Cardinals of the Holy Roman Church, even those who are not bishops. 2. The Patriarchs, Primates, Archbishops, Residential Bishops, even those not yet consecrated. 3. The Abbots and Prelates Nullius. 4. The Abbot Primus, abbots who are superiors of monastic congregations, and the supreme heads of clerical exempt orders of religious. The superiors general of other religious bodies are not to be called, unless the bull of convocation explicitly states that they are to be called. 38. The New Canon Law. If titular bishops are called to the General Council, they have a decisive vote, unless it is otherwise stated in the convocation. The theologians and experts of the sacred canons who may be invited to the General Council have but a consultative vote. Canon 223, 155. If any one of those called to the Council, who according to the foregoing canon have a right to be present, cannot come on account of some just impediment, he may send a procurator and prove the impediment. If the procurator is one of the fathers of the Council, he shall not have a double vote. If he is not, he shall be allowed to be present only at the public sessions, but without a vote. When the council is finished he is entitled to subscribe his name to the acts of the council. Canon 224, 156. No one of those who must be present at the council will be allowed to leave before the council is lawfully finished, unless the president of the council shall have investigated and approved of the reason for leaving and have granted permission to leave. Canon 225, 157. The fathers of the council may add other questions to those proposed by the Roman Pontiff, but they must previously have been approved by the president of the council. Canon 226, 158. The decrees of the council have no definite binding force, unless they shall have been confirmed by the Roman Pontiff and promulgated by his orders. Canon 227, 159. The General Council has supreme jurisdiction in the whole Church. From the judgment of the Roman Pontiff there is no appeal to the General Council. Canon 228, 160. If it happens that the Roman Pontiff dies during the celebration of the Council, the council is by that very fact suspended until the new pontiff shall have ordered its reassumption and continuation. Canon 229. Chapter 3. The Cardinals of the Holy Roman Church. Canons 230-241 treat of the creation, the rights and duties of cardinals. 161. Canon 239 contains the privileges and faculties. The Cardinals of the Holy Roman Church. 39. Which are granted to the Cardinals of the Church from the time when their promotion to the Cardinalate is published in a consistory by the Roman Pontiff, and from that time they obtain the right to vote at the election of the Roman Pontiff. If the Roman Pontiff announces the creation of a cardinal but reserves the name impector, as it is called, the one who has been thus promoted does not in the meantime enjoy any of the rights and privileges of cardinals, but after his name has been made public by the Roman Pontiff, he participates in them from the time of publication, but he takes precedence from the time his elevation was announced as reserved impector. Cf. Canon 233. The list of privileges, besides others scattered through the canons, is as follows. 1. To hear confessions in the whole world, also of the religious of either sex, and to absolve their penitents from all reserved sins and censures, with the exception of those reserved to the Holy See special immomoto and the censures incurred by revealing secrets of the congregation of the Holy Office. 2. To choose for themselves and their servants a priest as confessor who, if he should not have jurisdiction, obtains it by the very fact that the cardinal appoints him as confessor, and who also has the faculty to absolve from all reserved sins and censures as stated in the preceding paragraph. 3. To preach the word of God everywhere. 4. To celebrate, or to allow another to celebrate in his presence, 1 Holy Mass on Holy Thursday and 3 Holy Masses on Christmas night. 5. To bless everywhere, by the sign of the cross alone, rosaries and other crowns of prayer, crosses, medals, statues, all scapulars approved by the Holy See, and to impose them without the obligation of having the names inscribed, and to attach all the indulgences to these sacred objects which the Holy See usually grants. 6. To erect the Stations of the Way of the Cross with one blessing in churches, oratories, even private ones, and in other pious places, with all the indulgences granted to those who make this devout exercise, to bless crucifixes with the indulgences of the Way of the Cross for the use of the 40. The New Canon Law. Sick and those who are in any other way legitimately impeded from making the Stations in a place where they are erected. 7. To say Holy Mass on a portable altar, not only in their own residences but wherever they actually stay, and to allow that another Mass is said in their presence. 8. To celebrate on the ocean observing the proper precautions. 9. To say Holy Mass in any church or oratory in conformity with their own calendar. 10. To have each day the personal indult of the privileged altar. 11. To gain in their own oratories the indulgences for the gaining of which is prescribed a visit to some church or shrine of the town or city in which the cardinal actually stays, and his servants participate in this indult. 12. To bless the people in any place with the episcopal benediction, but in the city of Rome only in churches, pious institutions and at gatherings of the faithful. 13. To wear the pectoral cross over the mosetta like the bishops and to use the mitre and crozier. 14. To celebrate Holy Mass in any private oratory without prejudice to the one who enjoys the indult. 15. To exercise pontifical functions with throne and canopy in all churches outside the city of Rome. If the cardinal wishes to make use of the pontificals in a cathedral, he shall previously advise the ordinary of the fact. 16. To receive everywhere the honors which are usually bestowed on the local ordinaries. 17. To authenticate in the external forum the oral pronouncements of the Supreme Pontiff. 18. To have a private oratory which is exempt from the visitation of the ordinary. 19. To freely dispose, also by last will, of the revenue of their benefice, saving the exception contained in Canon 1298. This canon, which refers to cardinals who reside in the city of Rome, is quoted below. 20. To consecrate and bless everywhere churches, altars, sacred utensils, abbots, and exercise similar functions. The Roman Curia. 41. With the exception of the consecration of the holy oils, if the cardinal is not ordained bishop, observing the prescribed regulations in the law of Canon 1157, which rules that notwithstanding any privilege, No one can bless or consecrate a sacred place without the consent of the ordinary. 21. To have precedence over all prelates and patriarchs and even the papal legates themselves, unless the legate be a cardinal residing in his own territory. A cardinal legate elector outside the city of Rome precedes all other prelates. 22. To confer the first tonsure and minor orders, provided the candidates have the dismissorial letters of their own ordinary. 23. To confer the sacrament of confirmation with the obligation of having the names of those confirmed entered in the record as required by law. 24. To grant an indulgence of 200 days, to be gained toties quoties, in places or institutions for persons under his jurisdiction or protectorate, also in all other places, but to be gained by those present only and once only each time. Canon 239. Chapter 4. The Roman Curia. 162. The Roman Curia consists of the sacred congregations, tribunals and offices as described in the following canons. Canon 242. 163. In each of the congregations, tribunals and offices the laws and rules for transacting business shall be followed, which are either in general or for each in particular given by the Roman Pontiff. All who belong to any of the congregations, tribunals and offices of the Roman Curia are held to secrecy within the limits and according to the laws laid down for each. Canon 243. 164. Nothing of importance shall be transacted in these congregations, tribunals and offices without the moderator of them having notified the Roman Pontiff of the affair. All favors and all decrees need the approval of the Pope, except those affairs for which special faculties have been, 42 the new canon law, given to the moderators of the offices, tribunals and congregations. The sentences of the tribunals of the Roman Rota and of the Apostolic Signatura also do not need the Pope's approval. Canon 244. 165. If any controversy arises concerning the competency between the sacred congregations, tribunals and offices of the Roman Curia, a committee of cardinals which the Roman Pontiff shall designate will decide the question. Canon 245. Article 1. The Roman Congregations. 166. Each of the congregations is presided over by a cardinal prefect, or if the Roman Pontiff is himself the prefect of the congregation, it shall be directed by a cardinal secretary. To the prefects are joined as many cardinals as the Pontiff may think fit to assign, together with other necessary assistants. Canon 246. 167. The Congregation of the Holy Office, of which the Supreme Pontiff is the prefect, guards the doctrines on faith and morals. It judges crimes which according to its own proper law are reserved to it, with the power to judge these criminal cases not only in the case of appeals from the court of the local ordinaries, but also in the first instance, if the case has been directly brought before this congregation. It has exclusive jurisdiction in cases concerning the Pauline privilege in marriage, disparity of cult and mixed religion, and to this congregation belongs the power to dispense from these impediments. It is left to the judgment of the congregation to give the case over to another congregation or to the tribunal of the Roman Rota. All questions of forbidden books are subject to this congregation. The Eucharistic fast for priests who say Holy Mass is exclusively subject to this congregation. Canon 247. 168. The consistorial congregation has the Roman Pontiff as prefect. The Cardinal Secretary of the Holy Office, the prefect of the Congregation of Seminaries and Universities and the Secretary of State belong ex officio to this congregation. Among the consultors of the consistorial, the Roman congregations 43 congregation are numbered the Assessor of the Holy Office, the Secretary of the Congregation for Extraordinary Affairs of the Church, and the Secretary of the Congregation of Seminaries and Universities. This congregation prepares the matters to be treated in the consistory. It appoints bishops, coadjutor and auxiliary bishops, erects and divides dioceses, in districts not subject to the propaganda, and receives and examines the reports of the bishops on the state and condition of their respective dioceses. Canon 248. 169. The Congregation of the Sacraments has charge of the disciplinary regulations concerning the 7 sacraments, with the exception of what is reserved to the Holy Office in Canon 247 and to the Congregation of Rites. Dispensations from marriage impediments and dispensations in other sacraments are under the jurisdiction of this congregation. except what is given expressly to other congregations. The question of the matrimonium inconsummatum, examination of reasons for granting the dispensation and whatever is connected with it belongs to this congregation. Also questions concerning the validity of marriage, of sacred orders and of other sacraments, can be brought before this congregation, which according to its own judgment may turn the cases over to the tribunal of the Roman Rota. Canon 249, 170. The congregation of the council has charge of the entire discipline of the secular clergy and the Christian people. The observance of the precepts of the Church, conduct of the pastors and of canons of cathedral and collegiate chapters, pious sodalities and unions, even those in charge of religious, pious legacies, institutions of charity, mass stipends, benefices and offices, church property, diocesan taxes, taxes of the episcopal curias, are subject to this congregation. The celebration and approval of provincial and national councils and meetings of bishops outside of places subject to the propaganda. Canon 250, 171. The congregation of the religious has exclusive jurisdiction over the religious orders and congregations, and over communities which, even if they have no vows, lead a 44. The new canon law. Community life after the manner of the religious. The government, discipline, studies, goods and property, privileges, dispensations from the common law of the Church for the religious, with the exception of the Eucharistic fast for the celebration of Holy Mass, are subject to this congregation. In districts subject to the propaganda, certain of these rights are given to that congregation as is stated in the following canon. Canon 251, 172. The congregation of the propagation of the faith has charge of the Catholic missions for the spread of the faith, and whatever is connected with and necessary for the management of the missions. Councils held in missionary countries are subject to the propaganda. Its jurisdiction is limited to those districts where either the hierarchy is not yet established, or, if established, is still in its initial stage. Societies and seminaries founded exclusively for the training of missionaries are under the jurisdiction of the propaganda. The propaganda is held to refer to the competent congregations the cases concerning faith, marriage or general rules of the sacred liturgy and interpretation of liturgical laws. As regards the religious, the propaganda has jurisdiction over them in as far as they are missionaries, individually and collectively. In their character as religious they are under the jurisdiction of the congregation of the religious. Canon 252, 173. The congregation of sacred rites has authority to watch over and regulate the sacred rites and ceremonies of the Latin Rite. Whatever belongs only remotely to the sacred rites, as, for instance, the rites of precedence, and rites of that kind, is not subject to the congregation of sacred rites. The congregation grants exemptions from the liturgical laws, insignia to be worn at the sacred functions, and other privileges of honor. The causes of beatification and canonization, and all questions concerning sacred relics, are subject to the congregation of sacred rites. Canon 253, 174. The ceremonial congregation regulates the ceremonies in the pontifical chapel and the papal court, and the Roman congregation's 45 sacred functions which the cardinals perform outside the papal chapel. This congregation decides the questions of precedence among the cardinals, as well as of the legates whom the various nations send to the Holy See. Canon 254, 175. The Congregation for Extraordinary Affairs of the Church has jurisdiction to constitute, divide dioceses and appoint bishops in those instances where the civil governments have to be dealt with. It also has to handle those cases that the Supreme Pontiff through the Secretary of State may turn over to this congregation, especially matters that refer to the civil laws and to agreements of the Holy See with the various nations. Canon 255, 176. The Congregation of Seminary and University Studies has jurisdiction over the government, discipline, temporal administration and studies in seminaries, except those in charge of the propaganda. The universities which are under the jurisdiction of the Church are in their government and in their studies subject to this congregation, including those that are directed by some religious body. It approves new universities, gives authority to confer academical degrees and prescribes the requisites for conferring the degrees, and when there is question of a man distinguished for exceptional learning, it may itself confer on him degrees. The Cardinal Secretary of the Consistorial Congregation, among other cardinals, belongs to the Congregation of Seminaries and Universities, and the assessor of the consistorial congregation belongs to its consultors. Canon 256, 177. The Congregation for the Oriental Church has for its prefect the Roman Pontiff. To this congregation are reserved all affairs of any kind referring to persons, discipline and rites of the Oriental churches, even those of a mixed nature, that is to say, such as affect partly a Catholic of the Oriental and partly a Catholic of the Latin Rite, e.g. in marriages between Catholics of the Latin and the Oriental Rite, or an Oriental priest celebrating Holy Mass in a church of the Latin Rite, and vice versa. The Congregation for the Oriental Church has for the 46th the new canon law churches of the Oriental Rite all the powers of the other congregations combined, saving the jurisdiction of the Holy Office, as stated in Canon 247. Canon 257, Article 2. Tribunals of the Roman Curia, 178. The sacred penitentiary is presided over by a cardinal called the Major Poenitentiarius. The jurisdiction of this tribunal is limited to affairs concerning the internal form, both sacramental and non-sacramental. It grants favors for the internal form exclusively, as for instance, absolutions, dispensations, commutations, senations, condonations. The sacred penitentiary does, moreover, discuss and decide questions of conscience. The use and concession of indulgences is also subject to the sacred penitentiary, saving the right of the Holy Office to decide dogmatic questions on indulgences and indulgence prayers and devotions. Canon 258, 179. The tribunals of the Roman Rota and the Signatura Apostolica decide cases that must be settled by canonical trial, within the limits and according to the rules laid down in Canons 1598 to 1605. Canon 259, Article 3. Offices of the Roman Curia, 180. The Apostolic Chancery, in charge of the Cardinal Chancellor of the Holy Roman Church, has the duty of drawing up and mailing the apostolic letters or bulls for the appointment to benefices and offices made in consistory, for the erection of new provinces, dioceses, and chapters, and for other, more important, affairs of the Church. Such letters and bulls must not be written except by orders of the consistorial congregation in those matters over which it has authority, or by order of the Supreme Pontiff in other affairs, and the instructions given in each individual case must be observed. Canon 260, 181. The Apostolic Dataria, in charge of the Cardinal Datarius of the Holy Roman Church, has the office of investigating the qualifications of candidates to be promoted to non-consistorial benefices reserved to the Holy See, to draw up and send out the apostolic letters of appointment to these benefices, to exempt in conferring the benefices, legates of the Roman Pontiff. 47. From conditions required, when the conferring does not belong to the ordinary, to take care of the pensions and obligations which the Supreme Pontiff may impose in the appointment to the aforesaid benefices. Canon 261, 182. The Camera Apostolica, in charge of the Cardinal Camerarius of the Holy Roman Church, has the care and administration of the temporal goods and rights of the Holy See, especially for the time of vacancy, in which case the laws of the Constitution of Pope Pius X, Vacantia Apostolica, of December 25, 1904, must be observed. Canon 262, 183. The Secretariat of State, in charge of the Cardinal Secretary of State, consists of 3 divisions. 1. The first division, presided over by the Secretary of the Congregation for Extraordinary Affairs, attends to those matters which must be subjected for examination to that congregation according to Canon 255. 2. The second division, under the direction of the substitutus, attends to daily business. 3. The third division is under the direction of the Chancellor of Apostolic Briefs and attends to the drawing up and mailing of briefs. Canon 263, 184. The Secretariat of Briefs to Princes and of Latin Letters has the office of writing in Latin the acts of the Supreme Pontiff which he may commit to it. Canon 264. Chapter 5, Legates of the Roman Pontiff, 185. The Roman Pontiff has the right, independently of any civil power, to send legates to any part of the world, either with or without ecclesiastical jurisdiction. Canon 265, 186. The papal legate is called legate illatur when the supreme pontiff sends out a cardinal with this title to impersonate him like another ego and he has such faculties as the pope may give him. Canon 266, 187. Legates who are sent with the title of nuntius or internuntius. 1. Maintain according to the accepted rules of the 43 the new canon law. Holy See the relations between the Holy See and the civil government of the country where they act as permanent legates. 2. In the territory assigned to them they must watch over the condition of the Church and make report to the Roman Pontiff. 3. Besides these two, ordinary, powers, they usually receive other faculties which are in the nature of delegated jurisdiction. Those who are sent with the title Delegate Apostolic have but one ordinary office or power, viz. that of watching over the Church and informing the Holy See. They do not stand in any official relation to the government. Other powers are granted to them by the Holy See in the form of delegated faculties. Canon 267, 188. The office of the legates, with all the faculties committed to them, does not expire at the vacancy of the Holy See, unless the contrary should be stated in the papal letters. It ceases, however, when the object for which they were sent is accomplished, by revocation made known to the legate, and by renunciation accepted by the Roman Pontiff. Canon 268, 189. The legates are not to impede the free exercise of jurisdiction of the local ordinaries. Though the legates may perhaps not be consecrated bishops, they precede all ordinaries except cardinals. If they are bishops, they can without permission of the ordinaries bless the people and perform the liturgical function in pontificals, using also throne and canopy in all churches, except the cathedral. Canon 269, 190. Bishops who on account of their see have the title of apostolic legates, do not thereby acquire any special right. Canon 270. Chapter 6. Patriarchs, Primates, Metropolitans. Canons 271-280 speak of these dignitaries of the Church. He title of Patriarch and of Primate does not denote superior jurisdiction but merely the honor of precedence. The Plenary and Provincial Councils 49. Patriarchs precede Primates, the Primates precede the Metropolitans, the Metropolitans precede the Bishops. In his own diocese, however, the Bishop precedes all Archbishops and Bishops except Cardinals, Papal Legates and his own Metropolitan. Canons 271 and 280, 191. The Metropolitan, or Archbishop, has the following rights of jurisdiction over the dioceses of the ecclesiastical province whose Archbishop he is. 1. The Metropolitan can put into office those who have been presented for a benefice, if the suffragan bishop without a just impediment neglects to do so within the time specified in law. 2. He can grant 100 days indulgence, the same as in his own diocese. 3. Appoint the vicar capitular, according to conditions of Canon 432. 2. 4. Watch over the faithful observance of faith and discipline and report to the Roman Pontiff abuses in these matters. 5. To make the canonical visitation of the dioceses, if the suffragans neglect this duty, provided the Holy See has first judged of the case. 6. To exercise the pontificals in all churches, even those exempt, notifying the bishop beforehand if the archbishop wants to celebrate with pontificals in the cathedral. He may bless the people like the bishop in his own diocese and have the cross carried before him. Other acts import in jurisdiction the archbishop may not perform in the dioceses of the suffragan bishops. 7. The archbishop receives appeals from the judicial sentences of the suffragans, and acts as the judge of the second instance. 8. He acts as judge of the first instance in cases concerning the rights or the temporal goods of the bishop, AC according to Canon 1572, 2. Canon 274. Chapter 7. Plenary and Provincial Councils. Canons 281-292 treat of plenary and provincial councils. Here are a few of the more important canons. 50. The New Canon Law, 192. The ordinaries of several ecclesiastical provinces may meet in plenary council but they must first ask the permission of the Holy See, which will appoint a legate to convoke and preside over the council. Canon 281, 193. At the plenary council must be present the following persons who have a decisive vote, besides the papal legate, The archbishops, the residential bishops who may send the coadjutor or auxiliary bishop to take their place, the apostolic administrators of dioceses, abbots or prelates nullius, vicars apostolic, prefects apostolic, vicars capitular, also titular bishops, staying in the territory where the council is held, must, if called by the papal legate according to his instructions, appear at the council and they have a decisive vote, unless in the document of convocation other provisions are made. Other persons, of either the secular or the regular clergy, if invited to the council, have only a consultative vote. Canon 282, 194. In each ecclesiastical province a provincial council shall be held at least every 20 years. Canon 283, 195. The archbishop, or, if he should be legitimately impeded, or if the see should be vacant, the oldest, in promotion to the suffragan see, bishop shall appoint the place within the province where the council is to be held, after he has consulted all those who have a right to assist with a decisive vote. The archiepiscopal church should not be neglected, if there is no just cause why the council should not be held there. The archbishop, or the oldest suffragan bishop, convokes the council. Canon 284, 196. To the provincial council are to be called the following who have a decisive vote: all suffragan bishops, the abbots and prelates nullius and suffragan bishops who are not subject to any archbishop, and who have to choose with the approval of the Holy See the province to which they wish to belong. Finally, all others mentioned in Canon 282, are to be called. Titular bishops who are staying in the province can be called by the President with the consent of the majority of those who have a decisive vote, and if they are called, they, administrators apostolic 51, have a decisive vote unless the contrary is stated in the convocation. The cathedral chapters, or diocesan consultors of those bishops who take part in the council, should be invited to the council, and if invited, they should send 2 of the chapter or 2 consultors selected by common vote, who shall have only a consultative vote in the council. The major superiors of clerical exempt orders and of monastic congregations who live within the province must be invited, and if invited must either appear or give reason to the council why they are prevented to come. These, however, as also others that might be called to the council, have only a consultative vote. Canon 286, 197. The acts of the plenary and the provincial council must be subjected to the revision and approval of the sacred congregation of the council before they are published. Canon 291, 198. A conference of the bishops of each ecclesiastical province is to held at least every 5 years, to be called by the archbishop, or in case of vacancy of the archiepiscopal see or other impediment on the part of the archbishop, by the oldest suffragan. At the meeting the place for the next meeting should be agreed upon. Canon 292. Chapter 8. Vicars and Prefects Apostolic. Canons 293-311. Chapter 9. Administrators Apostolic. 199. The Holy See sometimes appoints for a canonically erected diocese an administrator apostolic, either while the bishop is still alive or when the see is vacant. Canon 312. 200. If the administrator apostolic is appointed for a diocese while the bishop is still in possession of the see, he takes canonical possession of the administration by showing his letters of nomination to the chapter as well as to the bishop, if the latter is of sound mind. If the see is vacant, or the bishop is not of sound mind, 52 the new canon law, or not residing in the diocese, the administrator apostolic takes possession in the same way as the bishop, according to Canon 334, 3, Canon 313, 201. The rights, duties and privileges of the administrator apostolic are either according to special instructions or to the following canons. Canon 314, 202. The administrator apostolic who is permanently appointed has the same rights, honors and duties as the residential bishop. If he is appointed temporarily, he has the same rights and duties as the vicar capitular. If the bishop is still in possession, he can nevertheless visit the diocese according to the rules of canon law, and he is not obliged to apply Holy Mass for the people, which obligation rests with the bishop. Canon 315, 203. If the administrator apostolic is appointed to rule the diocese while the bishop retains his see, The jurisdiction of the bishop and of his vicar general is suspended. Canon 316, 204. If the administrator dies or is otherwise impeded from acting, the Holy See must be notified. Canon 317, 205. The jurisdiction of the administrator apostolic does not cease with the death of the Roman pontiff or the bishop, but ceases when a bishop has legitimately taken possession of the vacant diocese according to Canon 334. 3. Canon 318. Chapter 10. Inferior Prelates. 206. Prelates who rule over the clergy and people of a district that is separated from every other diocese are called either abbots or prelates nullius. 1e. Of no diocese, abbots nullius, if their church is abbatial, prelates nullius, if their church is a secular prelacy. The abbacy or prelacy nullius that does not consist of at least 3 parishes is ruled by special laws, and to such does not apply what the canons state concerning abbacies and prelacies nullius. Canon 319, 207. Abbots and prelates nullius have the same ordinary jurisdiction as the bishop, even though they be not bishops. S3. Consecrated bishops. They have the right to consecrate churches and immovable altars, give all blessings reserved to bishops, excepting only the pontifical blessing, consecrate chalices, patens, portable altars, with the holy oils blessed by a bishop, grant indulgences of 50 days, give confirmation, first tonsure and minor orders. Confer Canons 782, 3 and 957, 2. Canon 323, 208. The abbots and prelates nullius, though they be not consecrated bishops, can make use in their territory of the insignia of a bishop with throne and canopy and celebrate there the sacred functions according to the pontificate. The pectoral cross, the ring with the gem, and the purple cap, they may wear also outside their territory. Canon 325, 209. The rights and privileges of the domestic prelates of the Roman pontiff, both those who have the title of prelates and those who have not, are regulated by the laws and customs of the papal palace. Canon 328. Title 8. Episcopal jurisdiction and participants of the same. Chapter 1. Bishops. 210. The bishops are the successors of the apostles and are placed by divine law over the individual churches, which they govern with ordinary authority under the authority of the Roman pontiff. They are freely appointed by the Pope. If some college has received the right to elect the bishop, Canon 321 shall be observed, which requires the absolute majority of votes of all those who have the right to vote. Canon 329, 211. Before a person is elevated to the episcopate, proof must be furnished in the manner prescribed by the Holy See that the individual is worthy. Canon 330, 212. The requisites of a candidate for the episcopate are: 1. He must be born of legitimate wedlock. Even those legitimatized by subsequent marriage are excluded. 54. The New Canon Law. 2. He must be at least 30 years of age. 3. He must have been ordained priest for at least 5 years. 4. He must be of good character, piety, zeal for souls, prudent and otherwise qualified to govern the diocese about which there is question. 5. He must be a doctor or licentiate in theology or canon law, in an institution of learning approved by the Holy See, or must at least be well versed in these sciences. If the candidate is religious, he must have received from the major superiors a similar degree, or at least have their testimony certifying to his learning. Also those who are elected, presented or designated for a bishopric by persons who have the privilege from the Holy See to elect, or present or designate, must have the aforesaid qualifications. The Holy See has the exclusive right to pass judgment on the qualification of any candidate for the episcopate. Canon 331, 213. Every candidate to the episcopate, even those elected, presented or designated by the civil government, needs the canonical provision or institution in order to be the lawful bishop of a vacant diocese. The only one to institute a bishop is the Roman pontiff. Canon 332, 214. Unless prevented by legitimate impediment, the person promoted to the episcopate, even though he be a cardinal, must within 3 months from the receipt of the apostolic letters receive the consecration and go to his diocese within 4 months. Canon 333, 215. The residential bishops are the ordinary and immediate pastors in the dioceses committed to them. They cannot exercise their jurisdiction, either by themselves or through others, unless they have first taken canonical possession of the diocese. If they were vicars capitular, officials, economi in the diocese before their designation to the bishopric, they can continue to retain and exercise these offices. They take canonical possession of the diocese as soon as they exhibit, in person or by a procurator, the apostolic letters to the cathedral chapter, the secretary of the chapter, bishops 55, or the chancellor of the curia being present to make official entry of the fact in the acts of the diocese. In countries where there are no cathedral chapters, the diocesan consuetors take the place of the chapter. Canon 334, 216. The bishop has the right and the duty to govern the diocese in spiritual affairs as well as in temporal, and has to this end legislative, judicial and coercive power which must be exercised according to the laws of the sacred canons. The laws of the bishop begin to bind immediately when promulgated unless he provides otherwise in the same laws. The manner of promulgation is determined by the bishop himself. Canon 335, 217. The bishop must urge the observance of the laws of the Church, and he cannot dispense with the common law except in as far as Canon 81 allows. Canon 336, 218. The bishop can everywhere in his diocese exercise the pontifical functions, even in exempt places. Outside the diocese he cannot exercise pontifical functions except with at least the reasonably presumed consent of the ordinary of the place, and, if there is question of an exempt church, the consent of the religious superior. To exercise the pontificals means to perform those functions in which according to the laws of liturgy the use of the pontifical insignia of the crozier and the mitre is demanded. When the bishop grants to another the permission to exercise the pontificals in his diocese, he may also allow the use of the throne and the canopy. Canon 337, 219. The bishop is obliged to reside personally in the diocese. Although he has a coadjutor bishop, the bishop may not be absent from his diocese more than 2 or at most 3 months, either continuous or interrupted, in a year. This is the time allowed for vacation. Regarding the visit ad limina, absence to attend the provincial or plenary council, or on account of a civil office legitimately connected with his church, such absence is not counted. In order, however, that the bishop may not be absent from his diocese for too long a period at one time, this canon forbids to combine the months of vacation with 56 the new canon law, and add them to the time required for the visit ad limina, etc., and for a newly appointed bishop to add the vacation to the months allowed until he must take up his residence in the diocese. The bishop should not be absent from the cathedral church in Advent, Lent, on Christmas, Easter, Pentecost, Corpus Christi, except for grave and urgent reasons. Canon 338, 220. The bishop must apply Holy Mass for the people of his diocese on all Sundays and holidays of obligation, also those suppressed. On Christmas, or on Sundays on which a holiday of obligation falls, it is sufficient to apply one Holy Mass for the people. If a holiday of obligation is transferred in such a way that on the date to which it is transferred not only the Mass and office but also the obligation of hearing Holy Mass and the duty to abstain from servile work is transferred, Holy Mass is to be applied for the people on the transferred day. Otherwise on the day of the feast, the bishop must on these days apply Holy Mass himself. If he is legitimately prevented from saying Holy Mass, he may have it applied by another. If he cannot do that, he must as soon as possible apply Holy Mass either himself or through another. If a bishop has 2 dioceses that are united dic principaliter, or in addition to his own diocese as administrator of another, he satisfies his obligation by applying one Holy Mass for all the people in his charge. If the bishop should not have satisfied the obligation spoken of in this canon, he shall as soon as possible supply the number of masses omitted. Canon 339, 221. Every bishop is held to make report of the state of his diocese every 5 years according to the formulas issued by the Holy See. The 5 years 5 term is fixed and runs from January 1, 911. In the first year of the quinquennium report must be made by the bishops of Italy, the islands of Corsica, Sardinia, Sicily, Melita, and the other small islands off the coast. In the second year the bishops of Spain, Portugal, France, bishops 57, Belgium, Holland, England, Scotland, Ireland with the adjacent isles. In the third year the other bishops of Europe with the adjacent isles. In the 4th year the bishops of all America and the adjacent isles. In the 5th year the bishops of Africa, Asia, Australia and the islands in these parts of the world. If the year assigned for the report should fall entirely or in part within the first 2 years of the bishop's reign of the diocese, the bishop may for that term abstain from sending a report to the Holy See. Canon 340, 222. The bishops who are to make the report are to go to Rome that same year to venerate the tomb of the holy apostles SS, Peter and Paul, and to appear before the Roman pontiff. The bishops, however, who are outside of Europe have permission to make the visit ad limina every 10 years. Canon 341, 223. The bishop must make the visit ad limina in person or through his coadjutor if he has any, or frangistria sons, to be approved of by the Holy See, through a qualified priest who resides in the diocese of the bishop. Canon 342, 224. The bishop must visit the entire diocese at least once in 5 years either in person, or, if legitimately excused, through his vicar general, or another priest. The bishop has the right to take 2 of the clergy, even those of the cathedral chapter, or any other he may choose, as companions on his visitation. No contrary custom or privilege restricting this right of the bishop is recognized in law. If the bishop neglects to hold the visitation, the archbishop has the right to interfere, according to Canon 274, in N. 4. 5. Canon 343, 225. To the visitation of the bishop are subject the persons, goods and pious institutions, even though exempt, within the limits of his diocese, unless special exemption is proved to have been granted them by the Holy See. The bishop can visit the exempt religious only in the cases stated in law. Canon 344, 226. The visitor should proceed in a paternal manner concerning the object and purpose of the visitation. From 58 The New Canon Law. The precepts and decrees given in the visitation there is allowed only an appeal in devolutivo. In other cases, 1e. Matters outside the scope of the visitation, the bishop, even at the time of visitation, must proceed according to the rules of law. The appeal in devolutivo means that the orders must be obeyed in the meantime even though a complaint regarding their fairness or justice is sent to the higher authorities. Canon 345, 227. The visitation should not be unduly prolonged, no unnecessary expense should be put on the places visited, and no donation should be allowed to be given either to the bishop or to any of the men accompanying the bishop. All contrary customs are disapproved. Concerning the living and traveling expenses for the bishop and his companions, the legitimate custom of the various dioceses should be added to. Canon 346, 228. In his own diocese the bishop precedes all archbishops and bishops except his own archbishop, cardinals and papal legates. While outside his own diocese the rules of Canon 106 are to be observed. Canon 347, 229. Titular bishops cannot exercise any active jurisdiction in the diocese of their title, neither do they take possession of that diocese. Charity should urge them to apply sometimes Holy Mass for the titular diocese, but there is no obligation to do so. Canon 348, 230. The following privileges are granted to bishops, both residential and titular, from the time they receive authentic notification of the canonical promotion. 1. Besides other privileges mentioned in the various titles of the Code, they enjoy the privileges in Canon 239, 1, in N. 712, viz. To celebrate with the portable altar not only in their own residence, but wherever they travel, and to permit another Mass to be celebrated at which they assist, to celebrate on the ocean, observing due precautions, to celebrate in all churches and oratories Holy Mass according to their own calendar, to have the benefit of the personal privileged altar, to gain in their own private chapel those indulgences for which the visit to a church or public place of worship is prescribed in the town or city where they see, coadjutors and auxiliary bishops. 59. To alle stay, which privilege is shared by their servants, to bless the people after the manner of the bishops, but in the city of Rome in churches only and pious institutions and at gatherings of the faithful. N. 2 of the same canon, viz. To elect a confessor for themselves and their servants who, if he should not have any jurisdiction, receives it by the very fact of being chosen, and has power to absolve from the reservations of the local ordinary and from all papal reserved sins and censures, with the exception of those special immodo reserved and those that are incurred by the revelation of a secret of the Holy Office, n. 3 of Canon 239, viz. To preach the Word of God everywhere with at least the presumed consent of the local ordinary, n. 4, viz. To celebrate, or to permit another to celebrate in their presence, 1 Holy Mass on Holy Thursday, and 3 Holy Masses at midnight on Christmas, provided they are not obliged to celebrate in their cathedral, in n. 5, 6, viz. To bless everywhere with the prescribed rites of the church beads, rosaries and other crowns of prayer, crosses, medals, statues, scapulars approved by the Holy See with all the indulgences attached to these objects by the Holy See, to bless in churches, oratories, even in private ones, and other pious places the stations of the Way of the Cross, to bless crucifixes with the indulgences of the Way of the Cross for those who through sickness or other legitimate cause cannot make the stations in places where they are erected. They have the right to wear the episcopal insignia AC according to the liturgical laws. 2. Residential bishops from the moment that they have taken possession of their diocese have the right, 1. To receive the income of the mensa episcopalis, 2. To grant 50 days indulgence in places of their jurisdiction, 3. To erect in all churches of their diocese the throne with a canopy. Canon 349, Chapter 2. Coadjutors and Auxiliary Bishops. 231. The Roman Pontiff only can give to a bishop a coadjutor. 60. The New Canon Law. The coadjutor as a rule is given to the person of a bishop with the right of succession, sometimes also to the see. The coadjutor given the person of the bishop without the right of succession is called by the special name of auxiliary. Canon 350. 232. The rights of the coadjutor given to the person of a bishop are to be learned from the apostolic letters of appointment. Unless otherwise stated in these letters, the coadjutor given a bishop who is quite incapacitated, has all the rights and duties of the bishop. In other cases he can exercise only such duties as the bishop may commit to him. What the coadjutor can do and is willing to do, the bishop should not habitually delegate to another. The coadjutor has the duty to perform the pontifical and other functions which the bishop would have to perform himself as often as he is requested by his bishop and is able to attend to them. Canon 351, 233. The coadjutor who is given to the see can in the territory of the diocese exercise the functions of the episcopate, except the sacred ordination. In other affairs he can do only as much as has been committed to him either by the Holy See or by the bishop. Canon 352, 234. In order that the coadjutor may take canonical possession of his office it is necessary that he show his apostolic letters of appointment to the bishop. The coadjutor with the right of succession and the coadjutor given to the see must, moreover, show the letters of appointment also to the chapter, in countries where there are no chapters, to the diocesan consultors, according to Canon 334, 3. If the bishop has condition should have gone to such a stage that he is not capable of eliciting a human act, coadjutors of any kind need not show the letters to him but only to the chapter. Canon 353, 235. Every coadjutor is bound, like the bishop himself, to reside in the diocese from which, outside of the period of vacation, as provided by Canon 338, he is not allowed to be absent except for a short time and with the permission of his bishop. Canon 354. The Diocesan Synod 61, 236. The coadjutor with the right of succession becomes immediately at the vacancy of the bishopric the ordinary of the diocese for which he was appointed, provided he took legitimate possession of his office according to Canon 353. The office of the auxiliary expires with the office of the bishop, unless it is stated otherwise in the apostolic letters of appointment. If the coadjutor was given to the see, his office continues also when the see becomes vacant. Canon 355. Chapter 3. The Diocesan Synod. 237. The Diocesan Synod, to be held every 10 years at least, is to treat such questions only as touch the particular needs of the clergy and people of that diocese. Canon 356, 238. The Diocesan Synod is convoked and presided over by the bishop, not by the vicar general except by special mandate, nor by the vicar capitular. It is to be held in the cathedral, unless there is good reason to have it elsewhere. Canon 357, 239. To the synod must be called, with a duty to answer the call, 1. The vicar general, 2. The canons of the cathedral or the consultors, 3. The rector of the diocesan seminary, at least of the major seminary, 4. The deans, 5. One deputy of each collegiate church to be chosen from among the members by the collegiate chapter, 6. The pastors of the city where the synod is being held, 7. One pastor at least from each deanery to be elected by all the priests of the district who have the care of souls, pastors and assistants, and the pastors must provide priests to take their places in their parishes during their absence, 8. The abbots who are actual superiors, and one of the superiors of each clerical order of those who live in the diocese, to be designated by the provincial. If the residence of the provincial is in the diocese, he may go to the synod himself instead of sending one of the superiors. If the bishop wishes, he may call to the synod also. 62. The new canon law. Others, namely all the canons, pastors, religious superiors, even any of the secular priests of the diocese, provided enough priests are left to attend to the care of souls. Those invited have the right to vote just as the others, unless the bishop in the invitation states otherwise. Canon 358, 240. Those who must come to the synod and are impeded by some legitimate impediment cannot send a procurator in their place, but they must notify the bishop why they cannot come. Those who neglect to come to the synod may be compelled by the bishop with just penalties, except exempt religious who are not pastors. Canon 359, 241. The bishop may before the synod appoint committees who are to prepare the subjects for discussion in the synod. Before the sessions open, a schedule of the subjects to be discussed is to be given to all who answered the call to the synod. Canon 360, 242. The proposed questions are to be submitted by the bishop, or the one presiding in his place, to the free discussion of the members of the synod in the preliminary sessions. Canon 361, 243. The bishop is the only legislator in the synod, the others having only a consultative vote. He alone signs the laws passed in the synod, which, if they are promulgated in the synod, begin to go into force immediately, unless the bishop decrees otherwise. Canon 362, Chapter 4. The Diocesan Curia, 244. The diocesan curia consists of those persons who assist the bishop, or the one who in place of the bishop rules the diocese, in the government of the diocese. To the curia belong the vicar general, the official, cf. Can. 1573 as to his office and appointment, the chancellor, the promoter of justice, the defensor vinculi, the synodal judges and examiners, the parochial consultors, the auditors, notaries, cursors and the apparitors. Canon 363, 245. The nomination of those who are to hold the aforesaid offices and appointments should be done in writing, as Canon 159 demands. The Vicar General 63. Those nominated must, 1. Take an oath before the bishop that they will faithfully attend to their office without respect of persons. 2. Transact their respective duties under the authority of the bishop according to the rules of law. 3. Keep the secret within the bounds and according to the requirements of law or the command of the bishop. Canon 364, 246. Concerning the official, the promoter of justice, the defender of the marriage bond, the synodal judges, the auditors, cursors and apparitors, the laws of Canons 1573, 1593 shall be observed. The other officials are to be guided by the following canons. Canon 365, Article 1. The Vicar General. 247. Whenever the proper government of the diocese demands it, a Vicar General is to be instituted by the bishop to assist him, with ordinary jurisdiction in the entire diocese. The bishop does not need the consent of anyone in the appointment of his vicar, and he can remove him at will. As a rule, there should be but one Vicar General, unless either the diversities of rights or the size of the diocese demand otherwise. If the vicar is absent or impeded to act, the bishop may appoint someone else to take his place. Canon 366, 248. The Vicar General should be a priest of the secular clergy, at least 30 years of age, a doctor or licentiate in theology and canon law, or at least perfectly conversant with these subjects, and commendable for sound doctrine, probity of life, prudence and experience. If the diocese has been committed to a religious order, the Vicar General may be an alumnus of the same order. The office of Vicar General must not be given to the canon penitentiary, or to a blood relation of the bishop in the first or in the second degree mixed with the first, or, excepting the case of necessity, to a pastor and others having the care of souls. The bishop is not forbidden to take the vicar from his own diocese, even though he would have to take one of those whom this canon does not desire to be appointed to that office. Canon 367, 249. The Vicar General has, by virtue of his office, and 64 the new canon law, the entire diocese jurisdiction in spiritual and temporal matters to the extent of the bishop has ordinary jurisdiction, excepting only those affairs which the bishop has reserved to himself, or which by law demand a special mandate of the bishop. Unless the law state otherwise, the Vicar General can execute the rescripts of the Holy See which are sent to the bishop or his predecessor in the diocese, and in general he has the faculties which are habitually given to the ordinary by the Holy See. As Canon 66 states, habitual faculties are called all those that do not refer to one individual case. For Canon 66 calls habitual faculties not only those given in perpetuum, but also those for a definite period of time or a certain number of cases. The same canon also states that, unless there is an exception made, all these faculties of the bishop are considered given also to the Vicar General. Canon 368, 250. The Vicar General should refer to the bishop the principal acts of the curia, inform him of what has been, or is to be done, to safeguard discipline among the clergy and people. He should take care not to use his powers contrary to the good pleasure of the bishop. Canon 44, 2 decrees that a favor asked of and refused by the Vicar General cannot be asked of the bishop without mentioning the appeal to, and refusal of, the Vicar General, otherwise the bishop's concession is null and void. A favor which was refused by the bishop cannot validly be granted by the Vicar General, even though the refusal of the bishop is mentioned. Canon 369, 251. The Vicar General has within the diocese precedence over any other priests, even the dignitaries of the cathedral chapter. The only ones who precede him are those who have the order of the episcopate, e.g., a titular bishop. If the Vicar General is a titular bishop, he has all the privileges of honor of these bishops. If he is not a bishop, he has during the time of his office the privileges and insignia of titular protonotary apostolic. The protonataries apostolic are not monsignori or domestic prelates. The cassock of titular protonataries is black, as is also the silken sash which hangs down on the left side. This girdle may end in 2 tassels. The protonotary may wear the rochetum. Chancellor, notaries, archives 65, and black mantle. At Holy Mass and other solemn functions he may use the extra candle on a small stand with a handle called the palmatoria. Canon 370, 252. The jurisdiction of the Vicar General expires by resignation made according to the Canons 183, 191, or by the revocation of the bishop made known to the vicar, or, finally, by the vacancy of the bishopric. If the bishop has jurisdiction is suspended, that of the vicar suffers the same fate. Canon 371, Article 2. The Chancellor, other notaries, the Episcopal Archives 253. In every curia the bishop should appoint a chancellor who must be a priest, and whose office is principally to keep the acts of the curia in the archives, to arrange them in chronological order and make an index of the same. If needs be, he may have an assistant whose title shall be vice-chancellor. The chancellor is by his very office a notary. Canon 372, 254. The bishop may also appoint besides the chancellor other notaries whose signature is recognized by the church in her courts. The bishop may appoint a notary either in general for all acts or for specified acts or occasions only. He may also appoint laymen as notaries, if clerics are not available. But in criminal cases of the clergy the notary must be a priest. Canon 373, 255. The office of a notary is, 1. To write the acts and transactions in judicial proceedings, 2. To faithfully consign to writing the proceedings, adding place, day, month and year, and his own signature, 3. to show to those who have a right to see them the acts and documents on file and to attest that copies agree with the original. The notary cannot write acts outside the diocese where he is appointed as notary nor for affairs beyond his appointment. Canon 374, 256. The bishop should have a safe and convenient place for the archives of the diocese. A catalog or index of all the documents with a summary of its contents should be carefully made. Canon 375, 66. The New Canon Law, 257. Each year within the first 2 months the catalog should be brought up to date, classifying the documents of the past year. The ordinary should inquire about the documents missing from the archives, and he has authority to use any necessary means to have them returned. Canon 376, 258. The archives must be kept locked and no one else except the chancellor shall have a key to it. Without the permission of the bishop or the vicar general and the chancellor no one is allowed to enter the archives. Canon 377, 259. Without the bishop's or vicar general's permission no one is allowed to take any document out of the archives and they must be returned after 3 days. The ordinary only may allow a longer period of time which, however, should not easily be granted. He who takes any document out of the archives must leave a signed receipt for it with the chancellor. Canon 378, 260. The bishop should also have a special place where are kept documents that should remain secret. Each year, as soon as possible, the documents of trials for bad behavior, the subjects of which have passed this life, or in whose case 10 years have elapsed since their condemnation, should be taken out of the archives and burned. A brief summary of the case and the text of the definite sentence should be preserved. The secret archives should be so constructed that they can be opened only by the use of 2 different keys, one to be kept by the bishop or administrator apostolic, the other by the vicar general, or if there is no vicar, by the chancellor. Only the bishop may ask for the other key to open, without any witness, the secret archives. Canon 379, 261. The documents to be kept in the parochial or the episcopal curia's archives and not of a secret character shall be free for inspection to anyone interested, and persons have the right to ask that a legal copy be made and given to them if they are willing to bear the expense. The chancellors of the curias, the pastors, and others, who are custodians of archives, shall in the communication, examiners and consultors 67 of documents and in the writing out and giving them to others observe the rules given by the legitimate ecclesiastical authority and in doubtful cases the ordinary of the place is to be consulted. Canon 384, Article 3, Synodal Examiners and Parochial Consultors, 262. In each diocese there must be synodal examiners and parochial consultors, who are all instituted in the synod, the bishop proposing, the synod approving them. There should be as many as the bishop judges necessary, not less, however, than 4, and not more than 12. Canon 385, 263. If any of the synodal examiners or the parochial consultors die, or otherwise go out of office, in the time between the synods, the bishop may appoint others, called prosynodal, with the advice of the cathedral chapter or the diocesan consultors. This rule should also be followed in appointing examiners and parochial consultors whenever no synod is held. Canon 386, 264. The examiners and parochial consultors, whether instituted in the synod or outside of it, go out of office after 10 years, or also sooner, if the synod is held. They can, however, finish an affair of their office which they had begun to handle, and they may be reappointed, provided the rules of law are observed. Those who are appointed in place of examiners or parochial consultors who go out of office before their term is up, remain in office only as long as those would have remained in whose place they were chosen. Canon 387, 265. They cannot be removed from office by the bishop except for a grave reason and with the advice of the cathedral chapter, or the diocesan consultors. Canon 388, 266. The synodal examiner should faithfully lend their services, especially in the examinations for the appointment of pastors and in the trials, as prescribed in Canon 2147 and following. Canon 389. For the examination of the candidates for ordination, and of priests to be approved for confessions or for preach. 68. The New Canon Law, Inc. and for the yearly examination of the junior clergy, the bishop is free to either call the examiners or others. 267. The same person can be both examiner and parochial consultor, not, however, in the same case. Canon 390. Chapter 5. Chapters of Canons. Canons 391-422. Chapter 6. Diocesan Consultors. 268. In those dioceses in which it has not yet been possible to institute, or to revive former, cathedral chapters of canons, the bishop shall appoint diocesan consultors, except where the Holy See has given special laws to some diocese. Canon 423. 269. The consultors are nominated by the bishop, observing Canon 426. Canon 424. 270. There shall be at least 6 diocesan consultors, in dioceses where there are few priests at least 4 consultors, and all consultors must live either in the episcopal city or in nearby places. Before they undertake this office, they must take an oath that they will faithfully attend to their office without respect of persons. Canon 425. 271. The office of consultors lasts for 3 years. When the 3 years are up, the bishop shall either appoint others, or reappoint the same ones for another term of 3 years, which rule shall be followed every triennium. If any of the consultors go out of office before their 3 years' term is up, the bishop shall appoint others in their place, with the advice of the other consultors as to who shall fill out the term. If the consultor's term expires during the vacancy of the bishopric, the consultors remain in office until the new bishop takes possession, and he is to provide within the first 6 months according to this canon. If during the vacancy any one of the consultors dies or resigns, the vicar capitular, or the administrator, shall, with the consent of the other consultors, nominate a substitute who needs, however, the vicar capitular. 69. The confirmation of the bishop to continue in office after the new bishop has taken possession. Canon 426. 272. The body of diocesan consultors takes the place of the cathedral chapters as the council of the bishop. Whatever part the canons give the cathedral chapter in the government of the diocese either during the reign of the bishop or during a vacancy is to be also the part of the body of consultors. Canon 427. 273. During their term the consultors should not be removed except for a just cause and with the advice of the other consultors. Canon 428. Chapter 7. Obstruction in the government. Vacancy of the episcopal see, the vicar capitular. 274. If the bishop is in captivity, or banished, exiled, or otherwise inhabilitated, so that he cannot even by letter communicate with the people of his diocese, the government of the diocese shall rest with the vicar general or another priest delegated by the bishop, unless the Holy See has made other provision. The bishop may in such circumstances for grave reasons delegate several persons who are to succeed each other. If all of them fail, or are impeded in any of the ways described above, the cathedral chapter shall appoint a vicar who shall assume the government with the powers of vicar capitular. Those called upon to assume the government of the diocese in such circumstances, shall as soon as possible inform the Holy See of the state of affairs and of their having taken over the government. If the bishop should have fallen into excommunication, interdict, or suspension, the archbishop, or in case of the archbishop being under censure, the oldest suffragan, shall at once have recourse to the Holy See that proper provision may be made. If there is question of bishops and prelates nullius who belong to no ecclesiastical province, but who have to choose an archbishop to whose jurisdiction they wish to belong for the purpose of provincial councils, cf. Canon 70. The New Canon Law. 285. The archbishop thus chosen shall report to the Holy See. Canon 429. 275. The episcopal see becomes vacant by the death of the bishop, by renunciation accepted by the Roman pontiff, by transfer, and by deprivation made known to the bishop. Nevertheless, all acts of the vicar general are valid until he has received certain notice of the bishop's death, and, in the case of removal or transfer by the Holy See, all acts of the bishop or of his vicar general hold until official notice from the Roman pontiff has reached them. Only appointments to benefices and offices are excepted from this rule. In case of transfer of a bishop to another diocese, the bishop must within 4 months from the receipt of the notice take possession of the new diocese, according to Canons 333, 334, and the diocese he leaves becomes fully vacant from the day the bishop takes possession of the new diocese. In the meantime, the following rules govern: 1. The vicar capitular has the right and duty of government, the power of the vicar general ceasing as soon as the notice from Rome arrives. 2. The vicar capitular has the privileges of honor of residential bishops. 3. He receives all the income of the mensa episcopalis according to Canon 194. 2. Canon 430, 276. In case of vacancy, the government of the diocese belongs to the cathedral chapter, unless there is an apostolic administrator or the Holy See has otherwise provided. If by special arrangement of the Holy See the archbishop, or another bishop, has the right to appoint an administrator for a vacant diocese, such administrator has all those, and only those, faculties and powers which the vicar capitular has, and he is held to the same obligations and penalties. Canon 431, 277. The cathedral chapter must within 8 days from the notice of the vacancy of the episcopal see elect the vicar capitular for the government of the diocese. If the chapter neglects to do so within that time, the archbishop has the right to appoint the vicar capitular, and in case of the metropolitan see, the oldest suffragan bishop. The same rule governs in the vacancy of independent dioceses or prelacies nullius, of which Canon 285 speaks. The cathedral chapter shall as soon as possible notify the Holy See of the vicar capitular. 71. The vacancy and of the election of the vicar capitular. Canon 432, 278. Under pain of nullity, the chapter shall appoint only one vicar capitular by canonical election, in which the absolute majority of votes suffices. Canon 433, 279. The vicar capitular must under pain of invalidity of the election be a priest, at least 30 years of age, and must not have been elected, nominated or presented to the Holy See for the bishopric by those having the right to elect, present, etc. If the election of the vicar capitular is invalid, the archbishop, or as the case may be, the oldest suffragan, has the right to appoint in that instance the vicar capitular. Canon 434, 280. The cathedral chapter, and after his election the vicar capitular, have ordinary episcopal jurisdiction in all things spiritual and temporal, with the exception of those acts which are explicitly forbidden them in law. Wherefore they have all the rights enumerated in Canon 368. 2. They have power to allow any bishop to exercise the pontificals in the diocese, and, if the vicar capitular is a bishop, he can exercise them himself with the exception of the throne and the canopy. The vicar capitular and the chapter are not allowed to do anything that might be prejudicial to the rights of the diocese or the future bishop, and they are specially forbidden to take away, destroy, conceal, or change any of the documents of the episcopal curia. Canon 435, 281. During the vacancy no changes shall be made. Canon 436, 282. In the election of the vicar capitular the chapter cannot retain for itself any part of jurisdiction, nor fix the time of duration of office of the vicar, nor attach any restrictions. Canon 437, 283. The vicar capitular, having made the profession of faith demanded in Canons 1406 to 1408, obtains jurisdiction immediately and does not need any confirmation of his election. Canon 438, 284. The rules of Canon 370 concerning the vicar general also apply to the vicar capitular. Canon 439, 285. The vicar capitular is obliged to reside within the 72 the new canon law diocese, and to apply Holy Mass for the people according to the rules of Canons 338, 339, Canon 440, 286. Unless other rules have lawfully been made, the vicar capitular and the economist have the right, 1. To a proper salary to be specified in the provincial council, or by acknowledged custom, from the income of the mensa episcopalis or other sources. 2. The rest of the income of the diocese should be reserved to the future bishop for the needs of the diocese, if it would have come to the bishop had he been in office. Canon 441, 287. The economist of the diocese shall have the administration of the goods and revenue of the diocese, under the authority, however, of the Vicar Capitular. Canon 442, 288. The removal of the Vicar Capitular and of the Economus is reserved to the Holy See. Their renunciation is to be handed in authentic form to the chapter, but it is not necessary for its validity that the chapter accept it. The appointment of a new vicar or an economus after the resignation, death, or removal by the Holy See belongs to the chapter after the manner of Canon 432. Their authority, moreover, expires from the moment the new bishop takes possession. Canon 443, 289. The new bishop has authority to demand an account from the Vicar Capitular, and from all officials of their actions during the vacancy, and to punish delinquents, even though the chapter should have exonerated them. They must also give an account of documents belonging to the church that came to them during the vacancy. Canon 444, Chapter 8. Deans. 290. A dean, vicarius foerinus, is a priest who presides over a deanery by appointment of the bishop. Cf. Canon 217. Canon 445, 291. The bishop should appoint to the office of dean worthy priests, especially from among the pastors. The dean may be removed at will by the bishop. Canon 446, 292. Besides the faculties which the diocesan statutes, deans 73, or otherwise the bishop, may give them, they have the right and duty, 1. To watch over the clergy of their district in order that they live according to the laws of the Church, keep presidents, attend to preaching and instruction of the children and the adults and fulfill their duty towards the sick and infirm. 2. To see to it that they fulfill the decrees and orders of the bishop issued at the time of visitation. 3. To see to it that the rules concerning the keeping of the Blessed Sacrament are observed. 4. That the churches and whatever is used for divine worship are kept in proper condition, that the laws of liturgy are observed in the divine services, that the church property is properly and faithfully administrated and the obligations annexed to church endowments, as for instance legacies of masses, are tended to, that the church records are properly kept. In order to obtain knowledge of these matters the dean should at stated times, to be fixed by the bishop, visit the parishes. It is the dean's duty to see to it as soon as he hears of the serious illness of any pastor of his district, that such a priest receives the necessary spiritual and temporal assistance, and, in case of death, a becoming burial. He has, moreover, the duty to watch that during the illness and after the death of a pastor the books, documents, sacred utensils and other objects belonging to the parish are not lost, or taken away. Canon 447, 293. The dean must on days appointed by the bishop summon the priests of his district for the conferences of which Canon 131 speaks, and preside at them. If they are held in several places of his district, he must watch that they are properly attended. If the dean is not a pastor, he must reside in the territory of the deanery or in a place nearby, according to the regulations to be made by the bishop. Canon 448, 294. At least once a year the dean should submit report to the bishop, not only of the good that has been accomplished but also of evils that have crept in, scandals that have arisen, and what has been done to repair them, and what he has to suggest for wiping out the evils. Canon 449, 74. The New Canon Law. 295. The dean should have a seal proper to the deanery. He precedes all the pastors and other priests of his district. Canon 450. Chapter 9. Pastors. 296. The pastor is an individual priest, or a body of men, to whom a parish has been conferred to attend to the care of souls by and under the authority of the bishop. The following persons are in law held equal to pastors with all parochial rights and duties. 1. The quasi-pastors who are in charge of quasi-parishes, that is to say, in vicariates and prefectures apostolic where the territory has been divided into districts and an individual rector been appointed over the district. In countries like the United States and others withdrawn from the jurisdiction of the propaganda, the rectors of parochial churches are called pastors in the strict sense of the term. 2. The parochial vicars, if they have full parochial power. Concerning the major and minor military chaplains, the special regulations of the Holy See are to be observed. Canon 451, 297. Without apostolic indult the bishop cannot unite a parish to a body of men, e.g. a monastery, college, in full right, namely in such a way that the body of men as a collective person becomes pastor of a parish. Cf. Canon 1432. 2. A body of men to whom a parish has been given by full right can retain only habitually the care of souls. The actual exercise of the pastoral rights and duties rests with the parochial vicar, who is appointed according to the rules of Canon 471, Canon 452, 298. In order that a cleric may validly be appointed pastor, he must be a priest, Canon 453, 299. Those who are appointed as rectors of a parish should remain in office permanently, which rule, however, does not forbid to change any pastor provided the rules of canon law are observed. Not all pastors have the same stability in office. Those who enjoy greater stability are called irremovable. Those who, pastors 75, have a lesser degree of stability are usually called movable pastors. Irremovable parishes cannot be made movable without the beneplacitum of the Holy See. The movable parishes can be made irremovable by the bishop, not however by the vicar general, with the advice of the cathedral chapter or the diocesan consultors. New parishes to be established should be made irremovable, unless the bishop, having sought the counsel of the chapter or the consultors, should prudently judge that peculiar circumstances of place and persons make movable pastorships more advisable. All pastors of quasi-parishes are movable. Pastors belonging to religious communities are always, as far as the individual person is concerned, movable, and they can be removed as pastors both by the will of the bishop, notifying the superior, and also at the will of the respective religious superior, notifying the bishop. Both have equal rights, and the one does not need the consent of the other, nor has one to give reason to the other, much less proof. Both have the right of recourse in devolutivo to the Holy See in a disagreement. Canon 454, 300. The right to nominate and institute pastors belongs to the bishop, except for parishes reserved to the Holy See. All contrary customs injuring this right of the bishop are disapproved. Those, however, who have legitimately been given the right to elect or present the pastor do retain their right. When the diocese is vacant or impeded, as described in Canon 429, the vicar capitular, or another who rules the diocese has the right, 1. To institute parochial vicars AC according to Canons 472-476, 2. To confirm the election or accept the presentation to a vacant parish and to grant the elected or presented priest the canonical institution as pastor, 3. To appoint pastors to parishes in general, if the see has been vacant for at least 1 year. The vicar general has no power to confer parishes without a special mandate from the bishop, except in cases where the bishop is in captivity, exile, inhabilitated to act, etc., as described in Canon 429, 1. Canon 455, 301. For parishes entrusted to religious, the superior. 76. The new canon law, whose office it is, according to the constitutions of the order, has the right to present a priest of his order to the ordinary for the pastor's office. The ordinary gives him the canonical institution, observing Canon 459, 2, which leaves to the bishop the judgment of the requisite qualifications. Canon 456, 302. Quasi-pastors are nominated from the secular clergy by the local ordinary with the advice of his council. Quasi-parishes are those in vicariates and prefectures apostolic, where, according to Canon 302, the vicar or prefect apostolic is to appoint at least 3 of the elder missionaries as his advisory board, whom he should consult in all more important cases. Canon 457, 303. The bishop should not delay the appointment of a pastor to a vacant parish for more than 6 months, unless peculiar circumstances of place and persons induce the ordinary to delay the conferring of the pastorship. Canon 458, 304. The ordinary is bound in conscience to give the vacant parish to the priest whom he judges best qualified, without favoritism. In judging the candidates for the pastorship there must be considered not only learning but also all other qualities required for the proper administration of the parish. Wherefore the ordinary should, 1. Not neglect to gather information from any source as to the character of the priest, 2. Refer to the examinations he passed when belonging to the junior clergy, cf. Canon 130, 2, 3, subject the candidate to an examination as to his theological knowledge before himself and the synodal examiners, unless there is question of a priest well known for his theological learning, in which case he may with the consent of the examiners dispense him from the examination. 4. In countries where the conferring of parishes is done by a concursus, either in the form of the Constitution of Pope Benedict XIV, commulio December 14, 1742, or by a general concursus, that form shall be retained until the Holy See shall have otherwise provided. Canon 459, 305. A pastor should have, according to Canon 156, pastors 77, only one parish, unless there is question of two parishes which have been united dic principaliter. In one and the same parish there can be but one pastor who has the actual care of souls. All contrary customs are disapproved and privileges recalled. Canon 460, 306. The pastor assumes the care of souls from the moment of taking possession. The manner of taking possession may, according to Canon 1444, be regulated by particular law or by custom. Before taking possession, or in the act of taking possession, he must make the profession of faith prescribed by Canon 1406, 1, n. 7. Canon 461, 307. The functions reserved to the pastor, unless the law states otherwise, are the following: 1. To baptize solemnly. 2. To carry the blessed sacrament publicly to the sick within his parish. 3. To administer the holy viaticum, whether publicly or privately, and to give extreme unction. The bishops receive the last sacraments from the canons of the chapter according to their rank of dignity. Where there are no cathedral chapters, the consultors of the diocese take their place. In clerical religious communities, the administration of the last rites to the religious, and to all that live in the religious house, belongs to the superior. In case of necessity, any priest may administer the last rites, and sometimes also by presumed permission. 4. To announce sacred orders and the marriage banns, to assist at marriages and to give the nuptial blessing. 5. To perform the funeral services of his parishioners unless they themselves selected before their death another church for burial. 6. To bless the houses on Holy Saturday or any other day, according to local customs, with the blessing of the ritual. 7. To bless the baptismal font on Holy Saturday, to have biblic processions outside the church in his parish, to give blessings outside the church with great pomp and ceremony, unless there is question of the cathedral chapter which may perform such public functions. Canon 462, 73. The New Canon Law, 308. The pastor has the right to the revenue to which legitimate custom or legal taxation, according to Canon 1507, 1. Entitle him. If he exacts more than he is entitled to, he is held to restitution. If any of the parochial offices are attended to by another priest, the fees or offerings belong to the pastor, unless the contrary will of those making the offering is certain concerning the sum that is over and above the ordinary tax. He must not refuse to gratuitously serve those who are not able to pay for the services. Canon 463, 309. The pastor is bound by virtue of his office to exercise the care of souls for all who are not legitimately exempt from his jurisdiction. The bishop may for just and grave reasons exempt from the authority of the pastor the religious houses and pious institutions within the limits of the parish, though they are not exempted by the common law. Canon 464, 310. The pastor is obliged to live in the parochial house, near his church. The ordinary may permit him for a just reason to live elsewhere, provided the house is not so far away from the church that the attendance to the duties of his office thereby suffers. He is allowed to have 2 months' vacation in a year, either continuous or interrupted, unless the ordinary restricts or prolongs that period. The days spent in the retreat of the priests of the diocese do not count as part of the vacation. Whether the pastor takes his vacation for 2 months in succession or with interruptions, the rule is that whenever he goes away for more than a week he must, in addition to a good reason for going, have the written permission of the bishop. While away from his parish the pastor must provide a substitute approved by the ordinary. If the substitute is a religious priest, he must have both the approval of the bishop and of the religious superior. If the pastor is obliged to leave his parish suddenly, on account of some very urgent reason, and must be away for over a week, He shall as soon as possible inform his bishop by letter of the facts and state what priest he left in charge of the parish. Pastors 79. Also, in cases when the pastor is away from the parish for less than a week, he must provide for the wants of the people, especially when the peculiar circumstances of the parish demand constant attention. Canon 465, 311. Pastors are strictly bound to apply Holy Mass for their congregation on all Sundays and holidays of obligation, even on abolished holidays. Quasi-pastors, that is to say, pastors in districts subject to the propaganda, are advised out of charity to say Holy Mass for their congregation on Sundays and the greater feasts of the year. As the pautors in the United States, whether irremovable or immovable pastors, are pastors in the strict meaning of the term by virtues day of the Code, they will have to apply Holy Mass for their congregations. The feast days are the following: Christmas, New Year's, Epiphany, Easter Sunday, Monday and Tuesday Day, Ascension, Pentecost Sunday, Monday and Tuesday, Trinity, Corpus Christi, Invention of the Holy Cross, Immaculate Conception, Purification, Annunciation, Assumption and Nativity of the Blessed Virgin, Dedication of Saint Michael, Nativity of Saint John Baptist, SS, Peter and Paul, Saint Andrew, Saint James, Saint John, Saint Thomas, SS, Philip and James, Saint Bartholomew, Saint Matthew, SS, Simon and Jude, Saint Matthias, Saint Stephen, Holy Innocents, Saint Lawrence, Saint Sylvester, Pope, Saint Joseph and Sweet Anne, all saints. It is the common teaching of moralists that even if on these days the pastor says 2 holy masses, he cannot accept a stipend for either mass. If the pastor should have several parishes which are united eque principaliter, or should be administrator of an additional parish or parishes, he satisfies his obligation by saying 1 Holy Mass for the people. The ordinary can for a just reason allow the pastor to apply Holy Mass for the people on another day than that specified in law. The pastor should say the Mass for the people in his parish church, unless circumstances demand otherwise. If the pastor is legitimately absent, he may either himself say the Mass for the people in the place where he stays, or have it said by the priest who takes his place in the parish. Canon 466, 312. The pastor must celebrate the divine offices, add 80 the new canon law, minister the sacraments to the faithful as often as they legitimately request it, get acquainted with the people, admonish the erring, assist the poor and the sick, and give his special care to the instruction of the children in the Catholic faith. The faithful should be admonished that they, if possible, frequently go to their parish church to assist at the divine services and to hear the word of God. Canon 467, 313. The pastor shall take special care of the sick, especially when they are dying, give them the sacraments frequently, and commend their souls to God. The pastor, and any other priest assisting the sick, has the faculty to give the apostolic blessing with a plenary indulgence for the moment of death, to be applied according to the formula of the ritual. Canon 468, 314. The pastor must watch that nothing shall be done against faith or morals in his parish, especially in the schools whether private or public, and he must advance the works of charity, faith and piety in the parish. Canon 469, 315. The pastor must keep the parochial records of baptism, confirmation, marriage, and the deceased. He shall take care to have the census book as correct as possible, and he shall keep these books with great care and according to the approved custom or the regulations of the bishop. In the baptismal record should be inserted a notice about the confirmation, and the marriage, or subdiaconship, or solemn profession. When issuing baptismal certificates, these facts should always be mentioned in the certificate. At the end of each year, the pastor should send an authentic copy of the records to the episcopal curia with the exception of the census book. The pastor should have a parochial seal and a safe place for the above-mentioned parochial books, where he should also keep the bishop's letters and other documents that may be useful or necessary to keep. Canon 470. Chapter 10. Parochial Vicars, 316. If a parish is united to a religious house, to a cathedral or collegiate chapter, or any other body of men, parochial vicars 81, by full right, A vicar must be appointed for the actual care of souls who shall receive a suitable salary from the income of the parish according to the judgment of the bishop. The religious superior, or the chapter, or other legal body to which the parish is attached, shall nominate the vicar and present him to the bishop, who must appoint him if he finds him qualified, according to the rules of Canon 459. Only in case of legitimate privilege or custom, or endowment of the vicariate by the bishop in which he reserved to himself the right of freely nominating the pastor, can the bishop himself nominate the parochial vicar. If the parochial vicar is a religious, he is movable like the religious pastor, as stated in Canon 454. 5. All other parochial vicars are perpetual as far as the college or chapter that presents him is concerned, but the bishop has the right to remove him in the same way as pastors, notifying the one who presented the vicar. To the vicar exclusively belongs the care of souls with all the rights and duties of law and the statutes of the diocese and laudable customs. Canon 471, 317. During the vacancy of the parochial office, the bishop shall as soon as possible appoint, with the consent of the religious superior if there is question of religious, a vicar economus who shall rule the parish during the vacancy and receive a proper portion of the revenue. Before the vicar economus is appointed, the assistant of the former pastor shall assume the government of the parish, if there are several assistants, the first, if they are all equal, the senior in office of the assistants. If there are no assistants, the nearest pastor takes charge, in case of religious, the superior of the house. The bishop in the diocesan synod, or outside of the synod, shall determine beforehand which parish is to be considered nearest. He who takes charge of the parish after the manner of the preceding paragraph, shall notify the bishop of the vacancy. Canon 472, 318. The vicar economus has the same rights and duties as the pastor in all things concerning the care of souls. He must, however, do nothing that might be prejudicial to the rights of the pastor and the parochial benefice. 82. The new canon law. The vicar economus shall in presence of the dean or another priest appointed by the bishop hand to the newly appointed pastor the key of the parochial archives and all other things belonging to the parish, and give an account of the receipts and expenditures, for the time of his administration. Canon 473, 319. The vicar who takes charge of the parish in the absence of the pastor, e.g., during vacation, has all the rights of a pastor as far as the care of souls is concerned. Canon 474, 320. If the pastor, on account of old age, mental debility or other perpetual inability, is not able to administrate the parish, the bishop must give him an assistant as vicar of the parish. If it is a parish in charge of the religious, the superior presents the vicar. The assistant who takes the place of the pastor in all the affairs of the parish has all the rights and duties of a pastor, with the exception of the application of the Mass for the congregation, which rests with the pastor. If, however, he has only part of the pastoral duties to attend to, his rights and obligations must be learned from his letters of appointment. If the pastor is of sound mind, the assistant must help him in the pastoral work under his authority and according to the bishop's instructions. If the parish cannot be properly taken care of by an assistant acting as parochial vicar, the bishop has the right to remove the pastor according to Canons 2147 to 2161. Canon 475, 321. If the pastor alone cannot take care of all the work in the parish, on account of the great number of the people or for other reasons, the bishop may give him one or several assistants, called in law vicarii cooperatores, who shall receive a proper salary. The assistants may be appointed either for the entire parish or for a certain specified part of it. The bishop, not the pastor, has the right to nominate the assistants of the secular clergy, after having given hearing to the pastor. The assistants of the religious pastor are presented to the rectors of churches. 83. Bishop by their competent religious superior, and it belongs to the bishop to approve them. The assistants are obliged to reside in the parish according to the diocesan statutes, or the laudable customs, or the laws of the bishop. Where it is possible, the bishop should arrange that they live in the rectory. The rights and duties of the assistants are derived from the diocesan statutes, the letters of appointment, and the commission of the pastor. Unless the contrary has been expressly stated, they must assist the pastor in the general minutes history of the parish, With the exception of the application of Holy Mass for the people, the assistants are subject to the pastor, who should paternally instruct and direct them in the care of souls, watch over them, and send each year a report to the bishop concerning their conduct. If the parish is so large that even the appointment of assistants does not properly provide for the spiritual welfare of the people, the bishop has the right to divide the parish, according to Canon 1427, Canon 476, 322, parochial vicars and assistants, of which Canons 472-476 treat, may be removed at will by the bishop or the vicar capitular. The vicar general can remove them only by special mandate of the bishop, religious either by the bishop or the superior of the order, according to Canon 454. 5. If a benefice is connected with the assistant's position, he can be removed by canonical trial, not only for reasons on account of which a pastor can be removed, but also for grievous disobedience to the pastor in the due exercise of his duties. Canon 477, 323. The pastor of the cathedral church precedes all other pastors in rank. The parochial vicar of the cathedral chapter precedes all other parochial vicars. Canon 478, Chapter 11, Rectors of Churches, 324. By the name of rectors of churches are meant here those priests who have charge of a church that is neither parochial nor capitular, nor annexed to a religious community, which holds services in that church. 84. The new canon law concerning the chaplains of religious women, of local communities of men, of confraternities, and other legitimate associations, the laws of particular canons shall be observed. Canon 479, 325. The rectors of churches are freely appointed by the ordinary, except in places where certain individuals have the right to elect or present the candidate. The approval in that case belongs to the bishop. Even if the church belongs to an exempt order, the rector nominated by the superior must be referred to the bishop for approval. If the church is connected with a seminary or college conducted by the clergy, the superior of the seminary or college is at the same time rector of the church, unless the local ordinary directs otherwise. Canon 480, 326. In the church committed to him the rector cannot hold parochial functions. Canon 481, 327. The rector of a church can celebrate the divine services also solemnly, observing, however, the laws of foundation. 1e. Such regulations as were made or approved of by the bishop when the church was built by individual benefactors, and provided that the holding of solemn services in the church does not injure the parish church. The bishop is the judge in these matters. Canon 482, 328. If the non-parochial church is so far away from the parish church that the parishioners who live near the chapel could not be expected to go to the parish church for divine service, the bishop may command the rector, even under grave penalties, to have divine services at hours convenient for the people, to announce the feasts and fast days, give catechetical instruction, an explanation of the Holy Gospel. The pastor has the right to take Holy Communion to the sick from such church, if the bishop has allowed that the Blessed Sacrament be kept there. Canon 483, 329. Without the permission of the rector, or other legitimate superior, no priest is allowed to say Holy Mass, or administer the sacraments, or hold any functions, in that church. Canon 484, 330. The rector must take proper care of the church. Canon 485. The religious 85, 331. Rectors of any kind are removable at will by the bishop. Canon 486, Part 2. The religious, 332. The religious state, by which is meant a permanent community life, in which the faithful besides observing the common precepts, oblige themselves to the observance of the evangelical counsels by the vows of obedience, chastity and poverty, should be held in honor by all. Canon 487, 333. The meaning of the various terms used in the law for the religious is defined as follows. Canon 488. 1. Religio means a society, approved by legitimate, ecclesiastical authority, whose members strive after evangelical perfection by living according to the special laws governing the society and by taking public vows, either perpetual or temporary, to be renewed, if temporary, when the time of the vows expires. 2. Ordo denotes a religious organization in which solemn vows are taken, Congregatio monastica is a combination of several independent monasteries of monks under one superior. Religio exempta means a religious organization, of either solemn or simple vows, that has been withdrawn from the jurisdiction of the ordinary of the diocese. Congregatio religiosa, or simply congregatio, signifies a religious body in which only simple vows are taken, which vows may be either perpetual or temporary. 3. Religio Juris Pontifice is a religious organization which has received from the Holy See either approval or at least the Decretum Laudis. Religio Juris Diocesani is a religious organization which has been instituted by the ordinary and has not yet obtained the Decretum Laudis from the Holy See. 4. Religio Clericalis means a religious organization whose members are mostly priests, otherwise it is called Religio Localis. 5. Domus religiosa signifies the residence of any religious organization. Domus regitoris is the house of an order. Domus formata means a religious house in which reside. 86. The new canon law, at least 6 professed members, of Hajj, if there is question of a clerical religious organization, 4 at least must be priests. 6. Provincia is a combination of several houses of religious under one superior, constituting a part of the religious order or congregation. 7. Religiosi are those who have taken vows in any religious community. Religiosi votum simplicem are those who have taken vows in a religious congregation. Regulares are the professed members of an order. Suras are religious women who have taken simple vows. Moniales are religious women with solemn vows, unless either by the very nature or the context of the canons their meaning is to be taken otherwise. There are also nuns whose vows are by their rule solemn, but who have for certain countries been declared simple by order of the Holy See. 8. Superiores majores are the abbess primus, abbots who are superiors of monastic congregations, abbots of independent monasteries though belonging to some monastic congregation, the generals or highest heads of any religious organization, the provincial superiors and their vicars, and all others who have the same jurisdiction as provincials. 334. The rules and particular constitutions of individual religious organizations which are not contrary to the canons of the code remain in force. Those rules and statutes that are opposed to the canons are hereby abolished. Canon 489, 335. The laws of the canons for the religious when speaking in the masculine gender, religiosus, religiosi, apply in the same manner to religious women, except the context or the nature of the law prove the contrary. Canon 490, 336. The order of precedence is as follows: the religious precede lay people, clerical organizations precede legal, canons regular precede monks, monks precede other regulars, regulars precede religious congregations, congregations of papal law precede diocesan congregations. Among religious bodies of the same kind in the same town or city, precedence is regulated according to the priority of residence in the place. The secular clergy precedes both legal and clerical. Religious organizations 87. Religious bodies outside the churches of these bodies, and even in their churches if they are legal organizations. The cathedral or collegiate chapter precedes the religious everywhere. Canon 491, Title 9, Erection and suppression of a religious organization, of a province, or a house. 337. Bishops, and not the vicar capitular or the vicar general, can establish religious congregations. They shall not establish them, nor allow their foundation, without first consulting the Holy See. If there is question of tertiaries living in community, it is required, moreover, that the supreme head of the first order aggregate them to his order. A diocesan religious congregation remains diocesan even though it has in the course of time spread to several dioceses, and it stays under the absolute jurisdiction of the bishops until it has obtained from the Holy See approval or, at least, the Decretum Laudis. The name and religious habit of an established order or congregation cannot be assumed by those not lawfully belonging to that body nor by a new organization. Canon 492, 338. Any religious body, even a diocesan congregation, which has been legally established cannot be dissolved, even though it should consist only of one house, except by authority of the Holy See, to which is also reserved the disposition of the goods of the congregation, saving the legitimate will and intention of the donors. Canon 493, 339. To the Holy See it belongs to divide congregations of papal law into provinces, to join provinces that have been established, or to change their circumscription, to establish new ones and suppress others, to separate independent monasteries from some one monastic congregation and unite them to another. Concerning the goods of a province that has been abolished, the general chapter, or, outside the chapter, the superior general with his council, has the right to dispose, unless the constitutions provide otherwise. The laws of Jew. 88. The new canon law, Tice and the will of founders must be safeguarded. Canon 494, 340. A diocesan congregation cannot establish a house in another diocese except with the consent of both the bishop of the diocese where its principal house is situated, and the bishop of the diocese to which it wishes to go. The bishop of the principal house should not deny permission without serious reasons. If a diocesan congregation has already spread to other dioceses, changes in the laws of that congregation cannot be made except with the consent of each and every bishop of the dioceses in which it has a house. What the Holy See ordained at the time the bishop consulted the same about the founding of a congregation, as prescribed in Canon 492, 1. Cannot be changed by bishops. Canon 495, 341. No religious house shall be established unless it can be prudently judged that the community will be able to properly support itself, either by fixed income, or the usual alms, or by other means. Canon 496, 342. For the erection of a house of an exempt order or congregation, whether it be a domus formata or non formata, cf. Canon 488, 5, for a monastery of nuns with solemn vows, and for any religious house in countries subject to the propaganda, the beneplacitum of the Holy See is required, together with the written consent of the local ordinary. For all other cases the consent of the ordinary suffices. The permission to establish a house given to a clerical religious organization carries with it the right to have a church or public oratory, and to perform therein the sacred functions according to the rules of the law, and for all religious to exercise the pious works proper to each, observing the conditions under which the permission was granted. When religious intend to build a church, the bishop has approval of the location must be sought, according to Canon 1162, 4. For the building and opening of schools, hospices, or other houses separate from the religious house, exempt or non-exempt, the written permission of the bishop is required, and not that of the Holy See. Superiors and Chapters 89. In order to convert a religious house to other purposes, the same formalities are required as for a new foundation. It is not considered a change to other purposes, if there is question of changing it for purposes belonging to the internal regime and discipline, e.g., to use a house, or build a new house, of studies for the religious themselves. If, however, contrary agreements between the bishop and the provincial were made at the time of entering into the place, these must be adhered to. Canon 497, 343. A religious house, whether a domus formata or non formata, belonging to an exempt order can be suppressed only by permission of the Holy See. If it belongs to a non-exempt congregation of papal law, it can be suppressed by the general with the consent of the local ordinary. If it is a house of a diocesan congregation, it can be suppressed by the sole authority of the bishop after having given hearing to the head of the congregation, and then the congregation has the right of appeal to the Holy See in suspensive, that is to say, the community or house cannot be disturbed before Rome has decided. If the congregation has but one house, Canon 493 provides. Canon 498, Title X. The Government of Religious Organizations. Chapter 1. Superiors and Chapters. 344. All religious are subject to the Roman Pontiff as their highest superior, whom they are bound to obey also in virtue of the vow of obedience. The Cardinal Protector of the individual orders has no jurisdiction over the order or over the individual members, unless the contrary has been ordained for particular circumstances. Nor can he interfere in the internal discipline and the administration of property, it being his office only to promote the good of the order by his advice and patronage. Canon 499, 345. The religious are subject also to the local ordinary, with the exception of those who have obtained from 90 the new canon law. The Holy See the privilege of exemption, but avert these are in some things subject to him, as the canons specify in various places. Nuns with solemn vows, who by their constitutions are under the jurisdiction of the regular superiors, are subject to the local ordinary in those cases only which are specified in law. No order of men can without a special papal indult have under its jurisdiction religious congregations of women, or claim a special right to care for and direct the members of such congregations. Canon 500, 346. The superiors and the chapter have governing power over their subjects, according to the constitutions and the common law. In clerical, exempt, religious orders they have ecclesiastical jurisdiction for the internal as well as for the external form. All superiors are strictly forbidden to interfere in cases belonging to the Holy Office. The abbot primus and the superior of a monastic congregation have not all the power and jurisdiction which the common law gives to major superiors. Their power and jurisdiction must be gathered from the proper constitutions and the special laws of the Holy See. Canons 655 and 1594, 4, are to be observed. Canon 655 refers to the dismissal of a solemn professed religious or one with perpetual simple vows, which case is to be judged by the abbot superior of a monastic congregation, and Canon 1594, 4, states that the abbot superior of a monastic congregation is the judge of the second instance for cases tried by the abbot. Canon 501, 347. The highest superior of a religious organization obtains power over all provinces, houses, and the individual religious, to be exercised according to the constitutions. Other superiors have that power within the limits of their office. Canon 502, 348. The major superiors in clerical exempt orders can constitute notaries for the ecclesiastical affairs of their order only. Canon 503, 349. Unless the proper constitutions of individual religious bodies demand a more advanced age, and other more. Superiors and chapters 91. Difficult conditions. Those are inhabilitated for the office of a major superior who are not at least 10 years professed, the years to be counted from the first profession, not born of legitimate wedlock, and for the office of the highest superior of a religious body, or for abbess in monasteries of nuns with solemn vows, those under 40 years of age, 30 years of age or the minimum required for other major superiors. Canon 504, 350. The major superiors are to be temporary, unless the constitutions demand otherwise. Minor local superiors, however, must not be appointed to office for more than 3 years. After that term they may be appointed for a second term, not, however, for a third term in the same religious house. Canon 505. It may be noted that the canon does not restrict the regulations for the terms of office to large houses only, but speaks of all, without distinction. 351. Before the election of major superiors in orders of men takes place, each and every one of the chapter must take an oath to vote for those only for whom before God he believes he should vote. In monasteries of nuns with solemn vows, if they are subject to the bishop, he or his delegate, with 2 priests who act as tellers, presides at the election of the abbess, without entering the enclosure. If the nuns are subject to the superiors of a religious order, the regular superior presides, in which case the bishop must be notified in due time of the coming election and he may, together with the religious superior, be present or send a delegate. If the bishop comes in person, he presides. The ordinary confessors of that monastery should not be appointed to act as tellers. In religious congregations of women the local ordinary presides in the election of the superior general. If there is question of diocesan congregations, he may at will confirm or annul the election, as he in conscience sees fit. Canon 506, 352. In elections held by the chapter, the common law, contained in Canons 160-182, is to be observed, together with the constitutions of the order or congregation, in as far as they are not contrary to the canons. 92. The new canon law. All religious should guard against procuring votes, directly or indirectly, for themselves or for others. The election by postulatio can be admitted only in extraordinary cases, and only when not forbidden by the constitutions. Canon 507, 353. The superiors shall reside in their respective houses and not leave them, except according to the rules of the constitutions. Canon 508, 354. Every superior must promote among his subjects the knowledge and execution of the decrees of the Holy See for the religious. The local superiors shall take care, 1. That once a year, on the prescribed days, the constitutions of the order or congregation are read publicly, as also the decrees which the Holy See order to be read before the whole community. 2. That at least twice a month an instruction on Christian doctrine is given to the lay brothers and servants, accommodated to the needs of their condition of life, and that, especially in local organizations, pious exhortations are addressed to all the members. Canon 509, 355. Every 5 years, or more frequently if the constitutions so demand, a report must be sent to the Holy See by the abbot primus, by the superior of a monastic congregation, and by the supreme head of any religious organization of papal law, concerning the state of the organization, signed by the general and his council, and, in case of a congregation of religious women, also by the bishop of the place where the superior general and her council reside. Canon 510, 356. The major superiors on whom the constitutions put the obligation of visiting at stated times all the houses subject to them, must attend to this duty personally if they can, or otherwise through delegates. Canon 511, 357. The local ordinary must, either himself or through another, visit every 5 years, 1. Each monastery of nuns with solemn vows which is subject to him or immediately subject to the Holy See. 2. Each house of the diocesan congregations of both men and women. He must within the same time also visit, 1. The monasteries of nuns with solemn vows subject, superiors and chapters 93, 2 regulars, to inquire about the observance of the law of enclosure, and also concerning the rest of the religious life if the regular superior did not hold any visitation within the last 5 years. 2. Each house of clerical congregations of papal law, even those enjoying exemption, the visitation to extend only to the church, sacristy, public oratory, and places where confines are heard. 3. Each house of local congregations of papal law, the visitation to embrace not only those points mentioned in the preceding number, but also all other affairs concerning internal discipline. Canon 618 provides, however, that these congregations are not subject to visitation in regard to the economical affairs of the community. The administration of goods and property shall be conducted according to Canons 532-535. Canon 512, 358. The visitor has the right and duty to ask any of the religious, whom he thinks according to his own judgment that he should ask, to obtain knowledge of those things that are within the scope of the visitation. All religious have the duty to answer truthfully, and superiors are not allowed to dissuade them from this obligation, or in any other way to frustrate the purpose of the visitation. From the decrees of the visitor there is allowed an appeal in devolutivo only, which means that the orders have to be obeyed in the meantime. If the visitor proceeds by way of a canonical trial, there is opened an appeal in suspensive, which suspends the orders of the judge. Canon 513, 359. In all clerical religious communities the superior has the right and the duty, either in person or by another, to administer the viaticum and extreme unction to the professed, the novices, and to others who live day and night in the religious house, either as servants or for the purpose of education, or as guests or convalescents. In the house of nuns with solemn vows the ordinary confessor, or the one who takes his place, has the same right. In other lay congregations and orders this right and duty belongs to the pastor, or to the chaplain to whom the ordinary has given full parochial powers, according to Canon 464, 2. Concerning funerals of religious, from the various 94 the new canon law. Canons dealing with this question the general rule can be deducted that he who has the right to minister the last sacraments, also has the right to bury those to whom he ministered the last rites. Cf. Canons 1221 and 1230, 5. Canon 514, 360. Merely honorary titles of dignities and offices are forbidden, but if the constitutions allow it, Titles of major offices which a religious has actually held in his own order are tolerated. Canon 515, 361. The Supreme Superior of a religious organization or of a monastic congregation, and the Superior of a Domus Formata, must have their counsel, the consent or advice of which they need in various affairs, according to the regulations of the constitutions and the common law. There should also be economy or procurators for the administration of the temporal goods, an economus concurrens who has charge of the administration of goods for the entire order or congregation, a provincial economist for the province, a local economist for each individual house. All these shall exercise their office under the direction of the respective superior. The general and the provincial are not allowed to have the office of economist. The office of the economist can be combined with that of local superior, if necessity demands, but it is preferable to have a separate official for the administration. If the constitutions are silent about the manner of electing the economist, the major superior and his council may elect him. Canon 499, 362. Every religious organization of men approved by the Holy See shall have a procurator general who is to be designated according to the Constitution. His office is to transact affairs of his order with the Holy See. He shall not be removed before, according to the constitutions, the term of his office expires, without consulting the Holy See. Canon 517, Chapter 2. Confessors and Chaplains. 363. In every clerical order or congregation there shall be appointed for each house several, lawfully approved, confessors and chaplains. 95. Confessors, in proportion to the number of religious, with the faculty, 2. There is question of exempt religious, to absolve the religious also from the reserved cases of the order. Religious superiors who have the power to hear confins may, provided they observe the laws, hear the confins of those of their subjects who of their own free will ask to be heard, but without a grave reason this should not be done habitually. The superiors must beware of inducing, either by themselves or through others, any of their subjects by force or fear, or by importune urging, or in any other way, to come to them for confession. Canon 516, 364. The regulations of constitutions to the effect that the religious are to make their confession at stated times, to certain specified confessors, remain in force. However, if a religious, even of an exempt order, for the peace of his conscience makes his confession to a priest approved by the bishop of the diocese where the confession is made, even though such priest be not appointed by the superior of the order for the confessions of religious, the confession is valid and licit. All contrary privileges of orders, by which their subjects could not validly confess to a priest not approved for their confessions by the order, are hereby revoked. The priest thus chosen by a religious for his confession can absolve the penitent also from sins and censures reserved in the order. Canon 519, 365. In each house of religious women there should be appointed only one confessor for the whole community, unless on account of the large number of religious, or for any other just cause, 2 or more are deemed necessary. If any sister, for peace of soul or greater progress in spiritual life, ask for a special confessor or director, the ordinary should readily grant the request, but he should watch that no misuse is made of this concession. If abuses creep in, the bishop shall eliminate them, saving the liberty of conscience. Canon 520, 366. Each community of women shall have an extraordinary confessor who shall go to the convent 4 times a year, on which occasions all the sisters shall go to him, at least to receive his blessing. 96. The new canon law. The local ordinaries shall appoint several priests in the vicinity of each convent who may be called to hear the confins of sisters in particular cases, without being required to get the faculties each time. If a sister asks for any of these priests, no superioress is allowed, either by herself or through another, either directly or indirectly, to inquire for the reason, nor to refuse the request in words or actions, or to show dislike in any way. Canon 521, 367. If, notwithstanding the concessions of the 2 foregoing canons, a sister goes for her peace of conscience to any confessor approved by the local ordinary, in any church, public or semi-public oratory, the confession is licit and valid. Any privilege to the contrary of orders and congregations is revoked. The superioress cannot forbid the sisters to go to confession outside the convent, nor is she allowed to inquire about it, nor are the sisters obliged to tell her. Canon 522, 368. Whenever a sister is seriously ill, even though there be no danger of death, the sick sister may call any approved priest of the diocese to confess to him, even if he is not one of the particular confessors appointed by the bishop, according to Canon 521. 2. During illness, sisters may confess to such a priest as often as they desire, and the superioress cannot, either directly or indirectly, forbid it. Canon 523. It may be noted here that in the various canons speaking of a confessor to whom sisters may confess outside the convent, the code says that they should be a probati pro mulierum confinibus, which we have translated as approved for confessions / because it is not the custom in the United States to approve a priest for confessions of men only, whereas in some other countries such a limited approval is at times given. Canon 876 declares, however, that special approval is necessary to validly hear the confessions of sisters in their own convents. From this rule, Canon 523 allows an exception for cases of sickness. 369. The bishop should appoint for each community of women an ordinary and an extraordinary confessor from the secular clergy, or also from the religious with the permission of their superior. The confessor should be a priest who has, confessors and chaplains 97, no jurisdiction in the external form over the sisters, and he should be 40 years of age or over unless the bishop for good reasons dispenses with the requirement of age. The ordinary confessor cannot be made the extraordinary confessor, nor can he be again appointed as ordinary except after at least 1 year from the expiration of his term. With the exception mentioned in Canon 526, the extraordinary confessor can immediately when his term as extraordinary expires be made the ordinary confessor. The ordinary and extraordinary confessors of religious women should not in any way interfere in the internal or external government of the community. Canon 524, 370. If a house of religious women is under the immediate jurisdiction of the local ordinary, the latter chooses both the ordinary and extraordinary confessors. If the house be subject to a regular superior, he presents the confessors to the ordinary who alone can approve them, and in case this superior neglects to present confessors, the bishop chooses them himself. Canon 525, 371. The ordinary confessor should not exercise his office for more than 3 years. The bishop may, however, reappoint him for a second and third term if on account of scarcity of priests for this work he cannot easily appoint new ones, or when the majority of the sisters, by secret vote in which every sister has a right to cast a ballot, express the wish to retain the confessor. Those sisters who dissent must be allowed to go to another confessor. Canon 526, 372. The local ordinary may, for a grave reason, remove both the ordinary and extraordinary confessor, even if the convent is subject to a regular superior and the confessor be a regular, nor is the bishop bound to give any reason for the removal except to the Holy See when requested. He must, however, notify the regular superior, if the sisters are subject to him. Canon 527, 373. In houses of local religious orders or congregations of men, extraordinary and ordinary confessors should likewise be appointed according to the rules of Canons 874, 1, and 875, 2. If a religious asks for a special confessor, the superior shall not inquire for the reason, nor show dislike for the request. Canon 528, 98. The New Canon Law, 374. If there is question of local non-exempt religious, the local ordinary has the right to designate the priest for the sacred ministry and for the preaching to the community. If they are exempt, the regular superior designates this priest. In default of the superior to designate a priest, the ordinary supplies. Canon 529, 375. Religious superiors are strictly forbidden to induce their subjects in any way to manifest their state of conscience to them. The subjects, however, are not forbidden to manifest of their own free will and choice their conscience to the superiors. On the contrary, it is proper that they should approach their superiors with filial confidence, and if they are priests, to reveal to the many doubts and anxieties of their conscience. Canon 530. Chapter 3. Temporal Goods and Their Administration. 376. Not only the order or congregation, but also the province and the individual house, are capable of acquiring and possessing temporal goods, together with fixed revenues and endowments, unless such capacity is excluded or restricted by their rule or constitutions. Canon 531. 377. The goods of the order, of the province and individual houses, are to be administrated according to the constitutions. Expenditures and legal acts of ordinary administration can be validly made by the superior, and also within the limits of their office by the officials designated for this purpose by the constitutions. Canon 532. 378. For the investment of money, the previous consent of the bishop, besides compliance with the regulations of the constitutions, is required in the following cases. 1. The superioress of nuns of solemn vows and of diocesan congregations needs this consent for any investment of money. If the monastery of solemn professed nuns is subject to a regular superior, also his consent is required. 2. The superioress in a congregation of papal law, if temporal goods and their administration. 99. The money to be invested constitutes the dowry of professed sisters, according to Canon 549. 3. The superior, or superioress, of any religious congregation, if real estate has been donated or given by last will to the religious house for the purpose of divine worship, or for works of charity to be carried on in that place. 4. Any religious, even of an exempt order, if the money was given to the parish or mission, or to the religious on account of the parish or mission. 5. When the investment is changed, the bishop's consent is likewise required. Canon 533. 379. When there is question of disposing of objects of great value, or of a sum of money exceeding $6,000, or of contracting debts and obligations above the said sum, the contract is invalid unless the beneplacitum of the Holy See was first obtained. In smaller amounts, the permission of the superior, with the consent given by his council in secret vote, is sufficient. The constitutions determining the extent of power of the general, the provincial and local superiors, in sums below $6,000 are to be observed. Moreover, in the case of religious women with solemn vows, and of diocesan sisters, the written consent of the bishop is demanded, and in addition the consent of the regular superior is required by a house of nuns of solemn vows under his jurisdiction. In the petition for consent to contract debts, or any other obligations, there must be stated the amounts allowing of debts and obligations previously contracted by the house, province or order for which respectively permission is asked, otherwise the obtained permission is null and void. Canon 534. 380. In every monastery of nuns with solemn vows, even exempt ones, 1. The superioress shall once a year, or more frequently if the constitutions so demand, give an account to the bishop of her administration, and also to the regular superior, if the house is subject to him. 2. If the ordinary does not approve of the administration, he may employ proper means to remedy the defect, removing even, if necessary, the economists and other administrators. If the house is subject to the regular superior, the bishop shall add 100 the new canon law, admonish the superior to remedy the deficiency, and if he does not attend to it, the bishop has the right to take the matter in hand. In all other houses of religious women an account must be given to the ordinary of the administration of goods that constitute the dowry of the sisters. This must be done at the visitation of the ordinary, and even more frequently if the bishop thinks this necessary. The ordinary shall always have the right, 1. To inquire into the financial standing of the religious houses of diocesan sisterhoods. 2. To demand an account of the administration of real estate and legacies given to parishes or for works of religion and charity in a place. Canon 535. 381. If a legal body, the order as such, the province, or the individual house, has contracted debts and assumed obligations, even with the permission of the superior, the respective body is held to its obligations. If a regular has contracted any liability with the permission of his superiors, the community whose superior gave the permission is held. If a religious with simple vows has contracted any debts, he is himself liable, except in case he acted for the community with the permission of the superior. If a religious made a contract without any permission of the superiors, he is personally responsible and the order, province or house cannot be held for it. In all cases the one who suffered by the contract shall have the right to sue for damages. The superiors shall take care not to permit the contracting of debts unless it is certain that from the ordinary revenue the interest on the loan can be paid, and that in not too long a time a mortgage can be paid off. Canon 536, 382. Donations from the goods of a house, province or order shall not be permitted, except by way of alms or other just cause, with the permission of the superior and in accordance with the constitutions. Canon 537, Title XL, Admission into a religious community. 383. Admission to the religious life is open to any Catholic who is not under any legal impediment, who has the postulate, novitiate 101, right intention, and is capable to fulfill the duties of the religious life. Canon 538, Chapter 1, Postulate. 384. In all organizations with perpetual vows the women, and in orders of men the lay brothers, must stay fully 6 months as postulants before they can be admitted to the novitiate. In religious communities with temporary vows, their constitutions are to be observed in regard to time and necessity of the postulate. The major superior may prolong the time of the postulate for, at most, another 6 months. Canon 539, 385. The postulate may be spent either in the house of novitiate or in another house in which the religious life is accurately observed according to the constitutions and under the special direction of a religious of tried virtue. The postulants shall wear plain clothing which must be different from that of the novices. In monasteries of nuns with solemn vows the postulants are held to the law of enclosure. Canon 540, 386. The postulants shall, before they begin the novitiate, make a retreat for at least 8 complete days and, according to the judgment of the confessor, a general compscion of their whole life. Canon 541, Chapter 2, Novitiate. Article 1. Conditions for admission. 387. Besides the regulations of the foregoing canons about the postulate, and other conditions imposed by the constitution of each religious organization, the following shall be observed. 1. Admission into the novitiate is invalid. 1. If one has adhered to a non-Catholic sect. 2. If one has not the required age. 3. If one was compelled to enter by grave fear, or by 102 the new canon law, deceit, or by force, or if a superior thus constrain receive the individual. 4. If one is married, for the duration of the marriage. 5. If one actually is, or has been, a professed member of any religious body. 6. If one is subject to penalty for grave crime of which he has been, or may be, accused. 7. If one is either a residential or titular bishop, though he has been as yet only designated as such by the Pope. 8. If one is a cleric who, by the law of the Holy See, is held by oath to serve the diocese or mission, for such times as the oath lasts. In countries subject to the propaganda the clerics are usually ordained under the explicit promise to serve the diocese or mission. In some missionary colleges the clerics take the oath to serve the missions for a definite number of years, etc. 2. Illicitly are received. 1. Clerics in major orders who enter without the knowledge of their bishop, or against the will of the bishop, who has the right to keep them from entering if it would entail great harm to souls and the bishop cannot in any way prevent such hardship. The Church wants religious life to be of access to all, and she has declared repeatedly that even a cleric educated at the expense of the diocese has the right to embrace religious life, unless he has taken the oath referred to above, and seminaries where the Holy See has authorized the taking of such an oath. When in great need of priests, the bishop may detain a cleric for a while, but as soon as he is not needed, he must be permitted to take up the religious life. 2. Those who have debts to pay and cannot settle the obligation. 3. Those who are held responsible for positions of trust or who are implicated in any other secular business, by reason of which lawsuits and other annoyances may come to the religious. 4. Children whose father, or mother, grandfather or grandmother, are in great want and in need of the help of Novitiate 103. This child, or whose parents need their help for the bringing up and education of younger children. 5. Those who suffer from irregularity or any other impediment to the priesthood, are forbidden to be admitted as future candidates of the priesthood. 6. Catholics of an Oriental rite admitted to a religious community of the Latin Rite without the permission of the Congregation for the Oriental Church. Canon 542, 388. The right of admitting candidates to the novitiate and to subsequent profession, either temporary or perpetual, belongs to the major superiors with the vote of the council or the community, according to the regulations of the Political Law or constitutions of each order or congregation. Canon 543, 389. 1. In every religious community the aspirants without exception must, before they are admitted, submit certificates of baptism and confirmation. 2. In orders and congregations of men the applicants must, moreover, get testimonial letters from the bishop of their birthplace as also from all other bishops in whose dioceses they have lived for more than one, morally speaking, continuous year after their completed 14th year of age. Any privilege exempting from this obligation is hereby revoked. 3. If there is question of admitting those who have been in any seminary or college, or in the postulate or novitiate of another order or congregation, the testimonials of the rector of the seminary or college, after consulting with the ordinary, or at the major religious superior are required, in addition to the testimonials spoken of in the preceding paragraph. 4. For the admission of clerics there are required only the testimonials of ordination and of the bishops in whose dioceses they have lived after ordination for more than one morally continuous year, as also of the rector of the seminary where they studied. 5. A professed religious who by permission of the Holy See joins another order, needs only the testimonials of the major superior of the former order. 104. The New Canon Law. 6. In addition to these testimonials the major superiors who have the right to receive applicants can demand of them such other testimonials as seem necessary or useful for the purpose. 7. Women should be received only after accurate investigation as to their character and disposition. In case they have been in a college, etc., the testimonials decreed by 3 must be obtained. Canon 544, 390. 1. He who has to write the testimonials prescribed by these canons, shall issue them within 3 months from the time they are asked for. He shall not give them to the applicants but to the religious superiors and shall append his seal. In case of seminarians, college students, and former postulants or novices in another order, the superior or rector shall confirm the testimonial by oath. 2. If he of whom are requested testimonials thinks that on account of serious reasons he cannot answer, he shall within 3 months explain the reasons to the Holy See. 3. If he answers that the applicant is not sufficiently known to him, the religious superior shall supply the testimonials through other accurate investigation and trustworthy reports. If the bishop, rector of the seminary, etc., does not answer at all, the religious superior who needs the testimonial shall inform the Holy See about the failure of receiving an answer. 4. The testimonials are to deal with the origin, manners, talents, character, reputation, studies, whether the candidate is under irregularity or other canonical impediment, whether the parents are in need of his services, and, in case of those who are in a novitiate or in a seminary or college, why they were dismissed or why they left of their own accord. Canon 545, 391. All those who receive the above-mentioned information are strictly bound to observe secrecy as to the knowledge they secured and from what persons it was obtained. Canon 546, 392. 1. In monasteries of women with solemn vows the postulant must bring the dowry required by the constitutions or determined by lawful custom. Novitiate 105. 2. This dowry shall be given to the monastery before the reception of the habit, or shall at least be made certain in legal form recognized by the civil law. 3. In congregations of women with simple vows, the existing customs concerning the dowry shall be observed. 4. The prescribed dowry cannot be remitted, either in whole or in part, without an indult of the Holy See, if there is question of a community of papal law, and not without the permission of the ordinary, if a diocesan congregation. Canon 547, 393. The dowry is acquired irrevocably by the ministry or religious congregation by the death of the religious, even though she should have taken only temporary vows. Canon 548, 394. After the first profession of the religious, her dowry is to be placed by the superioress, acting with her counsel, in safe, lawful and fruitful investment. The bishop has consent is required, and also that of the regular superior if the nuns are under his jurisdiction. It is absolutely forbidden to expend the dowry in any way before the death of a sister, not even for the building of the convent, or the reduction of a debt. Canon 549, 395. The dowry must be carefully administered at the monastery or habitual residence of the Mother General or Mother Provincial. The ordinaries should specially watch over the conservation of dowry and demand an exact account at the time of the visitation. Canon 550, 396. The dowry of a sister, either of simple or of solemn vows, who for any reason leaves the religious life, must be returned to her entirely, without the interests which have already matured. If a professed sister goes, by indult of the Holy See, over to another order, the new order has the right to the income from the dowry during the novitiate, and upon profession in the new order the dowry itself must be turned over. If she is transferred to another monastery, there is understood such monastery as is of the nature of an abbey, the dowry belongs to that monastery from the time of the transition. Canon 551, 106. The New Canon Law, 397. 2 months at least before the reception of novices, or the profession of either temporary or perpetual, simple or solemn vows, takes place in communities of women, even exempt ones, the superioress must notify the bishop. The bishop, or in case of absence or other impediment, the priest delegated by him, shall at least 30 days before the reception examine each of those to be received to the novitiate, or admitted to profession, whether she of her own free will enters the novitiate or makes, or renews, her profession. Canon 552. Article 2. Education of the novices. 398. The novitiate begins with the reception of the habit, or in such other way as prescribed by the constitutions. Canon 553, 399. The house of novitiate shall be erected according to the constitutions. If, however, there is question of orders and congregations approved by Rome, the permission of the Holy See is required for the erection of the novitiate. There cannot, as a rule, be several novitiates in one and the same province, if the organization is divided into provinces. But if there should be grave reason for having several novitiates, a special indult of the Holy See must be obtained. The superiors must place in the house of novitiate only such religious that will give a good example of religious discipline. Canon 554, 400. Besides the other conditions required by Canon 542, for validity of the novitiate, the following points are demanded for a valid novitiate. 1. The candidate must be at least 15 years of age. 2. He must stay in the novitiate for 1 continuous and complete year. 3. He must stay in the house of novitiate. If the constitutions prescribe a longer period for the novitiate, this is not necessary for validity, unless the constitutions explicitly demand it under pain of invalidity. Canon 555, 401. The novitiate is interrupted so that it must be made over again, if the novice after dismissal by the superior, novitiate 107, has actually left the house, or if without permission he left the house with the intention not to return, or if for any reason, even with the permission of the superior, he remained outside the house of novitiate for over 30 days, either continuous or otherwise. If the novice remained outside over 15 days, but not over 30, either with the permission of the superior or by force of circumstances, as for instance, fire, flood, etc., and continued under the obedience of the superior, it is necessary for validity to supply as many days as the novice was away, even though he was absent only a day or 2 at a time. If all the days a novice was absent from the novitiate do not amount to over 15 days, the superior may demand that they are supplied, but this is not required under pain of invalidity. The superior must not give permission to a novice to remain outside, except for a serious reason. If the novice is transferred by his superiors from one house of novitiate to another of the same order or congregation, the novitiate is not interrupted. Canon 556, 402. During the entire year of the novitiate the novice shall wear the habit prescribed by the constitutions, unless the peculiar circumstances of a place demand otherwise. Canon 557, 403. In religious communities where there are two classes of novices, the novitiate made for one class is not valid for another. For instance, in orders where some novices are destined for the priesthood, others for lay brothers. Canon 558, 404. A master of novices is to be appointed for the training of the novices. He should be at least 35 years of age, 10 years professed, counting the years from his first profession, possessed of the qualities required for his office, and in clerical religious communities the master of novices must be a priest. If on account of the large number of the novices, or for another just cause, it seems advisable to have a submaster of novices, he shall be under the immediate authority of the master in regard to the management of the novitiate. The submaster should be 30 years of age or over, at least. 108. The New Canon Law. 5 years professed, and possess other necessary qualifications for high-s office. Both master and submaster of novices must be free from all offices and duties which would interfere with the government of the novices. Canon 559, 405. The master and submaster of novices shall be elected according to the constitutions, and, if these fix the term of office, the master and submaster should not within their term be removed from office, except for a grave and just reason. They may be re-elected. Canon 560, 406. The government of the novitiate belongs exclusively to the master of novices, and all others are forbidden to interfere, except those superiors to whom the constitutions give that power, and the visitor. In reference to the discipline of the entire community, master and novices alike are subject to the local superior. The novices are under the authority of the master and of the superiors of the order and are held to obey them. Canon 561, 407. The master has the serious duty of zealously instructing the novices in the practices of religious life, AC according to the constitutions and the rules of Canon 565. Canon 562, 408. During the year of novitiate the master shall make report of the conduct of the individual novices to the chapter, or the major superior, according to the regulations of the constitutions. Canon 563, 409. The novitiate must, as far as possible, be separated from that part of the house where the professed live, and without special reason and the permission of the superior or the master they shall have no communication with the professed religious, nor these with the novices. The novices for the lay brotherhood shall have assigned to them a separate place. Canon 564, 410. The master of novices must instruct the novices in the rule and the constitutions, in the 3 vows and the corresponding virtues, in prayer and meditation, in pious exercises conducive to the acquisition of virtue, and in the suppression of faulty habits. The lay brother novices should moreover be thoroughly, Novitiate 109, instructed in Christian doctrine, for which purpose a special instruction shall be given to them at least once a week. During the year of novitiate the novice, if a priest, shall not be appointed to preach, or to hear confessions, or to attend to services outside the house. The novices should not engage in regular courses of studies of letters, sciences or arts. The lay brother novices may within the religious community attend to the duties of lay brothers, not, however, as principal brother in charge of the various workshops, for instance, and only in so far as such work does not interfere with the exercises prescribed for them in the novitiate. Canon 565, 411. The confessor of the novices in communities of women is to be appointed according to Canons 520-527. In communities of men, saving the law of Canon 519, the following shall be observed. 1. According to the number of novices there should be appointed one or more ordinary confessors, provided the master of novices does not hear their confessions, which Canon 891 ordinarily forbids. 2. The ordinary confessors, in clerical religious communities, must be residents of the house of novitiate. In local religious communities they must frequently come to the house of novitiate to hear the confessions of novices. 3. Besides the ordinary confessors, several other confessors should be appointed to whom the novices may freely go in particular cases, and the master should not show displeasure. 4. 4 times a year at least the novices shall have an extraordinary confessor, whom you all novices must approach to receive his blessing, if perhaps they do not want to confess to him. Canon 566, 412. The novices enjoy all privileges and spiritual favors granted to the order or congregation. If they die as novices, they have a right to the suffrages prescribed for professed members. The novices shall not be promoted to orders during the novitiate. Canon 567, 413. If the novice during the year of novitiate renounces in any way his right to benefices, or goods, or 110 the new canon law, property, such renunciation is not only illicit but invalid by law. Canon 568, 414. Before taking simple vows, either temporary or perpetual, the novice must see the administration of his temporal goods to a person of his choice and also dispose of their use and revenue at pleasure, unless the constitutions of his order have other regulations concerning the use and revenue of the goods of novices. If a novice did not make any arrangement concerning temporal goods because he had none at the time, and afterwards acquired some, or if he made such disposition, but acquired more goods afterwards, he shall notwithstanding his simple profession dispose of the goods according to the foregoing paragraph of this canon. Novices in religious congregations can, before taking temporary vows, freely dispose by last will of goods both actually possessed, and those they may chance to receive in future. Novices of orders with solemn vows cannot dispose by last will, or any other way, of goods that may after solemn profession come to them by inheritance or other right, for from the moment of solemn profession the order enters into all the rights of the professed, or the Holy See if the order is incapable of possessing. Canon 569, 415. No compensation can be asked for the expenditures of keeping a novice in the novitiate, except what the constitutions perhaps demand for food and clothing, or what was agreed upon for these purposes by explicit contract. Whatever the applicant brought along, and has not ac to all consumed by use must be returned to the individual if he does not make profession and returns to the world. Canon 570, 416. The novice is free to leave the community, and the superior or the chapter, according to the constitutions, may dismiss the novice for any just cause without obligation on the part of the superior or chapter to tell the novice the reason why he was dismissed. When the year of novitiate is completed, the novice, if judged qualified, shall be admitted to profession, otherwise he must be dismissed. If there exists some doubt as to his religious profession. 111. Fitness for profession. The major superiors may prolong the time of novitiate for not longer than 6 months. Before taking vows, the novice shall make a retreat for at least 8 full days. Canon 571, Chapter 3, Religious Profession. 417. For the validity of any religious profession the following is required. 1. The novice must have the requisite age according to Canon 573, namely, at least 16 years. 2. He must be admitted to profession by the legitimate superior, he, namely, who has by the constitutions of the respective order or congregation the right to admit to profession, or to delegate others. 3. A valid novitiate must have preceded, according to the conditions of Canon 555. 4. The profession must be made without force or grave fear or deceit. 5. The profession must be explicit. Up to the present time there was no general law of the Church demanding an explicit profession under pain of invalidity, and an implicit profession was recognized under certain circumstances, unless the constitutions of an order or congregation positively rejected implied profession. 6. The profession must be made into the hands of the superior whom the constitutions authorize or his delegate. For the validity of the profession of perpetual vows, both simple and solemn, it is, moreover, required that the simple, temporary profession proceeds, according to Canon 574, Canon 572, 418. Whosoever wants to make religious profession must be fully 16 years of age if there is question of temporary vows, and 21 years in the case of perpetual profession either solemn or simple. Canon 573, 419. In every order, both of men and women, and in every congregation which has perpetual vows, the novice must in the house of novitiate take temporary vows for 3 years, or for a longer period if he will not yet be 21. 112. The new canon law. Years of age after 3 years of temporary vows. If the constitutions demand yearly profession, They are to be followed. An exception from this rule is made only in case of transition of a perpetually professed member to another order, of which Canon 634 treats. In this canon there are two important points which are new in the legislation of the Church. Up to the present time the clerical novices in many orders took simple perpetual vows immediately after the novitiate. By the present law all novices without distinction must take temporary vows for at least 3 years. Secondly, they must be fully 21 years of age in order to take solemn vows in religious orders, and simple perpetual vows in congregations. The vows up to 21 years of age must necessarily be temporary, for only after those years does the code habilitate a person to take perpetual or solemn vows. The superior who has authority to admit members to profession may prolong the period of the temporary vows by making the religious again take temporary vows, but not for more than another term of 3 years. Canon 574, 420. After the time of the temporary vows has expired, the religious may either return to the world, according to Canon 637, or make the perpetual profession which is either simple or solemn, according to the constitutions of various religious organizations. If during the period of the temporary vows the religious is not judged worthy to take solemn vows he may be dismissed in the manner defined by Canon 647. The vote of the council or the chapter for the first, temporary profession, is deliberative, which means that the superior is not allowed to act against it. For the following, perpetual profession both simple and solemn it is merely consultative, which does not oblige the superior to act according to the vote. Canon 575, 421. In the making of the profession the rite prescribed by the constitutions shall be observed. The record of the profession shall be signed by both the religious who made the profession, and the one who received the profession. Moreover, when there is question of solemn profession, the superior who officiated shall inform the pastor. Religious profession 113. Of the place where the professed was baptized, as Canon 470, 2, demands. Canon 576, 422. When the time of the temporary vows expires, there should be no delay in the renewal of the vows. Faculty is given to the superiors to allow for a good reason that the renewal of temporary vows may be anticipated for some time, not over 1 month. Canon 577, 423. The religious who are under temporary vows in orders and congregations, according to Canon 574, 1. Enjoy the same indulgences, privileges and spiritual favors as the religious in perpetual or solemn vows, and if they die in temporary vows they have the right to the same suffrages as the other professed members. 2. They are held to the observance of the rule and constitutions, but, if the order has the obligation of the choir, they are not held to the private recitation of the divine office, unless they are in sacred orders, or the constitutions impose the private recitation. 3. They have neither active nor passive vote, unless the constitutions explicitly state otherwise. The time, however, prescribed for having active and passive vote, for instance, the requirement of 10 years of profession for being elected to an office, is counted from the first profession, if the constitutions determine nothing on this point. Canon 578, 424. The simple profession, both temporary and perpetual, renders actions against the vows illicit, not invalid, unless the contrary has been explicitly decreed. The solemn profession, however, renders actions contrary to the vows also invalid, if they can be invalidated by their nature. Canon 579, 425. Every simple professed religious, whether in temporary or perpetual vows, retains the proprietorship of his goods and the capacity to acquire other goods, within the limits of Canon 569, unless the constitutions limit the capacity to possess, or to acquire, whatever the religious acquires by work, or what is given him in consideration of his being a religious. He acquires for the community any change which the professed religious wants to make. 114. The new canon law concerning the administration, use, etc., of his goods, spoken of in Canon 569, 2, he cannot make of his own free will, unless the constitutions allow this, but he needs the permission of the supreme head of the order or congregation. In communities of nuns with solemn vows the permission of the bishop, and of the regular superior also if the nuns are under his jurisdiction, is demanded. Such change cannot be allowed if it is made for the benefit of the religious community in notable quantity. By the very fact of abandoning the religious life, all cession of rights and other dispositions are annulled, and the former religious regains his rights to the goods of which he had the ownership. The Church forbids that simple professed religious give up the ownership of the goods they have, for the reason that through loss of vocation or other reasons it may become necessary to dispense a religious from his vows, in which case he will need again what goods he had. Canon 580. 426. The simple professed religious cannot validly renounce rights of proprietorship of his goods until 2 months before solemn profession, at which time he must, under condition that solemn profession is made, renounce all goods which he actually has in favor of any persons he prefers. Special indults given by the Holy See to orders of solemn vows that solemn professed members retain proprietorship of the goods they have, are to remain in force. When solemn profession has been made, the formalities of the civil law necessary to make the renunciation of the goods of the professed valid in the civil courts should be complied with. Canon 581. 427. After solemn profession, saving special indults of the Holy See, all goods which may in any way come to the individual religious, 1. Belong to the order, or province, or house, according to the constitutions, if the order is capable to possess goods. 2. In an order incapacitated by canon law to possess, the Holy See assumes the title of ownership. Canon 582. 428. The simple professed religious in congregations are not allowed, 1. To give away or make donation of their goods. 2. They may not change the last will made according to Canon 569. 3. Without permission of the Holy See. Studies in Clerical Religious Communities 115. Or, if the matter is urgent and there is no time for recourse to Rome, without the permission of the major superior of the congregation, or at least the local superior if the major superior cannot be reached in time. Canon 583. 429. After 1 year from the making of any profession, parochial benefices which the professed religious possessed become vacant, other benefices after 3 years. Canon 584. 430. The religious who takes perpetual vows, whether simple or solemn, thereby loses his own proper diocese he had when in the world. Canon 585. 431. The profession which was invalid on account of some external impediment does not become valid by any subsequent acts. It is necessary either to obtain a censatio from the Holy See, or to make the profession over again after the impediment has ceased and the religious has come to the knowledge of the nullity of his profession. If the profession was invalid merely on account of want of internal consent, it is validated by giving consent, provided the consent of the order or congregation has not been revoked. If there is serious doubt as to the validity of the profession, and the religious refuses either to ask for a censatio ad coelum from the Holy See, or to make the profession over again, the matter shall be laid before the Holy See. Canon 586. Title 12. Studies in Clerical Religious Communities. 432. Every clerical religious organization shall have houses of study approved by the General Chapter or the superiors, and, according to Canon 554, 3, only such religious that are perfect in their religious life shall be placed in those houses. In the house of study the community life must be perfect. Otherwise the students cannot be promoted to orders. If the province has no properly equipped houses of study, or though it has them, access to them has become difficult, the religious students may be sent to a well-equipped house of studies of another province, or another. 116 The New Canon Law. Order, or to the Episcopal Seminary, or to a Catholic university. Religious who are sent to a distant place for study are not allowed to board in private houses, but must live either in a nearby house of their order, or with another religious community of men, or in a seminary or other institution in charge of priests and approved by the ecclesiastical authority. Canon 587. 433. During the entire course of studies the religious shall be under the special care of a prefect or master, who shall lead them on in religious life by timely admonition and instruction. The prefect or master must have the same qualifications as required in the Master of Novices by Canon 559, 2, 3. The superiors shall see to it that the regulations of Canon 595 for all religious houses are most perfectly observed in the house of studies. Canon 588, 434. The religious, after due instruction in the inferior studies, shall engage in the study of philosophy for at least 2 years, in theology 4 years, following the teaching of St. Thomas, according to Canon 1366, 2, and the instructions of the Holy See. During the time of studies no duties should be imposed on professors and students which will interfere in any way with the studies. The general, and in particular cases other superiors, may exempt professors and students from some community exercises and also from the choir, especially the midnight office, if they judge it necessary. Canon 589, 435. The religious priest shall each year, for at least 5 years after the completion of the course of studies, pass an examination before learned fathers appointed for that purpose. Those who teach sacred theology, canon law or scholastic philosophy are exempted, and the major superiors may exempt others for a grave reason. Canon 590, 436. In every large community, domus formata, at least there shall be held once a month, or more frequently, a discussion on moral or liturgical cases to which may, at the discretion of the superior, be added a sermon on dogmatic and kindred subjects. All professed clerics who in duties and privileges of religious 117 gauge in the study of theology, and the priests of the community must assist at these conferences, unless the constitutions rule otherwise. Canon 591, Title 13, Duties and Privileges of Religious. Chapter 1, Duties. 437. All religious are held to the common obligations of the clergy outlined in Canons 124-142, unless the context or the nature of the law argue the contrary. Canon 592, 438. All religious, superiors as well as subjects, must not only faithfully keep the vows which they have taken, but also live according to the rules and constitutions proper to their order or congregation, and in this manner strive after the perfection of their state. Canon 593, 439. In every community the community life shall be followed by all, also in those things pertaining to food, clothing and furniture. Whatever is acquired by religious, not excepting the superior, according to Canons 580, 2, and 582, n. 1, must be added to the goods of the order, province, or house, and any money, deeds, etc., must be deposited in the common treasury. The furniture of the religious must be in harmony with the poverty they have vowed in their profession. Canon 594, 440. The superiors shall see to it that all religious, 1. Make a retreat each year. 2. Are present at the daily Mass, and perform the meditations and other spiritual exercises prescribed by rule and constitutions. 3. Make their confession at least each week. The superiors shall promote frequent and daily communion. Frequent and even daily communion must be freely allowed to religious who are properly disposed. If a religious after the last confession has given great scandal to the community, or has committed an external 118 the new canon law mortal sin, the superior can forbid that person to go to Holy Communion until he has gone again to confession. If any religious community, both of simple and solemn vows, has regulations or constitutions in which the days for Holy Communion are prescribed, such regulations shall have merely the force of directive rules. Canon 595, 441. All religious shall wear the habit of their order or congregation in the house as well as outside, unless AC according to the judgment of the major superior, or in case of necessity, of the local superior, an exception should be made. Canon 596, 442. The papal enclosure must be observed in all houses of religious men and women with solemn vows, even in the small houses or residences. Under the law of enclosure fall the whole house inhabited by the religious, with the gardens and recreation grounds reserved to the religious, the public church with the adjoining sacristy, the hospice for strangers, the parlors, which should as far as possible be near the door of the house, are excepted from the enclosure. The places subject to the law of enclosure shall be plainly indicated by public notices. The major superior or the general chapter, as the constitutions may determine, and in case of nuns with solemn vows the bishop, shall have the right and duty to accurately fix the limits of the enclosure or also to change them for good reasons. Canon 597, 443, within the enclosure of regulars, women of any age, family and state, are forbidden to be admitted under any pretext. Exception from this law is made for the wives and their lady attendants of the highest rulers of nations. Canon 598, 444. If a house of regulars has attached to it a school or college for its own students, or conducts other institutions proper to the order, a separate part of the building should be reserved, as far as possible, for the exclusive dwelling of the religious and subject to the law of enclosure. To the places outside the enclosure set apart for the students or for other purposes of the order, women should not be admitted except for good reason and with permission of the superior. Canon 599, Duties and Privileges of Religious 119, 445. Within the enclosure of nuns with solemn vows no person of whatever sex, age, family, and condition of life must be admitted without the permission of the Holy See. The only exceptions granted are as follows: 1. The local ordinary, or the regular superior, or another visitor delegated by them may at the time of visitation enter the enclosure for the purpose of inspection only, and on condition that at least one cleric or religious of mature age accompany them. 2. The confessor, or the priest who takes his place, may with due precautions enter the enclosure to administer the sacraments or to assist the dying. 3. The highest ruler of the nation with his wife and escort, also cardinals. 4. The mother superior may, with previous general permission of the local ordinary, and the observance of due precautions, admit within the enclosure doctors, surgeons and others whose help is needed. If necessity urges, and there is no time to ask the approval of the bishop for admitting the aforesaid persons, the law presumes permission. Canon 600, 446. No nun with solemn vows is allowed to leave the enclosure without special permission from the Holy See, except in a case of imminent danger of death or other most serious evil. If there is time, the local ordinary must be consulted concerning the reason for leaving the enclosure. Canon 601, 447. The enclosure of nuns with solemn vows must be so arranged that view of the outside world is cut off, and that outsiders cannot look in. Canon 602, 448. The enclosure of nuns, though they be under the jurisdiction of the regulars, is subject to the bishop of the diocese, who can punish all violations of the enclosure, even on the part of the regulars, with ecclesiastical penalties and censures. The enclosure of nuns subject to the regulars is, moreover, under the jurisdiction and custody of the regular superior, who can punish the nuns and his other subjects with 120. The New Canon Law, Ecclesiastical Penalties for the Violation of the Law of Enclosure. Canon 603, 449. In the houses of religious congregations of women, both of papal law and diocesan, the law of enclosure shall be observed so that those only who by law have a right to enter, as specified in Canons 598, 2, and 600, shall be admitted, and others with permission of the superiors for good reason. The regulations of Canon 599 shall be applied also to the houses of religious congregations of men and women. The bishop may for special and serious reasons safeguard the enclosure of congregations with ecclesiastical censures, except for a clerical, exempt congregation. The bishop has, however, the right in all cases to see to the observance of the enclosure, and to correct abuses that might creep in. Canon 604, 450. All those whose duty it is to guard the enclosure shall see to it that the religious discipline and spirit does not suffer by useless visits of outsiders. Canon 605, 451. Superiors shall attend to it that regulations of their own constitutions concerning the going out of subjects, the visiting of seculars, and the visits in the parlor, are faithfully observed. The superiors cannot give permission, outside the cases mentioned in Canons 621-624, to their subjects to live outside the houses of the order, except for a short period. For an absence of more than 6 months, except in cases of study, the permission of the Holy See must be obtained. Canon 606, 452. The superioress and the bishops shall see to it that no sister, except in case of necessity, shall go out of the house without another sister as companion. Canon 607, 453. The superiors should see to it that the religious priests destined for outside work do gladly and willingly help out, at the request of the ordinary or of the pastors, in the sacred ministry wherever they are needed, especially in their own diocese. Religious discipline, however, must not suffer by it. On the other hand, ordinaries and pastors are urged by the Church to avail themselves of the work of the religious, duties and privileges of Religious 121, especially of those in their own diocese, in the sacred ministry, particularly for confessions. Canon 608, 454. If a church at which the religious live, is at the same time a parish church, the rules of Canon 415 shall be applied. In the churches of religious women, either with solemn or simple vows, no parish can be established. The superiors should see to it that the services in their churches do not interfere with the attendance at the catechetical instructions and the explanation of the Holy Gospel in the parish churches. The judgment concerning this question is left to the bishop. This canon has reference to places where the religious have no parish church. Canon 609, 455. In all houses of religious, both men and women, who have the obligation of the choir, the divine office must be said if there are at least 4 choir members who are not actually impeded by lawful impediment. Even fewer members may be bound to say the office in common, if the constitutions so demand it. The Holy Mass corresponding, according to the rubrics, with the office of the day, shall daily be said in all religious houses of men, and also, as far as possible, in those of sisters. In orders of men, and orders of nuns with solemn vows, who have the obligation of the choir, the solemn professed, with the exception of the lay members, shall be bound to recite the divine office privately, if they have been absent from choir. Canon 610, 456. All religious, both men and sisters, may freely write and send letters, without their being subject to inspection, when addressed to the Holy See or the Papal Legate of the country, to the Cardinal Protector of the Order, to their own major superiors, to their own local superior during his absence from the house, and to the local bishop, if they are subject to him, and the nuns who stand under the jurisdiction of the regulars, also to the major superiors of the order. The same religious may likewise receive letters from the aforesaid superiors which no one is allowed to open and inspect. Canon 611, 457. The bishop may command also the exempt religious to have, according to Canon 1345, a brief explanation. 122. The new canon law of the Holy Gospel in the Masses on Sundays, prescribe the ringing of church bells on certain occasions, ordain public prayers, processions, etc., saving the constitutions and privileges proper to each order. Canon 612. Chapter 2. Privileges of the religious. 458. Each religious order or congregation has only those privileges which are either contained in this code or which have been directly granted to each, and for the future all communication of privileges is excluded. The privileges which regulars enjoy belong likewise to the solemn professed nuns of the same order, in as far as they are capable of enjoying them. Canon 613, 459. All religious, not excluding lay brothers and Novemberices, enjoy the privileges of clerics spoken of in Canons 119-123. Canon 614, 460. Regulars, and nuns with solemn vows subject to regulars, are exempt with their novices, houses and churches from the jurisdiction of the bishop of the diocese, with the exception of the cases explicitly mentioned in the law. Canon 615, 461. Regulars who are unlawfully away from their house, even though under the pretext of recurring to their superiors, do not enjoy the privilege of exemption. If a regular has committed a crime outside the religious house and the ordinary has without result admonished the superior to punish him, the ordinary can punish such a religious, even though he was lawfully outside the house when he committed the crime, and has since returned to the house. Canon 616, 462. If disorders have crept into an exempt religious house and the bishop has without result asked the superiors to stop the disorders, the bishop is obliged to refer the matter to the Holy See. The small houses or residences of even the exempt religious remain under the special vigilance of the local ordinary, and if their abuses have crept in which are a scandal to the faithful, the ordinary may in the meantime while await privileges of the religious. 123. Instructions from the Holy See take the steps necessary to end the scandal. Canon 617. 463. Religious congregations with simple vows do not possess the privilege of exemption, unless it has been specially given them by the Holy See. In religious congregations of papal law the bishop is not allowed, 1. To change the constitutions in any way, or to interfere in the administration of the goods and property, except in as far as Canons 533-535 give him the right, 2. To interfere in the internal government and discipline of the religious, except in the cases stated in law. Nevertheless, in lay congregations the bishop has the right to inquire whether the religious discipline is observed according to the constitutions, whether in faith or morals there is fault to be found, whether the enclosure is observed, whether the sacraments are received as frequently as they should. If the superiors, after having been admonished to correct abuses, have not done their duty, he himself may take the matter in hand. If, however, anything of greater importance arises which does not suffer any delay, he may give his orders, but he must report to the Holy See what he has done in the matter. Canon 618. 464. In all matters in which religious are subject to the bishop they may also be punished by him with ecclesiastical penalties. Canon 619. 465. By an indult legitimately granted by the ordinary to the people of the diocese, the religious living in the diocese are also freed from the obligation of the common law from which dispensation was granted, saving the vows and the constitutions of the various orders or congregations. Canon 620. 466. Regulars who are by their institution mendicants and live as such, may in the diocese in which they have a house go begging for alms with the sole permission of their superiors. Outside the diocese they need the written permission of the ordinary of the diocese. This permission the ordinaries of nearby dioceses should not deny, nor recall, except for grave and urgent reasons. If the religious house cannot get sufficient support from the alms collected in its own diocese. Canon 621. 124. The New Canon Law. 467. All other congregations of papal law are forbidden to collect alms without special permission of the Holy See. If they have obtained this permission, they need, moreover, the written consent of the local ordinary, unless the papal indult states otherwise. A diocesan congregation must have permission to ask for alms of both the bishop in whose diocese their house is located and the bishop in whose diocese they wish to go begging. Religious congregations should not be allowed to go begging except when it is really necessary, and if it suffices for their needs to beg in the place or diocese where the house is located. Permission to go to other places or dioceses should not be given them. Latin ordinaries should not allow any of the Orientals of any order or any ecclesiastical dignity to collect money in their diocese unless these men have an authentic and recent rescript of the S. Congregation for the Oriental Church. Bishops of the Latin Rite should not let their subjects go into an Oriental diocese for alms. Canon 622. 468. Superiors are not allowed to send out for alms any other than professed members of mature age, especially when there is question of sisters, and never should they send out religious engaged in studies. Canon 623. 469. As to the manner of going out begging for alms, the religious of either sex must observe the instructions that have been issued before by the Holy See. Canon 624. 470. The regular abbots in charge of an abbey must within 3 months from their election receive the blessing from the bishop of the diocese in which the abbey is situated. After the reception of the blessing they have the power to confer the first tonsure and minor orders according to Canon 964, and enjoy also the privileges mentioned in Canon 325, with the exception of the purple skull cap. Canon 625. Chapter 3. Duties and privileges of a religious promoted to an ecclesiastical dignity, or to rectorship of a parish. 471. The religious cannot without indult of the holy. Duties and privileges of religious. 125. C. Be promoted to dignities, offices or benefices incompatible with the religious state. A religious legitimately elected by some college to such offices cannot assent to the election without the permission of his superior. If the religious is held by vow not to accept dignities, A special dispensation of the Roman Pontiff is required. Canon 626, 472. The religious raised to the cardinalate or the episcopate, whether residential or titular, continues to enjoy the privileges of his order, and remains subject to the vows and other obligations of his profession, with the exception of those things which according to his judgment are not compatible with his dignity. Other exceptions are contained in the following canon. He is, however, exempt from the authority of his superiors, and, as far as his vow of obedience is concerned, he becomes subject solely to the Roman Pontiff. Canon 627, 473. The religious who has been raised to the dignity of the episcopate or any other outside his own order. 1. If he by his profession lost the ownership of goods, he gets the use, usufruct and administration of the goods which he acquires. The proprietorship of goods acquired by a residential bishop, vicar, or prefect apostolic belongs to the diocese, vicariate or prefecture. The proprietorship of the goods of titular bishops, or any others not mentioned above, goes to the Holy See, according to the rules of Canons 582 and 239, 1, n. 19. 2. If he did not lose proprietorship by his profession, he regains the use, usufruct and administration of the goods he had, and those he acquires afterwards he acquires for himself with full right. In both cases he must dispose of those goods which do not come to him in consideration of his own person according to the will of the donors. Canon 628, 474. When he abdicates the cardinalate or episcopate or has finished the office outside the order committed to him by the Holy See, the religious is bound to return to the order. A cardinal or a bishop returning to his order may, 126. The New Canon Law, choose any house of his order where he wishes to stay, but he has neither active nor passive vote. Canon 629, 475. The religious who rules a parish with the title of either pastor or vicar, remains bound to the observance of the vows and constitutions in as far as their observance is possible in performing the duties of his office. Wherefore in those things which pertain to the religious discipline he is subject to the religious superior to whom alone it belongs, to the exclusion of the ordinary, to inquire concerning his observance of the religious life and to punish him. The goods which come to him in consideration of the parish which he governs, he acquires for the parish. Other goods he acquires in the same manner as other religious of his order or congregation. Notwithstanding his vow of poverty he is allowed to keep and collect and administrate alms for the benefit of the parishioners, or for the Catholic school, or other pious institutes connected with the parish. He may also according to his judgment spend those alms in accordance with the intention of the donors. The superior, however, has the right to watch the doings of the pastor, to collect, accept, keep and administrate alms for the building, conservation, repair or decoration of the parish church belongs to the superior if the church is owned by the religious community, otherwise to the bishop. Canon 630, 476. Such a pastor or vicar is subject to the visitation, correction and entire jurisdiction of the bishop, like any other pastor, excepting only the question of his religious observances. The bishop has this power over a religious pastor even though he is pastor in the place where the major superior has his ordinary residence. The bishop, when finding the pastor neglectful in his office, can issue commands and punish him with ecclesiastical penalties. The religious superior, however, has the same right as the bishop to proceed against the neglectful pastor. If the bishop and the superior disagree, the orders of the bishop prevail. Both the bishop and the religious superiors have equal rights in removing the pastor, and neither has to give a transition to another order. 127. Son to the other, as Canon 454, 5, states. As regards contracts and investments, etc., concerning the goods of the parish, the bishop's consent is required as demanded by Canons 533, 1, n. 4, and 535, 3, n. 2. Canon 631. Title 14. Transition to another order. 477. A religious cannot go over to another order, even a stricter one, nor from one independent monastery to another, without permission from the Holy See. Canon 632. 478. The religious who goes over to another order must make the novitiate, during which the vows he has taken in the first order continue, but the particular duties and privileges of that order are suspended. He is held to obey the superiors and the master of novices of the new order also in virtue of the vow of obedience. If he does not make profession in the order to which he goes over, he must return to the former order, unless his temporary vows have expired in the meantime. The religious who goes over from one monastery to another of the same order, for instance in a religious of the order of Saint Benedict obtains papal indult to join another Benedictine abbey, need not make again novitiate and profane. Canon 633, 479. A religious and solemn or simple perpetual vows, who obtains the papal indult to join another religious organization with solemn or perpetual simple vows, shall after the completion of the novitiate in the new order or congregation take immediately either solemn or perpetual simple vows, or, if rejected, return to his former order or congregation. The superior has the right to prolong the time of novitiate for another year, but no longer. Canon 634. This canon is an exception to the rule of Canon 574, which demands that in all religious communities temporary vows should be made before a person is admitted to solemn or simple perpetual vows. It may be noted, also, that this canon refers only to religious who join another order or congregation while they are under vows. If they obtained a dispensation from their vows and after that the permission to enter another order or congregation, they must follow the law of Canon 574. 128. The New Canon Law. 480. Those religious who go over to another monastery of the same order, shall from the day of transition, and those who go to a different order, shall from the day of profession in that order, 1. Lose all rights, and are freed from all obligations, of the former order or monastery, and acquire the rights and are subject to the obligations of the new order or monastery. 2. The former order or monastery retains the goods of which it has already acquired ownership on account of the religious. As regards the dowry and its revenue, and other personal goods which the religious might have, the rule of Canon 551, 2, is to be observed. The new order has the right to demand some compensation for maintenance of the religious during the year of novitiate, if the order is according to Canon 570, 1. Allowed to accept compensation for the maintenance of novices. Canon 635. 481. If a religious with solemn vows has obtained permission to join a congregation with simple vows, his former solemn vows are dissolved by the very taking of simple vows in the congregation, unless the papal indult expressly states the contrary. Canon 636. Title 15. Departure from religious life. 482. The religious who has taken temporary vows may freely leave religious life when the time of the vows has expired. The superior may also for good reason refuse to let the religious take again temporary or perpetual vows and dismiss him, except for reason of illness, unless it can be proved that he had the malady before entering and intentionally deceived the order or congregation. Canon 637. 483. The indult to live outside the cloister, whether temporary, called the indult of exclustration, or perpetual, called secularization, can only be given by the Holy See for orders and for congregations of papal law. For diocesan congregations the local ordinary can give this indult. Canon 638. 484. A religious who obtained from the Holy See the departure from religious life. 129. Indult of exclustration is held to the observance of his religious duties, insofar as they can be observed in his condition, but he is not allowed to wear the religious garb. During the time of the temporary secularization he has neither active nor passive vote in the order, but he enjoys the purely spiritual privileges of his order, and, as regards his vow of obedience, he becomes subject to the bishop in place of the superiors of the order. Canon 639. 485. The religious who obtains an indult of secularization and leaves the order, 1. Becomes separated from his order, and cannot wear the exterior garb of the order, in Holy Mass in the Divine Office, and in the reception of, and administration of, the sacraments he is equal to the seculars. 2. He is free from the vows, but if he is in sacred orders he is held to the obligations of clerics in major orders, he is not held to the recitation of the Divine Office by reason of his profession, nor to the other rules and regulations of religious life. If the secularized religious is again received into the order or congregation, for which an apostolic indult is required, He must make the novitiate and profession and take his place in the community from the day of the new profession. Canon 640, 486. If a religious in major orders did not lose his diocese, as determined by Canon 585, and he returns to the world, either at the expiration of his temporary vows or by indult of secularization, he must go to his own diocese and the ordinary is bound to receive him. If he has lost his diocese, namely by taking perpetual vows, he cannot exercise his major orders after having left the order unless he finds a bishop willing to receive him, or the Holy See has made other provision. The bishop may receive the secularized religious either unconditionally or for a 3 years experiment. If received unconditionally, the religious becomes then and there incorporated in that diocese. In the other case the bishop can prolong the time of probation, not, however, for more than another term of 3 years. When the second term of 3 years has expired the religious becomes ipso facto in corpo. 130 The new canon law. Rated, unless he has been dismissed before the end of the term. Canon 641, 487. Every secularized religious who may according to Canon 641 exercise the sacred ministry is nevertheless forbidden without a new and special indult of the Holy See. 1. To obtain any benefice in major and minor basilicas and in the cathedral church. 2. To obtain any professorship or office in the major and minor seminaries and in colleges in which clerics are educated, as also in any university or institution which by papal indult confers academic degrees. 3. To obtain any office or position in the curia of the bishop, or in religious houses both of men or women, even when there is question of diocesan congregations. These rules apply also to those men and women who have taken temporary vows, or the oath of perseverance, or certain special promises according to the constitutions of their organizations, and have been dispensed from them, after they lived in them for fully 6 years. Canon 642, 488. Religious who leave their order or congregation at the expiration of the temporary vows, or by indult of secularization, or being dismissed, cannot ask for any compensation for work done for the order or congregation. However, if a religious woman had been received without a dowry and has no goods of her own, the religious organization is held by charity to give her what is necessary to reach her home in a safe and respectable manner, and to provide, according to natural equity, for some time a respectable living. This arrangement is to be made by common consent, and in case of disagreement the bishop is to decide what equity demands in the case of a woman who has no means of her own, until she can get work or position. Canon 643, 489. An apostate is a religious with either simple perpetual or solemn vows who unlawfully leaves the religious house with intention not to return, or he who had indeed permission to go out but fails to return because he wants to withdraw from the religious obedience. The evil intention to separate himself from the religious life is presumed by law if the religious does not return within dismissal of religious 131 a month, nor has notified his superior of his intention to return. A fugitive is a religious who leaves the house without the permission of the superiors but has the intention to return. Canon 644, 490. The apostate and the fugitive are not released from the obligation of observing the rule and vows and have the duty to return without delay. The superiors have the duty of searching for them and to receive them if they return with true repentance. In case of a sister who has become an apostate or fugitive, the ordinary shall take the necessary steps for her return, and in case of exempt nuns also the regular superior. Canon 645. Title 16. Dismissal of religious. 491. Religious are to be considered dismissed ipso facto in the following cases. 1. In public apostasy from the Catholic faith. 2. If the religious elopes with a woman, or the religious sister with a man. 3. Those attempting, or contracting, marriage, or concluding a so-called civil marriage bond. In these cases it suffices that the major superior with his chapter or council, as the constitutions may demand, makes a declaration of the fact. He shall, however, take care that the proofs of the fact which were collected are preserved in the archives of the house. Canon 646. Chapter 1. Dismissal of religious with temporary vows. 492. The professed religious with temporary vows, both in orders and congregations of papal law, can be dismissed by the supreme head of the organization, or the abbot of an independent monastery, with the consent of their respective council, to be expressed by secret vote. In monasteries of nuns the ordinary, or if the house is subject to the regulars, the regular superior, can dismiss the nun, after the superioress of the monastery with her council have in writing attested the reasons for dismissal. In Diocesan Congrega, 132 the new canon law, the bishop in whose diocese the house is situated has the right to dismiss sisters, but he should not make use of that right without the knowledge nor against the reasonable objection of the superioress. The aforesaid persons cannot exercise the right of dismissal unless they conscientiously observe the following points. 1. The reasons for dismissal must be serious. 2. There may be reasons either on the part of the religious or on the part of the organization. The want of a religious spirit which is a scandal to others is sufficient reason for dismissal, if admonition together with penance did not have any result. Poor health is no reason, except it is known with certainty that the malady had before profession been intentionally concealed. 3. The reason for dismissal must be known with certainty to the superior, but a formal canonical trial is not required. The religious must be told of the reasons why he is dismissed, and be given a chance to freely answer concerning the charges, and his answer must in full be given to the superior who has the right of dismissal. 4. Against the decree of dismissal the religious has the right to appeal to the Holy See, and, pending the appeal, the dismissal has no juridical effect. 5. In reference to a dismissed sister Canon 643, 2. Is to be observed. Canon 647, 493. The religious who has been dismissed according to the preceding canon is ipso facto absolved from the vows of religion. The cleric in major orders, however, is subject to the obligations of those orders and to the other regulations of Canons 641, 1, and 64 9. The cleric in minor orders is by the very dismissal reduced to the state of the laity. Canon 648. Chapter 2. Dismissal of religious with perpetual vows and non-exempt clerical and inaulical organizations. 494. In non-exempt clerical and inaulical orders or congregations of men, a religious with perpetual vows cannot be dismissed unless he has previously committed 3. Dismissal of religious 133 crimes and been twice admonished without result, according to the rules of Canons 656-662, Canon 649, 495. 1. When such a threefold crime has been committed, the supreme head of the order or congregation, together with his council shall, considering all circumstances, discuss whether there is cause for dismissal. 2. If the majority of the votes is in favor of dismissal, 1. In diocesan congregations the entire matter is to be referred to the ordinary of the diocese where the house of the religious is situated, who may decide as he sees fit, AC according to Canon 647. 2. In a clerical congregation of papal law the supreme head of the congregation itself issues the decree of dismissal, but in order to have effect it must be confirmed by the Holy See. 3. The religious has a right to freely defend himself, and his defense must be faithfully entered in the acts of the proceeding. Canon 650. 496. To dismiss religious women with perpetual vows either simple or solemn, there are likewise serious external causes required, together with incorrigibility, and time for amendment must have been granted so that the superioress may judge of the hopelessness of further experiment. The rule of Canon 650, 3, is to be observed also in the dismissal of sisters. Canon 651, 497. If there is question of diocesan congregations, the ordinary of the place where the house of the professed sister is located, has the right to examine the reasons for dismissal, and to issue the decree of dismissal. If there is question of solemn professed sisterhoods, the local ordinary shall send all acts and documents to the sacred congregation, together with his opinion on the case, and that of a regular superior also if the monastery is subject to the regulars. If there is question of religious congregations of women under papal law, the Mother General shall refer the matter of dismissal to the sacred congregation, with all acts and documents. The sacred congregation will then, in this as in the preceding case, decide whatever seems best to it. 134 The new canon law. Canon 643, 2, must be observed in case the sister is dismissed. Canon 652, 498. In cases of scandal to the outside world, or of very great harm to the religious community, a delinquent religious can be dismissed at once by the major superior with his council, or in case there is danger in the delay and the major superior cannot be reached in time, the local superior with the consent of his council and of the bishop of the diocese, can dismiss the religious. The matter must, however, be submitted without delay to the Holy See, either by the bishop or by the major superior, if he is present. Canon 653. Chapter 3. The canonical trial and the dismissal of religious with perpetual or solemn vows in a clerical exempt religious organization. 499. A religious man who has taken perpetual or solemn vows in a clerical exempt order or congregation shall not be dismissed except by the process of a canonical trial. The exceptions of immediate dismissal mentioned in Canon 646, 668 hold good also in this case. Otherwise all contrary privileges are revoked. Canon 654. 500. The supreme head of the order, or the abbot general of a monastic congregation, with their council or chapter of at least 4 religious, is competent to issue the decree of dismissal. If there are not at hand 4 consultors, the superior with the consent of the other consultors shall choose the required number of men who will act as judges with the superior. The superior shall nominate the promoter of justice with the consent of his council according to Canon 1589, 2, which prescribes that the promoter must be a priest of the same order. Canon 655. 501. A canonical trial cannot be instituted unless there have preceded 1. Grave external crimes, either against the common law or the law for the religious. 2. The admonitions. 3. Failure to amend. Canon 656. 502. The crimes must be at least 3 in number and of dismissal of religious 135. The same species, or, if of a different species, such that, taken together, manifest the perverse will and obstinacy in sin. It may also be one continued crime which virtually becomes threefold by the admonitions. Canon 657. 503. In order to issue the admonitions it is required that the crime is either notorious, or that it is known by extrajudicial confession, or by sufficient proof furnished by previous investigation. If the crime is neither notorious nor altogether certain, but only a rumor and public talk, or it has become known by denunciation, or by complaint for damages, or by the general investigation made by the superior, or any other way, there must be first a special investigation instituted in order that it may become certain whether the individual has committed the crime, and what proof there is for it. Canon 658, cf. Canon 1939. 504. The admonition must be made by the major superior, either in person or through another by his command. The command to issue the admonition should not be given until after due investigation by the major superior, according to Canon 658, 1, but the delegation once given for the first admonition holds good also for the second. Canon 659. 505. There must be at least 2 admonitions, 1 for each of the first 2 crimes. In crimes which are continued or permanent it is required that there is an interval of at least 3 days between the first and second admonition. Canon 660. 506. To the admonitions the superior must add exhortation and penances and other penal remedies which are judged appropriate for amendment and reparation of scandal. The superior is, moreover, held to take the guilty religious out of the occasions of sin, even by transferring him, if necessary, to another house where he can be better watched and where the occasion of relapse is more remote. To each of the admonitions must be added the threat of expulsion. Canon 661. 507. The religious is judged to have failed to amend, when after the second admonition he commits a new crime or continues in the same crime. After the second admonition 6 days at least must elapse before further proceedings can be instituted. Canon 662. 508. The immediate major superior, after the admonitions, 136 the new canon law, and corrections have proved a failure, shall carefully collect the acts and documents and send them to the supreme head of the order or congregation. The general shall give the documents to the promoter of justice, who must examine them and draw his conclusion. Canon 663, 509. The promoter of justice has the right to institute further investigations if he thinks it proper. If he concludes that accusation should be made against the religious, the canonical process must be instituted according to the rules of the canons in the first part of the fourth book. In the process must be proved the commission of the crime, the issuing of the admonitions, and the failure of amendment. Canon 664, 510. The tribunal, after due consideration of the charges of the promoter of justice and the defense of the accused, and of the points mentioned in the preceding canon, 2, shall pronounce the sentence of dismissal. Canon 665, 511. The sentence cannot be executed unless it is confirmed by the sacred congregation, to which the superior general shall as soon as possible send the sentence and all acts of the process. Canon 666, 512. For distant countries the general can, with the consent of his council, also for ordinary cases delegate the power of dismissal to trustworthy religious who must be at least 3 in number and who must observe the rules of Canon 663-666. Canon 667, 513. In the case mentioned in Canon 653, the religious can be dismissed immediately by the major superior, or, if there is danger in the delay and the major superior cannot be reached in time, by the local superior with his council. The religious must not wear the habit after being dismissed. The canonical trial, if not yet instituted, must be commenced at once, according to the preceding canons. Canon 668, Chapter 4. Dismissed religious who had taken perpetual vows. 514. The professed religious of perpetual vows remains bound to his vows after the dismissal, unless the constitutions of dismissal of religious 137, the order or congregation, or an adult of the Holy See, declare the vows dissolved. If the dismissed religious is a cleric in minor orders, he is by the very dismissal reduced to the state of the laity. Canon 669, 515. The cleric in major orders who committed one of the crimes enumerated in Canon 646, or who was dismissed on account of a crime to which the law attaches loss of good reputation or degradation, is forbidden forever to wear the clerical garb. Canon 670, 516. If he was dismissed for any other crime than those referred to in the preceding canon, 1. He remains ipso facto suspended until he obtains absolution from the Holy See. 2. The sacred congregation may, if it see fit, command the dismissed religious to wear the garb of the secular clergy and stay in a specified diocese, informing the ordinary of that diocese of the reasons for which the religious was dismissed. 3. If the religious does not obey the command spoken of in the preceding paragraph, the order is not responsible for him, and he is thereby deprived of the right to wear the clerical garb. 4. The ordinary of the diocese assigned for the dismissed religious shall send him to a house of penance or commit him to the care and vigilance of a pious and prudent priest. If the religious does not obey, the bishop is not responsible for him and the ex-religious forfeits the right to wear the clerical garb. 5. If the ex-religious obeys the orders of the sacred congregation and of the bishop, the order or congregation to which he belongs should through the bishop furnish him with the necessary maintenance, unless he has an income from other sources to defray his maintenance. 6. If the dismissed religious does not lead a life worthy of a cleric, the ordinary may after 1 year of trial, or also sooner, deprive him of the maintenance, order him out of the house where he was to stay for trial, and deprive him of the right to wear the clerical garb. The bishop shall at once send notice of this action both to the sacred congregation and to the order or congregation from which the cleric was dismissed. 7. If, however, the dismissed religious behaves so well that he can justly be considered amended, the ordinary should, the New King's Law, endorse in's petition to the Holy See for a sahition from the ensign of Sastament, ad when he lag obtained the ipso tribo him in IBS diocese, with due precautions and limitations, a celebration of half-mass, and a fio if he sees fit other functions of the sacred ministry high which he may properly support himself. After this the order may train the charitable assistance. If he is a deacon or subdeacon, the matter should be referred to the Holy See. Canon 671, 517 To dismiss regents whose vows were not dissolved else return to his elder or congregation. If he has for through years given signs of true T vertical bar FFG for the order or congregation is bound to receive him. If there are serious reasons, either on the part of die dismissed or on the part of the religious organization, why his reception is not desirable, die matter shall be subjected to AC judgment of the Holy See. If AC toes were dissolved by the dismissal and the dismissed has found a height and hop waiting to receive him, he remains on DCR the jurisdiction and special vigilance of the bishop, otherwise die matter shall be referred to die Holy See. The bishop who received die dismissed religious MSFL observe Canon 642 in reference to the position he gives died Kmvukjar for Agar Canon 67z. Titles Vil. Societies of within or woman leading a community life, without vows. 518. A society of men or women who lead a community 5 after die manner of the religious under proper superiors, but without die 3 usual vows of religion's life, is not a religion's Rani tie properly so called, nor are its members religious in die strict sense of die term. Such a society is other clerical or laical, of papal law or Djofson, according to Canon 489, Volume 3, 4, Canon 673, 519. The erection and suppression of such a society and of its provinces and houses follows the rules laid down for die RC. C.if, r.c.i:r.5c, r.r. V. 520. The government of each society is regulated by the individual constitutions. In all of them, however, Canons 499-530 must be observed, Canon 675, 521. The society and its provinces, as weak as the societies without vows 139. Dual houses are capable of acquiring and possessing temporal goods. The administration of the goods is regulated by the rules of Canons 532-537. Whatever the members of the society acquire in consideration of the society, belongs to the society. The other goods they retain, acquire and administrate according to their constitutions. Canon 676, 522. In the admission of candidates the constitutions of the society shall be observed insofar as they are not contrary to Canon 542. Canon 677, 523. In the arrangement of studies and the reception of orders the members of the society are held to the same laws as the secular clergy, saving special regulations which the Holy See may have given to some society. Canon 678, 524. The members of a society are held to the common obligations of clerics, besides their special regulations contained in the constitutions, unless the nature of the law, or the context, shows that the law is not intended for members of a society. They are also held to the obligations of the religious as outlined in Canons 595-612, unless their constitutions rule otherwise. They shall observe the enclosure according to their constitutions, under the supervision of the local ordinary. Canon 679, 525. The members of the society, both clerics and lay brothers, enjoy the privileges of clerics as contained in Canons 119-123, and other concessions given directly to the society. They do not have the privileges of religious unless granted them by special indult of the Holy See. Canon 680, 526. Besides the proper constitutions of individual societies regarding the transition to another society or another religious body, and the departure of members of societies either diocesan or of papal law, these matters shall with due distinction be regulated by Canons 632-635, 645, in reference to the dismissal of members. Canons 646-672 are to be observed, Canon 681, Part 3. The laity. 527. The laity has the right to receive from the clergy the spiritual benefits and specially the necessary means of salvation, according to the rules of ecclesiastical discipline. Canon 682. 140. The New Canon Law. 528. Laymen are not allowed to wear the clerical garb, with the exception of seminarians and other candidates of orders to whom Canon 972, 2, refers, and laymen legitimately appointed to the service of the Church while they are, either within the church building or outside, engaged in the ministry of the Church. Canon 683. Title 18. General Regulations for Associations of the Faithful. 529. The faithful deserve praise for joining associations erected, or at least recommended, by the Church. They should beware of associations that are secret, condemned, seditious, suspected, or those which strive to withdraw from the legitimate supervision of the Church. Canon 684. 530. Associations distinct from the religious organizations and societies spoken of in Canons 487-681, can be erected by the Church either to promote a more perfect Christian life among its members, or for the undertaking of works of piety and charity, or, finally, for the advancement of the public cult. Canon 685. 531. No society is recognized in the Church unless it has been either erected by the competent ecclesiastical authority, or at least approved by it. To erect and approve societies is the privilege of the Roman Pontiff and of the Bishop. Some are by papal indult reserved to others, though it can be proved that a papal privilege was granted to someone to erect a certain society. The consent of the Bishop, given in writing, is nevertheless required for the validity of the erection of a society. The consent of the bishop given for the erection of a religious house is valid also for the erection, in that house or church, of a society annexed to that order or congregation, if it is not of the nature of an organic body and is proper to the religious community. A vicar general by merely general commission, and a vicar capitular, cannot erect societies, nor give consent for their erection or for aggregation. The letters of erection given by persons who in virtue of an apostolic indult have the right to erect certain societies must be given gratis, accepting only a tax for the necessary expenses. Canon 686. Associations of the Faithful 141. 532. The societies do only then acquire the right of a legal person in the Church when they have obtained from the competent ecclesiastical superior the decree of erection. Canon 687. 533. An association should not assume a name or title which savors of levity or unbecoming novelty, or gives express sign to a form of devotion not approved of by the Holy See. Canon 688. 534. Every society shall have its statutes approved, either by the Holy See or by the Bishop of the diocese. Statutes that have not been confirmed by the Holy See remain always subject to modification and correction by the Bishop. Canon 689. 535. All societies, even those erected by the Holy See, are under the jurisdiction and vigilance of the Bishop of the diocese, unless there is a special privilege of exemption, and the Bishop has the right and the duty to inspect them. Societies, however, that have been erected by the religious in their own churches in virtue of an apostolic indult, the Bishop has no right to visit in regard to internal discipline or spiritual direction of these societies. Canon 690. 536. A society legitimately erected, may, unless the contrary has been expressly ordered, possess and administrate temporal goods under the authority of the Bishop of the diocese, to whom it should render a financial statement at least once a year. This is to be done by the society itself and not by the pastor in whose parish the society is erected, unless the Bishop has ordered the pastor to make such report. The society may, according to its statutes, receive alms and spend them for the pious purposes of the society and in accordance with the intention of the people who make the offerings. No society may collect alms unless either the statutes permit it, or necessity require it, and it has the permission of the ordinary of the diocese whose regulations in this matter must be observed. If the society wishes to collect alms outside the diocese, the permission in writing of the bishop in whose diocese it wishes to collect must be obtained. The society must give to the bishop in whose diocese it is established an exact account of the alms collected, and how they were spent. Canon 691. 142. The New Canon Law. 537. In order to participate in the rights, privileges, indulgences and other spiritual favors of a society, it is required that a person be validly received into the society according to the statutes proper to the society, and that one has not legally been deprived of membership. Canon 692. 538. Non-Catholics, members of a condemned society, persons publicly known to be under ecclesiastical censure, and in general any public sinners cannot be validly received into a society. The same person may be ascribed to several societies, except several third orders, cf. Canon 705. Absent persons cannot be enrolled in a society which is constituted in the form of an organic body, and those present cannot be received except with their knowledge and consent. Religious may be received into societies, except third orders, unless the laws of the society are according to the judgment of the superiors incompatible with the observance of the rule and constitutions of the order or congregation. Canon 693, 539. The reception should be performed according to the rules of the common law and the particular statutes of the individual societies. In order that there may be a record of the reception, the names should by all means be entered in the roll book of the society, and this inscription is required for validity of membership if the society is erected as a legal person. Canon 694, 540. On occasion of the reception into a society, no payment should be demanded, either directly or indirectly, except the fees which the lawfully approved statutes prescribe, or which the ordinary of the diocese has sanctioned for reason of special circumstances. Canon 695, 541. No member of a society shall be dismissed from the same except for a good reason, and in accordance with the statutes. Members who fall into a case mentioned in Canon 693, 1, shall after previous admonition be deprived of membership in the manner provided in the statutes of the respective society. Recourse to the bishop is open to a member who thinks himself unjustly expelled. The bishop shall always have the right to dismiss members of any society, even though there is no such provision in the Associations of the Faithful 143, Toots, and the religious superior may dismiss members of societies that are by virtue of apostolic indult erected by religious. Canon 696, 542. Lawfully erected societies have the right to hold meetings, publish regulations for the society itself, elected administrators of the goods of the society, officers and assistants, in accordance with the rules of law and their proper statutes. Canon 715 rules that the bishop has right of jurisdiction over the societies and all their proceedings must be respected. Canon 697, 543. Unless an apostolic indult states the contrary, the nomination of the moderator and the chaplain of societies which are either erected or approved by the Holy See, and of societies erected by religious in virtue of apostolic indult outside their own churches, belongs to the bishop of the diocese. For societies erected by religious in their own churches, the moderator and chaplain are appointed by the religious. If, however, the superior should appoint a secular priest for these offices, the consent of the bishop of the diocese is required. The moderator and chaplain have for the time of their office the faculty to bless the habit of the society, its insignia, scapulars, etc., and to invest the new members with them. The moderator and chaplain can be removed from office for good reasons by those who appointed them, or by their superiors or their successors in office. The same priest can be both moderator and chaplain. Canon 698, 544. For serious reason, the bishop of the diocese can suppress societies which were erected either by himself or by his predecessor, and also societies erected by religious in virtue of apostolic indult with consent of the ordinary. Recourse to the Holy See is permitted to those concerned. Societies erected by the Holy See itself can be suppressed only by the Holy See. Canon 699, Title 19, Particular Regulations for Associations of the Faithful. 545. There are three kinds of associations or societies of the faithful, namely third orders, secular, confraternities, pious unions. Canon 700, 144. The New Canon Law. 546. The order of precedence between the various lay societies is as follows: 1. Third orders. 2. Arch-confraternities. 3. Confraternities. 4. Primary pious unions. 5. Pious unions. The confraternity of the Blessed Sacrament precedes the arch-confraternities and processions of the Blessed Sacrament. A society has only then the right of precedence when it takes part in ecclesiastical functions in a body, under cross or banner of their own, invested with the insignia or the habit of the society. Canon 71, Chapter 1, Third Orders Secular. 547. Secular tertiaries are those persons who in the world strive after Christian perfection, under the guidance of, and in harmony with, the spirit of some order, in a manner compatible with the life in the world and according to rules approved by the Holy See. If the Third Order Secular is divided into several societies, each legitimately established branch is called a sodality of tertiaries. Canon 702. 548. No order or congregation can call into life a third order. The privileges granted to some orders to have a third order are to continue, though an order has the apostolic indult to erect the third order. They cannot validly establish a sodality of tertiaries in any church without the consent of the bishop of the diocese, though they may receive into the third order individual persons, according to the law of Canon 686, 3. The religious cannot allow the sodalities of tertiaries to wear the particular garb of that third order in public sacred functions without a special permission of the bishop. Canon 703. 549. Persons who have taken vows, either perpetual or temporary, in some religious organization, cannot at the same time belong to any third order, though they had been received into the third order before they embraced religious life. When such persons' vows cease or are dissolved, the former membership revives. Canon 704. Confraternities and Pious Unions 145. 550. No sodality of tertiaries can without an apostolic indult receive tertiaries of another third order, if they intend to remain in the former third order. Individual tertiaries may go over from one third order to another and also from one sodality to another of the same third order. Canon 705. 551. The tertiaries may, but are not obliged to, take part in a body in public processions, funerals and other ecclesiastical functions. If, however, they are present, they must march under their own cross, wearing the insignia of their order. Canon 706. Chapter 2. Confraternities and Pious Unions. 552. Associations of the faithful erected for the exercise of some work of piety or charity come under the name of pious unions. If these associations are established after the manner of an organic body, they are called in law sodalitia. Sodalitia which have, moreover, for their purpose the furtherance of divine worship are called confraternities. Canon 707. 553. Confraternities can be erected only by a formal decree of erection. For the erection of pious unions the approval of the ordinary is sufficient, which entitles them to gain spiritual favors, especially indulgences. Canon 708. 554. The members of a confraternity cannot take part in a body in sacred functions unless they wear the insignia or the habit of the confraternity. Women can be enrolled in confraternities for the purpose only of gaining the indulgences and spiritual favors of the confraternity. Canon 709. 555. The titles of confraternities and pious unions are to be taken from the attributes of God, the mysteries of the Christian religion, the feasts of our Lord, the Blessed Virgin, the saints, or the work itself of the society. Canon 710. 556. There should not be several confraternities of the same name and institution in the same town, unless the law or special regulations allow an exception. In large cities it is left to the judgment of the bishop what distance is considered sufficient for the establishment of confraternities of the same kind in various churches. 146. The New Canon Law. The Holy See desires that the bishops establish in every parish the confraternities of the Blessed Sacrament and of Christian doctrine, which, when legally erected by the ordinary, ipso facto obtain affiliation with the arctan fraternities erected at Rome by the Cardinal Vicar. Canon 711. 557. Confraternities and pious unions should be erected only in churches, public and semi-public oratories. They should not be established in the cathedral and in collegiate churches without the consent of the chapter. In churches and oratories of religious women the bishop can allow only the erection of societies of women, or of pious unions, who only meet for the recitation of certain prayers and have merely communication of spiritual favors with some confraternity. Canon 712. 558. The religious can give to the confraternities and pious unions erected by them those indulgences which the Holy See has declared communicable, and they should at the time of the erection of the confraternity be made known to all members. They cannot allow the confraternity to wear in public sacred functions the habit or other insignia without special permission of the bishop. Canon 713, 559. The confraternities shall not change, nor abandon, the habit or insignia proper to the confraternity without permission of the bishop. Canon 714, 560. The bishop has the right to preside at the meetings of confraternities, even in the churches and oratories of regulars, and though he has no vote in the election of the officers, he has the right either in person or through a delegate to watch over the election, confirm or reject the officers elected, and unless the statutes are approved by the Holy See he can correct and change them. If the confraternities wish to hold extraordinary meetings they shall advise the ordinary or his delegate in due time, otherwise the bishop has the right to stop the meeting and cancel their proceedings. Canon 715, 561. The confraternities and pious unions which have been erected in churches of their own, have the right, with due observance of the law, to have non-parochial functions independently of the pastor, provided they do not injure the parochial ministry in the parish church. The bishop has the right to decide. Our confraternities and primary unions 147, whether or not the functions of the confraternity unduly interfere with the services in the parish church. Canon 716, 562. The goods and belongings of a confraternity or pious union established in a parish church or any other not belonging to the confraternity itself, must be kept separate from the accounts of the parish. Canon 717, Chapter 3, Our confraternities and primary unions. 563. Societies which possess the right to affiliate to themselves other associations of the same kind, are called arch confraternities, or primary unions, congregations, societies. Canon 720, 564. No association can without apostolic indult affiliate other societies. Our confraternities and primary unions can affiliate only such confraternities and pious unions which have the same title and the same purpose, unless the papal indult grants greater powers. Canon 721, 565. By the affiliation are communicated all indulgences, privileges and other communicable spiritual favors which have been granted to the affiliating body directly and by name, or shall in future be granted in that manner by the Holy See, unless a restriction is made in the papal indult. The affiliating body does not acquire any right over the other confraternity by the act of affiliation. Canon 722, 566. For the validity of the affiliation the following is required. 1. The association must have been already canonically erected and not been affiliated before to any other arch confraternity or primary union. 2. The affiliation must be done with the written consent of the bishop of the diocese together with his testimonial letters. 3. The indulgences, privileges and other spiritual favors which are communicated by the affiliation must be enumerated in an alincus which is to be inspected by the bishop of the diocese where the arch confraternity resides and be given to the affiliated society. 148. The New Canon Law. 4. The affiliation is to be given in the prescribed formula and for all times. 5. The letters of affiliation must be issued absolutely gratis without any retribution even in the form of alms, except the necessary expenses. Canon 723, 567. The arch confraternity or primary union cannot be transferred from its residence to another place except by the Holy See. Canon 724, 568. The title of archsodality or arch confraternity or primary union cannot be given, even as an honorary title, to any society by another than the Holy See. Canon 725. The Third Book. Sacred Things. 569. The things spoken of in this book are so many means for obtaining the purpose of the Church. Some of these are spiritual, others are temporal, others mixed. Canon 726. 570. The intentional will to buy, or sell, for a temporal price things intrinsically spiritual, e.g., the sacraments, ecclesiastical jurisdiction, consecration, indulgences, etc., or a temporal object annexed to the spiritual in such a way that the temporal object cannot exist without the spiritual, e.g., an ecclesiastical benefice, or when the spiritual good is the object even though only partially of the contract, e.g. the consecration and the sale of a consecrated chalice, is simony forbidden by the divine law. Again, to give temporal objects annexed to the spiritual for other temporal objects annexed to the spiritual, or spiritual objects for spiritual, or temporal for temporal, in cases where the Church forbids this for the sake of reverence toward spiritual objects, constitutes simony by ecclesiastical law. Canon 727, 571. When there is question of simony, the buying and selling, exchange, etc., is to be taken in a wide sense for any agreement, even though it did not take effect, and even though the agreement was merely tacit, namely, such in which the simoniacal intention was not expressly manifested, but can be understood from the circumstances. Canon 728, 572. While the penalties of law remain, the simoniacal contract is null and void if simony is committed concerning benefices, offices, dignities. The subsequent conferment is likewise void, even though the simony was committed by a third person and without one's knowledge, provided it was not done fraudulently to injure the one who was to get the office or done against his protest. Wherefore, 1. Before any sentence of the judge the valuables given and accepted simoniacally must be returned, if such restitution is possible and can be done without irreverence to the 149, 150 the new canon law, spiritual, and the benefice, office or dignity must be vacated. 2. The one who through simony obtained the benefice or office does not become the owner of the income of that office. If he received it in good faith, it is left to the prudent judgment of the ecclesiastical judge, or the ordinary, to condone the income thus received, either in whole or in part. Canon 729, 573. There is no simony when the temporal object is not given for the spiritual, but rather on occasion of it, by a just title acknowledged by law or legal custom. The same holds good when the temporal object is given for another temporal object which has something spiritual annexed to it, as for instance, the consecrated chalice, provided the price is not raised on account of the blessing or consecration. Canon 730. Part 1. The Sacraments. 574. As all the sacraments instituted by our Lord are the principal means of sanctification and salvation, they should be administered and received with great care and reverence. It is forbidden to minister the sacraments of the Church to heretics and schismatics, even though they are in good faith and ask for them, unless they have first renounced their errors and been reconciled to the Church. Canon 731, 575. The sacraments of baptism, confirmation and orders which imprint a character cannot be received a second time. If, however, there is prudent doubt whether they have been received, or whether they were validly received, they may be conditionally repeated. Canon 732, 576. In the administration and reception of the sacraments, the liturgical rites and ceremonies prescribed in the approved ritualistic books of the Church must be accurately observed. Each one shall follow his own rite, saving the exceptions of Canons 851, 2, and 866. Canon 733, 577. The holy oils required in the administration of several of the sacraments, must have been blessed by the bishop on the preceding Holy Thursday, nor are the old ones to be used except in case of necessity. When the holy oils are about to give out, other olive oil that has not been blessed may be. Baptism 151, added, even repeatedly, but always in smaller quantity than the holy oils. Canon 734, 578. The pastor must obtain the holy oils from his bishop and keep them in the church in a safe and becoming place under lock and key. He shall not keep them in his house except where necessity or other good reason approved by the ordinary justify him to do so. Canon 735, 579. In the administration of the sacraments the minister shall not exact or ask for any remuneration, for any reason or occasion, directly or indirectly, except the offerings spoken of in Canon 1507, 1. Canon 736. Title 1. Baptism. 580. Baptism, which is the door and foundation for all other sacraments, and which, either actually received or at least desired, is necessary for salvation to all, is given validly only by ablution with truly natural water and pronouncing the prescribed form of words. Baptism administered with the observance of all the rites and ceremonies prescribed in the liturgical books, is called solemn, otherwise not solemn, or private. Canon 737, Chapter 1. The Minister of Baptism. 581. The ordinary minister of solemn baptism is the priest. Its ministration, however, is reserved to the pastor or to another priest acting with the permission of the pastor or the local ordinary, which permission is lawfully presumed in a case of necessity. Even of Gregorius, 1e. A person who is at the time outside the parish where he resides, should go to his own proper pot or to be baptized solemnly, if this can be easily done and without delay. Otherwise any pastor may in his territory solemnly baptize the peregrini. Canon 738, 582. In the territory of another pastor no pastor is allowed to baptize solemnly, not even one of his own parishioners, without due permission. Canon 739, 152. The New Canon Law. 583. Where parishes or quasi-parishes are not yet established, the diocesan statutes and accepted customs should be consulted in order to know what priest, besides the ordinary, has the right to baptize, either in the entire territory or in some particular district. Canon 740, 584. The deacon is the extraordinary minister of solemn baptism. He cannot, however, use his power without the permission of either the bishop or the pastor, which may be granted for a just cause and may lawfully be presumed when necessity urges. Canon 741, 585. Private baptism may be given by anyone who uses the proper matter and form and has the right intention. As far as possible 2 witnesses, or at least one, should be present at such a private baptism, by whom the conferring of baptism may be proved. Cf. Canon 759. If a priest is present he should be preferred to a deacon to a subdiacon, a cleric to a lay person, a man to a woman, unless decency demand that the woman be preferred, or in case the woman knows better the form and manner of baptism. The father and mother are not allowed to baptize their own child except in danger of death if there is no one else at hand who can baptize. Canon 742, 586. The pastor should take care that the faithful, especially midwives, doctors and surgeons, learn how to baptize properly in case of necessity. Canon 743, 587. The baptism of adults, where it can be conveniently done, should be referred to the bishop, in order that he himself or his delegate may baptize more solemnly. Canon 744, Chapter 2. The subject of baptism. 588. A subject capable to receive baptism is omnis et solus homo viator, 1e. A human being born into this life, who has not yet been baptized. When there is question of baptism, the term parvulus, or infans, means, according to Canon 88, 3, one who has not yet the use of discretion, and held equal to them are those insane from infancy, no matter of what age they may be. Adults are the subject of baptism. 153. Called those who have the use of reason, and it is sufficient for admitting these latter to baptism that they of their own free will ask for it. Canon 745, 589. An infant shall not be baptized while still enclosed in the mother's womb, as long as there is probable hope that it can be baptized when born. If the infant puts forth the head, it may be baptized on the head, if there is immediate danger of death, and baptism shall not then be given again conditionally if the child lives. If the infant puts forth any other limb, it may be baptized on that limb conditionally, if there is imminent danger to life, but if the infant is born alive it must be baptized again conditionally. If the mother dies in pregnancy, and the fetus, when extracted by those whose duty it is to do this, shows sure signs of life, it shall be baptized absolutely, conditionally, if life is doubtful. If the fetus was baptized in the mother's womb, the child shall, when born, be baptized again conditionally. Canon 746, 590. Care should be taken that every fetus born prematurely, no matter at what stage of pregnancy, be baptized absolutely, if life is certain, but conditionally if life is doubtful. Canon 747, 591. Monstrous and unusual forms of fetus should always be baptized, at least conditionally, when in doubt whether the fetus is one being or several, one should be baptized absolutely, the others conditionally. Canon 748. 592. Infants that have been abandoned and found shall be conditionally baptized, if after careful investigation there is no certainty about their baptism. Canon 749. 593. An infant of infidel parents can lawfully be baptized even though the parent's object, in case the danger of death is such that it may be prudently judged the child will not live until he comes to the use of reason. Outside danger of death the infant may be licitly baptized, provided there is guarantee for the Catholic bringing up of the child. 1. If the parents or guardians, or at least one of them, consent. 2. If there are no parents, 1e. Father or mother, nor grandfather or grandmother, nor guardians, or if they have lost the right to the child, or cannot in any way exercise that right. Canon 750. 154. The New Canon Law. 594. Regarding the child of two Protestants or schismatics, or two fallen away Catholics, the rules of the above canon shall generally be followed. Canon 751. 595. An adult should not be baptized except with his own knowledge and will, and after due instruction. He is, moreover, to be admonished to repent of his sins. In danger of death, if he cannot be thoroughly instructed in the principal mysteries of faith, it is sufficient for the conferring of baptism that he show in some way his assent to these points of faith, and earnestly promises that he will keep the commandments of the Christian religion. If he cannot even ask for baptism, but has either before, or in his present condition manifested in some probable manner an intention of receiving baptism, he may be baptized conditionally. If afterwards he gets well, and there remains doubt as to the validity of the baptism, he may be baptized again conditionally. Canon 752. 596. Both, the priest as well as the adult to be baptized, if he is in good health, are advised to remain fasting. Unless there are grave and urgent obstacles, the baptized adult should immediately after baptism assist at Holy Mass and receive Holy Communion. Canon 753. 597. Insane and delirious persons should not be baptized unless they have been such from birth, or became such before they had obtained the use of reason, in which case they should be baptized like infants. If they have lucid intervals, they may in those moments be baptized if they desire it. They may also be baptized in imminent danger of death, if before becoming insane they have shown a desire for baptism. Those suffering from lethargy or delirium should be baptized only while conscious and desirous of baptism, if the danger of death is imminent. The rule of the foregoing paragraph of this canon is to be followed. Canon 754. Chapter 3. The Rites and Ceremonies of Baptism. 598. Baptism should be given solemnly, except in the cases spoken of in Canon 759. The local ordinary can for a grave. Rites and Ceremonies of Baptism 155. And reasonable cause allow the ceremonies for the baptism of infants to be used for the baptism of adults. Canon 755. 599. The child must be baptized according to the rite of the parents. If one of them belongs to the Latin rite, the other to an Oriental, the child shall be baptized in the rite of the father, unless other rules have been made by special law. If only one of the parents is a Catholic, the child shall be baptized in the rite of the Catholic party. Canon 756. 600. In solemn baptism water blessed for that purpose shall be used. If the water in the baptismal font be so diminished that it does not suffice, other common water may be added in smaller quantity, and this may be repeated. If the blessed water has become putrid, or has escaped from the font, or is wanting for any other reason, the pastor should have the font well cleaned, then put in fresh water and bless it as prescribed in the ritual. Canon 757. 601. Though baptism may be conferred validly in any of the three ways, infusion, immersion, aspersion, the first or second, or both mixed, whichever is more in use, should be retained, according to the approved rituals of the various dioceses. Canon 758. 602. In danger of death private baptism may be given. If it is administered by one who is neither a priest nor a deacon, only that should be done which is necessary for the validity of the baptism. If a priest or a deacon baptizes, and there is time, he should perform the ceremonies that follow baptism. Outside the case of danger of death, the ordinary cannot allow private baptism, except in cases of adult converts from heresy who are baptized conditionally. The ceremonies of baptism, which for any reason had been omitted in the conferring of baptism, should as soon as possible be supplied, except in the case mentioned in the preceding paragraph. Canon 759, 603. If baptism is given again conditionally, the ceremonies should be supplied if they were omitted in the first baptism, saving the exception of the foregoing canon. If the ceremonies were observed in the first baptism, one is at liberty to go through them again or not. Canon 760, 604. The pastor shall take care that the one baptized receives a Christian name. If they do not succeed in this they should. 156. The new canon law. Add to the name given by the parents the name of some saint, and enter both names in the baptismal record. Canon 761, Chapter 4. Sponsors. 605. According to a most ancient custom, no one is baptized solemnly unless he has, whenever possible, a sponsor. Even in private baptism a sponsor should be had, if it is easily possible. If there was no sponsor in the private baptism, there should be one in the supplying of the ceremonies, but in that case he does not contract any spiritual relationship. Canon 762, 606. When baptism is repeated conditionally, the same sponsor should, if possible, act who was present at the first baptism. Outside this case, there is no need of a sponsor in conditional baptism. In the repetition of baptism under condition, neither the sponsor of the first, nor the one at the second baptism contract spiritual relationship, unless the same sponsor was present at both baptisms. Canon 763, 607. There should be but one sponsor, who may be either of the same sex with the one to be baptized, or of the different sex, but two sponsors, at most, namely, one man and one woman, are allowed. Canon 764, 608. In order that one may validly act as sponsor, he must, 1. Be baptized, of the age of discretion, and have the intention to undertake that office. 2. He must not belong to an heretical or schismatical sect, not be excommunicated by a condemnatory or declaratory sentence, nor suffer from infamy of law, nor be excluded from legal actions, nor be a deposed or degraded cleric. 3. He must not be the father or mother of, or married to, the one to be baptized. 4. He must be designated either by the one to be baptized or by the parents or guardians, or in their default, by the minister of baptism. 5. The sponsor must, either in person or through proxy, physically hold or touch the one baptized, or receive him. Time and place of baptism 157. Immediately after baptism from the sacred font or from the hands of the minister. Canon 765, 609. In order that one may licitly act as sponsor, he must, 1. Be 14 years of age, unless for a just reason the minister admits younger ones. 2. He must not be under excommunication for a notorious crime, nor excluded from legal actions, nor suffer from infamy of law, even though no sentence was pronounced against him in the ecclesiastical court, nor must he be under an interdict, or otherwise a public criminal, or disgraced by infamy of fact. 3. He must know the rudiments of the faith. 4. He must not be a novice or professed member in any religious organization, unless there is no other to act as sponsor and permission is granted by at least the local superior. 5. He must not be in sacred orders, unless he has the express permission of his own ordinary to act as sponsor. Canon 766, 610. In doubtful cases as to whether one can validly or licitly be admitted as sponsor, the pastor should, if time permits, consult the ordinary. Canon 767, 611. In baptism spiritual relationship is contracted with the one baptized by the minister and the sponsor. Canon 768. In this, therefore, the law of the Council of Trent has been greatly restricted, so that no impediment is contracted with the parents. 612. It is the duty of the sponsor, by virtue of his office, to take an interest in his spiritual child, and to take good care that he is instructed in the duties of a Christian life and that he lives up to it. as in the ceremony he solemnly pledged himself for this. Canon 769. Chapter 5, Time and Place of Baptism. 613. Infants should be baptized as soon as possible. Pautors and preachers should often remind the faithful of this grave obligation. Canon 770. 614. Private baptism may, in case of necessity, be given at any time and in any place. Canon 771. 615. Solemn baptism may be given any day. It is most. 158. The New Canon Law. Proper, however, according to the most ancient rite of the Church, to baptize adults on the vigils of Easter and Pentecost, especially in metropolitan and cathedral churches, if this can be done conveniently. Canon 772. 616. The proper place for solemn baptism is the baptistry in churches and public oratories. Canon 773. 617. Every parish church shall have a baptismal font. All contrary statutes, privileges and customs are disapproved and rescinded. If other churches have acquired the right to have baptismal fonts, such rights may continue. The bishop can for the convenience of the people allow or demand that baptismal fonts be placed also in other churches and public oratories within the limits of the parish. Canon 774. 618. If the child cannot be brought to the parish church, nor to any other having the right to baptize, on account of distance or any other circumstances attended by great inconvenience or danger, the solemn baptism can and must be given by the pastor in the nearest church or public oratory within the parish, even though there be no baptismal font. Canon 775. 619. In private houses solemn baptism cannot be given except under the following conditions. 1. If those to be baptized are the sons or nephews of the highest ruler of a country, or have the right of succession to the throne, if they lawfully ask to be so baptized. 2. If the local ordinary with prudent and conscientious judgment should allow it when in some extraordinary case there are good reasons to have the baptism in the private house. 3. In these cases baptism must be given in the private chapel of the house, or at least in a decent place, and baptismal water is to be used. Canon 776. Chapter 6, Recording and Proof of Baptism. 620. The pastor should, carefully and without delay, enter into the records the name of the one baptized, the minister, parents and sponsors, date and place. In the baptism of illegitimate children the name of the mother is to be entered, if her motherhood is publicly known, Confirmation 159. Or if she of her own accord demands this either in writing or before 2 witnesses. Also the name of the father, provided he himself demands it either in writing or before 2 witnesses, or if he be known from some public document. In all other cases the child should be entered as one whose father or parents are unknown. Canon 777. 621. If baptism was not given by the pastor, nor in his presence, the minister shall as soon as possible inform the pastor of the domicile of the one baptized. Canon 778. 622. For the proof of baptism, where no third party is harmed, one witness who is absolutely trustworthy, or the oath of the one baptized in adult age, is sufficient. Canon 779. Title II. Confirmation. 623. The sacrament of confirmation must be conferred by imposition of hands, with the anointing of the forehead with holy chrism and the words prescribed in the pontifical books approved by the Church. Canon 780. 624. The chrism to be used in the sacrament of confirmation must be blessed by the bishop, even when a priest, either by law or special indult, confers this sacrament. The anointing should not be done with any instrument, but with the hand of the bishop, properly imposed on the head of the one confirmed. Canon 78. 1. Chapter 1. The Minister of Confirmation. 625. The ordinary minister of confirmation is the bishop only. The extraordinary minister is a priest who either by common law or by special indult of the Holy See has received the faculty to confirm. This faculty have by law the cardinals, abbots and prelates nullius, vicars and prefects apostolic, who cannot validly make use of the faculty except within the limits of their territory, and for the time of their term of office only. In reference to cardinals, cf. number 161, 23. 160. The New Canon Law. The priest of the Latin Rite who has this power by virtue of an indult can validly confer confirmation on Catholics of his rite only, unless the indult expressly allows more. It is not lawful to priests of the Oriental Rite who have the faculty or the privilege to give confirmation together with baptism to the infants of their rite, to confirm infants of the Latin Rite. Canon 782, 626. The bishop can within his diocese lawfully confirm also strangers, unless there is an explicit prohibition of their bishop to go outside the diocese for confirmation. In the diocese of another bishop, a bishop must have at least the presumed permission of the local ordinary, except when he confirms his own subjects privately and without crozier and mitre. Canon 783, 627. The priest who has a local apostolic privilege to confirm, may also confirm strangers in the territory of his jurisdiction, unless the ordinaries of these strangers have explicitly forbidden their people to receive confirmation outside the diocese. Canon 784, 628. The bishop is obliged to administer confirmation to his subjects who lawfully and reasonably ask for it, especially at the time of his visitation of the diocese. The same obligation rests with the priest who, by apostolic privilege, has the right to confirm in regard to those in whose favor this faculty was given him. The ordinary who is lawfully prevented, or who has no faculty to confirm, must see to it that at least every 5 years this sacrament is administered among his subjects. If he gravely neglects to administer this sacrament, either himself or through another, the Archbishop shall report the matter to the Holy See. Canon 785. Chapter 2. The subject of confirmation. 629. He who is not baptized cannot validly be confirmed. In order that one may receive confirmation licitly and with fruit, he must be in the state of grace, and, if he has the use of reason, he must be sufficiently instructed. Canon 786, 630. Although this sacrament is not an absolutely necessary time and place of confirmation 161, necessary means of salvation, no one is allowed to neglect to receive it when occasion offers. The pastors must see to it that the faithful receive confirmation in proper time. Canon 787, 631. In the Latin Church, confirmation is usually deferred until about the 7th year of age. Nevertheless, it may be conferred before this, if the infant is in danger of death, or if the minister in any other case thinks it expedient for good and weighty reasons. Canon 788, 632. If there are several to be confirmed, they should be present at the first imposition or extension of hands, and they must not leave until the rite is completed. Canon 789. Chapter 3. Time and place of confirmation. 633. This sacrament can be administered any time. It is most befitting to administer it during the week of Pentecost. Canon 790, 634. The proper place for confirmation is a church, never theolus. If the minister has any just and reasonable cause, he may confirm in any becoming place. Canon 791, 635. The bishop has the right to administer confirmation within the limits of his diocese in any, even exempted places. Canon 792. Chapter 4. The sponsors. 636. By a most ancient custom the Church requires a sponsor at confirmation, if one can be had. Canon 793. 637. The sponsor should not stand for more than 2, except the minister for a just reason allow him to stand for more. No candidate for confirmation should have more than 1 sponsor. Canon 794, 638. In order that one may validly act as sponsor, he must, 1. Be confirmed himself, have the use of reason and the intention to act as sponsor. 2. Not belong to an heretical or schismatic sect, nor be under any of the penalties spoken of in Canon 765, n. 2, by a declaratory or condemnatory sentence. 3. Not be the father, mother of, or married to, the one confirmed. 162. The New Canon Law. 4. Be designated by the one to be confirmed, or by his parents, guardians, or in their default or refusal to designate a sponsor, the minister or the pastor may designate him. 5. physically touch either in person or through a proxy the one confirmed in the very act of confirmation. Canon 795, 639. The requirements for licit sponsorship are: 1. He should not be the sponsor of baptism, unless there is a good reason which is left to the judgment of the minister of confirmation, or unless confirmation is given immediately after baptism. 2. He should be of the same sex as the one confirmed, unless the minister allows an exception in particular cases and for good reasons. 3. He must have the other requisites mentioned for baptism in Canon 766. Canon 796, 640. Spiritual relationship arises in valid confirmation between the one confirmed and the sponsor, and the sponsor is held by his office to interest himself in the spiritual welfare of the one confirmed and care for his Christian education. Canon 797, Chapter 5, Record and Proof of Confirmation. 641. In the confirmation record there should be entered the names of the minister, parents, sponsors, and the date and place, besides making note of it in the baptismal record, as demanded in Canon 470. 642. If the proper pastor of the one confirmed was not present, the minister of confirmation should either himself or through another send the report to the pastor. Canon 799, 643. For proof of the confirmation, when no one else's right is at stake, it is sufficient to have one witness who is altogether trustworthy, or the sworn statement of the one confirmed, unless confirmation was given in infancy. Canon 800. Title 3. The Blessed Eucharist. 644. In the Blessed Eucharist Christ, the Lord, is Himself contained, offered, and received under the species of bread and wine. Canon 801. The Holy Sacrifice of the Mass. 163. Chapter 1. The Holy Sacrifice of the Mass. Article 1. The Celebrant. 645. Priests only have the power to offer the sacrifice of Holy Mass. Canon 802. 646. It is forbidden that several priests can celebrate, except in the Mass of ordination of priests, and in the Mass of consecration of bishops, according to the Pontificate Romanum. Canon 803, 647. A priest who wishes to celebrate in a church outside his own, must exhibit authentic and still valid letters of his ordinary, if he is a secular, or if he is a religious, of his superior, or, if he belongs to an Oriental rite, of the Sacred Congregation for the Oriental Church, in order that he may be admitted to say Holy Mass, unless it be known that in the meantime he has committed some act for which he should not be admitted to say Mass. If he has no such letters, but his good character is known to the rector of the church, he may admit him. If, however, he is unknown to him, he may still be admitted once or twice, provided he wears priestly attire, does not get any remuneration under any title from the church in which he says Holy Mass, and signs his name, office and diocese in a book specially to be kept for that purpose. The special regulations of the bishop concerning this matter, saving the rules of this canon, must be observed by all, even exempt religious, unless there is question of admitting to celebration of Holy Mass religious priests in churches of their own order. Canon 804, 648. Every priest is obliged to say Holy Mass several times a year. The bishop, or the religious superior, shall see to it that the priests celebrate at least on all Sundays and holy days of obligation. Canon 805, 649. The priest is not allowed to say Holy Mass more than once a day, except by papal indult or by permission of the local ordinary. On Christmas and on All Souls' Day permission is given to say 3 Holy Masses. The ordinary cannot grant the permission to binate unless in holidays of obligation a considerable part of the faithful. 164. The new canon law would have to miss Holy Mass on account of the scarcity of priests. It is not in his power, however, to allow a priest to say more than 2 Holy Masses in one day. Canon 806, 650. The priest who should find himself in mortal sin shall not dare to say Holy Mass without previous sacramental confession, no matter how contrite he may be over his sins. If he has no chance to go to confession and urgent need obliges him to celebrate, he shall make an act of perfect contrition before saying Holy Mass, and shall be obliged to confess as soon as possible. Canon 807, This regulation is the same as the Council of Trent had it. 651. The priest is not allowed to celebrate unless he has observed the natural fast from midnight. Canon 808. 652. The priest is free to apply Holy Mass for any living person, and also for the poor souls in purgatory, provided he observes the rules of Canon 2262, 2, n. 2. This canon allows Holy Mass to be privately applied, if scandal is avoided, for an excommunicated person, but when it is excommunicatus vitandus, Holy Mass can be said only for his conversion and not for any other intentions for which he may ask to have Holy Mass applied. Canon 809. 653. The priest should not omit to prepare his soul by pious prayer for the oblation of the Eucharistic sacrifice, and upon its conclusion give thanks to God for such a great benefit. Canon 810. 654. The priest about to say Holy Mass should wear the cassock and the sacred vestments prescribed by the rubrics of his rite. He must not wear cap and ring, unless he be a cardinal, bishop or an abbot who has received the abbatial blessing, or has received an apostolic indult which allows him their use in the celebration of Holy Mass. Canon 811. 655. No priest, except the bishop and other prelates having the use of the pontificals, is allowed to have an assistant priest for the sole reason of honor and solemnity. Canon 812. 656. The priest should not say Holy Mass unless he has a server who serves and answers him. The server at Mass should not be a woman, unless no man can be had, and provided the woman stays at a distance to the holy sacrifice of the Mass. 165. Swear the prayers and does not in any way approach the altar. Canon 813. Article 2. The rites and ceremonies of Holy Mass. 657. The holy sacrifice of the Mass must be offered up in bread and in wine which is to be mixed with a little water. Canon 814. 658. The bread must be purely of wheat flour and recently made, so that there is no danger of corruption. The wine must be the natural juice of the grapevine and uncorrupt ethyl. Canon 815. 659. In the celebration of Holy Mass the priest must, ac according to his own rite, use either unleavened or fermented bread, wherever he celebrates. Canon 816. 660. It is forbidden, even in extreme cases of necessity, to consecrate one species without the other, or both outside of Holy Mass. Canon 817. 661. The celebrant must accurately and devoutly observe the rubrics of his liturgical books, and guard against adding other ceremonies and prayers of his own choice. All contrary custom is disapproved. Canon 818. 662. Holy Mass must be celebrated in the liturgical language proper to each one's rite, as approved by the Church. Canon 819. Article 3. Time and place of Holy Mass. 663. Holy Mass may be said on all days except those which are excluded by the priestess' own right. Canon 820. 664. Holy Mass should not be commenced earlier than 1 hour before the aurora, nor later than 1 hour after midday. On Christmas Day only the conventual or parochial Mass can be begun at midnight, but no other Mass without an apostolic indult. In all religious or pious houses having an oratory with the right of keeping there habitually the Blessed Sacrament, one priest may at midnight say 1 or also 3 Masses, and this Holy Mass will for all who assist satisfy the obligation of hearing Mass, and Holy Communion may be given to those who wish to receive. Canon 82-1. 166. The New Canon Law. 665. Holy Mass must be celebrated on a consecrated altar, and in a church or oratory consecrated or blessed according to law. Regarding private and semi-public oratories, Canon 1196 is to be observed. The privilege of the portable altar is conceded either by law or by indult of no other than the Holy See. This privilege is to be understood in such a sense, that it bestows the faculty to say Holy Mass anywhere in a decent and respectable place, and on a consecrated altar stone, not, however, on the ocean. The local ordinary, or when there is question of an exempt religious house, the major superior, can give permission for a just and reasonable cause to celebrate Holy Mass outside the church or oratory on a consecrated altar stone, in a decent place, but never in a bedroom. This permission can be given in an extraordinary case and only per modum actos, 1e. Not perpetually. Canon 822, 666. Holy Mass may not be said in churches of heretics and schismatics, even though they were in ancient times properly consecrated or blessed. If there is no altar of the priest's own right, he may celebrate on an altar consecrated by another Catholic rite, following his own rite in the celebration of Holy Mass. He may not celebrate with the Greek antiphonsa, a kind of corporal in which relics are deposited. On papal altars no one is allowed to celebrate without an apostolic indult. Canon 823. Article 4. The alms or stipends of Masses. 667. According to an established and approved custom of the Church, any priest who says and applies Holy Mass may receive an alms or stipend. Whenever he says Holy Mass several times a day, and has to apply one Mass from a title of justice, he cannot receive another stipend, excepting some compensation from an extrinsic title. On Christmas, however, he may receive a stipend also for the second and third Mass. Canon 824, 668. It is never lawful, 1. To apply Holy Mass for the intention of one who may offer a stipend in the future, but who has not yet asked for the Holy Sacrifice of the Mass. 167. Mass, and then to accept the stipend afterwards given for the Mass said before. 2. To accept a stipend for a Mass that was due and applied from another title. 3. To receive 2 stipends for the application of one Mass. 4. To receive one stipend for only the celebration, and another for the application of one and the same Mass, unless it is certain that one stipend was offered for the celebration without the application. Canon 825, 669. Manual stipends are called those which the faithful offer out of their own devotion, or from some obligation, even a perpetual one imposed on heirs by the testator. Ad instar manualium, are called the stipends of foundation Masses which cannot be applied in the proper church, or not by those who, according to the laws of those foundation Masses, should say them, and which may either by law or by papal indult be given to other priests to say. Other stipends, received from a fund set apart for foundation Masses, are called stipendia fundata, or missi fundati. Canon 826, 670. Any kind of negotiation or trading with Mass stipends must absolutely be avoided. Canon 827, 671. So many Masses must be said and applied as Mass stipends, even small ones, were offered and accepted. Canon 828, 672. Though the Mass stipends should have been lost without the fault of the one who has the responsibility to say the Masses, the obligation does not cease. Canon 829, 673. If a person has offered a certain sum of money for Holy Masses to be said, without indicating how many Masses he desires, the number must be reckoned according to the ordinary stipends customary in the place where the giver of them lived, unless circumstances are such that it must be lawfully presumed that his intention was different. Canon 830, 674. It is the right of the local ordinary to fix the amount of the stipend, which should, as far as possible, be done in the diocesan synod. The priest may not demand a larger stipend than has been fixed by the law of the bishop. Where there is no law of the bishop fixing the stipend, the custom of the diocese should be followed. 168. The New Canon Law. All religious, also the exempt ones, are obliged to observe the law of the bishop, or the custom of the diocese, concerning Mass stipends. Canon 831, 675. The priest may accept a larger stipend, if voluntarily offered, and, unless the ordinary has forbidden it, he may ac kept a smaller one. Canon 832, 676. It is presumed that the one who offers the stipend only requests the application of Holy Mass. If, however, he has explicitly stipulated certain circumstances for its celebration, the priest who accepts the stipend must fulfill the conditions made by the one who offered the stipend. Canon 833, 677. Concerning the time when Holy Mass is to be said, the following rules must be observed. 1. If the day was specified by the giver of the stipend, Holy Mass must absolutely be said that day. 2. If the giver of manual stipends did not expressly specify the day, then, 1. Masses ordered for an urgent cause must be said as soon as possible, and within the time proper to obtain the purpose, e.g., a Mass said for a successful examination, which naturally has to be said before the examination takes place. 2. In all other cases Holy Mass must be said within a short time, a longer or shorter period, according to the number of Masses. 3. If the giver of the stipend expressly left the time for saying the Holy Masses to the judgment of the priest, he may say them at a time that he finds more convenient. The rule of the following canon, however, must be observed. Canon 834, 678. No one is allowed to receive more Masses than he himself can say within a year. Canon 835, 679. In churches where, on account of the special devotion of the faithful, stipends for Masses are offered in such a number that it is impossible to say all of them in that church within the required time, the faithful should be notified by notices posted in a conspicuous place that the Holy Masses will be said either in that church when possible, or in other places. Canon 836, 680. He who has Masses which are to be said by others, should distribute them as soon as possible. Observing Canon 841. The time prescribed by law for their application begins on the Holy Sacrifice of the Mass 169 day on which the priest received them, unless the contrary is certain from other reasons. Canon 837, 681. He who has a number of Masses which he is allowed to give to others, may distribute them among priests of his choice, provided he knows they are absolutely trustworthy or are recommended by the testimony of their ordinary. Canon 838, 682. He who has given to other priests Masses which he received from the faithful, or which are in any way entrusted to him, is held to their obligation until he received notice that the stipends were received by the priest, and that he has accepted to say the Masses. Canon 839, 683. He who transmits manual stipends to others must send away the stipends as he received them, and cannot retain part of larger stipends, unless the giver expressly permits this, or it is certain that what was offered above the usual stipend was given into persone, that is to say, for special personal reasons. In Masses ad instar manualium, cf. Canon 826, unless the intention of the founder is otherwise, the excess of the ordinary stipend may be retained, if the larger stipend takes the place of a partial endowment of the benefice or pious institution, and it is sufficient to send the manual stipend customary in the place where the Masses are to be said. Canon 840, 684. Each and every administrator of pious institutions, or anyone else who is obliged to attend to the saying of Holy Masses for stipends, whether clerics or laymen, must at the end of each year send to their ordinaries those stipends for which they have not yet satisfied, according to the manner to be specified by the ordinary. This time is to be understood in such way that for stipends ad instar manualium the obligation of sending them to the bishop begins with the end of the year during which they should have been said. For manual stipends, 1 year from the day on which they were received, saving the different will of the givers. Canon 841, 685. The right and duty to see that the obligation of the Mass stipends is attended to in secular churches belongs to the ordinary, in churches of the religious, to their superiors. Canon 842, 170. The New Canon Law, 686. The rectors of churches and other pious places, both secular and religious, in which stipends for Masses are usually received, must have a special book in which they should accurately mark down the number, intention, amount of stipend, and the celebration of the Masses they receive. The ordinaries are obliged to inspect these books at least once a year, either in person or through someone else. Canon 843, 687. The ordinaries of dioceses, and religious superiors, who give Masses to their subjects or to others to say, shall mark down at once the Masses with the alms they receive, in the order in which they get them, and attend to it that as far as possible they are said soon. Every priest, whether secular or religious, must mark down accurately the Mass intentions which they receive, and whether and when they have satisfied them. Canon 844. Chapter 2. The Blessed Sacrament. Article 1. The Minister of Holy Communion. 688. The priest alone is the ordinary minister of Holy Communion. The deacon is the extraordinary minister, who must have the permission of the ordinary or of the pastor, which can be given for a grave reason and can be lawfully presumed in case of necessity. Canon 845, 689. Every priest may distribute Holy Communion in the Mass, and, if he celebrates privately, also immediately before or after Mass. Outside Holy Mass, any priest may administer Holy Communion, and if he does not belong to that church, he should have at least the presumed permission of the rector of the church. Canon 846, 690. Holy Communion should be brought to the sick publicly, unless good reasons make the private ministration advisable. Canon 847, 691. The right, a greater than indeed duty, to carry Holy Communion publicly to the sick within the parish, even to non-parishioners, belongs to the pastor. Other priests may do so only in case of necessity, and with the Blessed Sacrament 171, at least the presumed permission of the pastor or ordinary. Canon 848, 692. Any priest may privately bring Holy Communion to the sick with at least the presumed permission of the priest to whom the custody of the Blessed Sacrament is entrusted. When Holy Communion is administered privately to the sick, the reverence and respect due to such a sacrament should zealously be safeguarded, by observance of the regulations laid down by the Holy See. Canon 849, 693. The administration of the Holy Viaticum, whether public or private, belongs to the pastor, according to Canon 848. The exceptions to this canon are stated in Canons 397, n. 3 and 514. I_3. Canon 850, 694. The priest shall give Holy Communion either in fermented or unfermented bread, according to the rules of his rite. In case of urgent necessity, when there is no priest of another rite to be had, the priest of the Oriental rite, who uses fermented bread, may give Holy Communion in unfermented bread, and vice versa. Each one shall observe the ceremonies proper to his own rite. Canon 851, 695. Holy Communion is to be given only under this size of bread. Canon 852, Article 2. The recipient of Holy Communion. 696. Every baptized person not barred by law can and must be admitted to Holy Communion. Canon 853, 697. Children who, on account of their age, have not yet the knowledge and desire for this sacrament should not be given Holy Communion. In case of danger of death, Holy Communion may be given to young children, if they know to distinguish the Holy Eucharist from ordinary bread, and reverently adore it. Outside the case of danger of death, a deeper knowledge of Christian doctrine, and a more accurate preparation is justly demanded, to an extent that they know at least the mysteries of faith necessary as absolute means of salvation, and that they do approach Holy Communion with such devotion as can be expected from young children. The judgment of the sufficient disposition of children for 172. The New Canon Law. First, Holy Communion shall rest with the confessor of the children and their parents, or those who take the place of the parents. The pastor has the duty to watch that the children do not approach Holy Communion before they have come to the use of reason, and without sufficient knowledge. Wherefore he has the right to examine the children. It is the pastor's duty to see to it that the children who have attained the years of discretion and have sufficient instruction are as soon as possible strengthened by this divine food. Canon 854, 698. Notoriously unworthy Catholics, such as those excommunicated, interdicted, and of public bad repute, must not be admitted to Holy Communion until after their repentance and amendment is known, and satisfaction has been made for public scandal. Occult sinners who secretly ask for Holy Communion should be refused by the priest if he knows that they have not amended. If, however, they ask publicly and the priest cannot pass them over without scandal, he may give them Holy Communion. Canon 855, 699. No one who is conscious of mortal sin shall go to Holy Communion before making a sacramental confession, no matter how contrite he may be. If necessity urges the reception of Holy Communion, and there is no opportunity to go to confession, an act of perfect contrition should first be made. Canon 856, 700. No one is allowed to receive Holy Communion a second on time on the same day, except in the cases mentioned in Canon 858, 1. Canon 857, cf. Canon 864, 2. 701. Those who have not kept the natural fast from midnight are not allowed to receive, except in danger of death, or in case it should become necessary to consume the blessed sacrament to safeguard it against irreverence. The sick who have been laid up for a month without certain hope of speedy recovery, may, with the advice of the confessor, receive Holy Communion once or twice a week though they have taken medicine or some liquid food. Canon 858. The reader will notice that the Code extends the original concessions in favor of sick people. The decree of the S. Congregation of the Council, December 7, 1906, distinguished between the Blessed Sacrament 173, patients lying ill in a hospital or other place where the Blessed Sacrament was kept, and allow them to receive once or twice a week under the same conditions as mentioned in this canon, while patients in other places could receive only once or twice a month without observing the Eucharistic fast. 702. Each and every Catholic of either sex must, after having attained the years of discretion, receive Holy Communion once a year at least in the Easter season, unless at the direction of his priest he believes it proper to abstain for some time. The Easter Communion is to be received between Palm Sunday and Low Sunday. The local ordinaries have the right to extend this period for all the faithful of the diocese, if they think this necessary on account of the condition of people and place, from the fourth Sunday in Lent to Trinity Sunday, but no further. The faithful are to be advised to satisfy their Easter duty in their own parish church, and those who received in another church should take care to inform their pastor of the fulfillment of their Easter duty. If for any reason one has not made his Easter duty within the prescribed time, he is still bound by that precept. Canon 859, 703. The obligation of the Easter duty for children below the age of puberty rests principally on those who have the responsibility for the children, namely, parents, guardians, confessor, teachers, and the pastor. Canon 860, 704. The precept of receiving Holy Communion is not satisfied by a sacrilegious communion. Canon 861, 705. It is proper that priests who do not celebrate on Holy Thursday receive Holy Communion in the solemn, or conventual, Mass on that day. Canon 862, 706. The faithful should be admonished according to the decrees of the Holy See to receive the Eucharistic bread frequently, and even daily, and that those who assist at Holy Mass should not only communicate spiritually, but be prepared to receive in reality our Lord in the Holy Eucharist. Canon 863, 707. In danger of death, no matter from what cause the danger arises, the faithful are bound to the precept of receiving Holy Communion. 174. The New Canon Law. Though they have received Holy Communion the same day, they are to be strongly advised to receive again if in the course of the day they should come into danger of death. During the danger of death, the Holy Viaticum may, ac according to the judgment of the confessor, be administered repeatedly for several days. Canon 864, 708. The Holy Viaticum for the sick should not be deferred too long, and those who have the care of souls should see to it that sick people receive it while as yet fully conscious. Canon 865, 709. All the faithful of any rite are given permission for devotion's sake to receive the blessed sacrament consecrated in any rite. They are to be advised, however, that each one receive the Easter Communion in his own rite. The Holy Viaticum must be received in one's own rite, but in urgent necessity it is lawful to receive it in any rite. Canon 866. Article 3. Time and place for the distribution of Holy Communion. 710. Holy Communion may be distributed every day. On Good Friday, however, it may be given only in the form of the Holy Viaticum to the sick. On Holy Saturday, Holy Communion cannot be given to the people except in the Mass of the day, or immediately after the Mass is finished. Holy Communion is to be given only during those hours of the day when the celebration of Holy Mass is allowed, unless there is good reason to give it at other times of the day. The Holy Viaticum may be given any hour of the day or night. Canon 867, 711. The priest who says Holy Mass is not allowed to give Holy Communion during the Mass to people who are so far away from the altar that the priest has to go out of sight of the altar. Canon 868, 712. Holy Communion may be given wherever Holy Mass is allowed to be said, even in a private oratory, unless the bishop of the diocese should for good reasons have forbidden it in some particular case. Canon 869, The Sacrament of Penance 175, Title 4, The Sacrament of Penance, 713. In the Sacrament of Penance the faithful who are properly disposed receive pardon of the sins they have committed after baptism, by the judicial absolution of a legitimately appointed priest. Canon 870, Chapter 1, The Minister of the Sacrament of Penance. 714, A priest only is the minister of this sacrament. Canon 871, 715. Besides the power of orders, there is the power of jurisdiction, either ordinary or delegated, necessarily required in the minister for valid absolution from sins. Canon 872, 716. Ordinary jurisdiction for the hearing of confessions in the whole Church have, besides the Roman Pontiff, also the cardinals, and, in their respective territory, the local ordinaries, the pastor, and others who take the place of pastors. Ordinary jurisdiction have also the canon penitentiary of a collegiate church, according to Canon 401, and the superiors of exempt religious for their subjects, according to their constitutions. This jurisdiction ceases with the loss of office, according to Canon 184, and by incurring excommunication, suspension from office, and interdict after a declaratory or condemnatory sentence of the ecclesiastical judge. Canon 873, 717. Delegated jurisdiction to hear the confession, both of seculars and of religious, is given to secular priests as well as to exempt and non-exempt religious by the ordinary of the place where the confessions are to be heard. The religious, however, should not make use of this faculty without at least the presumed permission of their superiors. The rule of Canon 519, however, shall stand. The ordinaries of dioceses should not give to the religious habitual faculties to hear confessions unless they have been presented by their own superiors, and to those presented by their own superiors they should not deny this faculty without a serious reason. Canon 877 is, however, to be observed. Canon 874, 176. The New Canon Law. 718. In clerical exempt religious orders and congregations the proper superior, according to the constitutions, can give delegated jurisdiction to hear the confessions of the professed, the novices and of those who board in the religious house, mentioned in Canon 514, 1. This jurisdiction he may give also to secular priests and priests of another order or congregation. In local exempt orders the superior proposes the confessor who, however, must obtain jurisdiction from the ordinary of the diocese where the religious house is situated. Canon 875, 719. Revoking all contrary particular laws or privileges. All secular and religious priests need special jurisdiction to validly and licitly hear the confessions of any religious women, even of novices. Exceptions to this rule are contained in Canons 239, 1, n. 1, 522 and 523, which canons refer to the faculties the cardinals have to hear confessions of seculars and religious anywhere. The other canons refer to the confessions of religious made in any church, public or semi-public oratory, where any approved priest can hear religious women, and to cases of serious illness when the sick sister may call any approved priest to hear her confession. Outside these cases therefore no priest can hear the confession of sisters in their convents without being specially approved for the sisters. This faculty is to be given by the ordinary of the diocese where the house of the sisters is situated, according to Canon 525. Canon 876, 720. Both, the bishop and the religious superior, should not grant faculties to hear confessions except to those who by examination have been found capable, unless there is question of priests whose theological learning is plainly known from other sources. If, after the faculty has been granted, serious doubt arises as to whether the priest who is approved continues to be capable, those who approved him may recall him for examination, even though there is question of a pastor or a canon penitentiary. Canon 877, 721. Delegated jurisdiction or permission to hear confessions can be given with certain restrictions. The bishop and religious superiors should, however, not limit the jurisdiction or permission too much without a reasonable cause. Canon 878, 722. Jurisdiction must be given either in writing or ex minister of the sacrament of penance. 177. Pressed in words in order to be valid for the hearing of confessance. No compensation can be demanded for the granting of jurisdiction. Canon 879. 723. The bishop and the religious superior should not revoke or suspend the jurisdiction or permission to hear confessions except for a serious reason. For grave reasons the bishop may deprive of the faculties to hear confessions even pastors and penitentiaries, who may, however, take recourse to the Holy See, but must in the meantime abide by the orders of the bishop. The bishop is not allowed without consulting the Holy See to deprive all the confessors of a religious community at one and the same time of their faculties, if there is question of so-called formed houses. Canon 880. 724. All priests, seculars as well as religious, approved for confessions in some diocese, either with ordinary or delegated jurisdiction, could also hear and absolve those who have no domicile, called vagi, and those who belong to another diocese or parish, and Catholics of any Oriental rite. Those who have ordinary jurisdiction can absolve their subjects anywhere in the world. Canon 881. 725. In danger of death any priest, though he be not approved for confessions, may validly and licitly absolve all penitents from all sins and censures, no matter in what manner they are reserved and how public their censure is, though there be present an approved priest. There are two modifications to this rule, one contained in Canon 884, which will be seen there, and the other in Canon 2252, which orders that when the priest absolves a penitent in danger of death from a censure special immomodo reserved to the Holy See or from a censure inflicted by the Holy See or an ordinary by special sentence on the guilty person, recourse must be had to the Holy See in the one case, and to the authority that inflicted the censure in the other, for the imposition of a penance, if the sick person gets well. Canon 882. 726. All priests who make an ocean trip can hear confessions on board during the time of the voyage and absolve the faithful who travel with them, though the boat may pass through the diocese of other bishops or stay for a while in some. 178. The new canon law. Port, provided they have been approved for confessions either by the bishop of their own diocese, or by the bishop of the port where they take ship, or by the ordinary of any of the ports at which the boat calls. Whenever the boat stops at some port during the trip they may hear and absolve not only the people who for any reason come on board ship, but, if the priest goes ashore for a while, also those people who request him to hear their confession, in which case he may absolve also from sins reserved by the bishop of that place. Canon 883. 727. The absolution of the priest's own accomplice innocent of impurity is invalid except when that person is in danger of death. The priest absolves illicitly even in danger of death unless another priest cannot be had, or the calling of another under the circumstances would implicitly reveal the sin of the priest and of the sick person. The apostolic constitutions, and especially that of Pope Benedict XIV, Sacramentum Poenitentiae, thus declare. Canon 884. 728. Though the prayers attached by the Church to the formula of absolution are not necessary for the validity of the absolution, nevertheless they should not be omitted except for good reasons. Canon 885. 729. If the confessor cannot call in at the proper disposition of a penitent who asks for absolution, the priest must neither deny nor defer absolution. Canon 886. 730. The confessor should impose a salutary penance in proportion to the number and gravity of the sins, and accommodated to the condition of penitents, which penance they must see kept with a willing heart and perform personally. Canon 887. 731. The priest should remember that in the hearing of confessions H is to act the part of both judge and physician, and that he is appointed by God a minister of both divine justice and mercy, so as to safeguard the honor of God and provide for the welfare of souls. The priest must absolutely guard against inquiring about the name of an accomplice in sins confessed, and against attaining penitents with useless and too inquisitive questions, especially concerning the sixth commandment, lest he may by imprudent questions teach the youth what they should not know. Canon 888. Reservation of sins 179. 732. The sacramental seal is inviolable, wherefore the confessor must carefully watch himself not to betray the sinner by words or signs, or in any other way, for any reason whatsoever. The obligation of keeping the sacramental seal rests also with the interpreter, and with all other persons to whom knowledge of the confession has come in any way. Canon 889, 733. The confessor is absolutely forbidden to use the knowledge derived from confession in any manner disagreeable to the penitent, even though there be no danger of revelation. The actual superior, as well as the confessor who is made superior afterwards, cannot use the knowledge they have gained from confessions for the purpose of the external government in any way. Canon 890, 734. The master of novices and his associate, and the superior of a seminary or college, shall not hear the confessions of the pupils in their charge, except in particular cases where the novice or student for grave and urgent reasons should of his own accord ask them to hear his confession. Canon 891, 735. Pastors and others to whom the care of souls is entrusted by virtue of their office, are held under grave obligation of justice to hear, either in person or through others, the confessions of the faithful in their charge whenever they reasonably ask to be heard. In case of urgent necessity, all confessors are by the duty of charity obliged to hear the confessions of the faithful, and in danger of death any priest, though he is not approved or is under censure. Canon 892. Chapter 2. Reservation of Sins. 736. Those who have the ordinary power of giving to others faculties to hear confessions or to inflict censures, could also reserve some cases to their own tribunal and thus limit the power of absolution given to their priests. Though the vicar capitular and the vicar general have ordinary power to approve others for confession, the vicar capitular, with us the administrator of the diocese, cannot reserve cases, and the vicar general only by special mandate from the bishop. This restriction of jurisdiction is called the reservation of cases. 180. The new canon law. In reference to the reservation of censures, the rules of canons 2246 to 2247 are to be followed. Canon 893, 737. Among the papal reserved censures there is only one case reserved after the manner of reserved sins, namely the false accusation before ecclesiastical judges of an innocent priest, charging him with the crime of solicitation in confession. Canon 894, the Code, in Canon 2363, punishes this sin with excommunication reserved to the Holy See specially modo, which censures new. Papal censures as a rule are reserved in such a manner that the censure is the primary object of the reservation, so that a case ceases to be reserved if the censure was not incurred, be it through ignorance of the penalty or through any other excuse from the censure admitted in law. The case of Canon 894 is an exception from the general rule, and as the canon states, the only exception in papal cases. 738. The ordinaries of dioceses should not reserve sins until after a thorough discussion in the diocesan synod, or outside the synod with the cathedral chapter or the diocesan consultors and other experienced and prudent confessors, so as to make sure that the reservation will be really necessary, or at least useful. Canon 895, 739. The superior general, and the abbot of an independent monastery, with a respective council are the only superiors of religious who can reserve sins of their subjects. Canon 896, Canon 518. 1. Demands that in each house several confessors are to be appointed to whom the faculty to absolve from sins reserved in the orders must be granted. Canon 519 rules that a priest approved by the bishop of the diocese to whom a religious comes to confession may absolve him from all sins, even from those reserved in the order. Former concessions granting to exempt religious the right to make their confession to a priest not approved by the superior for the confessions of their subjects, had various restrictive clauses. For instance, that only when they were for an entire day away from the house, or that for a whole day there was no other priest of the order at home, etc. The present law does not place any such restrictions and revokes all contrary privileges. In the matter of confession, the privilege of exemption has therefore been considerably diminished for all exempt religious, but it has been done in the best interests of liberty in affairs of conscience. Reservation of sins 181, 740. The reserved cases should be few in number, namely 3 or at most 4, and they should embrace the more grievous and hideous external crimes specifically stated. The reservation should not remain in force longer than necessary for the extirpation of some inveterate public crime, or for the restoration of weakened Christian discipline. Canon 897, 741. The inferior authorities shall abstain from reserving to themselves sins which are by reason of the censure attached to the sin already reserved to the Holy See. They shall also as a rule refrain from reserving sins to which the law has already attached a censure that is not reserved. Canon 898. The Code, therefore, does not wish the ordinaries to make those sins which are punished with a censure by the laws of the code diocesan reserved sins, in case the papal censure was not contracted by the guilty person through ignorance of the censure or other excuses admitted in law. 742. The ordinaries of dioceses should see to it that once they have reserved some cases as seem to them necessary or useful, these reservations come to the knowledge of the people, and they should not grant faculty too freely to absolve from the reserved cases. The faculty to absolve from the bishop has reserved cases is granted by law to the canon penitentiary of cathedral and collegiate churches, and should be given habitually to the deans, with the power to subdelegate priests of their district for individual cases, especially in towns and districts far away from the episcopal city. By law the pastors, and others who come under the name of pastors in the code, have the faculty to absolve from the bishop has reserved cases, no matter in what manner they are reserved, during the time in which the Easter duty can be fulfilled, and the missionaries for the time of missions given to the people. Canon 899, 743. Any reservation ceases, 1. If the sick who cannot leave the house make their confession, and when those about to be married confess, 2. Whenever the legitimate superiors has refused the faculty to absolve asked in an individual case, and also in cases where the confessor judges that the faculty to absolve cannot be asked from the proper superior without great inconvenience to the penny. 182. The new canon law. Or without danger of violating the sacramental seal. In ordinary cases, when the penitent cannot conveniently wait for absolution, he may be indirectly absolved from the bishop has reserved case and faculty obtained afterwards to absolve directly. 3. If the penitent who has fallen into a case reserved to the bishop goes outside the diocese, even for no other purpose than to get absolution, he can be absolved by any priest. If, however, the same case should perchance be reserved also in that other diocese, the priest cannot absolve the penitent because his jurisdiction over that sin is taken away from him. Canon 900, Chapter 3. The subject of the sacrament of penance. 744. Any person who has committed mortal sins after baptism, for which he has not yet received direct pardon through the power of the keys, is bound to confess all mortal sins which after a diligent examination of conscience he finds himself guilty of, together with the circumstances which may change the species of sins. Canon 901. 745. Mortal sins committed after baptism, and already directly remitted by the power of the keys, or venial sins, are sufficient but not necessary matter for the sacrament of penance. Canon 902. 746. Those who cannot make themselves understood any other way are not forbidden to confess through an interpreter if they wish to do so, and the interpreter is, as Canon 889, 2, states, held to the seal of confession in the same manner as the priest. Canon 903. 747. According to the Apostolic Constitutions, and especially according to the Constitution of Pope Benedict XIV, Sacramentum Poenitentiae, of June 1, 1741, the penitent has the duty to denounce to the ordinary or the sacred congregation of the Holy Office within 1 month the priest who is guilty of solicitation in confession. The confessor has the duty, under pain of mortal sin, to remind the penitent of this obligation. Canon 904. 748. All the faithful may, if the prefer, make their confession to a lawfully approved priest of any other Catholic rite. Canon 905. The place where confessions are heard. 183. 749. Each and every one of the faithful of either sex have the obligation, from the time they attain the use of reason, to confess all their sins truthfully at least once a year, that is to say, all their mortal sins which have not yet been properly confessed and directly remitted by absolution. Canon 906, 750. He who makes a sacrilegious, or intentionally invalid confession does not satisfy the precept of confessing his sins. Canon 907, Chapter 4. The place where confessions are heard. 751. The proper place for sacramental confession is the church, or a public or semi-public oratory. Canon 908, 752. The confessional for hearing the confessions of women shall always be placed in an open and conspicuous place, and as a rule in a church or public or semi-public oratory appointed for women. The confessional must be so constructed that between the penitent and the confessor there is an irremovable grate with small holes. Canon 909, 753. The confessions of women are not to be heard outside the confessional, except in case of illness or any other real necessity, and under the precautions prescribed by the bishop of the diocese. The confessions of men may be heard also in private houses. Canon 910. Chapter 5. Indulgences. Article 1. Concession of indulgences. 754. All the faithful should hold in great reverence the indulgences which the ecclesiastical authority grants from the treasury of the Church. Indulgences given to the living are granted in the form of absolution from temporal punishment due for sins already pardoned as to their guilt, and if granted to be gained for the faithful departed they are applied in the form of suffrage, because the Church has no longer jurisdiction over the faithful once they have passed this life. Canon 911, 755. To the Roman Pontiff is committed by Christ the entire spiritual treasury of the Church, wherefore only the Pope, 184 the new canon law, and those to whom he has given participation in the power by law, have the ordinary power to grant indulgences. Canon 912, 756. Those inferior to the Roman Pontiff cannot, 1. Give to others the faculty to grant indulgences, unless the Holy See has expressly given them this indult. 2. Concede indulgences that are applicable to the poor souls. 3. Attach an indulgence to the same object, or the same pious work, or to a sodality to which the Holy See or another authority has already granted an indulgence, unless additional conditions are prescribed for gaining the indulgence. Canon 913, 757. The papal benediction with a plenary indulgence may be given in the prescribed form of the ritual by the bishop in his own diocese twice a year, namely on Easter Sunday and on an other solemn feast to be designated by him, though he only assist at the solemn Mass. Abbots and prelates nullius, vicars and prefects apostolic, though they are not consecrated bishops, may in their territory give the papal benediction on one of the more solemn feasts of the year. Canon 914, 758. Regulars who have the privilege to give the papal benediction are not only obliged to observe the prescribed form, but cannot make use of their privilege except in their own churches and in the churches of the nuns and of tertiaries legitimately aggregated to their order. They are not allowed to give it on the same day in the same place where the bishop imparts the papal benediction. Canon 915, 759. The bishops, abbots, prelates nullius, vicars and prefects apostolic, and the major superiors of clerical exempt religious, can designate and declare one altar privilege daily and forever, provided there is no other altar in the church that has already the same privilege, in their cathedral, abbatial, collegiate, conventual, parochial and quasi-parochial churches, not, however, in public or semi-public oratories unless they are united to the parish church, or subsidiary to it. Canon 916, 760. On All Souls' Day all Masses have the same privilege as though they were celebrated at a privileged altar. All altars of a church are privileged on days on which the 40 hours devotion is held. Canon 917, 761. In order to indicate that the altar is privileged noth, indulgences 185. Nothing else should be inscribed except privileged altar, with the addition of perpetual, or temporary, daily, or otherwise, according to the wording of the indult. For masses to be said at the privileged altar no larger stipend can be demanded by reason of the privilege. Canon 918, 762. New indulgences, also those granted to churches of regulars, must not be published without first consulting the bishop of the diocese. If, however, the indulgence has been published at Rome, For instance, by publishing the indult in the Ada Apostolicae Citus, they need not be submitted to the ordinary. In the publication of books, pamphlets, etc., containing a list of indulgences granted to various prayers and pious works, Canon 1388 is to be observed, which demands the approval of the bishop, and in certain instances that of the Holy See. Canon 919, 763. The person who obtained from the Roman Pontiff a concession of indulgences for all the faithful, is obliged, under pain of nullity of the concession, to place before the sacred penitentiary an authentic copy of the concession. Canon 920, 764. Plenary indulgences conceded for the feasts of our Lord and of the Blessed Virgin, are to be understood for those feasts only that are found in the universal calendar of the Church. A plenary or partial indulgence conceded for the feasts of apostles can be gained only on their dies natalis. A plenary indulgence granted, either daily and perpetually or for some time, to those who visit a church or public oratory is to be understood in such way that it can be gained any day but only once a year by any of the faithful, unless the indult expressly makes other provisions. Canon 921, 765. The indulgences annexed to feasts, or to sacred supplications and prayers in the form of novenas, or held for a week or 3 days either before or after the feast or during the octave, are to be considered transferred to that day to which the feast is legitimately transferred, if the transferred feast has an office and holy mass without solemnity and external celebration, and the transfer is made perpetual, or if either for a time or forever the external celebration of the solemnity is transferred. Canon 922, 766. In order to gain an indulgence affixed to a certain day, 186. The new canon law, for which the visit of some church or oratory is required, the visit can be made from noon of the preceding day until midnight of the day appointed for the indulgence. Canon 923, 767. In accordance with the rule of Canon 75, the indulgences attached to some church do not cease if the church should be totally destroyed but rebuilt within 50 years in about the same location and under the same title. Indulgences attached to prayer beads, and other religious objects, cease then only when the beads or other blessed articles cease to exist, or are sold. Canon 924, Article 2. Manner of gaining indulgences. 768. In order that one may gain for himself any indulgence he must be baptized, free from excommunication, in the state of grace at least at the end of the pious works prescribed, and a subject of the authority granting the indulgence. If a subject capable of gaining indulgences is to actually acquire them, he must have at least the general intention to gain them, and fulfill the prescribed good works at the stated time and in the manner required by the wording of the indult. Canon 925, 769. The plenary indulgence is to be considered granted in such manner that, if one cannot gain it for oneself as a plenary indulgence, he may gain it partially according to the disposition in which his soul is. Canon 926, 770. Unless the concession reads otherwise, the indulgences granted by the bishop can be gained by his subjects also outside the territory of the diocese, and likewise by transients and vogui, and by all exempt persons actually living in the diocese. Canon 927, 771. A plenary indulgence can be gained once a day only, though the prescribed work be performed repeatedly on the same day, unless the indult expressly allows the repeated gaining of the indulgence. Partial indulgences, on the contrary, may be gained repeatedly on the same day by repetition of the prescribed good work, unless the indult explicitly makes a restriction. Canon 928, 772. The faithful of either sex who, either for the sake of religious perfection, or study and education, or for the sake of health, lead a community life in houses established with the con. Indulgences 187. Sent of the ordinary of the diocese, and all other persons living there to do service, can gain indulgences for which the visit of some church or public oratory in general is required by visiting the chapel in the house, where they can by law satisfy their obligation of hearing Mass on Sundays and holidays of obligation, provided there is no public church or oratory attached to the institution, and that they fulfill the other good works prescribed for the gaining of the indulgence. Canon 929, 773. No person gaining an indulgence can apply it to other living persons. To the poor souls in purgatory all indulgences conceded by the Roman Pontiff may be applied, unless the contrary is stated in the indult. Canon 930, 774. The confession which may be demanded for any of the indulgences, can be made within 8 days immediately preceding the date to which the indulgence is attached. Holy Communion may be received the day previous, and both, confession and communion, could also be made during the octave of the feast. To gain the indulgences granted for triduums, or exercises for a week, etc., the confession and communion can be made within 8 days immediately following the conclusion of the exercises. The faithful who are in the habit to confess at least twice a month unless legitimately impeded, or who receive Holy Communion dodgily in the state of grace and with a good and holy intention, though they may abstain from receiving once or twice a week, can gain all indulgences without actual confession, for which otherwise confession would be a necessary condition. The indulgences of an ordinary or extraordinary jubilee, and those granted in the form of a jubilee, are accepted from this concession. Canon 931, 775. By good works to which one is held by law or precept the indulgence cannot be gained, unless in the concession of the indulgence the contrary is expressly conceded. Good works imposed as penance in sacramental confession, however, which may perchance be enriched with indulgences, serve both for satisfaction of the penance and for the gaining of the indulgence. Canon 932, 776. To one and the same object or place various indulgences from different titles can be annexed, but by one and the same good work to which by different titles various indulgences. 188. The new canon law are annexed. One cannot gain all these various indulgences, unless the good work prescribed is confession and Holy Communion, or the indult granting the indulgence expressly states the contrary. Canon 933, 777. If for the gaining of an indulgence prayer in general for the intentions of the Holy Father is prescribed, purely mental prayer is not sufficient, the vocal prayer may be chosen by the faithful, unless particular prayers are assigned. If a particular prayer is assigned, the indulgences can be gained by reciting the prayer in any language, provided there is certainty as to the exactness of the translation either by declaration of the sacred penitentiary or by the bishop of the diocese where the language, into which the prayer has been translated, is commonly used. The indulgences, however, cease by any addition, diminution or interpolation. For the gaining of the indulgence it suffices to say the prayers alternately with others, or to follow them mentally while they are recited by another. Canon 934, 778. The confessors can commute the good works demanded for the gaining of indulgences for people who on account of some legitimate impediment cannot perform these works. Canon 935, 779. Mutes can gain the indulgences attached to the recitation of public prayers by assisting with the faithful at the services and raising their hearts and minds to God. If there is question of private prayers it is sufficient that they say them mentally, or by signs, or by perusing them with their eyes. Canon 936. Title V. Extreme Unction. 780. The sacrament of extreme unction must be administered by the sacred anointings with properly blessed olive oil and pronouncing the words prescribed in the rituals approved by the Church. Canon 937. Chapter 1. The Minister of Extreme Unction. 781. This sacrament can be validly administered only by a priest. The recipient of extreme unction 189, with the exceptions mentioned in Canons 397, n. 3, and 514, 1-3, the pastor of the parish in which the sick person happens to be is the ordinary minister of extreme unction. In case of necessity, or with the permission at least presumed of the pastor or the ordinary, any other priest may administer this sacrament. Canon 938, 782. The ordinary minister is bound in justice to administer extreme unction, and in case of necessity any priest is bound to do so by the virtue of charity. Canon 939, Chapter 2. The recipient of extreme unction. 783. Extreme unction can be given only to the faithful who after having come to the use of reason fall into danger of death, either through illness or old age. In the same illness this sacrament cannot be repeated, unless the sick person recovered from the illness after receiving the sacred anointing and again relapsed into danger of death. Canon 940, 784. When there is doubt whether the sick person has attained the use of reason, or whether he is really in danger of death, or whether he is still alive, this sacrament is to be given conditionally. Canon 941, 785. This sacrament may not be given to those who are known to have stubbornly persevered in mortal sin without repentance. If there is doubt about their disposition, extreme unction may be given them conditionally. Canon 942, 786. Those sick persons who, while they were conscious, did implicitly ask for extreme unction, or would very probably have asked for it, may be given this sacrament absolutely, even though they are at the time deprived of the use of their senses. Canon 943, 787. Although extreme unction is not a sacrament absolutely necessary for salvation, no one is allowed to neglect it, and care should be taken that the sick receive it while they are yet fully conscious. Canon 944. Chapter 3. The Rites and Ceremonies of Extreme Unction. 788. The olive oil to be used in extreme unction must be 190. The New Canon Law. Blessed for that purpose by a bishop, or by a priest who has the faculty for this blessing from the Holy See. Canon 945, 789. The olam infirma urim is to be kept by the pastor in a neat and properly ornamented place in a receptacle of silver or white metal. He shall not keep it in his house except in the case provided for in Canon 735. Canon 946, 790. The anointings are to be performed with the words, and in the order and manner prescribed in the rituals. In case of necessity, however, one anointing of one of the senses, or rather on the forehead, with the prescribed shorter form, suffices, but the obligation remains to supply the other anointings when the danger ceases. The anointing of the loins is always to be omitted. The anointing of the feet may be omitted for any good reason. With the exception of a case of grave necessity, the anointings are to be made by the hand of the priest without the use of any instrument. Canon 947, Title VI. The Sacrament of Orders. 791. The Sacrament of Orders, by the institution of Christ, distinguishes in the Church the clergy from the laity, for the government of the faithful and the ministry of divine worship. Canon 948, 792. In the canons which follow, the term of major or sacred order signifies the priesthood, deaconship and subdeaconship. The term minor orders refers to acolytes, exorcists, lectors and ostiarius. Canon 949, 793. In law, the terms ordain, order, ordination, sacred ordination, comprehend, besides the episcopal consecration, the orders enumerated in Canon 949, and also the first tonsure, unless the contrary is plain from the nature of the case, or the context of the canons. Canon 950. Chapter 1. The Minister of Sacred Ordination. 794. The ordinary minister of sacred ordination is the bishop. The extraordinary minister is a person who, although not the sacrament of orders 191, possessing episcopal consecration, has received either by law or by a special indult of the Holy See the power to confer some orders. Canon 951, 795. No one is allowed without permission of the Holy See to promote to higher orders a cleric who has received some orders from the Roman Pontiff. Canon 952, 796. The episcopal consecration is reserved to the Roman Pontiff, so that no bishop is allowed to consecrate another bishop, unless he has first received the papal mandate. Canon 953, 797. The consecrating bishop must employ 2 other bishops to assist him in the consecration, unless the Holy See has dispensed from this rule. Canon 954, 798. Every cleric shall be ordained by his own bishop, or with his legitimate demissorial letters. The proper bishop shall ordain in person his own subject. Unless he is impeded by some just cause, he cannot, however, licitly ordain a subject belonging to an Oriental rite without an apostolic indult. Canon 955, 799. The proper bishop in reference to the ordination of seculars is only that bishop in whose diocese the candidate has a domicile, together with the birthplace, or only a domicile without having been born in the diocese. In the latter case, the candidate must take the oath that he has the intention to perpetually stay in the diocese, unless there is question of a cleric who has already been incardinated into the diocese by the first tonsure, or of ordaining an alumnus who is destined for another diocese, according to Canon 969, 2, or, finally, of ordaining a professed religious, according to Canon 964, n. 5. Canon 956, 800. The vicar and prefect apostolic, the abbot and the prelate nullius, if they have episcopal consecration, are held equal to the bishop in the matter of ordination. If they do not have episcopal consecration, they can never theos confer in their own territory during the time of their office the first tonsure and minor orders on their own subjects, as well as on others who have the dismissorial letters required by law. Ordination which was conferred beyond these limitations is null and void. Canon 957, 801. Demissorial letters for the seculars can be given, as long as they retain jurisdiction over their territory. 1. By the proper bishop after he has legitimately taken 192 the new canon law session of his diocese, according to Canon 334, 3, even though he is not yet consecrated. 2. By the vicar general, by special mandate of the bishop. 3. By the vicar capitular with the consent of the chapter after 1 year of vacancy of the bishopric. Before the end of the year he can give demissorials only to those who must be ordained on account of a benefice they have received or are to receive, or on account of some certain office which must be filled on account of the needs of the diocese. 4. By the vicar or prefect apostolic, the abbot or prelate nullius, though they do not have episcopal consecration, and they can give demissorials also for major orders. The vicar capitular should not give demissorials to those who were rejected by the former bishop. Canon 958, 802. He who can give demissorial letters for the reception of orders can also confer the orders himself, if he has the necessary power to confer orders. Canon 959, 803. Demissorial letters should not be granted until after all the prescribed testimonial letters have been received in accordance with Canons 9931000. If after the ordinary has given the demissorial letters new testimonial letters are necessary according to Canon 994, 3. The other bishop should not proceed with the ordination until he has received the testimonials. If the candidate has lived in the diocese of the ordaining bishop for the length of time sufficient to contract an impediment, according to Canon 994, the ordaining bishop himself should directly collect the testimonials. Canon 960, 804. The demissorial letters can be sent by the proper bishop, also by a suburban cardinal bishop, to any bishop in communion with the Holy See, with the exception of a bishop of a different rite from that of the candidate for orders, unless an apostolic indult has been obtained to send the candidates also to a bishop of a different rite. Canon 961, 805. Any bishop lawfully ordains a non-subject after having received the demissorial letters, provided he has no reason to doubt the genuineness of the letters. Canon 994, 3. Must also be observed in the case mentioned there. Canon 962, 806. The demissorial letters may be limited or revoked by the person who issued them, as well as by his successor in the Minister of Sacred Ordination 193 office, but once they have been granted they do not expire with the loss of office by the grantor. Canon 963, 807. In reference to the ordination of religious the following rules are to be observed. 1. The regular abbot in charge of a monastery, even without a territory nullius, can confer first tonsure and minor orders, provided the candidate is his subject by virtue of at least simple profession, and that the abbot is a priest, and has legitimately received the abbatial blessing. Otherwise the ordination given by the abbot is null and void, unless he is a consecrated bishop. All privileges to the contrary are revoked by the Code. 2. The exempt religious cannot be lawfully ordained by any bishop without the demissorials of their proper major superior. 3. The superiors can give simple professed religious, to whom Canon 574 refers, demissorial letters for first tonsure and minor orders only. 4. The ordination of members of any other religious organizations is regulated by the law for seculars, and every privilege is revoked by which the superiors could give to the temporary professed religious demissorials for major orders. Canon 964, 808. The bishop to whom the religious superior must send the demissorial letters is the bishop of the diocese in which is situated the house where the candidate for ordination lives as a member of that community. Canon 965, 809. The religious superior can send demissorial letters to another bishop in the following cases: if the bishop of the diocese gives permission, if the bishop should be of a different right from that of the religious, if he is absent, if he will not have ordinations on the next ordination days, cf. Canon 1006, 2, or, finally, if the diocese is vacant and the person in charge has no episcopal consecration. In each of these cases, however, the ordaining bishop must have an authentic statement from the episcopal curia concerning the reason why the religious may be sent outside the diocese for ordination. Canon 966, 810. Religious superiors are forbidden to send their candidates for ordination to another house of the order, thus defrauding the bishop of the diocese of his right, or to delay the 194. The new canon law. Ordination intentionally to such a time when the bishop will be absent or have no ordinations. Canon 967, Chapter 2. The subject of sacred ordination. 811. A baptized man only can validly receive orders. For the licit reception the candidate must by the judgment of his own ordinary have the qualifications required by the sacred canons, and must not be under irregularity or any other impediment. Those who suffer from irregularity or any other impediment, although it arose after the ordination and without their fault, are forbidden to exercise the orders they have received. Canon 968, 812. No secular shall be ordained, unless his own bishop judges him necessary or useful for the churches of the diocese. The bishop, however, is not forbidden to ordain his subjects for the future service in another diocese, excardination and incardination having been legitimately made. Canon 969, 813. The proper bishop and the major religious superior can forbid his clerics for any canonical reason, even occult ones, and without canonical trial, to receive higher orders. The cleric may have recourse to the Holy See, or also, in the case of a religious, to the Superior General. Canon 970, 814. It is unlawful to force anyone in any way, or for any reason, to embrace the clerical state, or to keep a properly qualified person from that state. Canon 971, 815. Care should be taken to receive the aspirants to sacred orders into the seminary from tender age. All candidates must stay in the seminary at least for the entire course of theology, unless the ordinary in particular cases dispenses from this rule for serious reasons. Those candidates for orders who, with the permission of the bishop, live outside the seminary, are to be given into the care of a responsible priest who shall watch over them and instruct them in the virtues. Canon 972. Article 1. Requisites for candidates of ordination. 816. First tonsure and minor orders are to be given to those only who intend to ascend to the priesthood, and of whom one can reasonably expect that they will be worthy priests. The subject of sacred ordination. 195. The cleric who has received some of the orders, and refuses to receive higher ones cannot be forced to it by the bishop, who neither can forbid him the exercise of the orders he has received, unless he is under a canonical impediment, or there is, according to the bishop's judgment, another serious reason. The bishop should not confer major orders on any candidate unless he is certain from positive reasons that the candidate is canonically fit, otherwise the bishop does not only sin gravely, but also exposes himself to the danger of cooperating in the sins of another. Canon 973, 817. In order that a candidate may be licitly ordained, the following is required: 1. Previous reception of confirmation. 2. Good moral character concordant with the order to be received. 3. The canonical age. 4. Requisite knowledge. 5. Reception of inferior orders. 6. Observance of the intervals between orders. 7. Canonical title, if there is question of major orders. In the consecration of a bishop, Canon 331 is to be observed. Canon 974, 818. Subdiaconship is not to be given before the completed 21st year of age. deaconship not before the completed 22nd, priesthood not before the completed 24th year of age. Canon 975, 819. Neither seculars nor religious are to receive first tonsure before they commence the theological course. Provided the candidate has the required age, subdiaconship is not to be given until the end of the 3rd year of the theological course, deaconship after the commencement of the 4th year, priesthood not until the beginning of the 2nd semester of the 4th year. By special concession of the Holy See to the Church in the United States, the course of theology has for the time of the war been shortened to 3 years. The raising of immense armies in which there is a great percentage of Catholic men, has necessitated the appointment of hundreds of chaplains to attend to the spiritual needs of the men. The time for the major orders will have to be arranged accordingly. The theological course must not have been made privately, 196 the new canon law, but in proper theological schools, according to the plan of studies prescribed by Canon 1365, Canon 976, 820. The orders must be given in proper succession, so that the skipping of any is absolutely forbidden. Canon 977, 821. In the ordinations the intervals of time between orders is to be observed, during which the clerics shall, according to the bishop's regulations, exercise the orders received. The interval between the first tonsure and the first minor order, as well as the intervals between the individual minor orders, are left to the judgment of the bishop. Between the last minor order and subdiaconship there must be 1 year's interval, between subdiaconship and deaconship at least 3 months, unless the necessity or utility of the diocese, according to the bishop's judgment, demand otherwise. Without special permission of the Roman Pontiff, minor orders and subdiaconship, or 2 major orders, cannot be given on one and the same day. All contrary custom is condemned. It is not even permitted to confer the tonsure in a minor order, or all minor orders on the same day. Canon 978, 822. For the secular clergy the canonical title is the title of benefice, or in default of a benefice, the patrimony or pension. The title by which one is ordained must be really certain for the whole life of the cleric, and truly sufficient for his proper maintenance, according to the rules to be laid down by the ordinaries for the various dioceses, and the conditions of time and circumstances. Canon 979, 823. If the cleric in major orders should happen to lose his title, he must provide for himself another, unless his bishop judges that his proper maintenance is provided for in another way. The persons, who, without an apostolic indult have knowingly ordained, or allowed to be ordained to major orders a subject without a canonical title, must assume obligation for themselves and for their successors, to furnish the needy cleric with proper sustenance, until other provision is made for his suitable maintenance. If the bishop ordained a candidate without a canonical title under an agreement that the one ordained shall not ask him for maintenance, such agreement is null and void. Canon 980, 824. If there is none of the titles of ordination, spoken of, irregularities and impediments 197. In Canon 979, 1. It may be supplied by the title of service of the diocese / and in places subject to the propaganda the candidates may be ordained by the title of the mission, in which case, however, the candidate must promise under oath to serve the diocese or the mission forever, under the authority of the local ordinary. The ordinary must give to the priest, who was promoted to major orders under the title of the service of the diocese or the mission, a benefice or office or support sufficient for his suitable maintenance. Canon 981, 825. For regulars the canonical title is the solemn religious profession, which is called the title of poverty. For religious with perpetual simple vows, the title of mensa communis, or congregations, or a similar one, according to their constitutions. All other religious are, also in reference to the title, governed by the law for seculars. Canon 982, Article 2, Irregularities and other impediments. 826. No perpetual impediment, called in law irregularity, whether ex defectu or ex delicto, is contracted unless it is expressly contained in the following canons. Canon 983, 827. The following persons are irregular ex defectu. 1. Illegitimates, both of public and occult illegitimacy, unless they have been legitimized or have made solemn profession. Canon 1116 explains in which cases illegitimate children are legitimized by subsequent marriage. 2. Bodily defective men who, on account of debility cannot safely, or for reason of deformity with due dignity, engage in the sacred ministry of the altar. To impede the exercise of lawfully received orders, a greater defect is required, and actions that can be properly performed are not forbidden by a supervening defect. 3. Epileptics, insane, possessed by the devil, who are or have been thus afflicted. If after reception of orders they became thus afflicted, but later on the malady beyond doubt disappeared, the ordinary may again allow his subjects the exercise of the orders they received. 4. Bigamists, by which the law understands men who contracted successively 2 or more valid marriages. This explana 198 The New Canon Law. The Code gives of bigamy settles questions of irregularity arising from the bigamia interpretativa, or any other. 5. Persons who have incurred by law the loss of good reputation. 6. A judge who has pronounced the sentence of death against some individual brought to trial. This irregularity is known under the name of defectus lenitatis in former commentaries of law. 7. Persons who held the office of executioner, and those who, of their own accord, undertook the office of immediate assistance in the execution of a death sentence. Policemen and others, that might be ordered to assist at and help in the execution of a criminal, are not voluntary assistants. Canon 984. It may be noted that the Code makes no mention of the former irregularity or defect arising from voluntary service in a just offensive war for all who killed or mutilated another in that war. 828. The following persons are irregular by crime: ex delicto. 1. Apostates from the faith, heretics, schismatics. 2. Men, who, outside the case of extreme necessity, allowed themselves in any way to be baptized by non-Catholics. 3. Married men, clerics in major orders, religious with solemn or simple perpetual or temporary vows, who attempt marriage or go through the civil formalities of marriage, and men who attempt marriage with a validly married woman, or with a sister bound by either perpetual or temporary vows. 4. Voluntary murderers, and those who procure abortion, if effective, and all cooperators. The common teaching of canonists held that all soldiers who took part in an unjust war and either killed or personally cooperated in the killing of others were irregular. The Code speaks only of voluntary murderers. In a war which is known to be unjust, those who volunteer for service and are instrumental in killing others are falling under the term of voluntary murderers, while those who are forced to take part in such a war could not be called voluntary participants. 5. Men who mutilated themselves or others, and those who attempted suicide. 6. Clerics practicing medicine or surgery forbidden to them, if thereby the death of a person is caused. Irregularities and impediments 199. 7. Men who usurp the exercise of an act of orders reserved to clerics in sacred orders, and also clerics in sacred orders who exercise such an act of major orders after they have been forbidden to do so by canonical penalty, either personal or local, corrective or punitive. Canon 985. 829. These crimes do not bring on irregularity unless they are mortal sins, committed after baptism, or in baptism as mentioned in Canon 985, 1, and external acts, either public or occult. Canon 986. 830. Simply forbidden to be ordained are the following: 1. The sons of non-Catholics, as long as their parents persevere in their error. 2. Married men for the time of their marriage. 3. Officials and administrators having an office forbidden to clerics, until they have resigned their office and settled all responsibility arising from such office or employment. 4. Slaves, properly so called, before they have obtained their liberty. 5. Men bound to the ordinary military service by the civil law may not be ordained until they have served their term. 6. Neophytes, until they are according to the judgment of the bishop sufficiently tried in their faith. 7. Those who are in ill repute on account of some public crime, until they have according to the bishop's judgment regained their good reputation. Canon 987, 831. Ignorance of the irregularities both ex delicto and ex defecto and of the impediments is not admitted as an excuse. Canon 988, 832. The irregularities and impediments are multiplied by the multiplication of the causes of irregularities or impediments, but the repetition of the same cause does not multiply the irregularity except in the case of deliberate homicide. Canon 989, 833. The ordinaries are allowed to dispense their subjects, or delegate others to dispense, from all irregularities incurred by secret crime except deliberate homicide and effective procuration of abortion, and other crimes brought before court. The confessor also has this faculty in more urgent occult cases, in which the ordinary cannot be asked, and there is imminent danger of great harm or of infamy, which faculty can, 200 the new canon law be made use of only for the purpose that the penitent may licitly exercise the orders he has already received. Canon 990, 834. In the petition for dispensation from irregularities and impediments, all irregularities and impediments must be specified. Otherwise a general dispensation will be valid for irregularities concealed in good faith, except voluntary homicide and effective abortion, but it will not be valid for those concealed in bad faith. If there is question of voluntary homicide, the number of crimes must be mentioned under pain of invalidity of the dispensation. A dispensation from irregularities to receive orders is generally valid also for major orders, and the one dispensed can obtain non-consistorial benefices, even those to which the care of souls is attached, but he cannot be made a cardinal, bishop, abbot or prelate nulls, nor major superior in clerical exempt orders. A dispensation from irregularities given in the internal, extra-sacramental form must be given in writing, and note must be made of it in the secret records of the curia of the respective ordinary. Canon 991, Chapter 3, Requisites prior to the ordination. 835. All candidates, both secular and regular, must in due time manifest their intention to receive orders to the bishop, or to others, who, in this matter take the place of the bishop. Canon 992, 836. The seculars, and those religious who, in the matter of ordination are held to the laws for seculars, cf. Canon 964, must, 1. Have the certificate of their last ordination, or if they are to receive first tonsure, the baptismal and confirmation certificates. 2. The certificate of studies required for the various orders, according to Canon 976. 3. The testimonials of the rector of the seminary, or of the priest in charge of those who do not board in the seminary, to testify to their good moral standing. 4. The testimonials of every ordinary in whose diocese the requisites prior to the ordination. 201. Candidate has stayed for such a length of time that he could contract a canonical impediment, cf. Canon 994. 5. The testimonials of the major superior, if the candidate is a religious. Canon 993, 837. The time in which a candidate may have contracted a canonical impediment, means a period of 3 months for soldiers, 6 months for others after their 14th year of age. The bishop can, however, demand testimonials also for a shorter period and for the time prior to the age of puberty. If the bishop in whose diocese a candidate has lived for a while, cannot ascertain anything definite about the behavior of the young man in question, so that he cannot testify that he did not incur a canonical impediment, or if the candidate has been living for a short time in so many dioceses that it would be either impossible or at least very difficult to obtain all the testimonials, the ordaining bishop shall demand of the candidate a so-called supplementary oath to prove that he is free from irregularity. If, after the testimonials were obtained and before ordination took place, the candidate did again live in the territory of the bishop who issued the testimonials, new testimonials are necessary if the stay extended for 3 or 6 months, as the case may be. Canon 994, 838. The religious superior must attest in his demissorial letters not only that the candidate for orders has made profession and is a member of the community in the diocese, but also concerning the requisite studies and other requirements of law. The bishop who has received these demissorial letters does not need any other testimonial letters. Canon 995, 839. Every candidate, whether secular or religious, must before ordination undergo an examination concerning the order which he is to receive. Those to be promoted to major orders shall have to take an examination also in other tracts of sacred theology. The bishop has the right to determine the method of examination and the subject matter in which candidates are to be examined. Canon 996, 840. This examination of both secular and religious candidates is to be made before the bishop of the diocese who has by law the right to ordain, or who gives demissorials to his subjects. He may also for a good reason leave it to the ordaining bishop, if the latter is willing to attend to this matter. 202. The New Canon Law. The bishop who ordains the subjects of another, whether secular or religious, with the demissorial letters of their superiors in which they testify that the candidates have successfully passed the examination demanded by the first paragraph of this canon, may accept this statement, but he is not obliged to do so. If he conscientiously believes that a certain candidate is not qualified, he should not promote him. Canon 997, 841. The names of the candidates for major orders, with the exception of religious and solemn or perpetual simple vows, should be announced in the parishes to which the candidates belong. The bishop may for good reasons dispense with the publication, or may demand that it be published also in other churches, or that in place of an announcement the names be posted at the door of the church and left there for several days, including at least one Sunday or holiday of obligation. The publication is to be made on a Sunday or holiday of obligation in the parochial mass, or on another occasion when there is a large gathering of people in church. If the ordination has not taken place within 6 months after the publication, it must be repeated unless the ordinary dispenses. Canon 998, 842. All the faithful are obliged in conscience to make known to the bishop or the pastor any impediment they may know of concerning the candidates. Canon 999, 843. The ordinary may demand of the pastor who has to make the publication, or of any other priest, to make a careful investigation concerning the character of the candidate, and to send the statement to the episcopal curia. The ordinary should not fail to make private investigation, if he judge this necessary or advisable. Canon 1844. The candidates for first tonsure and for minor orders shall make at least 3 full days of retreat, candidates for major orders at least 6 days. If within 6 months a candidate receives several major orders, the bishop can reduce days of retreat for deaconship to not less than 3 full days. If after the end of the retreat ordination is delayed for any reason for more than 6 months, the retreat must be made over again. In shorter delays the ordinary shall decide whether it should be repeated. This retreat is to be made by the religious in their own house. Time and place of ordination 203, or in another, according to the superioress judgment. The seculars shall make it in the seminary, or another place appointed by the bishop. The bishop is to receive a statement from the superior of the house of retreat that the candidates have duly made the exercises, and in the case of religious their own major superior shall make the statement. Canon 1001, Chapter 4. The rites and ceremonies of ordination. 845. In conferring any of the orders the bishop must faithfully follow the order of ceremonies laid down in the Roman Pontifical and other approved liturgical books. Canon 1002, 846. The Mass of ordination and of consecration of a bishop must always be said by the ordaining or consecrating bishop. Canon 1003, 847. If a cleric has received some orders in an Oriental rite, and afterwards obtains an indult of the Holy See to receive further orders in the Latin rite, he must first receive those orders of the Latin rite which are not given in the Oriental rite. Canon 1004, 848. All those who are promoted to major orders are obliged to receive Holy Communion in the Mass of ordination. Canon 1005, Chapter 5. Time and place of ordination. 849. Episcopal consecration must be given in Holy Mass on a Sunday or a feast of the Apostles. Major orders must be given in Holy Mass on the Ember Saturdays, Saturday before Passion Sunday, or Holy Saturday. For grave reasons the bishop may give major orders on any Sunday or holiday of obligation. First tonsure can be given any day and hour, minor orders on all Sundays and feasts of the rank of doubles, but only in the forenoon. Customs to ordain at other times than specified in this canon are disapproved and abolished. These times must be observed also by a bishop of the Latin Rite who, by apostolic indult, ordains a cleric of an Oriental Rite, and vice versa. Canon 1006. 204 The New Canon Law. 850 Whenever an ordination has to be repeated, or some ceremonies are to be supplied, whether absolutely or conditionally, it can be done also outside the prescribed ordination days and in secret. Canon 1007. 851 A bishop cannot, outside his own diocese, without permission of the local ordinary, give those orders which require the use of the mitre and crozier. The cardinals have the privilege of performing pontifical functions in any diocese, and need but notify the local ordinary, if they wish to pontificate in the cathedral, as Canon 239, 1, n. 15, decrees. Canon 1008. 852 The general ordinations should be held publicly in a cathedral church, in the presence of the cathedral chapter. If they are held in another place of the diocese, the more prominent church should be selected, and the clergy of the place should be present. The bishop is not forbidden, when occasion demands, to have special ordinations in other churches, or in the chapel of the episcopal residence, in the seminary, or in a religious house. The first tonsure and the minor orders may be conferred also in private oratories. Canon 1009. Chapter 6. Record and Testimonial of Ordination. 853. After ordination the names of those ordained, of the minister of ordination, also place and date, shall be recorded in a book specially set apart for that purpose in the episcopal curia, and all the documents required in the various ordinations shall be preserved. To each of the ordained clerics an authentic certificate of the orders received shall be given, which, if they were ordained by a strange bishop with demissorials from their own, they shall show to their ordinary so that record of the ordination be made in the episcopal curia. Canon 1010. 854 The ordinary in the case of seculars, the major superior in the case of religious, ordained with his demissorials, shall send notice to the pastors where those have been baptized who were ordained subdiacons, that the ordination may be entered in the baptismal record as Canon 470, 2, demands. Canon 1011. The Sacrament of Marriage. 205. Title 7. The Sacrament of Marriage. 855. Christ the Lord himself raised the matrimonial contract among baptized people to the dignity of a sacrament. Wherefore, among baptized people there can be no valid marriage contract unless it is at the same time a sacrament. Canon 1012. 856. The primary object of marriage is the procreation and education of offspring. The secondary purpose is mutual assistance and the remedy of concupiscence. The essential qualities of marriage are unity and indissolubility, which in the Christian marriage receives their peculiar firmness by reason of the sacrament. Canon 1013. 857. Marriage is favored in law, wherefore in a doubt the law insists on the validity of marriage until the contrary is proved. The exception to this rule in reference to the Pauline privilege will be seen in Canon 1127. Canon 1014. 858. The valid marriage of baptized people is called matrimonium ratum before its completion by the conjugal intercourse, and ratum et consummatum, if conjugal intercourse to which marriage of its nature tends has taken place, and by which the married become one flesh. If after the conclusion of the marriage contract the parties have lived together, consummation of the marriage is presumed in law until the contrary is proved. Valid marriage of unbaptized parties is called matrimonium legitimum. Invalid marriage is called matrimonium putativum, if it was contracted in good faith by at least one of the parties, until such time that both parties become certain of the invalidity of their marriage. Canon 1015. 859. The marriage of baptized persons is regulated not only by the divine law, but also by canon law, saving the competency of the civil power over the merely civil consequences of the marriage contract. Canon 1016. 860. The promise of marriage, whether one-sided, or bilateral, is null and void in either form unless it is made in writing and signed by the parties and either the pastor, or the local ordinary, or at least two witnesses. 206 The New Canon Law. If either one or both parties did not know how to write, or cannot write, as for instance, in accidents that injured the hand, etc., it is required for the validity of the engagement contract to note in the document the inability to write, and to employ an extra witness who shall sign the paper in addition to the persons mentioned in the preceding paragraph. The engagement to marry, though it be valid, and there be no just cause to shrink from its fulfillment, does not in law admit of action in the ecclesiastical court to force the other party to marriage. Action for possible injury done by the unjust breaking of the engagement is admitted in the ecclesiastical court. Canon 1017. 861. The pastor should not omit to prudently teach the people what they ought to know about marriage and its impediments. Canon 1018. Chapter 1. Requisites before marriage and specially the banns. 862. Before marriage is contracted it must be certain that there are no obstacles to its valid and licit celebration. In danger of death, if other proofs are not available, and there are no indications to the contrary, the sworn affirmation of the parties that they are baptized, and that there is no impediment to their marriage, suffices. Canon 1019. 863. The pastor whom the law entitles to assist at the marriage shall in good time inquire whether there is any impediment to the marriage. He should ask separately both the man and the woman whether they are under any impediment, whether they freely consent to the marriage, especially the woman, and whether they are sufficiently instructed in Christian doctrine, unless he knows otherwise that they are well instructed in their religion. The bishop of the diocese has the right to prescribe special regulations for this examination of parties before their marriage. Canon 1020. 864. Unless the parties were baptized in his own parish, the pastor must give the baptismal certificate of the parties, or of the Catholic party only in the case of a Catholic and an unbap. The banns of marriage. 207. Tized party to be married with the dispensation from disparity of cult. Catholics who have not yet received confirmation should first receive that sacrament, if they can do so without great inconvenience. Canon 1021. 865. The pastor should announce publicly the parties to be married. Canon 1022. 866. The banns of marriage are to be announced by the proper pastor of the parties. If a party has lived in some other place for 6 months after the age of puberty, the pastor should refer the matter to the bishop, who may either have the banns announced in that place, or otherwise order investigations made concerning the free state of the party. If there is any suspicion of some impediment, the pastor should refer the matter to the bishop even though the party has been living less than 6 months in another place, and the ordinary should not permit the marriage until all suspicion is removed by thorough investigation. Canon 1023. 867. The publication of the banns is to be made in church on 3 successive Sunday or holidays of obligation, during the Mass or at other services that are largely attended. Canon 1024. 868. The ordinary may also substitute in his diocese another form of publishing the banns, by posting the names of the parties at the church doors and leaving them there for at least 8 days, during which there must be 2 Sundays or holidays of obligation. Canon 1025. 869. Publication of the banns should be omitted in marriages contracted with dispensation from either disparity of cult or mixed religion, unless the ordinary judges that it should be permitted. This permission, however, can be given only when there is no scandal, and after apostolic dispensation from the impediment has been obtained, and no reference is to be made to the religion of the non-Catholic. Canon 1026. 870. All the faithful are obliged in conscience to manifest either to the pastor or to the bishop any impediment they may know concerning the marriage of the parties that are announced. Canon 1027. 871. The proper bishop of the contracting parties can for 208 The New Canon Law, legitimate reasons dispense from the publication of the banns, not only in his own diocese, but also in the diocese where the parties formerly lived. If the parties belong to 2 different dioceses, the bishop in whose diocese the marriage is to take place has the right to dispense. If the marriage is to be contracted outside either of the 2 dioceses, Either bishop is competent to dispense. Canon 1028, 872. If another pastor examined the parties and announced the bans, he should inform the pastor who is to assist at the marriage concerning these affairs. Canon 1029, 873. After the examination of the parties and the proclamation of the bans, the pastor should not assist at the marriage unless he has received whatever papers may be necessary, and wait 3 days after the last calling out of the bans, unless there is good reason to dispense with this rule. If marriage was delayed for 6 months after the announcement of the bans, they must be repeated, unless the ordinary decides otherwise. Canon 1030, 874. 1. The following rules are to be observed when doubt arises as to some impediment. 1. The pastor shall investigate the matter more accurately, and ask at least 2 trustworthy witnesses to make statement under oath, provided there is not question of an impediment that would bring disgrace upon the parties, and if necessary he may also put the parties under oath to make statement concerning the doubtful impediment. 2. He should continue or finish the announcing of the bans, if the doubt arose before the bans were published or during the time of their publication. 3. He should not assist at the marriage without consulting the bishop, if the doubt still continues. 2. When an impediment has been discovered with certainty. 1. If the impediment is secret, the pastor should continue the publication of the bans and refer the matter to the bishop or to the sacred penitentiary, not giving the names of the parties. 2. If the impediment is public and is discovered before the publication of the bans has been made, the pastor shall not announce the bans until the impediment is removed, though he may. Impediments in General 209. Know that a dispensation was obtained, but only for the internal form. If the impediment is detected after the first or second publication of the bans, the pastor should finish the publication and refer the matter to the bishop. 3. If there is neither a certain nor doubtful impediment, the pastor should admit the parties to the marriage contract when the publication of the bans is finished. Canon 1031, 875. The pastor shall not assist at the marriage of vagi. Canon 91, explains who are called vagi in law, except in a case of necessity, without referring the matter to the ordinary or a priest delegated by him for that purpose, and obtaining permission to assist at such marriages. Canon 1032, 876. The pastor shall not neglect to teach the parties to be married the sanctity of the sacrament of marriage, the mutual obligations of married people and the duty of parents toward the offspring. He shall also admonish them to make a good confession and receive Holy Communion before marriage. Canon 1033, 877. The pastor shall earnestly warn young people not to contract marriage against reasonable objections of their parents. If they nevertheless persist, against the lawful objection of their parents, the pastor shall not marry them, but refer the matter to the bishop. Canon 1034. Chapter 2. Impediments in General. 878. All persons may contract marriage unless forbidden by law. Canon 1035. 879. An impedient impediment contains a grave prohibition to contract marriage, but it does not invalidate a marriage contracted with such an impediment. A deramen impediment does not only forbid the marriage, but makes its celebration null and void. Though the impediment may be on the part of only one of the parties, marriage is nevertheless either illicit, or invalid, for both. Canon 1036, 880. An impediment is considered public in law when it can be proved in the external forum, otherwise it is occult. Canon 1037, 210. The New Canon Law. 881. The supreme authority of the Church alone has the right to authentically declare in what cases the divine law forbids or annuls a marriage. The same supreme authority has the exclusive right to constitute for the baptized people other impedient and deramen impediments of marriage, either by universal or particular law. Canon 1038, 882. The bishops can forbid anyone actually staying in their diocese, and their subjects also while they are outside the diocese, to marry, if there is some special reason, and for the time that the reason lasts. The Holy See alone can attach to its prohibition the pain of invalidity. Canon 1039, 883. The Roman Pontiff alone can abolish or modify the impedient or deramen impediments of marriage in the legislation of the Church, and no one else can dispense in these laws except in as far as is conceded to him either in the common law or by special indult of the Holy See. Canon 1040, 884. Custom introducing a new impediment of marriage or tending to change the existing impediments is disapproved by the Code. Canon 1041, 885. There are impediments of major and of minor degree. Impediments of minor degree are the following: 1. Consanguinity in the third degree of the collateral line. 2. Affinity in the second degree of the collateral line. 3. Public honesty, in the second degree. 4. Spiritual relationship. 5. The impediment of crime, arising from adultery with promise of marriage, or attempted civil marriage. All other impediments are of major degree. Canon 1042, 886. In urgent danger of death, the ordinaries can, for the sake of conscience and for the purpose of legitimizing offspring, dispense from the form of the contract as well as from any and all impediments of ecclesiastical law, public and occult as well as multiple, with the exception of impediments arising from the sacred priesthood and from the affinity in the direct line arising from consummated marriage. This dispensation they can apply to their subjects wherever these are at the time, and to all who actually are in the territory of their diocese. Scandal must, of course, be removed, and in case the dispensation is granted for impediments in general 211, disparity of cult, or mixed religion, the prescribed promises must be made. Canon 1043, 887. In the same circumstances as mentioned in the preceding canon, and only when danger is so urgent that there is no time to approach the ordinary, the pastor or priest who assists at the marriage, in accordance with Canon 1098, n. 2, and also the confessor, but the latter only for the internal forum and in sacramental confession, have the same faculties as those given to the bishops in the foregoing canon. Canon 1044, 888. The ordinaries can, under the conditions stated at the end of Canon 1043, if the impediment is discovered only after everything has been prepared for the marriage and the ceremony cannot be delayed until dispensation from the Holy See can be obtained without probable danger of great evil, grant dispensation from all the impediments mentioned in Canon 1043. This faculty holds good also for the convalidation of a marriage already contracted, if delay is dangerous and there is not sufficient time to recur to the Holy See. In the same circumstances all priests mentioned in Canon 1044 have the same faculties in occult cases and in emergencies when there is no time to recur to the bishop, or only with danger of violating the seal of confession. Canon 1045, 889. The pastor or priest spoken of in Canon 1044 who has granted a dispensation for the external forum shall at once inform the ordinary of this fact, and the dispensation shall be noted in the marriage record of the parish to which the parties belong. Canon 1046, 890. Unless the rescript of the sacred penitentiary contains other directions, it shall be the rule that dispensations granted by this tribunal for the internal, extra-sacramental, forum are to be recorded in the secret archives of the episcopal curia, and there is no need of another dispensation if afterwards the impediment becomes public. If the dispensation was granted for the internal sacramental forum only, a new dispensation would be required should the impediment become public. Canon 1047, 891. If the petition for a dispensation has been sent to the Holy See, the ordinaries should not in that case make use of their faculties, except for a serious and urgent reason. In such 212 the new canon law case reporting to the Holy See what they have done in the emergency. Canon 1048, 892. In marriages, whether contracted or to be contracted, he who has a general indult of dispensing from some certain impediment, can dispense from it even though the same impediment is multiple, unless it is stated differently in the indult. He who has a general indult to dispense from several impediments of various species, either diriment or impedient, can dispense from these impediments though they be public and occur in one and the same case. Canon 1049, 893. If he who has a general indult to dispense from several public impediments meets with a case where there is also another impediment from which he cannot dispense, he must ask the Holy See for dispensation from all impediments in the case. If, however, The impediment or impediments from which he can dispense are found out only after dispensation has been obtained from the Holy See. He may make use of his faculties. Canon 1050, 894. By a dispensation from an impediment, granted either by ordinary power, or by delegation in the form of a generalindult, the legitimation of the offspring, if the offspring is already born or conceived, is ipso facto granted, with the exception of adulterous or sacrilegious offspring. If dispensation is granted by rescript in particular cases, the legitimation is not given ipso facto, but must be specially asked for and obtained. One and the same rescript may, however, contain both the dispensation and the legitimation of offspring. Canon 1051, 895. The dispensation from the impediment of consanguinity and affinity given for some degree is valid although in the petition or in the concession there is an error concerning the degree, provided the degree that actually exists is inferior, or the impediment which was concealed is of the same species and of equal or inferior degree. Canon 1052, 896. The dispensation given by the Holy See from the matrimonium radum non consummatum, or the permission to marry again on account of the presumed death of the first partner, always includes the dispensation from the impediment of crime committed by adultery, and the promise of, or attempt at, marriage, if there is need of such a dispensation. But the impediment of crime incurred by adultery and the killing of the partner, impediments in general 213, by one of the adulterers, or by mutual cooperation of both, is not ipso facto included in the above dispensation, but must be specially obtained. Canon 1053, 897. The dispensation from an impediment of lesser degree, cf. Canon 1042, is not invalidated by positive lie or by concealing the truth, even though the only motive reason advanced in the petition be false. Canon 1054, 898. Dispensations from public impediments committed by the Holy See to the ordinary of the petitioners shall be executed by the ordinary who gave letters of recommendation to the petitioner of the dispensation, or who forwarded the petition to the Holy See, though by the time the dispensation arrives they have left the former diocese in which they had a domicile or a quasi-domicile with the intention not to return. The ordinary of the place, however, where they are to contract the marriage is to be advised of the dispensation which was granted by the Holy See. Canon 1055, 899. With the exception of a small charge for the necessary expenses of the Chancery Office for dispensations of those who are not poor, the bishop of the diocese and his officials are not permitted to demand any fee on occasion of granting a dispensation, unless the Holy See shall have explicitly given them this right. If they nevertheless exact any fee, they are held to restitution. All customs contrary to this rule are disapproved by the Code. Canon 1056, 900. The person who grants a dispensation in virtue of delegated powers received from the Holy See, must make explicit mention of the papal indult in granting the dispensation. Canon 1057. It may be noted in connection with the question of dispensation from impediments of marriage that a recent decree of the Consistorial Congregation, April 25, 1918, has revoked the special faculties which the bishops used to give for 3, 5, or 10 years. Several of these faculties referred to dispensation from marriage impediments. The Code, in Canons 1043 to 1045, gives the bishop the necessary faculties in urgent cases, and the mentioned decree grants to the bishops in America, the Philippine Islands, East Indies, Africa beyond the places along the Mediterranean Sea, and Russia, for 5 years, beginning with May 18, 1918, faculty to dispense from the impediments of 214. The new canon law, lesser degree mentioned in Canon 1042, and the senatio in ratus for marriages contracted invalidly on account of these impediments. The party who knows of the invalidity of the marriage is to be informed of the effects of the senatio. Furthermore, the same ordinaries receive faculty for 5 years to dispense from the impediments of major degree induced by canon law, either public or occult, and also multiple, with the exception of the priesthood and the affinity in the direct line after the consummation of marriage, and also from the impedient impediment of mixed religion, if after the petition for dispensation has been sent to the Holy See an urgent reason comes up making it necessary to grant the dispensation at once. Acta post. Citus, Volume X. Pag. 190. Chapter 3. Impedient Impediments. 901. Marriage is forbidden to those who have made the simple vows of virginity, of perfect chastity, not to marry, to receive major orders, or, to embrace religious life. No simple vow invalidates marriage, unless invalidity has been attached to it by the Holy See for some order, congregation, etc. Canon 1058. 902. In those countries where by the civil law marriage is forbidden on account of legal adoption, marriage is also by canon law illicit. Canon 1059. 903. The Church forbids most severely and in all countries marriage between a Catholic and an heretic, or schismatic. If there is danger of perversion for the Catholic party and the offspring, such marriage is also forbidden by the divine law. Canon 1060. 904. The Church does not dispense from the impediment of mixed religion unless 1. There are good and serious reasons, 2. The non-Catholic party promises to remove all danger of perversion of the Catholic party, and both parties promise that all their children shall be baptized and brought up as Catholics. 3. There is moral certainty that the promises will be kept. The promises are, as a rule, to be made in writing. Canon 1061. Impedient Impediments 215. 905. The Catholic party has the obligation to prudently work for the conversion of the non-Catholic. Canon 1062. 906. When the Church has given the dispensation from the impediment of mixed religion, the parties are not allowed, either before or after the Catholic wedding, to approach either in person or through proxies a non-Catholic minister as such, to give or renew the consent in the Protestant rite. If the pastor knows that the parties will certainly violate or have already violated this law, he shall not assist at their marriage, except for very serious reasons, and only after scandal has been removed, and the ordinary has been consulted. The Church does not censure parties who are forced by civil law to appear before a non-Catholic minister, who acts as an official of the government, but their intention must be to merely comply with the requirements of law and to gain the civil recognition of their marriage. Canon 1063. 907. Bishops and other pastors of souls shall, 1. Deter the faithful as much as they can from mixed marriages, 2. If they cannot prevent them altogether, they should by all means see to it that they are not contracted against the laws of God and of the Church. 3. Watch that those who contracted a mixed marriage in their own place, or come from other places, live up to their promises. 4. When assisting at a mixed marriage they shall observe Canon 1102, which demands that in such case no sacred ceremonies shall be made use of in witnessing the marriage contract. Canon 1064. 908. The faithful should likewise be discouraged from contracting marriage with those who have publicly given up the Catholic faith, though they have not joined a non-Catholic church, and with those who belong to societies condemned by the Church. The pastor shall not assist at such marriages without consulting his bishop, who, considering all circumstances, may permit him to assist at such a marriage, provided there are serious reasons, if the ordinary has good grounds to believe that the Catholic education of the children is sufficiently certain, and that 218 the new canon law about the death of his, or her, partner in marriage by physical or moral cooperation of the accomplice. Canon 1075. 919. The impediment of consanguinity is defined as follows. 1. In the direct line of consanguinity, marriage is invalid between persons of all degrees, for the legitimate descendants as well as the natural. 2. In the collateral or branch lines, marriage is invalid to the third degree inclusively, in such a manner, however, that the impediment is multiplied only as often as the common progenitors are multiplied. Cf. Canon 96 for further details on consanguinity. 3. Marriage shall never be allowed if there is any doubt as to whether the parties are of blood relation in any degree of the direct line, or in the first degree of the collateral line. Canon 1076. 920. The impediment of affinity. 1. Invalidates marriage in any degree of the direct line, and in the collateral line to the second degree inclusively. Canon 97 explains how affinity arises, and according to this canon the former impediment of affinity from sinful intercourse is dropped. 2. the affinity is multiplied, 1. As often as the impediment of consanguinity from which the affinity proceeds is multiplied, 2. By repeated successive marriage with a blood relation of the deceased partner in marriage. Canon 1077, 921. The impediment of public honesty arises from invalid marriage, whether consummated or otherwise, and from public and notorious concubinage. Marriage is invalidated in the first and second degree of the direct line between the man and blood relations of the woman, and vice versa. Canon 1078. The impediment from valid engagement is, therefore, abolished. 922. The spiritual relationship mentioned in Canon 768 only invalidates marriage between those who contracted spiritual affinity in baptism, namely between the person baptized, on the one hand, and the minister and the sponsors on the other. Canon 1079, 923. Those who by the civil law are declared incapable to marry on account of legal adoption, cannot equally under canon law contract valid marriage. The Church, therefore, in this, the Matrimonial Consent 219, particular impediment adopts the civil law and makes it also her own. To know whether there is a diriment impediment of relationship by adoption, and how far it extends, must be learned from the statute law of individual states. Canon 1080. Chapter 5. The Matrimonial Consent. 924. Marriage is effected by legally manifested consent of the parties qualified thereto by law, which consent cannot be supplied by any human authority. The matrimonial consent is an act of the will, by which either party gives and accepts the right to the body, a right both perpetual and exclusive, for the purpose of performing the actions apparent by their nature to procreate children. Canon 1081, 925. The matrimonial consent cannot be validly given unless the contracting parties know at least that marriage is a permanent union between man and woman, for the purpose of generating offspring. Ignorance concerning the nature of marriage is not presumed by law in persons who have attained puberty. Canon 1082, 926. Error concerning the individual person with whom one is to contract marriage renders marriage null and void. Error concerning any quality of the person, though such quality caused one to contract marriage, renders marriage invalid only in two cases: 1. If the error concerning a certain quality amounts to an error of the person; 2. If one contracts with a person who is believed to be free when he, or she, is in fact a slave properly so called in countries where slavery still exists. Canon 1083, 927. The mere error concerning the unity and indissolubility, or sacramental dignity of marriage does not annul the matrimonial consent, even if such error cause the consent. Canon 1084, 928. The knowledge or opinion of the nullity of marriage does not necessarily exclude matrimonial consent. Canon 1085, 929. The internal consent of the mind is always presumed to correspond with the words or signs by which consent is manifested in the celebration of marriage. 216. The new canon law. The danger of perversion of the Catholic party is removed. Canon 1065, 909. If a public sinner, or a person known to be under censure, does not agree first to go to confession and be reconciled with the Church, the pastor shall not assist at his marriage, unless there is grave and urgent reason, concerning which he should consult the ordinary, if it is possible. Canon 1066. Chapter 4. Diriment impediments. 910. A boy under 16 years of age and a girl under 14 cannot validly contract marriage. Though marriage is valid when these years are completed, the pastors of souls should dissuade young people from marriage at an earlier age than is commonly the custom in the respective countries. Canon 1067, 911. Antecedent and perpetual impotency either on the part of the man or the woman, whether known to the other or not, and whether absolute or relative impotency, annuls marriage by the very law of nature. The Code does not define the nature of impotency and sterility, wherefore the former doubts concerning this question are not solved authoritatively. One point, however, is made clear in the text here following, namely, that in doubtful impotency, both in a dubium juris and a dubium facti, there is no prohibition of marriage. If the impediment of impotency is doubtful, either as to fact or as to law, Marriage is not to be forbidden. Sterility neither invalidates nor makes marriage illicit. Canon 1068, 912. He who is held by a previous marriage bond, though it be not a consummated marriage, cannot validly contract another marriage. The exception of the Pauline privilege will be explained in another canon. Though the first marriage be, for some reason, invalid or dissolved, it is not lawful for Catholics to contract another marriage before there is legal proof of the invalidity or the dissolution of the first marriage. Canon 1069, 913. The marriage between a person baptized in the Catholic Church, or received into the Church from heresy or schism, and a non-baptized individual is null and void. Diriment Impediments 217. If a certain party at the time of the marriage was commonly held to have been baptized, or if his baptism was doubtful, the validity of such marriage must, according to the rule of Canon 1014, be upheld until it is proved with certainty that one party was, and the other was not, baptized. Canon 1070, 914. The rules prescribed in Canons 1060 to 1064 for mixed marriages must be applied also to marriages where there is an impediment of disparity of cult. Canon 1071, Canon 1061 plainly states that the Church does not dispense from the impediment of mixed religion, and the same is to be said of the disparity of cult, unless there are grave and urgent reasons and the required promises are made. In the case of disparity of cult, the marriage would be invalid, if the conditions of Canon 1061 are not verified. 915. Clerics in major orders cannot validly marry. Canon 1072, 916. Likewise religious, who have taken solemn vows, or whose simple vows have by the special law of the Holy See the power to annul marriage, cannot contract a valid marriage. Canon 1073, 917. Between the man guilty of rape and the woman whom he abducts with the purpose of marriage there can be no marriage as long as the woman is in the power of the man committing rape. If the abducted woman, after having been separated from the man, and been placed at full liberty consents to marry that man, the impediment ceases. As far as the nullity of marriage is concerned, the forcible detention of the woman is held equal to rape, namely when the man by force detains the woman with the purpose to marry her in the place where she lives, or to which she came of her own free will. Canon 1074, 918. The impediment of crime invalidates marriage with the accomplice of the crime. 1. If a married person commits adultery by complete conjugal action and enters into a mutual promise of marriage with the partner in adultery, or if they attempt a civil marriage. 2. If a married person commits such adultery and one of the adulterers kills the husband, or wife, of the adulterer. 3. If a married person, without committing adultery, brings 220 the new canon law. If either one or both parties by a positive act of the will exclude marriage itself, or all right to the conjugal act, or any of the essential qualities of marriage, they contract invalidly. Canon 1086, 930. Marriage is also invalid if entered into by grave fear, or force, which an outside agency brought to bear upon a person unjustly, and by which the person was forced to choose marriage as a means to free oneself from the force or the threats. No other fear carries with it nullity of marriage, though it cause the contract. Canon 1087, 931. In order to validly contract marriage the parties must be in each other's presence, either in person or through proxy. The parties must express their marriage consent in words, and they are not allowed to use equivalent signs, if they can speak. Canon 1088, 932. For the valid marriage by proxy a special mandate to contract with a specified individual is required, and the mandate must be signed by the party issuing the same, and by the pastor or the ordinary of the place in which the mandate is given, or by a priest delegated by either pastor or bishop, or at least by 2 witnesses. The diocesan statutes may demand additional precautions. If the person issuing the mandate does not know how to write, this shall be noted in the mandate and an additional witness shall be employed, otherwise the mandate is void. If the person who gave the mandate recalled the same, or became insane, before the proxy contracted marriage in his name, the marriage is invalid, though neither the proxy nor the other party to the marriage knew about the retraction of consent. The proxy must in person execute the mandate, Otherwise the marriage is invalid. Canon 1089, 933. Marriage may also be contracted by means of an interpreter. Canon 1090, 934. The pastor shall not assist at a marriage to be contracted by proxy or through an interpreter, unless there is good reason for contracting in the unusual manner, and unless he is certain of the authenticity of the mandate or the truthfulness of the interpreter. If time permits, the pastor must obtain the bishop's permission to assist at such marriages. Canon 1091. The matrimonial consent 221, 935. The condition added to a marriage consent, and not retracted, is governed by the following principles. 1. If the condition is of the future and either necessary, or impossible, or sinful, but not against the essence of marriage, it is considered as not added to the contract. 2. If the condition is of the future and against the essence of marriage, it renders the marriage invalid. 3. If the condition is of the future and licit, it suspends the validity of the marriage. 4. If the condition is either of the past or the present, the marriage is valid if the condition is realized, but invalid if it is not realized. Canon 1092. This impediment must not be confused with the impediment of error spoken of in Canon 1083, which states that marriage is valid though there was a mistake concerning non-essential quality ties, for instance concerning health, poverty, family rank, etc., of the party. The marriage is held valid in law even though the one party deceived the other purposely concerning these non-essential qualities. If, however, one party to the marriage explicitly states any of these qualities as a condition without which he will not contract marriage, for instance, I will not marry you unless you are free from such a disease, the marriage is invalid if the condition is not realized. This right the Church grants to the contracting parties for their protection against deceit. 936. Though marriage was contracted invalidly on account of some dearment impediment, the given consent is supposed to persevere until there is certainty about its revocation. Canon 1093. Chapter 6. Form of the marriage contract. 937. Those marriages only are valid which are contracted either before the pastor or the ordinary of the place, or a priest delegated by either, and at least 2 witnesses, in conformity, however, with the rules laid down in the following canons, and save for the exceptions mentioned below in Canons 1098 and 1099. Canon 1094, 938. The pastor and ordinary can assist at marriage validly only, 1. From the day they have taken canonical possession of their benefice, according to Canons 334, 3, 1444, 1, or have 222 the new canon law entered upon their office, provided they are not excommunicated, interdicted, or suspended from office by a condemnatory or declaratory sentence of the ecclesiastical court. The interdict is here added, whereas the Nitamir spoke only of excommunication and suspension. There is also a difference in the manner of inflicting the censures. The Nitienteri declared the bishop or pastor incapable of assisting at marriage if suspended or excommunicated by public decree and by name, while the code speaks of inflicting of censures by the ecclesiastical court. Practically it is the same, for a public decree of excommunication, etc., cannot be issued except after a canonical trial. 2. Within the limits of their territory, in which they assist validly at the marriages not only of their subjects, but also of non-subjects. 3. Provided they are not forced to assist by violence or grave fear, and ask for and receive the consent of the contracting parties. The code drops the rogati et invitati of the Nitamir, namely that the pastor or bishop should have been requested or invited to witness the marriage. The pastor and the bishop who can validly assist at marriages may also give permission to another priest to validly witness marriages within the limits of the parish, or the diocese respectively. Canon 1095, 939. The permission given to another priest according to the preceding canon, must be granted to a specified priest for a specified marriage. General delegation cannot be given except to regularly appointed assistants, for the parish to which they are appointed, Otherwise the permission or delegation is invalid. The pastor and the bishop should not give permission to assist until after all that which the law requires for the proof of the free state of the parties has been complied with. Canon 1096, 940. The pastor and the bishop assist licitly at marriage only. 1. After they have lawfully ascertained the free state of the contracting parties, according to the regulations of the Code. 2. After they have ascertained that at least one of the parties has a domicile or quasi-domicile in the place of marriage, or has lived there at least for a month. In case of voggie it suffices that they are actually staying in the place. Form of marriage contract 223. 3. If the pastor cannot claim the parties as his subjects under the provisions of the preceding paragraph, he must obtain permission to assist either from the pastor or the ordinary where one of the parties has a domicile or quasi-domicile, or 1 month thus sojourn, unless there is question of voggie who are actually traveling and have no place of sojourn anywhere, or there is grave necessity which excuses from obtaining permission. In every case it shall be the rule that marriage be celebrated before the pastor of the bride, unless some just reason excuses. Marriages of parties of different rights shall be contracted in the presence of the pastor of the husband as right, unless a particular law rules otherwise. The pastor who assists at marriages without the permission required by the present canon cannot make the stole fee his own, but must forward it to the proper pastor of the contracting parties. Canon 1097, 941. If the pastor or ordinary, or a priest delegated by either, according to Canons 1095 and 1096, cannot be had or the parties cannot go to him without great inconvenience, the following rules are to be observed. 1. In danger of death marriage may be validly and licitly contracted in the presence only of 2 witnesses. Even apart from the danger of death marriage may be contracted without the presence of an authorized priest, if it can be prudently foreseen that this state of affairs, namely the difficulty to have an authorized priest witness the marriage, will continue for a month. 2 important modifications of the Niedermayer are contained in this canon. First, that in danger of death marriage can be contracted without a priest before 2 witnesses, and, second, that in places where a priest cannot be had or the parties cannot go to him, they need not wait for a whole month, if there is good reason to judge that the same conditions will continue for a month. 2. In either case, if there is another priest not delegated, for instance on vacation or visit, who can be present, he should be called and together with the witnesses assist at the marriage, but only the 2 witnesses are necessary for validity. Canon 1098, 942. To the form of marriage as demanded by the preceding canons are held. 224. The New Canon Law. 1. All persons baptized in the Catholic Church, and converts to the Church from heresy or schism, though the first mentioned as well as the converts should afterwards have fallen away, if they contract marriage among themselves. 2. Catholics, as described in the foregoing paragraph, who marry non-Catholics, either baptized or unbaptized, even after they have obtained a dispensation from disparity of cult, or mixed religion. 3. Catholics of Oriental rites who marry persons of the Latin rite held to this form of marriage. Saving the rule of 1, n. 1, of this canon, non-Catholics, whether baptized or unbaptized, are nowhere held to the Catholic form of marriage when they contract marriage among themselves. Exempt are also children of non-Catholics, who, though they were baptized in the Catholic Church, were reared from their infancy in the non-Catholic faith or in infidelity and without religion, when they contract marriage with non-Catholics. Canon 1099, 943. Outside the case of necessity, the sacred rites prescribed in the liturgical books approved by the Church, or laudable customs approved by the Church, shall be employed in the celebration of marriage. Canon 1100, 944. The pastor should attend to it that the couple receives the nuptial blessing, which can be given them also after they have lived in marriage for a long time, but it can be pronounced only in Holy Mass with the observance of the special rubric, and on all days with the exception of the days specified in Canon 108. The solemn nuptial blessing can be bestowed only by the priest, or by his delegate, who has the right validly and licitly to witness the marriage contract. Canon 101, 945. In a marriage between a Catholic and a non-Catholic, the questions eliciting the consent of the parties are to be put by the priest as demanded by Canon 1095, 1, n. 3. All sacred rites, however, are forbidden. If from this prohibition greater evils are foreseen to follow, the bishop may allow some of the usual church ceremonies with the exception of the celebration of Holy Mass. Canon 1102, 946. After the celebration of marriage, the pastor, or he who takes his place, shall as soon as possible enter in the marriage record the names of the married couple and of the witnesses, the place and date, and other items prescribed in the rituals and the marriage of conscience. 225, Diocesan Statutes. The pastor shall make the entry even if another priest, delegated either by himself or by the bishop, bless the marriage. The pastor shall also, according to Canon 470, 2, note in the baptismal record that the parties contracted marriage in his parish on that day. If one or both parties were baptized in another parish, the pastor in whose parish the marriage was contracted shall send notice of the fact to the pastor where the parties were baptized, which he may do either directly or through the curia of his diocese. Whenever marriage was contracted according to Canon 1098, the priest, if there was one present, and otherwise the witnesses, must see to it that the marriage is entered in the two records. Canon 1103, Chapter 7, The Marriage of Conscience. 947. By a marriage of conscience is understood a marriage contracted without the publication of the banns and in secret. In accordance with the following canons, the bishop may allow such a marriage only for very grave and urgent reasons. The Vicar General cannot allow such marriages except by special mandate of his bishop. Canon 104, 948. The permission to contract a marriage of conscience imports the promise and grave obligation of observing the secret on the part of the assisting priest, of the witnesses, of the ordinary and his successors, and also of the contracting parties as long as one of the partners does not consent to the publication. Canon 1105, $49. This promise of secrecy on part of the ordinary does not bind him in cases where the keeping of the secret should cause scandal or grave injury to the sanctity of marriage, or when the parties do not have their children baptized, or give fictitious names to hide their parenthood, unless they give their true names to the ordinary within 30 days from the birth and baptism of the child, or, finally, when they neglect the Catholic education of their children. Canon 1106, 950. The marriage of conscience is not to be entered in the ordinary records of marriage and baptism, but is to be kept in the secret archives of the Curia. Canon 1107, 226. The New Canon Law. Chapter 8, Time and Place of Marriage. 951. Marriage may be contracted any time of the year. The solemn nuptial blessing only of marriage is forbidden from the first Sunday in Advent to Christmas, inclusively, and from Ash Wednesday to Easter Sunday, inclusively. The bishop may permit marriage in these seasons for a good reason, even with the nuptial blessing, as decided by S. R. C. June 14, 1918, but the parties must refrain from too much pomp. Canon 1108, 952. The marriage between Catholics shall be contracted in the parish church, in another church, public or semi-public oratory. It cannot take place without the permission of either bishop or pastor. In private houses the bishop may not permit the celebration of marriage except in some extraordinary case and for good reasons. In the churches or chapels of seminaries or of religious women, the ordinary should not allow the celebration of marriage except in urgent necessity and with due precautions. Marriages between a Catholic and a non-Catholic shall be contracted outside the church. If, however, the bishop judges that this rule cannot be insisted upon without causing other greater evils, it is left to his judgment to allow the marriage to take place in the church but without Holy Mass, as Canon 1102, 2 rules. Canon 1109, Chapter 9, Consequences of Marriage. 953. From valid marriage there arises between the married couple a bond perpetual and exclusive in its very nature. Christian marriage, moreover, gives to the parties who place no obstacle to it the grace of the sacrament. Canon 1110, 954. Either of the married parties possess, from the moment the contract has been concluded, equal rights and duties concerning the actions proper to conjugal life. Canon 1111, 955. Unless the special law rules otherwise, the wife shares in the state of her husband, as far as canonical effects are concerned. Canon 1112, 956. The parents are bound by a most serious obligation. Separation of married people 227. To provide to the best of their ability for the religious and moral as well as the physical and civil education of their children, and to care for their temporal well-being. Canon 1113, 957. Legitimate children are those conceived or born in valid marriage, or in marriage contracted in good faith though invalidly. If married people make solemn profession in a religious order, or if the husband receive major orders, the use of marriage is forbidden to them, and if by intercourse after such profession or ordination a child is conceived and born, it is not considered legitimate. Canon 1114, 958. As the father of a child is considered he who appears to be such by lawful marriage, unless there are evident arguments to prove the contrary. The children who are born at least 6 months after the date of marriage, or within 10 months from the dissolution of conjugal life, are in law presumed legitimate. Canon 1115, 959. By a subsequent marriage contracted validly, or in good faith, or by validation of marriage, though not consummated by conjugal intercourse, offspring is legitimized, if the parents were capable to contract marriage with each other either at the time of conception, or pregnancy, or birth. Canon 1116, 960. Children legitimized by subsequent marriage are, as far as canonical effects are concerned, held equal in all things to legitimate offspring, unless the canons explicitly make an exception. Canon 1117, Chapter 10. Separation of married people. Article 1. Dissolution of the marriage bond. 961. The valid marriage of Christians, consummated by the conjugal act, cannot be dissolved by any human authority for any reason. Death alone can dissolve the bond. Canon 1118, 962. Non-consummated marriage between baptized persons, or between a baptized and an unbaptized, is dissolved by law through solemn religious profession, as well as by dispensation of the Holy See, granted for a good reason at the request of either or both parties, or of one of them even though the other objects. Canon 1119, 228. The New Canon Law. 963. The valid marriage of unbaptized persons, though consummated, is dissolved in favor of the faith by the Pauline privilege. This privilege cannot be applied in a marriage between a Catholic and an unbaptized person if contracted with a dispensation from the disparity of cult. Canon 1120, 964. Before the converted and baptized party can validly contract a new marriage, he must first interpellate the unbaptized party. Canon 1125 contains some exceptions to this rule. The interpellation consists in this: that the convert is to ask, 1. Whether also the other party wishes to be converted and baptized; 2. In case the other party does not wish to be baptized, whether he, or she, is willing to live in marriage without offense to God, which is to say that he, or she, will not interfere with the religious obligations of the convert. These interpellations must always be made, unless the Holy See has decreed otherwise. Canon 1121, 965. The interpellations should as a rule be made in summary and extrajudicial form with the authority of the ordinary of the converted party, who is also entitled to grant the unbaptized party at his, or her, request a certain length of time to reflect before making answer, with a notification, however, that failure to answer within the specified time will be taken as a reply in the negative. Interpellations made privately by the converted party itself are also valid, and also licit, if the above-mentioned form cannot be observed, but in this case there must be proof of the interpellation by at least 2 witnesses or by other proof acknowledged in law. Canon 1122, 966. If the interpellations were omitted by permission of the Holy See, or if the unbaptized party should have given either explicitly or tacitly an answer in the negative, the baptized party has the right to contract a new marriage with a Catholic, unless after baptism he gave the unbaptized just cause for separation. Canon 1123, 967. The convert who after baptism lived again in marriage with the unbaptized party does not thereby forfeit the right to enter upon a new marriage with a Catholic, wherefore he can make use of his right, if the unbaptized party does afterwards change his mind, and, without the fault of the other party, separation of married people 229, separates, or does not live peacefully and without injury to the religious obligations of the converted Catholic. Canon 1124, 968. The Constitutions of Pope Paul III, Altitude June 1, 1537, of Pope Saint Pius V. Romani Pontificis August 2, 1571, of Pope Gregory XIII, Populus January 25, 1585, given to individual countries, are, as far as marriage is concerned, extended to all other countries in the same circumstances. The passages of these constitutions referring to marriage are given in the appendix of the Code. The Constitution Altitude refers to marriages of heathens who practice polygamy. The text seems to suppose that the husband as well as his several wives were all converted. If he remember not which was the first one he married, he shall take any one of them in contract marriage with her. If he remember which woman he married first, he shall dismiss the others and continue to live with the first. Dispensation is granted the converted heathens to marry, notwithstanding consanguinity, or affinity in the third degree. The Constitution Romani Pontificis deals with a case where a heathen has taken and dismissed several wives and married others. Finally he is converted and one of the wives he actually has is also converted. His first and only lawful wife has either been dismissed by him, or, if he still lives with her, it was not she that became a Catholic but one of the other wives. The Holy See allows that the man may continue to live in marriage with the one who became converted. Here dispensation is granted from the interpellation. The Constitution Populus gives faculties to the bishops, pastors, and priests, of the Society of Jesus to dispense from the interpellation in the cases of converts in Angola, Ethiopia, Brazil, and regions of India, who before baptism were married and whose partners in marriage were carried off into slavery, or otherwise separated, so that they could not easily be interpellated, or, if interpellated, did not reply within the time fixed for the answer, so that they may lawfully marry a Catholic of any right. If afterwards it should become known that the other party had become a Catholic by the time the second marriage took place, or that he had had no chance to reply to the interpellation, the second marriage is nevertheless to be considered firm and valid. Canon 1125, 969. The bond of the first marriage contracted in infidelity. 230. The new canon law is solved only when the converted party actually contracts a new and valid marriage. Canon 1126, 970. In doubtful cases the Pauline privilege enjoys the favor of law. Canon 1127, Article 2. Separation from bed and board. 971. The married couple is obliged to live together in conjugal relations, unless a just cause frees them from this obligation. Canon 128, 972. For reason of adultery of one party, the other has the right to solve even for all times the community of life, though the marriage bond remains, unless the other consented to the crime, or was the cause of it, or expressly, or tacitly, condoned it, or, finally, committed the same crime himself, or herself. Tacit condoning of the crime consists in this: that the innocent party, after having become certain of the crime, nevertheless continues to live with the other in marital relations. Such the law presumes to be the case, unless the innocent party within 6 months either expel or leave the guilty partner, or bring legal accusation against him, or her. Canon 1129, 973. The married person who, either upon sentence of the judge, or by his or her own authority lawfully leaves the guilty party, has no longer obligation to again admit the adulterer to conjugal life. The innocent party, however, has the right to admit the guilty partner, and to oblige him, or her, to return, unless he or she has in the meantime, with the consent of the innocent party, embraced a state of life contrary to marriage. Canon 1130. 974. Other reasons for separation. If one party joins a non-Catholic sect, or educates the offspring as non-Catholics, or leads a criminal and despicable life, or creates great bodily or spiritual danger to the other party, or if through cruelties he or she makes living together too difficult, and other such reasons, which are to the innocent party so many legal causes to leave the guilty party by authority of the ordinary of the diocese, or also by private authority, if the guilt of the other party is certain beyond doubt, and there is danger in delay. In all these cases the common life must be restored when the reason for the separation ceases. If, however, the separation, validation of marriage 231, was pronounced by the bishop either for a time, or indefinitely, the innocent party is not obliged to return except when the time specified has elapsed or the bishop gives orders to return. Canon 1131. 975. After the separation, the children are to be placed in charge of the innocent party, and if one of the parties is a non-Catholic, the Catholic party is to have charge over them, that they may be raised as Catholics, unless the ordinary decides differently for the sake of the welfare of the children, always safeguarding their Catholic education. Canon 1132. Chapter 40. Validation of marriage. Article 1. Simple validation. 976. In order to validate a marriage which is invalid on account of some dearment impediment, there is required either that the impediment ceases or is dispensed, and that at least the party conscious of the impediment renews the consent. This renewal of consent is required by ecclesiastical law for validity of the marriage, although in the beginning both parties gave their consent and did not afterwards revoke it. Canon 1133. 977. The renewal of consent must be a new act of the will for the marriage that is known to have been invalid from the beginning. Canon 1134. 978. If the impediment is public, the consent must be renewed by both parties, in the form prescribed by law. If it is occult and known to both parties, it suffices that the consent be renewed privately and secretly by both parties. If it is occult and known only to one party, it suffices that the party who knows of the impediment, privately and secretly renews the consent, provided the other party continues in its consent. Canon 1135. 979. Marriage which is invalid on account of want of consent is validated if the party which did not consent does now give the consent, provided the consent of the other party perseveres. If the defect of consent was merely internal, it is sufficient that the party who did not consent now gives consent by an internal act. 232. The New Canon Law. If the want of consent was manifested also outwardly, it is necessary to renew the consent outwardly, either in the form prescribed by law, in case the want of consent was public, or in some private and secret but outward manner if the want of consent was occult. Canon 1136. 980. Marriage which is null and void on account of the want of the prescribed form, must be validated by contracting in the form required by law. Canon 137. Article 2. Senatio in Gratis. 981. The senatio in radio e of marriage is its validation which imports, besides a dispensation from, or a cessation of, an impediment, a dispensation from the law of renewing the consent, and a retroaction, by fiction of law, in reference to the canonical effects in the past state while the union was invalid. The validation takes place at the moment of granting of this favor. The retroaction, however, is to be understood to reach back to the beginning of the marriage, unless it is expressly stated otherwise in the rescript. The dispensation from the law of renewing the consent can be given if one only or both parties are ignorant of the impediment. Canon 1138. 982. Any marriage contracted with the consent of both parties which would naturally suffice, but which consent is juridically ineffective on account of a dearment impediment of ecclesiastical law, or on account of want of the prescribed form, can be validated by the senatio in Gratis, provided the consent perseveres. Marriage contracted under an impediment of the natural or the divine law is not validated by the Church by means of the cessatio in ratis, though the impediment should have ceased afterwards, not even from the moment of the cessation of the impediment. Canon 1139, 983. If either in both or I one party consent has ceased to exist, the marriage cannot be validated by the cessatio in ratis, and this is true both in case here was no consent from the beginning, and also when it was first given and then revoked. If consent was wanting in the beginning but was given later on, the cessatio in ratis can be applied from the moment that consent was given. Canon 1140, Second Marriage 233, 984. The cessatio in ratis can be granted by the Holy See alone. Canon 1141, Chapter 12, Second Marriage, 985. Though chaste widowhood is more honorable, second and further marriages are valid and licit, provided that, according to Canon 1069, 2. The dissolution of the first marriage is proved. Canon 1142, 986. The woman who received the nuptial blessing once, cannot in a subsequent marriage again receive it. Canon 1143, Title 8. The Sacramentals. 987. Sacramentals consist of sacred objects and actions which the Church, in imitation of the sacraments to a certain extent, makes use of for the purpose of obtaining by her intercession favors, especially spiritual ones. Canon 1144, 988. The Holy See alone has the right to constitute new sacramentals, authentically interpret those in use, abolish or modify any of them. Canon 1145, 989. The legitimate minister of the sacramentals is the cleric who has received faculty to bestow them, and who has not been forbidden by the competent ecclesiastical authority to exercise this faculty. Canon 1146, 990. Consecrations no one can validly perform who is not a consecrated bishop, unless this faculty is given one either by law or by indult of the Holy See. Benedictions, with the exception of those reserved either to the Roman Pontiff, or the bishop, or others, may be given by any priest. A reserved benediction given by a priest without the necessary faculty, is illicit but valid, unless in the reservation the Holy See explicitly states that it cannot validly be given except by those to whom it is reserved or by those having special faculties. Deacons and lectors can validly and licitly give only those blessings which are explicitly permitted to them by law. Canon 1147, 234. The New Canon Law, 991. In the preparation and administration of the sacramentals, the rites prescribed by the Church must be accurately observed. Consecrations and blessings, both constitutive and invocative, are invalid if the formula prescribed by the Church is not employed. Canon 1148. Invocative benedictions are those by which God's blessing is called upon a person, object or place, e.g. blessing of infant, of edibles, of a house. Constitutive are those benedictions which render a person, object or place sacred, e.g. blessing of an abbot, church, sacred vessels. 992. Blessings are, first of all, to be given to Catholics. They may also be given to catechumens, and, where there is no prohibition of the Church, also to non-Catholics to obtain the light of faith and together with it bodily health. Canon 1149, 993. Consecrated objects, and objects rendered sacred by blessing, must be treated with reverence, and they are not to be used for profane purposes nor for purposes for which they are not intended, though these objects be owned by private individuals. Canon 1150, 994. No one who has the power to pronounce exorcisms can lawfully read them over those possessed unless he has received special and explicit permission from the bishop. This faculty should be granted by the bishop only to a priest who is distinguished for prudence and holiness of life. The priest shall not pronounce the exorcism until he has ascertained by prudent investigation that the person is really possessed by the devil. Canon 1151, 995. Exorcisms can be pronounced by the authorized men and sisters not only over the faithful but also over catechumens, over non-Catholics and excommunicated persons. Canon 1152. 996. The exorcisms which occur in baptism and in consecrations and blessings may be pronounced by the very same minute sisters who have the right to employ these sacred rites. Canon 1153. Part 2. Sacred Places and Seasons. Section 1. Sacred Places. 997. Sacred places are those which are blessed or consecrated either for divine worship or for the burial of the faithful. Churches 235. According to the rites prescribed by the approved liturgical books. Canon 1154. 998. The consecration of any place, though it belong to the regulars, pertains to the ordinary of the diocese or territory where such place is situated, provided the ordinary has episcopal consecration. The vicar general needs a special mandate of the bishop. Cardinals have the privilege to consecrate the church and altars of their title. The ordinary of the territory, though not possessed of episcopal dignity, may give faculty to any bishop of the same right to perform consecrations in his territory. Canon 1155. 999. The right to bless a sacred place belongs to the ordinary of the place if there is question of places belonging to the secular clergy, or to non-exempt religious, or to exempt lay orders. If it is a place belonging to a clerical exempt religious body, the major superior has the right to bless the place. Both the ordinary of the diocese and the major superior may delegate another priest for the blessing. Canon 1156. 1000. Notwithstanding any privilege, nobody may consecrate or bless a sacred place without the consent of the ordinary. Canon 1157. 1001. A document of consecration or blessing shall be drawn up, one copy to be kept in the episcopal curia, another in the archives of the respective church. Canon 1158. 1002. The consecration or blessing of any place is proved sufficiently by one absolutely trustworthy witness, if nobody else's rights are thereby injured. If there is legal proof of consecration or blessing, neither can be given again. In doubtful cases they may be repeated ad coelum. Canon 1159. 1003. The sacred places are exempt from the jurisdiction of the civil authorities, and in them the legitimate ecclesiastical authority freely exercises its jurisdiction. Canon 1160. Title 9. Churches. 1004. By the term church is meant a sacred building dedicated to divine worship, principally for the purpose that it serve all the faithful for the exercise of public worship. Canon 1161. 236. The New Canon Law. 1005. No church shall be erected without explicit permission in writing from the ordinary, which permission or consent the vicar general cannot give without a special mandate. The ordinary shall not give his consent unless he prudently foresees that the necessary means for the building and maintenance of the new church, for the support of the necessary minute sisters and the expenditures of the cult, will not be wanting. In order that the new church may not injure churches already established without proportionate spiritual benefit of the faithful, the ordinary before giving consent for the building of a new church shall hear the rectors of neighboring churches who are concerned. Canon 1676 gives to the parties who think themselves injured by the erection of a new church or other institution the right to object, and from the moment protest is made operations must come to a stop until a decision has been reached in the ecclesiastical court. Religious who have obtained permission from the ordinary to establish themselves in the diocese or in a city, must, before they build a public oratory or church, obtain approval of the location from the bishop. Canon 1162. 1006. The blessing and laying of the cornerstone of a church belongs either to the ordinary or to the major religious superior, the same as the blessing of a sacred place, according to Canon 1156. Canon 1163. 1007. The ordinaries should take care to have the churches built according to the approved traditions of ecclesiastical architecture, and in conformity with the laws of sacred art. In a church there must be no door or window opening into a house of lay persons. The space in the basement or above the church shall not be used for purely profane purposes. Canon 1164. 1008. Divine worship cannot be held in a new church before it has been solemnly consecrated, or at least blessed. If it can be foreseen that the church will be converted to profane purposes, the ordinary should not give his consent for the building of the same, and if it has already been built, he shall neither consecrate nor bless it. The solemn consecration ought to be given to cathedral churches and, as far as possible, to collegiate, religious and parochial churches. Churches 237. A church built of wood, or of iron or other metal, may be blessed but it cannot be consecrated. The altar may be consecrated without consecration of the church. In the consecration of a church, at least the major altar, and if it was already consecrated previously, another altar must be consecrated in the ceremony of its consecration. Canon 1165, 1009. The consecration of churches may be held any day. Sundays and holidays of obligation, however, are more becoming for this ceremony. The consecrating bishop and those who ask for the consecration must observe the fast the day before the consecration. When the church or an altar is consecrated, the officiating bishop, though he has no jurisdiction in the territory, concedes an indulgence of 1 year to those who visit the church or the altar on the day of consecration, and on the anniversary 50 days if a bishop consecrates, 100 days if an archbishop, 200 days if a cardinal. Canon 1166, 1010. The feast of the consecration of a church is to be kept annually according to the liturgical laws. Canon 1167, 1011. Each church which is either blessed or consecrated shall have its title, which it is forbidden to change afterwards. The feast also of the title of the church is to be observed each year, according to the liturgical laws. Churches cannot be dedicated in honor of beatified persons without permission of the Holy See. Canon 1168, 1012. It is desirable that each church have bells, by which the faithful may be invited to divine worship and other religious celebrations. The church bells must be either consecrated or blessed, AC according to the rite of the approved liturgical books. The use of the church bells is exclusively under the jurisdiction of the authorities of the church. With the exception of conditions stipulated by the donor of a church bell with approval of the ordinary, the bells must not be rung for merely profane purposes, except in case of necessity, or with the permission of the ordinary, or in accordance with legitimate custom. In reference to the consecration or the blessing of church. 238. The New Canon Law. Bells. The rules of Canons 1155 and 1156 shall be observed. Canon 1169, 1013. The Church does not lose its consecration or blessing unless it was totally destroyed, or the larger part of the walls collapsed, or it was reduced to profane purposes by authority of the ordinary, as provided by Canon 1187, Canon 1170, 1014. In the sacred edifice which has been legitimately blessed, all ecclesiastical rites may be performed, safeguarding the rights of parochial churches, and rights acquired by privilege, and legitimate customs. The ordinary may especially fix the hours for divine worship that they may not interfere with other churches. In churches of exempt religious, the bishop may not fix the hours for services, except in cases where the religious have no parish church and their services might interfere with the catechetical and gospel instructions in the parish church of the place. Canon 1171, 1015. Churches are desecrated only by the crimes here enumerated, if they are certain, notorious, and committed in the church itself. 1. The crime of homicide. 2. Sinful shedding of blood in considerable quantity. 3. Godless and sordid purposes for which the church was used. 4. Burial of an infidel, or of a person excommunicated by condemnatory or declaratory sentence. If the church is desecrated, the cemetery adjoining the church is not thereby desecrated, and vice versa. Canon 1172, 1016. In a desecrated church it is forbidden to hold divine worship, to administer the sacraments, and to have funeral services before it is reconciled. If the desecration happens during divine services, they shall immediately be discontinued. If during Holy Mass, before the beginning of the canon or after the communion, Mass must be discontinued at once, Otherwise the priest shall continue until the communion. Canon 1173, 1017. The desecrated church shall be reconciled as soon as possible with the sacred ceremonies prescribed in the approved liturgical books. If the desecration of the church is doubtful, it may be reconciled ad coelum. Canon 1174, 1018. A church which has been desecrated by the burial of an excommunicated or of an unbaptized person, shall not be Churches 239. Conciled before the body is removed, if the removal can be accomplished without grave inconvenience. Canon 1175, 1019. A church that is blessed can be reconciled by its rector, or by any other priest with at least the presumed permission of the rector. The reconciliation of a consecrated church belongs to either the bishop or the major religious superior, according to Canon 1156. In case of grave and urgent necessity, if the bishop cannot be approached, the rector of a consecrated church may reconcile it, notifying the ordinary afterwards. Canon 1176, 1020. The reconciliation of a blessed church can be done with ordinary holy water. The reconciliation, however, of a consecrated church is to be done with holy water specially blessed for that purpose with the ceremonies prescribed by the liturgical laws. It may be blessed not only by the bishop but also by the priest who reconciles the church. Canon 1177, 1021. All persons concerned must see to it that such cleanliness is observed in church as is becoming to the house of God. Business transactions and fairs and sales, though held for a pious purpose, shall be kept away from the church, and, in general, everything that is not in accordance with the sanctity of the place. Canon 1178, 1022. The churches enjoy the right of refuge, so that a criminal who has fled into it may, except in urgent necessity, not be taken out of it without the permission of the ordinary, or at least of the rector of the church. Canon 1179, 1023. The title of basilica cannot be given to any church except by apostolic indult, or by immemorial custom, and its privileges likewise are derived either from custom or from indult of the Holy See. Canon 1180, 1024. The admission to the sacred functions in church must be absolutely gratuitous, all contrary custom being disapproved. Canon 1181, 1025. The administration of goods intended for repairs and decoration of the church, and conducting of services, belongs, with the exception of special cases and privileges, to the ordinary together with the chapter if there is question of the cathedral church, but to the collegiate chapter if the church is collegiate, and to the rector in the case of other churches. Canons 240. The New Canon Law 1519 to 1528 concerning the administration of church property must likewise be observed. The offerings made for the benefit of the parish, or the mission, or a church situated within the limits of the parish or mission, are administered by the pastor of the church or by the rector of the mission, unless there is question of churches which have an administration of their own, distinct from that of the parish or mission, or the special law or legal custom rule differently. The pastor, missionary, rector of a church, both secular and religious, must administrate the offerings in accord with the regulations of the sacred canons and give account thereof to the ordinary of the place, as provided by Canon 1525. Canon 1182, 1026. If fathers, either clerics or laymen, are admitted to the administration of the goods of any church, they shall all act as an administrative council under the presidency of the ecclesiastical administrator, mentioned in the preceding canon, or his delegate. The members of the administrative board are to be chosen by the ordinary or his delegate, unless special laws provide otherwise, and they can be removed by him for a grave reason. Canon 1183, 1027. The administrative council is to care for the proper administration of the church revenues, according to Canons 1522 and 1523, but they may not interfere in any way in all those things that belong to the spiritual care of the parish, especially, 1. The exercise of worship in the church, 2. How and when to ring the church bells, the maintaining of order in church and in the cemetery, 3. To determine the manner of prayer, announcements and other affairs belonging in any way to divine worship and the solemnity of the same. 4. The care of altars, communion rail, pulpit, organ, place for the choir, pews, offering boxes and other objects belonging to the exercise of religious worship. 5. The judgment as to the fitness of sacred utensils and other things destined either for use in the divine worship, or for the decoration of church and sacristy. Churches 241. 6. The writing and keeping of the church records and documents belonging to the archives of the parish. Canon 1184. 1028. The sacristan, singers, organist, choir boys, workmen for the cemetery, and all others serving the church, are appointed, depend on, and can be dismissed by no one but the rector of the church, saving lawful customs and agreements, and the authority of the ordinary. Canon 1185. 1029. Unless there are special legal customs, or agreements, or an obligation placed on individuals by the civil law, the obligation of maintaining the cathedral church building rests with the persons here mentioned in the following order. 1. If the church as such has revenues, these are to be used for repairs of the church edifice, but the revenues necessary to carry on divine worship and the ordinary administration of the church must not be touched. 2. The bishop and the canons of the cathedral are held to defray the expenditures for repairs in proportion to their income, but the salary that is considered necessary for their proper living must not be attached. 3. If the two preceding sources fail, the people of the diocese are to defray the repairs of the cathedral, but the ordinary should by persuasion, rather than by force, induce the people to furnish according to their means the necessary funds for the cathedral. The duty of repairing the parish church rests with the following in this order. 1. The revenues of the church itself. 2. The patron. 3. Those who derive some income from the church, according to the rate fixed by the ordinary. 4. The parishioners, who, however, should be induced by persuasion rather than by strict command. These rules with proper proportion should be observed also in reference to other churches. Canon 1186. 1030. If a church is so dilapidated that it cannot at all be used for divine worship, and if all means to repair it are wanting, the ordinary may turn it to some decent profane use. The obligations with the respective funds, for instance, of foundation masses, and the title of the parish, if a parochial church, shall be transferred to another church appointed by the ordinary. Canon 1187. 242. The New Canon Law. Title X. Oratories. 1031. An oratory is a place destined for divine worship, not, however, with the principal object of serving the faithful at large as a house of worship. The oratory is called, 1. Public, if it has been erected indeed principally for the convenience of a body of men, or also for private individuals, but in such manner that all the faithful have the right to worship there, which right must be safeguarded to them by law to freely approach the oratory at least at the time of divine services. 2. Semi-public, if it has been erected for the convenience of some community or a body of the faithful who meet there, so that not everybody has the right to enter the place. 3. Private or domestic, if erected in a private house for the benefit of some family or of a private individual. Canon 1188. 1032. The oratories in the houses of cardinals and bishops, even titular ones, though private, have nevertheless all the rights and privileges given by law to semi-public oratories. Canon 1189. 1033. The small chapels erected in a cemetery by private individuals over their burial places have the nature of private oratories. 1034. Public oratories are governed by the same laws as churches. If, therefore, a public oratory has been dedicated to the public worship of God by blessing or consecration, under the authority of the bishop of the diocese in conformity with Canons 1155 and 1156, all sacred functions can take place there, except such that the rubrics do not allow in oratories. Canon 1191. 1035. Semi-public oratories cannot be erected without the permission of the ordinary. The ordinary shall not give this permission before he has inspected, either in person or through someone else, the place where the semi-public oratory is to be established, and has convinced himself that the place is in proper condition for the purpose. Once the permission has been granted, the place cannot be turned to profane purposes without the authority of the same ordinary. Altars 243. In colleges and other institutions for the education of youth, in high schools, castles, barracks of soldiers, prisons, hospitals, etc., there should not be erected other minor oratories besides the principal one, unless, according to the judgment of the ordinary, necessity or great utility make their erection advisable. Canon 1192, 1036. In semi-public oratories legitimately erected, all sacred functions can be held except such that the rubrics or the orders of the bishop exclude. Canon 1193, 1037. In private chapels and cemeteries, mentioned in Canon 1190, the ordinary may permit, also habitually, the celebration of several masses. In other private oratories he can allow only one mass for some extraordinary occasion and not habitually. The ordinary shall not give this permission except in conformity with Canon 1192. 2. Canon 1194, 1038. In private oratories which have received the indult of the Holy See to have Mass said there, the ordinary shall visit and approve of the place according to Canon 1192. 2. This having been done, one low Mass may be said there each day with the exception of the more solemn feasts of the Church. Other ecclesiastical functions shall not be held there. The ordinary may also for good reasons, other than those for which the indult was granted, allow Holy Mass and the more solemn feasts per modum actos, which means to say, not perpetually but by way of exception in a particular case. Canon 1195, 1039. Domestic oratories cannot be consecrated or blessed after the manner of churches. Domestic and semi-public oratories may either be blessed with the benedictio loci of the ritual or not at all, but they must be reserved exclusively to divine worship and may not be used for domestic purposes. Canon 1196. Title 11. Altars. 1040. In the liturgical sense there is understood, 1. By the term immovable or fixed altar, the upper table together with its support, consecrated as a whole. 2. By the term movable or portable altar, the stone, as a. 244 The New Canon Law. Rule small in size, which alone is consecrated and which is called portable altar stone, or sacred stone, or also the whole altar with table and support, which was, however, not consecrated as a whole. In consecrated churches at least one altar, principally the main altar, must be immovable. In blessed churches all the altars may be movable. Canon 1197, 1041. The table of an immovable altar, as well as the portable altar stone, must consist of one piece of natural solid stone. In the immovable altar the stone table must cover the entire altar and must be properly joined to the support. The support must be of stone, or at least the sides or columns on which the table rests must be of stone. The portable altar stone must be sufficiently large to hold the host and the larger part of the base of the chalice. In the immovable altar, as well as in the portable one, there must be the sepulchre containing the relics of saints as prescribed by the liturgical laws, closed with a stone. Canon 1198, 1042. In order that Holy Mass may be celebrated on such an altar, it must be consecrated according to the laws of liturgy, either as a whole in case of immovable altars, or the altar stone in case of movable altars. Every bishop, besides persons specially privileged, may consecrate portable altar stones. In reference to the consecration of immovable altars, the law of Canon 1155 is to be observed. The consecration of an immovable altar without the consecration of the church may take place any day. It is more becoming, however, to consecrate them on a Sunday, or a holiday of obligation. Canon 1199, 1043. The immovable altar loses its consecration if the table or mensa is separated from the support even for a moment's time, in which case the ordinary can allow a priest to again consecrate the altar with a shorter rite and formula. The immovable altar, as well as the portable altar stone, lose their consecration. 1. If they are considerably broken, either for reason of the size of the break, or for reason of the place of anointing. 2. If the relics are removed, or the cover of the sepulchre is broken or removed, excepting the case where either the bishop or his delegate remove the cover in order to fasten or repair it, or to substitute another, or to inspect the relics. Ecclesiastical Burial 245. A slight break of the cover does not induce desecration, and any priest can fill the crack with cement. The desecration of the church does not carry with it the desecration of the immovable or portable altars, and vice versa. Canon 1200, 1044. Just as the church has its title, so should also at least every immovable altar of the church have its own title. The primary title of the main altar should be the same as the title of the church. With the permission of the ordinary, the title of immovable altar may be changed, not, however, that of the immovable altar. Altars cannot be dedicated to the blessed, not even in the churches and oratories to which their office and mass is conceded, without permission of the Holy See. Canon 1201, 1045. Immovable as well as portable altars must serve only for divine services and specially for Holy Mass, to the exclusion of any use for profane purposes. Under the altar, bodies are not to be buried. Bodies which perhaps are buried near an altar must at least be 3 feet away from the altar. Otherwise it shall not be lawful to say Holy Mass on that altar until the body has been removed. Canon 1202, Title 12. Ecclesiastical Burial, 1046. The bodies of the faithful must be buried. Cremation is forbidden. If anyone has in any manner ordered his body to be cremated, it shall be unlawful to execute the desire, if this order has been attached to a contract, last will, or any other act. It is to be considered as not added. Canon 1203, 1047. Ecclesiastical burial consists in the transfer of the body to the church, the funeral services held over the same in church, and the depositing of it in the place lawfully appointed for the burial of the faithful departed. Canon 1204. Chapter 1. Cemeteries, 1048. The bodies of the faithful are to be buried in a cemetery which has been blessed according to the rites given in 246 the New Canon Law. The approved liturgical books, either with the solemn or simple blessing by the persons mentioned in Canons 1155 and 1156. In churches, bodies shall not be buried except those of residential bishops, abbots or prelates nullius in their own churches, or of the Roman pontiff, royal personages and cardinals. Canon 1205, 1049. The Catholic Church has the right to possess her own cemeteries. Where this right of the Church is violated without hope of regaining the same, the ordinaries should take care that the cemeteries belonging to the state are blessed, if those to be buried there are for the greater part Catholics, or at least that the Catholics may have a part of the cemetery reserved for themselves, which part is to be blessed. If even that much cannot be obtained, the individual graves ought to be blessed according to the ritual, each time the body of a Catholic is buried. Canon 1206, 1050. The laws of the canons concerning the interdict, violation, and reconciliation of churches, are to be applied also to cemeteries. Canon 1207, 1051. The individual parishes should have their own cemeteries, unless the ordinary should appoint one common cemetery for several parishes. The exempt religious may have a cemetery of their own, distinct from the common cemetery. Also other associations and private families may be permitted by the bishop to have a special burial place, apart from the common cemetery, to be blessed like the cemetery. Canon 1208, 1052. In parochial cemeteries the faithful may with the written permission of the ordinary, and in cemeteries proper to some ecclesiastical body with the written permission of the superior of that organization, construct for themselves and their relations special burial places. These they may, with the consent of the ordinary or the superior, also convey to others. The burial place for priests and clerics should, where it can be done, occupy a space, separate from the laity, in the more prominent part of the cemetery. Moreover, where it can be conveniently so arranged, a place should in this space be set apart for priests, and another for inferior ministers of the church. Funeral services 247. The bodies of infants should likewise be buried in a plot specially set apart for them, if it can be conveniently arranged. Canon 1209, 1053. Every cemetery should be well enclosed on all sides and carefully guarded. Canon 1210, 1054. The ordinaries of dioceses, and the pastors and superiors concerned, should see to it that in cemeteries there are not placed epitaphs, eulogistic inscriptions, and ornaments, out of harmony with Catholic faith and piety. Canon 1211, 1055. Besides the blessed cemetery there should be, if possible, a separate place well enclosed and guarded, where the bodies of those are to be buried to whom ecclesiastical burial was denied. Canon 1212, 1056. The body should not be buried, especially in cases of sudden death, until after such a length of time that is sufficient to remove all doubt of real death. Canon 1213, 1057. Without the permission of the ordinary it shall not be lawful anywhere to exhume a body which had received by the Church its final burial. The ordinary shall not allow to exhume a body unless it can with certainty be distinguished from other bodies. Canon 1214. Chapter 2. Transfer of the body to church, funeral services and interment. 1058. Unless a grave reason stands in the way, the bodies of the faithful are to be brought to church, where the funeral services are to be held according to the rite prescribed in the approved liturgical books. Canon 1215, 1059. The church to which the body is to be taken is by law the church which was the proper parish church of the deceased, unless the deceased legitimately elected another church for his funeral. If the deceased belonged to several parish churches, the parish in which he died is entitled to the funeral. Canon 1216, 1060. In a doubtful case as to the rights of another church the right of his own parish church always prevails. Canon 1217, 248. The New Canon Law. 1061. If a person died outside his own parish church, the body is to be brought to his nearest proper parish church for the funeral services, when the journey can be made on foot without inconvenience, otherwise to the nearest parish church in the place where he died. The ordinary may for his diocese determine under what conditions the body is, or is not, to be taken to the proper parish of the deceased. If the parish where the person died is not in the same diocese with his own parish, the rules of the ordinary of the place where the person died are to be observed. Though it be inconvenient to take the body to the church where the funeral should take place, or to the place of burial, the family, the heirs, and others who are concerned, have the right, provided they pay the expenses, to take the body to the parish church of the deceased, or to the church he lawfully chose for his funeral. Canon 1218, 1062. If a cardinal dies in the city of Rome, the body is to be transferred for the funeral services to the church which the Roman pontiff will appoint. If he dies outside the city, he is to be buried from the church highest in rank in the place of his demise, unless he chose another certain church for his funeral. The funeral of a residential bishop, also of those who are cardinals, abbots and prelates nullius, is to take place, if it can be conveniently done, in the cathedral, abbatial or prelatial church. If the body cannot be brought there, the church first in rank in the place where he died is entitled to the funeral. If they have chosen a church from which they desire to be buried, that church is entitled to the funeral. Canon 1219, 1063. Residential beneficiaries of a church are to be buried from the church where they hold a benefice, unless they have chosen another. Canon 1220, 1064. Professed religious and novices are to be buried from the church or oratory of their house, or from any house of the order or congregation. Novices may choose another church for their burial. If religious die outside the house, their religious superior has the right to conduct the funeral procession from the place where he died to the church where the funeral services are to take place. If the religious dies far away from any house of his order, and the superior does not wish to transfer the body to a house of funeral services 249, the order, which he is at liberty to do in accordance with Canon 1218, 3. The religious is to be buried from the parish church where he died, A novice may choose another church he prefers. The rules of this canon concerning the novices apply also to servants of the religious who continually live within the enclosure of the religious house. If they die outside the religious house, their funeral is regulated by Canons 1216 to 1218, Canon 1221, 1065. The persons who stayed in any religious house or college either as guests, or for reason of education or health, and died there, as also those who die in hospitals, are to be buried from their own parish church or from the church they chose for their funeral, according to Canons 1216 to 1218. Unless special law or privilege demand otherwise. Those who die in the seminary are, according to Canon 1368, to be buried by the rector who has parochial rights over the seminarians. Canon 1222, 1066. All the faithful, unless they are explicitly forbidden by law, as for instance professed religious, may choose a church from which they wish to be buried, as also the cemetery in which they desire to be interred. The wife, and children who have reached the age of puberty, are in this matter of free choice of the funeral church absolutely independent of the authority of husband and father. Canon 1223, 1067. The free choice of the church for their funeral is forbidden. 1. To children who have not reached the age of puberty. Parents or guardians may even after the death of these children choose any church from which they wish to bury them. 2. To professed religious of any rank or dignity, except those who are bishops. Canon 1224, 1068. The election of a church for the funeral in order to be valid must needs fall on a church which has a right to perform funeral services, namely either a parish church or a church of regulars, or another having this right by special privilege. In churches of convents of nuns funeral services cannot be held for outsiders, except of those women who permanently lived within the enclosure, either as servants, or for reason of education, sickness, housing. The patron of a church may be buried from the church of which he is the patron. Canon 1225, 1069. A person may choose church or cemetery either him. 250. The new canon law. Self or through another by his command, the election of the church for the funeral, or the mandate to choose for another, may be proved in any legal form. If the election is to be made by another, he may make use of the mandate even after the death of the person who gave the mandate. Canon 1226, 1070. The religious and the secular clergy are strictly forbidden to induce any person to vow, or swear, or otherwise promise, to choose their church or cemetery for burial, or not to change such election. If the clergy act against this rule, the election of the dying person is null and void. Canon 1227, 1071. If interment in a cemetery other than that of the proper parish of the deceased was desired by him, he shall be buried there, if those in charge of the cemetery do not object. If burial in the cemetery of the religious has been chosen by the deceased, the consent of the superior entitled by the Constitution to grant such permission is required and suffices. Canon 1228, 1072. If a person has a burial place of his ancestry and does not choose another cemetery for burial, he is to be buried there if his body can be conveniently transferred, or parents, heirs, etc., wish to transfer him. The wife shares the burial place of her husband, and, if she was repeatedly married, that of the last husband. If there are several burial places of ancestors or of the husband, the family of the deceased or the heirs shall select the place of burial. Canon 1229, 1073. The proper pastor of the deceased has not only the right but also the duty, except in case of grave obstacle, to conduct the body from the house to the church, and to conduct the funeral services either in person or through another. If the person died in the territory of another parish and the body can be easily brought to the deceased person's own parish church, the proper pastor may enter the parish of another pastor, notifying him of the fact, and conduct the funeral procession to his church. If the funeral is to take place in a church of regulars, or another church exempt from the jurisdiction of the pastor, The proper pastor has the right to conduct the body from the house to the church under the procession cross of the church, which has funeral services. 251. The funeral. The rector of the church which has been chosen for the funeral by the deceased conducts the funeral services. If the church chosen for the funeral is not exempt from the jurisdiction of the pastor, the celebration of the funeral services does not belong to the rector of the church, unless he can prove such right by special privilege, but to the pastor in whose territory the church is situated, provided the deceased was a subject of the pastor. The bodies of religious women and of their novices who died in the house, are carried by the sisters to the limit of the enclosure. From there, if there is question of sisters not subject to the pastor, the chaplain conducts the body to the church or oratory of the convent and conducts the funeral services. If the sisters are not exempt from the jurisdiction of the pastor, he conducts the funeral services. Concerning sisters who die outside their house, the general laws of the canons shall be observed. If a cardinal, or a bishop, die outside the city of Rome in a city where there is a bishop sc. the first dignitary of the canons of the cathedral has, according to Canon 397, n. 3, the right to conduct the funeral. If a body is sent to a place where the deceased did not have a parish of his own, nor where he chose a church for his funeral, the right to conduct all the funeral services, if they are to be held in that place, belongs to the cathedral church, or where there is no cathedral church, to the pastor of the church where the cemetery in which the body is to be buried is situated, unless the custom of the place or the diocesan statutes ordain otherwise. Canon 1230. 1074. The funeral services having been completed in the church, the body is to be interred in the cemetery of the same church, with the ceremonies prescribed by the rubrics of the liturgical books. The exceptions of Canons 1228 and 1229 in reference to the cemetery are to be observed. He who conducted the funeral services in church, has also the right and duty, excepting only a grave case of necessity, to conduct, either in person or through another priest, the body to the cemetery. Canon 1231. 1075. The priest who conducts the funeral procession to the church, or to the cemetery, has the right to pass through the territory of another parish or diocese with stole and cross, without the permission of the pastor or the ordinary. 252. The New Canon Law. If the body is to be buried in a distant cemetery, to which the body cannot conveniently be carried, the pastor or rector who conducted the funeral cannot claim the right to accompany the body outside the limits of the city or town. Canon 1232. 1076. The pastor cannot without a just and grave reason, to be approved by the ordinary, forbid secular clergy, religious and pious societies invited by the family, or the heirs to assist at the funeral procession and at the services in church. The clergy of the church where the funeral services are held should first of all be invited. Societies, and emblems, hostile to the church, shall under no circumstances be permitted at the funeral. Those who assist at the funeral must respect the orders of the pastor in the arrangement of the funeral procession, saving each one's rights of precedence. The clergy shall never carry the body of any lay person no matter what dignity he held, or to what family he belonged. Canon 1233. 1077. Ordinaries of dioceses shall, if such does not yet exist, draw up a schedule of funeral taxes or stipends for their territory, giving due consideration to the legitimate customs of particular places and the circumstances of persons and places. They shall consult the cathedral chapters, or diocesan consultors, in making these regulations, and if they think it advisable, they may also consult the deans and the pastors of the episcopal city. The schedule of taxes should for the various cases determine with moderation, and in such manner that all occasion for contention and scandal is removed, the rights of all concerned. If in the schedule several classes of funerals are enumerated, the party who arranges for the funeral is to have a free choice. Canon 1234. 1078. It is strictly forbidden to everyone to exact more than what the diocesan schedule allows for funerals and anniversaries. The poor shall be given decent funeral services and burial free of charge, according to the laws of liturgy and the diocesan statutes. Canon 1235. 1079. Whenever any of the faithful are not buried from their own parish church, The proper pastor is to receive the parochial portion of the funeral offerings, unless the particular law, burial granted or denied 253 grants a privilege of exemption from this law, or if the deceased could not conveniently be brought to his parish church. If a person had several pauper parishes, from any of which he could have easily been buried, and the funeral was held in another church, the parochial portion is to be divided between the various proper pastors. Canon 1236, 1080. The parochial portion solely is to be subtracted from the sum fixed by the diocesan tariff for the funeral services and burial. If for any reason on the day of burial there are only minor functions, and the first solemn service for the deceased is held within 1 month from the date of burial, the parochial portion shall be taken also for that service. The quantity of the parochial portion is to be fixed by diocesan schedule. If the parochial church of the deceased and the church which has the funeral belong to two different dioceses, the quantity of the parochial portion is to be reckoned according to the schedule of the diocese where the funeral takes place. Canon 1237, 1081. After the funeral, the minister shall mark down in the record of the deceased the name and age of the person, the names of parents or husband, date of death, the priest who administered the last sacraments, and what sacraments were given, as also time and place of burial. Canon 1238. Chapter 3. Persons to whom ecclesiastical burial must be granted or denied. 1082. Unbaptized persons must not be buried from a church, with the exception of catechumens who die without having, through no fault of theirs, received baptism, and are therefore to be counted among those baptized. All baptized persons are to receive ecclesiastical burial, unless they are explicitly deprived of it by law. Canon 1239, 1083. The following persons are to be deprived of ecclesiastical burial, unless they have before death given some signs of repentance. 1. Notorious apostates from the Christian faith, and persons notoriously known to belong to a heretical or schismatical sect, or to the Masons, and other societies of the same kind. 254. The New Canon Law. 2. Persons excommunicated or interdicted by condemnatory or declaratory sentence. 3. Culpable suicides. 4. Those dying in a duel or from wounds received in it. 5. Those who have given orders to cremate their body. 6. All other publicly known sinners. If in the foregoing cases some doubt arises, the ordinary must be consulted if time permits. If the case remains doubtful, the body should be given ecclesiastical burial but in such a manner that scandal is avoided. Canon 1240, 1084. When ecclesiastical burial had to be denied to a person, it is also forbidden to have for him any funeral mass, anniversary, or other public funeral services. Canon 1241, 1085. If it can be done without serious inconvenience, the body of an excommunicatus vitandus which had, against the laws of the canons, been buried in a sacred place, is to be exhumed with permission of the bishop, and to be buried in that part of the cemetery which is not blessed. Canon 1242. Section 2. Sacred Seasons. 1086. Sacred seasons are the holidays and the days of fast and abstinence. Canon 1243. 1087. The supreme authority of the Church alone has the right to establish, transfer and abolish holidays of obligation, and days of fast and abstinence, for the universal Church. Ordinaries of dioceses can for their territory appoint holy days of obligation, days of fast and abstinence only per modum actos, which means temporarily, not perpetually. Canon 1244, 1088. Not only the ordinary but also the pastor may in individual cases and for good reasons dispense individual subjects or individual families, also outside his territory, and transients in his territory, from the obligation of keeping the holidays of obligation, and from fast or abstinence, or from both, fast and abstinence combined. Ordinaries may also, for reason of great concourse of people on some special occasion, or for the sake of public health, dispense the whole diocese, or place, from the obligation of fast or of abstinence, or of both. Holidays of obligation 255. In clerical exempt religious communities, the superiors have for the religious and all those persons mentioned in Canon 514, 1, the same faculty as pastors. Canon 1245, 1089. The time of a holiday of obligation, as well as the day of fast or abstinence, is to be reckoned from midnight to midnight. For the gaining of indulgences, Canon 923 makes special provision. Canon 1246, Title 13, Holidays of Obligation, 1090. Holidays of obligation for the Universal Church are only the following: all the Sundays, the feasts of Christmas, Circumcision, Epiphany, Ascension, Corpus Christi, Immaculate Conception, Assumption, Saint Joseph, SS, Peter and Paul, and All Saints. The patron feasts are no longer holidays of obligation, but the ordinaries of dioceses can transfer the external solemnity to the next following Sunday. If any of the above-mentioned feasts have been lawfully abolished or transferred in some country, nothing should be done concerning these feasts without consulting the Holy See. In the United States, 4 of these feasts are abolished as holidays of obligation, namely Epiphany, Corpus Christi, Saint Joseph, and SS, Peter and Paul. Canon 1247, 1091. On holidays of obligation, Holy Mass must be heard and the people must abstain from servile work and from legal accessions, and unless legitimate custom or special indults make an exception, public sales, fairs and other public buying and selling are forbidden. Canon 1248, 1092. One may fulfill the obligation of hearing Mass by assisting at Holy Mass celebrated in any Catholic rite, either in the open air or in any church, public or semi-public oratory, and in the private chapels and cemeteries spoken of in Canon 1190, in the oratories and private houses. However, only those to whom the privilege is granted by the Holy See can fulfill the duty of hearing Mass. Canon 1249, Title 14, Fast and Abstinence, 1093. The law of abstinence forbids the eating of flesh meat and of broth made of meat, but does not exclude the use of eggs. 256. The New Canon Law. Milk and the products of milk, namely cheese and butter, and any seasonings of food, even those made from the fat of animals. Canon 1250, 1094. The law of fasting ordains that only one full meal a day be taken, but does not forbid a small amount of food in the morning and in the evening. As regards the kind of food, and the amount, that may be taken, the approved customs of one's locality are to be observed. One may partake of both fish and flesh meat at the same meal. The full meal may be taken in the evening and the collation at noon. Canon 1251, 1095. Abstinence only is enjoined on the Fridays throughout the year. Fast and abstinence are prescribed on the following days: Ash Wednesday, the Fridays and Saturdays in Lent, Ember Days, the Vigils of Pentecost, of the Assumption, of All Saints' Day, and of Christmas Day. Fast only is ordained for all the other days of Lent. On Sundays and holidays JF obligation, except on a holiday in Lent, there is neither fast nor abstinence, and if a vigil that is a fast day falls on a Sunday, the fast is not to be anticipated on Saturday but is dropped altogether that year. The Lenten fast and abstinence cease at 12 o'clock noon on Holy Saturday. Canon 1252, 1096. The foregoing canons make no change in particular indults. They do not affect the obligations imposed by a vow, either of individual persons or communities, nor alter the constitutions and rules of religious organizations and approved institutes of men or women living in community, even those without vows. Canon 1253, 1097. The law of abstinence binds all who have completed their 7th year of age. The law of fasting binds all who have completed their 21st year until the beginning of their 60th year. Canon 1254. In the matter of fast and abstinence days there remains some difficulty. 1. In reference to the particular fast days on Fridays in Advent which were of obligation in many dioceses in the United States, and, 2, in regard to the faculties of the bishops for the benefit of soldiers in the Army and Navy and of working divine worship. 257. People. A recent decree of the Consistorial Congregation, of April 25, 1918, seems to indicate that the Holy See desires uniformity of discipline also in the matter of fast and abstinence. To that end, the rules for abstinence days have been considerably mitigated, and for special occurrences Canon 1245, cited above, gives to bishops and pastors sufficient power to dispense from fast and abstinence. The 10, 5, 3 years faculties, and the brief of 25 years faculties, are specially mentioned by the decree as abolished. The indult for working people had, moreover, become unnecessary since the code makes liberal allowance for the use of flesh meat in Lent. Soldiers serving in army and navy usually received in the various countries special concessions, by which they were obliged to abstain only on a few days in the year from flesh meat. In the United States there were 6 of such days, namely, Ash Wednesday, the last 3 days of Holy Week, and the vigils of the Assumption of the Blessed Virgin and of Christ Mass. Since it is almost impossible for soldiers in actual service to observe the law of abstinence, since they have to take the food dealt out to them, the Holy See will certainly continue to release them from this law of the Church. This seems also indicated in number 3 of the decree referred to above, namely, that the concessions obtained by the ordinaries either on account of the present war, or for reasons of peculiar circumstances, are not included in this recall of faculties. In the formula of faculties, of the chaplains in the Army and Navy of the United States in the present war, the following days are enumerated as fast and abstinence days for the men in military service: Ash Wednesday, Vigil of Christmas, Good Friday and the forenoon of Holy Saturday. Part 3, Divine Worship. 1098. To the Blessed Trinity and to each of the 3 persons, and to Christ our Lord also under the sacramental species, is due the cult of Lituria, to the Blessed Virgin Mary the cult of Hyperdulia, to the other saints reigning with Christ in heaven the cult of Dulia. To sacred relics and images is due the veneration and cult proper to the person to which the relics and images refer. Canon 1255. 258. The New Canon Law. 1099. The cult which is exhibited, and offered to God, or to the saints and blessed, in the name of the Church by appointed ministers, in the form and manner prescribed by the Church, is called public, otherwise private. Canon 1256. 1100. The Holy See alone has the right to enact the form of the sacred liturgy, as well as to approve the liturgical books. Canon 1257. 1101. It is unlawful for the faithful to assist in any active manner, or to take part, in the sacred services of non-Catholics. Merely passive or material presence may be tolerated on account of a civil office, or for the purpose of showing respect to persons, to be approved in doubtful cases by the bishop for grave reasons, at funerals of non-Catholics, at their marriages, and similar solemnities, provided there is danger of neither perversion nor scandal. Canon 1258. 1102. Prayers and pious exercises in churches or oratories shall not be permitted without the revision and express permission of the bishop of the diocese, who in more difficult cases shall submit the entire matter to the Holy See. The ordinary of the diocese cannot approve new litanies to be recited publicly. Canon 1259. 1103. The ministers of the Church must depend solely on the authority of the ecclesiastical superiors in the exercise of worship. Canon 1260. 1104. The ordinaries should watch that in divine worship the rules of the sacred canons are faithfully observed, and that neither in public nor in private worship, nor in the private lives of the faithful, any superstitious practices are introduced, or anything contrary to faith, or to the ecclesiastical tradition, or anything that has the appearance of sordid profit-making. If the ordinary publishes any regulations concerning these matters, all his subjects are held to observe those rules, even the exempt religious, and he may visit their churches and public oratories for this purpose. Canon 1261. 1105. It is to be desired that, in harmony with the ancient discipline of the Church, the women should in church be separate from the men. The men should assist at divine services, either in church or outside of it, with uncovered heads, unless the approved customs of the people or peculiar circumstances demand the cult of the Blessed Sacrament. 259. Trary, The women should assist in modest dress and with heads covered, especially when they approach the table of the Lord. Canon 1262, 1106. Magistrates may, according to their rank and dignity, have a special place in the church, in as far as the liturgical laws permit this. Without the explicit permission of the ordinary, none of the faithful may have a pew in church reserved for himself and his family. The ordinary should not give his consent except where there are enough pews to accommodate the rest of the people. There is always the tacit understanding in these permissions that the ordinary may at any time for a good reason recall the permission, no matter for what length of time individuals have held such pews. Canon 1263, 1107. Musical compositions rendered either by the organ, or other instruments, or voice, which contain anything lascivious and improper must absolutely be kept out of church. The liturgical laws concerning sacred music shall be observed. Religious women, in as far as they are allowed by their constitutions and the laws of liturgy and of the bishop to sing in their own church or public oratory, shall occupy a place where they cannot be seen by the people. Canon 1264. Title 15. The keeping and cult of the Blessed Sacrament. 1108. The Blessed Sacrament may be kept in the following churches, if there is a person to guard it, and if the priest as a rule celebrates Holy Mass at least once a week in the place. 1. It must be kept in the cathedral church and in the principal church of an abbey and of a prelacy nullius, vicariate and prefecture apostolic, in every parochial and quasi-parochial church, and in a church attached to houses of exempt religious men and women. 2. It may be kept with the permission of the ordinary in collegiate churches and in the principal, public or semi-public, oratory of religious houses and charitable institutions, as also in ecclesiastical colleges in charge of either the secular clergy or of. In other churches and oratories it may be kept only by adult religious. 260. The New Canon Law of the Holy See. The ordinary can for a good reason grant this permission to a church or public oratory only per modum actos, that is to say, for a special occasion, not perpetually. No one is allowed to keep the Blessed Sacrament in his private house, or to carry it with him when traveling. Canon 1265, 1109. The churches in which the Blessed Sacrament is kept, especially parochial churches, should be open to the faithful for at least a few hours each day. Canon 1266, 1110. In a religious house, or pious institute, the Blessed Sacrament cannot be kept except in the church or principal oratory. And in the monasteries of nuns with solemn vows it cannot be kept inside the choir or the enclosure. All privileges to the contrary are revoked. Canon 1267, 1111. The Blessed Sacrament cannot habitually be kept on more than one altar of a church. It should be placed in the most prominent and best ornamented place in church and, therefore, as a rule on the main altar unless another altar is more convenient and appropriate for the veneration and cult of this great sacrament. The liturgical laws concerning the last 3 days of Holy Week are to be observed. In cathedral, collegiate and conventual churches in which choral functions are conducted at the main altar, it is, as a rule, more convenient not to keep the Blessed Sacrament on the main altar but on a side altar, in order that the Blessed Sacrament may not be an impediment to such functions. The rectors of churches should see to it that the altar of the Blessed Sacrament be above all others decorated and ornamented, so as to move the faithful to greater piety and devotion. Canon 1268, 1112. The Blessed Sacrament must be kept in an immovable tabernacle, placed in the middle of the altar. The tabernacle should be beautifully constructed, securely closed on all sides, properly ornamented in accordance with the liturgical laws, free from all other things, and guarded so well that there is no danger of profanation. For a grave reason and with the approval of the bishop it is lawful to take the Blessed Sacrament out of the tabernacle overnight and to keep it in a safer but decent place on a corporal, and with a light burning before it. Cult of the Blessed Sacrament. 261. The key of the tabernacle in which the Blessed Sacrament is kept must be most carefully guarded. This is a grave obligation of conscience on the part of the priest who has charge of the church or oratory. Canon 1269, 1113. A sufficient number of particles for the communion of the sick and of the faithful in general shall always be kept in a pyx of solid and respectable material, and it must be kept clean and well covered, and veiled with a veil of white silk. Canon 1270, 1114. Before the tabernacle in which the blessed sacrament is kept, there should burn at least one lamp day and night fed either with olive oil or beeswax. Where olive oil is not easily obtainable, the bishop may according to his prudent judgment allow the use of other oils, which should, as far as possible, be vegetable oils. Canon 1271, 1115. The consecrated hosts, either for the communion of the faithful or for the exposition of the blessed sacrament, must be fresh and are to be renewed frequently, consuming the consecrated species as prescribed, so that there may be no danger of corruption. The instructions of the ordinary in this matter must be faithfully observed. Canon 1272, 1116. Those whose work it is to give religious instruction to the faithful, shall not neglect to excite in their minds devotion towards the blessed Eucharist and to admonish them to assist at Holy Mass and to visit the blessed sacrament not only on Sundays and holidays of obligation, but also frequently during the week. Canon 1273, 1117. In churches and oratories that have received permission to keep the blessed sacrament, private exposition, that is to say with the ciborium, can be held for any good reason also without permission of the ordinary. Public exposition, that is to say, with the ostensorium, may be held in all churches on the feast of Corpus Christi and during the octave, both during Holy Mass and at Vespers. At other times, public exposition may be held only for good and serious reasons, with permission of the bishop, and this permission is required also in churches of exempt regulars. The exposition and reposition of the Blessed Sacrament may be done by either priest or deacon. The priest only can give benediction with the Blessed Sacrament. The deacon is not allowed to. 262. The New Canon Law. Give it except in the case where he, according to Canon 845, 2, takes the Holy Viaticum to the sick. Canon 1274, 1118. The 40 hours devotion shall as solemnly as possible be celebrated in all parochial and other churches where the Blessed Sacrament is habitually preserved on the days fixed by the bishop. Where the exposition cannot without great inconvenience or danger of irreverence be continued day and night for 40 consecutive hours, the ordinary should arrange that the exposition is held for several hours of the day on certain days. Canon 1275. Title 16. The Cult of the Saints, of Sacred Images and Relics. 1119. The veneration of the servants of God reigning with Christ, and of their relics and images, is good and useful. All the faithful should above all honor with filial affection the Blessed Virgin Mary. Canon 1276, 1120. Only those servants of God may be publicly venerated who have been inserted by the Church in the catalogue of the saints or blessed. Those proclaimed saints by the Church are to receive the cult of dulia, and they may be honored throughout the universal Church with any of the acts of that form of worship. The blessed, however, cannot be venerated publicly except in the places and in the form specified by the Roman Pontiff. Canon 1277, 1121. The saints of nations, dioceses, provinces, confraternities, religious organizations, and of other places and organizations, may laudably be chosen as patrons, and when the Holy See confirms such election they are constituted as the patrons. The blessed cannot be chosen without a special indult of the Holy See. Canon 1278, 1122. No one is without the approval of the ordinary allowed to place, or cause to be placed, in any church including those exempt, or in any other sacred places, an unusual picture. The ordinary shall not approve sacred images, to be exposed to the veneration of the faithful, that do not agree with the approved usage of the Church. The ordinary shall not allow in church and other sacred. The cult of the saints. 263. Places representations which are dogmatically incorrect, or are not executed with proper decency and respect, or may give to ignorant people an occasion of error. If the images exposed for public veneration are to be solemnly blessed, such blessing is reserved to the ordinary, who may, however, delegate a priest for that purpose. Canon 1279, 1123. Precious images, that is to say, such that are valuable for their antiquity, art or veneration, and exposed for public worship of the faithful in churches and public oratories, must, when in need of repair, not be restored without the written consent of the ordinary, who shall, before giving the permission, consult experts in the matter. Canon 1280, 1124. Prominent relics and images of great value, and any relic or image which are honored by great veneration of the people, cannot validly be given away, nor be perpetually transferred to another church, without permission of the Holy See. Prominent relics of saints or blessed are the entire body, or the head, arm, forearm, heart, tongue, hand, leg, or that part of the body in which the martyr suffered, provided it be entire and not small. Canon 1281, 1125. Prominent relics of saints or blessed may not be kept in private houses and private oratories without explicit permission of the ordinary. Small relics may be kept with due honor in the houses of the faithful, or carried on their persons. Canon 1282, 1126. Only those relics may be exposed to public veneration in any, even exempt, churches which are authenticated by document of a cardinal, or the bishop of the diocese, or by another ecclesiastic who has by apostolic indult the faculty to authenticate relics. The Vicar General cannot authenticate relics without a special mandate of the ordinary. Canon 1283, 1127. The local ordinaries should prudently withdraw from the veneration of the people relics which they do not know with certainty to be genuine. Canon 1284, 1128. If the document of authentication of sacred relics has been lost through civil disturbances, or for any other cause, the relics must not be exposed to public veneration until the 264. The new canon law. Bishop has given his approval. The Vicar General requires a special mandate of the ordinary to act in this matter. Relics venerated from ancient times are to continue to receive the same veneration, unless in some particular case it is known with certainty that they are false or supposititious. Canon 1285, 1129. The local ordinaries shall forbid the discussion of questions concerning the authenticity of sacred relics, especially by words exciting ridicule and contempt of educated people, in sermons, books, papers and magazines intended for devotional purposes, when their authenticity is objected to from mere conjecture, or only probable reason, or prepossessed opinions. Canon 1286, 1130. Relics that are to be exposed must be enclosed in a case and sealed. Relics of the Holy Cross must never be exposed to the veneration of the public enclosed in the same case with relics of the saints, but must be placed in a separate case. The relics of the blessed must not without special indult be carried in processions, nor exposed in any other churches than those to which the Holy See has given the faculty to say their office and Mass. Canon 1287, 1131. The relics of the Holy Cross which the bishop may have in his spectral cross become the property of the cathedral church at his death, to be transmitted to the succeeding bishop. If the deceased bishop had the government of several dioceses, the relic is to belong to the cathedral church of the diocese in which he died. If he died outside the diocese, to that diocese from which he last departed. Canon 1288, 1132. It is forbidden to sell sacred relics. The ordinaries, deans, pastors and others having the care of souls shall watch that the sacred relics, especially those of the Holy Cross, are not sold together with the inheritance and with sale of other goods, nor pass into the hands of non-Catholics. The rectors of churches, and others whose duty this is, shall zealously watch that the relics are not in any way profaned, or are lost through carelessness of people, or are kept in a manner showing want of proper respect. Canon 1289, Sacred Processions 265, Title 17, Sacred Processions, 1133. By the term sacred processions are meant the solemn supplications made marching in order under the leadership of the clergy from one sacred place to another for the purpose of stirring up the devotion of the people, or to commemorate God's benefits and to thank Him, or to implore divine help. Ordinary processions are those held on fixed days of the year according to the rules of the liturgical books or the custom of the churches. Extraordinary those appointed on other days for some public cause. Canon 1290, 1134. Unless a memorial custom or the circumstances of places demand, in the judgment of the bishop, otherwise, there shall be but one solemn and public procession through the streets of a town or city on the feast of Corpus Christi, to be held by the church first in rank of dignity. In this procession must take part all the secular clergy and the religious communities of men, also the exempt religious, and the confraternities of laymen. Regulars who perpetually live in strict enclosure, and those who are more than 3 miles from the town or city, need not come to the procession. The other parishes and churches, secular or religious, may during the octave institute their own processions outside their church. Where there are several churches, the ordinary shall appoint for each the day, hour and course of the procession. Canon 1291, 1135. The ordinary with the advice of the cathedral chapter may for a public cause order extraordinary processions, at which, the same as at ordinary ones, although spoken of in Canon 1291, 1, must take part. Canon 1292, 1136. The religious, exempt or non-exempt, cannot hold processions outside their churches and cloister without the permission of the ordinary, with the exception of the Corpus Christi procession spoken of in Canon 1291. 2. Canon 1293, 1137. Neither the pastor nor anyone else is allowed without permission from the bishop to introduce new processions or to change or abolish the usual ones. At the processions proper to any church all the clergy attached to that church must be present. Canon 1294, 266. The New Canon Law, 1138. The ordinary shall see to it that the processions are performed in good order, stopping all abuse that might have crept in, so that in these pious and religious acts proper sobriety and reverence may be observed by all. Canon 1295. Title 18, Sacred Utensils, 1139. The sacred utensils, especially those which are blessed or consecrated for use in the public worship of the church, are to be carefully guarded in the sacristy of the church, or in another safe and decent place, and must not be used for profane purposes. As prescribed by Canon 1522, 2, 3, an inventory shall be made and carefully kept of all the sacred utensils. The material and form of the sacred utensils must be in conformity with the liturgical laws, with ecclesiastical tradition, and, as far as possible, with the laws of sacred art. Canon 1296, 1140. Those who are, according to Canon 1186, obliged to attend to the repairs of the church edifice are also to provide the necessary utensils for divine worship, unless other provisions are made. Canon 1297, 1141. The sacred utensils, and all other objects perpetually destined for divine worship, in the possession of a deceased cardinal, who had his domicile in the city of Rome though he was a suburban bishop or an abbot nullius, belonged to the papal treasury, no matter by what kind of revenue they were acquired, unless the cardinal donated or willed them by testament to some church, public oratory, pious institution, or to an ecclesiastical or religious person. The rings and pectoral crosses, also those with sacred relics, are excepted from this rule. It is to be desired that the cardinal who wishes to make use of the faculty to donate or will his sacred utensils, should leave at least a part of them to the churches of which he held the title, administration or trust. Canon 1298, 1142. The sacred utensils of a deceased residential bishop, though vested with the cardinalical dignity, accrue to his cathedral church, with the exception of the rings and pectoral crosses with or without relics, and all sacred utensils of any kind which Sacred Utensils 267 can be proved to have been acquired by the deceased bishop with other than the funds of the diocese, and have not been turned over to the proprietorship of the church. The pectoral cross with relics of the Holy Cross must, according to Canon 1288, remain with the bishop sc for the use of the succeeding bishop. If the deceased bishop ruled 2 or more dioceses in succession, or at the same time presided over 2 or more dioceses which had been united, or which were given to him for perpetual administration, each diocese having its own proper cathedral church, the sacred utensils of the bishop that are known to have been acquired by the funds of one only of these dioceses accrue to the cathedral of that diocese, otherwise they must be equally divided between the various cathedral churches, provided the revenues of the dioceses are not divided, but constitute perpetually only one mensa episcopalis. If the revenues of each cathedral are kept separate, the sacred utensils are to be divided between the several cathedral churches in proportion to the amount of revenue the bishop received from each church, and the length of time he presided over the churches. The bishop is obliged to make an inventory in authentic form of the sacred utensils in which he should truthfully state when they were acquired, and point out distinctly those utensils which he did not obtain by church funds, but either bought with his own money or acquired by personal donations. Otherwise the law presumes that all were acquired by church funds. Canon 1299, 1143. The recs of the preceding canon are also to be applied to a cleric who obtained a secular or religious benefice in any church. Canon 1300, 1144. Cardinals, residential bishops and all other clerics are bound to take care that by a last will, or other document drawn up in the form recognized by civil law, the canonical laws laid down in Canons 1298 to 1300 may have effect also in the civil courts. Wherefore they shall in good time appoint, in a manner recognized by civil law, a person, according to Canon 380, who at their death shall take possession not only of the sacred utensils, but also of all books, documents, and all other goods belonging to the church, found in their house, and send them where they belong. Canon 1301, 268. The New Canon Law 1145. The rectors of churches and all others to whom the care of sacred utensils is entrusted shall see to it that they are kept in good condition. Canon 1302, 1146. The cathedral church must furnish the bishop gratuitously with the sacred utensils and all other objects he needs for the celebration of Holy Mass, and of other pontifical functions, even when he celebrates privately, not only in the cathedral church, but also in other churches of the episcopal city or its suburbs. If a church is very poor, the ordinary can permit that a moderate fee is demanded of priests saying Holy Mass there, to cover the expenses for the sacred utensils and other things needed for Holy Mass. The bishop, or by special mandate the vicar general and vicar capitular, has the right to define the amount of the fee, and no one, not even exempt religious, are allowed to demand more. The bishop should, if possible, define the fee for the whole diocese at the time of the synod, otherwise outside the synod with the advice of the chapter. Canon 1303.